I will make an observation which might help the general conduct of the proceedings before your worship," he said. He objected to the absence of a list of witnesses and protested against the secrecy of the testimony to come. "Mr. Sturgis, for reasons best known to the authorities who instruct him, is proposing to simply call witnesses without giving a summary, even to your worship at this stage, of the nature, extent, or their purpose in being called." "Mr. Sturgis?" Galvin said. Sturgis said, "I will bear that in mind and see what I can do." So that Kirkham could read her statement, he conceded that Sally Lowe might be stood down for an hour or two, but no later than the afternoon session. "I know that the lady is booked to return to Tasmania and to her family tomorrow," he said. This was news to Sally Lowe. She broke in. "I have an open ticket," she said loudly. "I'm willing to stay as long as it takes." At the bar table, Kirkham lowered his head to hide his grin. "I now call Michael Lee Chamberlain," Sturgis said. Kirkham was interjecting before he was fully out of his chair. "Your worship, we object to the calling of Mr. Chamberlain at this point in the proceedings." He laid out the technical form of his protest, which had to do with the rights of a witness to refuse. But his case law was still somewhere between Melbourne and Alice Springs. "I will be in a position to put authorities before you, I believe, this afternoon. I've arranged to have some unreported decisions recently made in similar proceedings in the Victorian Supreme Court flown up." Because Galvin was not drawn by the pause which followed, Kirkham kept on. "Inasmuch as they have the choice," and here he meant the Chamberlain's choice to testify or not, "it can only be a real choice if it is known what evidence is going to be called. We don't know the nature or extent of the fresh evidence to be put before you, and neither of the parties we represent is in a position to effectively exercise their rights without knowing the nature of the evidence to be called. The fairer course would be to call the evidence, then call the Chamberlains, and allow them to make an election, or to make submissions as to their rights, on the basis of what has gone on before." Galvin said, "Do your authorities cover this point?" "They do indeed." "On fairness, you say?" "Not on fairness alone, their common law rights as well." Galvin called on Sturgis for a reply. "Your worship," Sturgis said, hunching over the lectern, "I did invite my friends to make an application in closed court." Reporters in the pews behind craned forward to catch his unexpectedly moderated voice. "They said they would prefer not to do so. In view of the attention that this matter is receiving, publicly, one must be very careful how one chooses one's words." He chose his words to convey to Galvin that he proposed to call the Chamberlains first and other evidence afterwards. "I'm subject to your worship's direction, but, apart from that, I control who shall be called, and when they shall be called, and the order in which the evidence is presented, not the witnesses themselves." Galvin let the argument run a while, then said to Rice and Kirkham, "All I say is, if they are the authorities on which you are waiting, I am prepared to postpone the inquest until you argue it. But otherwise, I'm prepared to go along with counsel assisting. Your client should be cautioned, and they must elect to answer or not. But if you have got your authorities, I'm prepared to postpone it." It was, as it seemed to Kirkham, a grudging concession. They were, after all, only asking for time. This was going to be harder than they'd thought. When the court adjourned, Rice and Kirkham led the Chamberlains into the conference room. Stuart Tipple followed them in. Tipple was a young and neat Adventist solicitor from Gosford, near Corranbong. He had been on the case since the time of Charlwood's raid. Rice closed the door. "Well, you can see the way it's going," he said. Peter Dean arrived. He had called his office. There was yet no parcel from Melbourne. "I'm not sure it would make any difference," Rice said. "In any event, Jerry Galvin won't let us wait forever." Dean had worse news. A radio station was reporting already that Michael Chamberlain had refused to give evidence, so not to incriminate himself. This upset Lindy Chamberlain more, evidently, than being forced into the witness box early. She sat on the edge of her chair. "It's very important to us how we behave," she said. "We want to give evidence. We don't want to look as if we got something to hide." "I know," said Rice. "I know." Rice and Kirkham were worried about the rumors around town of blood in the car. Current stories identified the blood as fetal and splashed it about the car as far as the firewall near the passenger's feet. The Chamberlains had met this information so far with plain disbelief, which left the lawyers with little to go on either way. Rice recited the alternatives. If you refuse to testify, the only ground available is self-incrimination. You would have to repeat that after every question. If you do testify, you'll have to answer all sorts of questions and without knowing what you're up against. Only you can make the decision. Mr. Rice, the answer is out there. She waved a hand in the direction of the crowded foyer, the reporters, the bug-eyed cameras. We give evidence, she said, and Michael nodded. Rice was not finished yet. So great were the dangers that he wanted a declaration that they were properly advised. Dean had it typed out. The final sentence read, "We confirm that we consider we have nothing to worry about and that we wish to give evidence and intend to give evidence." After Lindy Chamberlain signed it, she laid a hand lightly on Kirkham's sleeve and smiled. "It'll be all right," she said. "Really." Rice sent a message to Galvin conceding the absence of their authorities, and the session resumed. Sturgis dealt with a geologist who had examined soil from Azaria Chamberlain's clothing and had found much of it like soil taken from around the campsite and some of it like the soil where the clothes were discovered. None of this excited Rice enough to cross-examine. Andrew Kirkham then had a fine time questioning Sally Lowe. He took her through her recollections of the baby's sleepy movements and of Lindy's motherliness in case they still had to meet some suggestion that the child was already dead or that Lindy had planned to get rid of her all along. She described the baby's cry again, the shock and sorrow of the night, and the blood she saw later in the tent. By the time Kirkham sat down, he was sure he had displayed Sally Lowe as an observant and truthful witness. It had occurred to Kirkham that Sturgis might plan to call no one else who was nearby when the baby vanished. Of the events at the campsite, Galvin would have the testimony of bystanders only on the inert and passionless page. Rice got to his feet as soon as Michael Chamberlain was called and before he took the oath. "Your Worship, we repeat our submission regarding Mr. Chamberlain being called at this stage. We have no control over his being called now. We would have thought it far fairer to have called him after other evidence which the authorities have, which they claim changes the aspect of things. I merely mention this because we cannot in any way control the time when Mr. Chamberlain, or Mrs. Chamberlain, can give evidence, and to that extent I rise in protest knowing that I am impotent to do anything about it." From the beginning, Michael Chamberlain was quiet and careful. He clasped his hands, pursed his lips. He paused before he answered any question, drawing first on some small provision of self-assurance. That provision ran out quickly. Sturgis was interested in blood on the sleeping bags. "You have identified Exhibit 20 as your sleeping bag?" "Yes." "And do you say that you did, subsequently when in Mount Isa, notice there was blood staining of your sleeping bag?" "I know there was blood staining. I seem to recall there were blood stains on both bags." "Well, I'm dealing with Exhibit 20, and the question related to that. Is it your recollection now that at Mount Isa you noticed there was blood staining of Exhibit 20? "It may have been pointed out to me. I cannot recall whether it was that bag or not that I saw it on." "Did you make any attempt to have Exhibit 20 cleaned when you got back to Mount Isa?" "If this is my bag." "Well, it is your bag, is it not?" "Yes. Then I think I did, yes." "What do you mean by saying you think you did?" Sturgis said, heavily. "Don't you know whether you did or didn't?" "Sir, I have been under a considerable amount of stress since the beginning of this, and a lot of things that have happened to me make it difficult to recall at times." Soon it was time for Rice to help. Sturgis was saying, "Can you tell me this? What was the nature of the blood staining upon the bag that you took to the dry cleaners, Mr. Chamberlain?" "There was blood, I think, around the collar area, and there may have been blood elsewhere, I can't recall, but I know there was blood on the bag, probably around the collar area." "And this is the situation, correct me if I am wrong, you think that bag is Exhibit 20 your bag, but you cannot be sure?" Michael Chamberlain frowned. It seemed to Kirkham that Michael was now so confused that he didn't know if he was being asked if the bag was his or if it was Exhibit 20. "Well," Michael said, "if you say that is Exhibit 20, that is my bag." Sturgis's voice was slow and scathing. "Yes, but that does not really answer my question, does it?" "The question was ambiguous, Your Worship," Rice interjected, "and I rise simply, if I may, to make the observation that my learned friend here is to assist Your Worship. He is not prosecuting." Rather than answer the accusation, Sturgis chose to rephrase the question. Rice and Kirkham were as interested in Sturgis's questions as they were in Michael's answers. They were listening for clues. "A towel is something you would have used?" "Yes." "Before you got to Mount Isa?" "Yes." "And on the occasion of using it, did you see any blood staining on it?" "Not my towel." "Any other towel?" "Not that I recall." Kirkham thought, so somewhere there's blood on a towel. "You would have travelled quite a few dusty roads, I take it, going from Ayers Rock and returning." "Yes." Michael smiled at what seemed to be a more pleasant turn in the questioning. "We tried to avoid as much dust as possible, but we had to. But the situation is that, back at Mount Isa, you had to clean the car outside and inside." "True." "And you did not notice any blood staining on the outside or the inside of the car when you so cleaned it? Is that what you say?" "That is correct." "Is this the situation? Apart from the blood staining that was inside the tent, you did not see any other blood staining whatsoever that could possibly be associated with this matter?" "No, I don't recall having done." And Kirkham whispered to Rice, "There's blood in the car, all right." "Have you been in any road accidents in the car?" "Yes." "Many?" "I think probably 3. Had anybody been injured?" "No." "Had anybody suffered any injury in the car which caused bleeding?" "Yes." "Who was that person?" "There were several. There were my 2 sons, I recall. Regan had bled in the car. I think Aidan had a nosebleed in the car. And we had at least one occupant in the car who had bled quite profusely as a result of a road accident, who we picked up and took to hospital." "Who was that person? Do you know?" Michael didn't know, but had a note of the date somewhere. He gave it as 16 June 1979. He and Lindy were trained first aiders and had taken the man to the Cairns Base Hospital. "And he travelled in the back seat, front seat, or where?" "As I recall, he was in the back." "What about Aidan now?" "Aidan had a nosebleed. I don't know where in the car he would have been put. I might add that I think there were others in the car who also bled. Pathfinders from time to time." "I beg your pardon?" "Pathfinders, young people in the church, that we would fix up." "What, young boys and girls?" "Yes." "You say Aidan had a nosebleed. What happened to him?" "I do not recall about him so much. It was mainly Regan who bled from the head." "Did you take him to the doctor in the car?" "Yes." "Where was he? Front or back seat?" "I think he was probably in the front seat." "Can you tell me anything else about possible contamination of the outside or the inside of the car by blood?" "Not within my memory at this stage, no." "Well, certainly we can be sure of this. There was no bleeding of the baby in the car, was there, that you know of?" "Not that I know of, no." The last question interested Rice and Kirkham most. They had to face more than blood in the car. Certainly now, the blood was thought to be fetal, blood from a tiny baby. "The police came to see you in Sydney, is that correct?" Michael did not argue that it was Currambong, not Sydney. "Yes." "And did you give them the camera bag you had at Ayers Rock?" "Yes. Yes, I had several bags out there, actually." Sturgis held one up. "That is the bag you gave to the police?" "Yes." "In that bag, then, you would have carried various parts of the camera, and the camera packed in separate bags?" "Yes." "Anything else?" "Probably a cleaning cloth." "Would you describe the type of cleaning cloth?" "Well, it was a soft sort of glass cleaning cloth." "One of those so-called lint-free cleaning cloths?" "Yes, you could call it that." "So, we've got the camera gear packed in the bags and the lint-free cleaning cloth. Anything else in the bag?" "There would have been probably a foam base to the bag." "Was there anything else?" Sturgis said, dissatisfied. "I will ask you the question again. Apart from what you have described, I would like you to be as particular here as in any other place." "Well, it wasn't always used for camera gear, that bag. Not since Ayers Rock. But I put various things in there. Other types of clothing, that sort of thing. This answer caused Sturgis some pause. I did not quite hear what you said. Other clothing. Before that, please, Mr. Chamberlain. You said it wasn't always used for camera gear. It wasn't always used for camera gear. It was being used for camera gear out of the rock, but I did put other things in it from time to time. Yes? What type of things? Clothing, usually. Sturgis thumbed through his notes on the lectern, as though looking for something, a sure sign in an advocate that the last answer came as a surprise. He had, Kirkham noted, twice used the term lint-free, talking of the cleaning cloth. So it was a fair bet they'd found lint of some sort in the camera bag and wanted to use it. Disposable nappies might shed lint, was that it? But it was the word clothing with which Sturgis was unhappy. Clothing in the camera bag wrong-footed him somehow. Where did you carry that bag when you were on your trip to Ayers Rock, and while you were at Ayers Rock with the gear in it? The back seat? On the front seat? Or under a seat? Well, usually I carried it underneath my feet during the trip, mainly so I could get at it quickly if I saw something on the side of the road. It was just so I could have very fast access to the camera. Under your feet? Between the front of the front seat and the pedals? Yes. You did not find it somewhat inconvenient there? Interfered with your access to the pedals? No, not really. When you weigh up the fact that you like taking pictures at a very smart rate, I was willing to forgo that small inconvenience. Sturgis called for a copy of the statement made by Bobby Downs. Roberta Downs, Bobby as she called herself, you say travelled with you from the campsite back to the motel. Is that right? Yes. Do you remember her calling your attention to this camera bag? Yes. And offering to take it from you? Yes. Saying that it appeared to be inconvenient or something like that? Yes, I remember that. She offered to hold it? Yes. But she refused that offer, is that correct? Correct. And Sturgis left the issue hanging there. Mr. Chamberlain, on the Monday you set out to get some photographs of the tent site, is that so? Yes. How did that come about? Well, I was rung up by a pressman from Adelaide. Do you know his name? Yes. I seem to remember it was the name of Scadden. Michael spelled it. His voice was getting weaker. Galvin said, Before you go on, if you wouldn't mind keeping your voice up a bit. Was this man known to you, Mr. Chamberlain? Sturgis continued. Or was he a total stranger? No. A total stranger? A total stranger. And when was he in touch with you about this matter? In the morning or in the afternoon? Sometime Monday morning. Can you be more precise than that? Was it fairly early in the morning, or getting towards midday, or when? I can't really recall. I think it was mid-morning, late morning. The courtroom stance Sturgis often adopted resulted in the lectern supporting much of his weight. It had nothing to do with nonchalance. It usually indicated the importance of an imminent question. Did you know that people were still out there, searching at that time? I'm aware that there was still some small search going on. You decided to go and get these photographs to oblige this man, is that correct? Yes. As I recall, I was fairly reluctant, but he pressed me and tried to, well, do it at all costs sort of thing. Taking time over the sentence, Sturgis repeated it. Do it at all costs. I think that was the general tenor. You had quite a lot of film with you, is that right? Used? Unused. I didn't have much unused film left. Anyway, you decided to get a black and white film, is that right? Yes. Why was that? Well, the press, as I understand, don't appreciate trying to use color films in black and white newspapers. This was enough for Rice. He climbed to his feet. This has all been gone through before in the previous sitting, Your Worship. It is all on record, and it is caking on the semblance of a very dexterous, inquisitorial cross-examination as to why this man did not go out searching, as one would have expected, perhaps, by the cross-examiner. This is entirely in Your Worship's hands, but I do not see this as assisting Your Worship. Rice used the phrase, assisting Your Worship, to convey in a legal manner the fairness and even-handedness he expected from a coroner's assistant. It is, more or less, to impute some impure motive, or at least to impute some sort of guilt to Mr. Chamberlain, and I object. On what basis? Galvin asked. On the matter that it has been gone into before? On all aspects. The fact is that it has been gone into before. "Can we get this one straight, Mr. Rice?" Galvin said, in the loudest tone he had used until now. "As far as I am concerned, this is a new matter, and I would have thought I had to see the witness." Rice might have been more satisfied with that answer if Galvin chose to see all the witnesses, including those at the campsite favorable to the Chamberlains. So heated was the exchange becoming that both he and Galvin were speaking at the one time. Rice won. "But is my friend alleging the commission of some sort of offence by Mr. Chamberlain? You see, we know nothing. He has gone into the witness box at this early stage without any notice to us at all. Now, we have been very patient, but I do object. If my friend is going to suggest that he has committed some offence, why has he not been charged, and the normal processes of justice allowed to proceed, instead of putting him in the witness box and cross-examining him, under the guise of an inquest, with a view to building up a case when presumably this other evidence, this other undisclosed evidence, does not seem to have the fibre?" "Well," Galvin said, "if I can perhaps paraphrase your argument, your objection is on the second leg rather than the first?" Rice conceded that. Galvin called on Sturgis. "Your Worship, I seek to examine the conduct of Mr. Chamberlain during the hours shortly following the raising of this alarm, what his conduct was on the Monday." "With a view to what?" "With a view, really," Sturgis said, as if searching for better words, "just to make a full examination of it at this stage." "Would you then say that the objection, that becomes an inquisitorial matter?" "If your Worship pleases, a coronial inquiry is an inquisitorial matter," Sturgis agreed. "One seeks to determine what occurred that is relevant to the matter being inquired into. Now, evidence that will be given might strongly suggest that some person or persons, subsequent to the alarm being raised on the night of the 17th, did certain things with the clothing that the child had been dressed in, and put it in a certain place, that there was human interference in relation to that matter. In those circumstances, I would submit that we have to be very much concerned with the conduct of the persons who were closest to this matter. I am seeking to examine what his conduct was on that Monday, and to examine the reasons why he went back to the campsite. We have, in the other proceedings, evidence of a return to the campsite and an explanation for it, and I am seeking to examine that side of things, why he went back there and what occurred, and how long he was back at the campsite. And this is conduct that is very, very close to the occasion in question. I would submit that it is a matter of considerable materiality." Galvin leaned back in his seat. "At this stage, I say that it is relevant to the—" He trailed off, substituting a wave of his hand for the rest of his adjudication. "Thank you," said Sturgis, turning back to the witness. After the overnight adjournment, Rice made another attempt to have Galvin restrain Sturgis from acting, as Rice put it, as if it were a trial. This time, Rice asked that Galvin lay down some clear ground rules. "I decline to do so, Mr. Rice. I think counsel assisting, in my view of the law, is entitled to ask leading questions and to conduct an inquiry as such. If you wish, I agree that there may be questions of natural justice, and I think you are going to have to take objections to questions as they come, and I will rule." This was all Rice could hope for now. He conceded and sat down. Clearly, it was just no use. Kirkham was astonished. He had appeared frequently here in Alice Springs and in Darwin Courts without striking anything like this before. The thoughts which were moving him to anger were not at all complicated. This was an ambush. Galvin was not going to put a stop to it. Perhaps he thought he should have tried to dissuade the Chamberlains from testifying, looking back on it now. A chastening mirror, hindsight. The spectators on the public benches are growing louder. Reporters sitting in front can hear them clearly. Galvin's decisions are popular back there. When Rice sits down, defeated in the last exchange, someone in a large primrose smock says, "How sad." From the sniggering nearby, she seems to be held in high regard. On the witness stand, Michael Chamberlain is handed a child's sleeping bag and asked to identify it. His nervous fingers can't loosen a knot in the cord, and he asks for help. "Poor thing," she says. The reporters turn to look. They know her. She is the mood of the town. The car is a main attraction for Sturgis. The questioning visits it time after time. "Do you recall washing the carpet?" The carpet? Using soap or detergent or something of that nature? No, I don't. Do you recall cleaning blood off the seats? I cleaned the seats fairly regularly, but specifically blood I don't recall actually, specifically cleaning blood. You said you did not recall. If the seats, or some of them, became badly stained with blood, and you cleaned them, you would recall that, would you not? The fact is, Mr. Sturgis, the car's interior is black, and it's very difficult to see dark things in that car. Yes, I accept what you say, but I'm trying to direct your attention to this. Did you, at any stage, discover enough blood in the car that you required, as a quite separate task, to set about cleaning the blood off? You understand, off the seats? Yes. No, I don't recall that. If that had happened, it is a matter you would not quickly forget, surely, Mr. Chamberlain. I beg your pardon? If that had happened, that is a matter you would not quickly forget. You've got enough blood in your car, on the seats and that you have got to set about attempting to remove it. Rice was climbing to his feet more slowly now, as if his energy had diminished with the fate of earlier objections. He has answered that question, Your Worship, and he does not specifically remember any such occasion, that is all, and he has answered. The rest becomes argumentative. I will allow the question, Galvin said. Question is this, Sturgis said slowly, his hands perching on the lectern. If the car had so much blood upon it that you then set out to remove that blood from the car, that was your task, not just a general clean-up of the car, you would remember that, would you not? Bearing in mind that you only purchased the car in December of 1977? December of 1977 was 4 years past. Michael Chamberlain shook his head. There are a number of instances when blood was in that car, as I remember, but I cannot specifically recall setting out to clean any of it up. Have a look at these scissors, please. Sturgis handed them up. They were small nail scissors which someone had evidently dismantled for examination. You will see that the rivet, or the screw, has been taken out, so they present as two separate articles. Those scissors were in the console, were they not? I believe so, yes. They weren't in that condition. They were screwed together, is that correct? Yes. Ordinarily, you kept those scissors in the little pocket of the console, is that correct? Well, they are toenail scissors. I think they were not always in the car. I think they might have been at home at our house. But you frequently carried them in the car, is that correct? Well, they were in the car sometimes, and other times they weren't. They were certainly in the car when the police took possession of it? Yes. Since Michael Chamberlain couldn't remember which scissors he had in the car on the trip to Ayers Rock, Sturgis came at it another way. We agree upon this, do we, that ordinarily you used to carry a pair of scissors in the Tirana? At least one pair, yes. At least one pair, and in that little pocket of the console. That's the lift-up? Yes, that one. Usually, yes. What about towels? Did you ordinarily carry towels in the Tirana? Yes, I did. For the next question, Sturgis turned from the witness, an advocate's mannerism which anticipates the inevitable and damning answer. In the well at the back? Yes, Michael said, apparently relieved that this was all there was to it. He was unashamed by the well at the back. Where the spare tire is? Correct. You ordinarily carried a towel there, did you? At least one. At the bar table, Kirkham's list of items on which the police might have found blood had grown by a pair of nail scissors and a traveling towel, and there was an attempt here to present the towel as hidden in the wheel well. Kirkham permitted a smile. He had carried a towel in such a place himself on occasions. "I've no further questions of Mr. Chamberlain at this stage," Sturgis said. The qualification brought Rice to his feet. "When my friend says, 'at this stage,' I understand that he does not have any present intention of asking any more questions, or he does not want to have him recalled. I really want to know whether he has any present intention of having Mr. Chamberlain recalled." Sturgis said, "I can answer that. Your Worship, much further evidence is going to be adduced, and I will at all stages, subject to what your Worship requires me to do, give Mr. Chamberlain the very fullest and the most complete opportunity to return to the witness box and discuss any of the further evidence from that position." It wasn't the complete opportunity of which Sturgis spoke that worried Rice and Kirkham, but the words, "at all stages." They were facing a novel form of inquest, perhaps a running interrogation. 3. The court took a short recess. No one left the public gallery for fear of losing a seat. Michael pushed through into the foyer, wiping his hands on a wilted kerchief, and headed for the washroom. He was followed in by 2 radio reporters who hoped to provoke some quotable remark. The ploy was foiled by a power failure in that part of the building. The washroom was in total darkness. The spectators had to wait, as it turned out, until the afternoon session to see Lindy Chamberlain in the witness stand. Rice won the postponement because he'd been told a carrier had arrived with Kirkham's case law aboard, but when court resumed, he was still empty-handed. Galvin said, "If I can just indicate that I see no reason to change the ruling or the nature of the questions." He looked down at Rice. "I do not feel I am doing anything wrong." 4. Lindy Chamberlain's voice was faint and unsure, but she seemed to have a better grasp of memory than her husband. It was not long before Sturgis moved to turn this to advantage. He began to confront her with Michael's answers. "You were present in court here today when I was questioning your husband, is that so?" "That's correct." "And do you recall me asking him about a number of visits to the dry cleaners?" "Yes." "As though he was searching for a parka?" "That's right, we were." "That had been lost?" "That's right, we were." "Do you know anything about that?" "Yes. When we had our interviews with the police, they wanted to know where Aiden's parka was because they hadn't received it and it had been posted across to them. And it seems that there was some hold-up in the mail or in some department, and it subsequently turned up after several inquiries." "I may not have heard what you said. You said, subsequently turned up, did you not?" "Yes, the police had it." "The police had it?" "The police had it, here in Alice Springs." "Well, do you know anything about inquiries, and a number of them being made to the dry cleaners at Mount Isa, about the whereabouts of a missing parka?" "Yes. They asked us to inquire every place we could think of, just in case it had been mislaid." Sturgis interrupted her here. "Those inquiries were made at the suggestion of the police, you say?" "Yes. We knew a number of things had been to the dry cleaners, and we thought that, by mistake, my husband's memory was rather bad, and I wondered if he had taken it to the dry cleaners instead of to the post office. But it turned up eventually." At the police station, which seemed to settle the matter. Sturgis called for the jungle hats. "This is an army hat, commonly called a giggle hat, Mrs. Chamberlain. Is that correct?" "I understand the other one is a giggle hat. This is just an ordinary army hat." "This is your husband's hat, is that so?" "No, it's my hat." "Your hat, is it?" She nodded. "May I see it, please?" "My husband did identify it as his hat, but it's mine." "Very well. He made a mistake, you say?" "That's right. He quite often borrows mine and consequently thinks it's his." "And the other one? You saw it being produced yesterday. You may as well have a look at it again. That one is his, in fact, you say?" "That's Michael's hat, yes." "You gave those hats to the police in September of this year, is that so?" "That's correct." "That is, when they were down there with a warrant?" "That's right." "And you suggested they had better have a look at them, is that so?" "That's right." Kirkham made a note about the army hats. So far, Sturgis had spent most time on clothes and bedding from the tent which were free of blood. Clearly the implication was to be that a dingo would have bloodied these items more. Now Kirkham was watching a curious reversal of tactics. "What was it that you wanted them to look at?" Sturgis asked. "Well, they were asking for anything we had in the tent, particularly anything that may have had blood on it. And I suggested that these items, to my observation, had blood on them. Although they had rejected them for the last inquest, I thought they should be looked at again if they were going through everything. Pick up your hat to start with, the one that is yours. Just indicate this stained area. Show it to his worship. What about on the brim, underneath the brim?" She let the hat dangle from her fingers and pointed. "Through here and also on there, and I think that area." Most of it, red and brown spots, seemed to be on the left brim. "I know that children did get hold of it at one stage and throw some mud on it, and I think this side is the mud." She looked it over. "But I'm not sure which was—" Sturgis turned to the bench. "Has your worship had the opportunity to look closely at the hat?" Galvin waved it away. "I saw it yesterday," he said. All this was like walking through quicksands by night, but the more devious the route became, the more sure-footed she seemed to be. "The next item, please." Sturgis handed her a baby's rug. It was small and fluffy. "It's a bunny rug," she said. "Was that in the tent on 17 August? "No." "Was it at Ayers Rock?" "Yes." "Whereabouts? Was it in the car?" She was very pale. "Yes, it would have been in the car. I think it would have been in the dirty clothes bag." She made an attempt to say something else, failed, and began again, "because I had used it the first 2 days of the trip." "The police took possession of that also in September of this year?" Palsy, which had begun as a trembling of the hands, now had her about the shoulders. She held the bunny rug tightly. Her helpless wail of assent was barely audible. Sturgis said, "I may require an adjournment, if your worship pleases." Galvin called a recess. A court orderly, a well-tanned woman who was stationed alongside the witness box, walked over to join the duty constable guarding the door. "It was the blanket," the orderly confided. She had seen the other things in court before, but not the blanket. I was nearly in tears myself. But his sympathy was not contagious, judging by the faces in the public gallery. She revisited, in questioning, the car and the tent, without further event. She had resorted again to dark glasses, but her voice grew stronger. By the time Sturgis got her as far as her interrogation by Sergeant Charlwood, she was tetchy. "Now, let me proceed with this account," Sturgis said, meaning Charlwood's account. "Did Mr. Charlwood say, 'Mrs. Chamberlain, did you kill your child?'" He said that was one question he hadn't asked before. He had asked me before what happened, but never had I done it. "Did you say this, or something to this effect to him? 'Well, what are the implications if I tell you?' That's correct. Did he say, 'It depends on your answer'?" That's not correct. I said that he had promised to keep conversations confidential before, and he had broken his word. He asked me, "What conversations?" And I said that he had asked me about hypnotism, and then in the box, last time, he maintained that it was an official request, when there was no indication of that given. I said to him, "If I speak to you again like this, what guarantee have I got that I don't have this thrown up at me in court, which obviously I am having right now?" This was the current danger as Kirkham saw it. Not that she might be disabled again by tears, but by losing her temper. "Why," Sturgis insisted, "did you ask him that question, 'Well, what are the implications if I tell you?'" "Because I had told him that our legal advice was not to give an interview. And although I've learned very fast how far to trust the police, I was still expecting them to honour their word, and I was not sure what he considered an interview and what he didn't. And as I had no legal advice there, I was asking him the question. Unfortunately, I was given the wrong advice. Now you understand what my question is. Why did you say to him, 'Well, what are the implications if I tell you?'" "Yes," she shook her head. "I've just explained why I asked him that." Sturgis's voice was derisory, the one sure way of making Lindy Chamberlain stubborn. "Is that your complete answer on the subject, Mrs. Chamberlain?" "That's all I'm prepared to say right now." "Perhaps I can shorten this," Sturgis said. "Did he ever at the police station ask you if you were prepared to give him your handprints?" "No. He said one of the things they would have liked to have done, if we had agreed to an interview, was to have taken our handprints, and we told him that was fine by us, provided they got in contact with our lawyers, and any interview or handprints took place with the lawyers, then we were quite happy about it." "Did he say something like this to you? Being fully aware of what I have told you of the forensic findings, are you prepared to give me your handprints? Before you answer that, I want to understand that the giving of them could be a means not only of tying you to the prints on the clothes, but of also excluding you? Did he say that, or something like that?" "Yes." "Did you say this, or something to this effect?" "Yes, I realize that. I'm prepared to let you have my handprints, but I would like to talk to my solicitor first." "That's correct." "And he said, 'Yes, that's all right.' Is that correct?" "That's right. And he promised to contact us the following day. We haven't heard from him since." Sturgis wasn't prepared for this level of vehemence. "Steady on," he said. He waited for the court to quieten. "Mrs. Chamberlain," he said, "would you be prepared to give to the police your palm prints?" He meant now. Rice leapt up. "Before any answer is given, your worship," he said, in the light of the previous evidence, no suggestion of any—" He readjusted the position of his chair and stood behind it, slowing the pace of things, trying to break the bewitching drama of the moment. He began again. "I have not cross-examined at all on the voir dire," which was his shorthand way of saying that he had not yet questioned Charlwood about this interrogation. "But your worship will well know that whatever was said by Mrs. Chamberlain to Charlwood was against the background of her declining to say anything at all. For my friend to now suggest that she comply with any request of his is to deny a person the rights they have. They are not here to assert anything. They are not here to volunteer any evidence. They have the right at all times, a right she has exercised at the police station, to refuse, and I would have to protest. I think the particular answer, one way or the other, is contrary to the conduct of a fair interview, let alone the examination of a person in the witness box." It rankled with Rice that Charlwood had so arranged things that he would take a copy of Lindy Chamberlain's palm prints only if her lawyers were absent. It made Rice suspicious. Why did the law department deny him a copy of the handprint on the clothing? And here was Sturgis now, demanding either her handprint or a public refusal. The question was, how far would Galvin allow it? So far, Galvin was not drawn. He rested back in his chair. From the floor of the court, the bench obliterated all but his spectacles and receding forehead. Rice decided he'd better keep going. "I don't care for this line of questioning," he said, resuscitating earlier arguments. "For this sort of request to be conducted, no one is obliged to comply with that request, and refusal, of course on advice, can be misconstrued. My advice would be not to allow Mrs. Chamberlain to respond to that request, irrespective of what her state of mind would be." The last sentence was directed as much to the witness box, where Lindy Chamberlain was watching events from somewhere behind her round glasses, as it was to the coroner, but it brought Galvin leaning into the argument. Galvin said, "That is a different issue to the question being put, is it not? I do not think the witness ought to be asked the question." "Why?" Galvin asked. "I'm sorry, I do not think I am quite with your application." "Simply on the grounds that a person is entitled at law to decline to answer anything on any ground at all." This was true of a police interview, though a little wide for an application in a court. It betrayed Rice's firm belief that what Sturgis had in train here was a police interrogation rather than an inquest. "The fact that she is in the witness box does not elevate her in any way to a position different from that of her ordinary rights and entitlements. The advice any lawyer would give any client would be to decline such a request. Therefore, she should not be exposed to the position of embarrassing herself because of the lawyer's advice not to answer the question." Kirkham, who had been scribbling a note, pushed it along the table. Rice didn't need to read it. He was there already. "In any event, we would have to give her advice before any question was asked of her." "That is why I wanted you to delineate your argument," Galvin said. "If you want time to advise your client, you can have it." Inside the conference room, Lindy pulled off her sunglasses and said, "What do we do now?" "Jerry Galvin is going to let Sturgis run on," Rice said heavily, "so the choice is refusal or agreement. Mr. Kirkham and I advise refusal." He looked at Kirkham. Kirkham nodded. "We don't know enough yet to advise any other course." "The thing," Kirkham said, "is a double bind. If your print is too big, they can say the mark is only part of your hand. If it's too small, they'll say the clothing was bunched." "Okay. How do I say it?" Kirkham let out a quiet breath. He had feared she might decide to go her own way about this. "What was it you said to Charlwood?" "I told Sergeant Charlwood, and I say the same thing again. I would have been quite happy to provide my palm prints to them, provided my lawyers agree. They do not agree that I give my palm prints at this stage. They know I'm quite happy to give my palm prints." Sturgis said, "You are not prepared to give, to the authorities, your palm prints so they can be compared with—" He did not describe what they could be compared with. He gathered his notes and sat. Galvin stood Lindy Chamberlain down. 5. God only knew where Kirkham's parcel of case law was now. The mail strike, which had immobilized the first batch he sent for, was bad enough. But there was also rain. The day before the inquest began, The town was hit by the heaviest cloudburst seen for decades. One storm delivered 50 millimeters in 2 hours. The desert all around was a slurry. Sandy stream beds filled and the banks broke. The casino moved tourists in and out by helicopter, so wide was the Todd River. The front page of the Centralian carried a photograph of a delighted aborigine wearing a suit and tie, riding the current barefoot on a surfboard. The roads were cut. Air cargo coming up from the south was now displaced by more urgent supplies. Deliveries of anything else could take days yet. In Rice's hotel room, they had had an evening drink and talked things through. The judgment for which Kirkham was most anxious, called Alexander's case, wasn't available anywhere but Melbourne. There, a judge had prevented a coroner from forcing a witness to the stand the way Galvin had compelled the Chamberlains, but nothing could be done about it now. Second-guessing Sturgis's tactics, it seemed likely he planned to cross-examine the Chamberlains after each new piece of scientific evidence and before they knew what was coming next. Plainly, the Chamberlains must refuse. The difficulty was publicity. The press would be merciless. Rice favored making a refusal before the Chamberlains were called on again and in writing rather than in open court. The real task lay in the presentation. It had to be confidential and restricted to the law department, Sturgis, and Galvin. Making it public would prejudice the Chamberlains irremediably in the eyes of the nation. It had to be worded so that no one would risk pulling a trick like that. They worked on it into the night. 6. The police compound in which the Chamberlain's sedan was stored was 5 minutes' drive from the courthouse. Galvin convened the hearing inside the main shed. It was Sturgis who called the press together to lay out the rules. He had no trouble speaking over the heads of those in front. "Be in no doubt about this," he said. "Anyone that doesn't do as he's told will be sent outside. I'll give you a few minutes to look at the car and take photographs. Don't touch anything. You may photograph what you will, but the moment the hearing starts, you must move away and then maintain complete silence. While evidence is taken, the use of cameras is prohibited." The compound was a wire mesh cage with a gate, now ajar. The fence reached nearly to the roof of the shed. All this was built, so press releases said, especially for this exercise. The yellow hatchback lay inside it, disabled, empty of engine and gearbox. The doors on each side hung open. 2 seats lay on a nearby bench. The engine hood was propped against a wall. The press photographers lit the passenger compartment with flashlight explosions. 3 TV crews, with shouldered telecameras, filmed the car and filmed each other filming it. Then Sturgis walked in, leading Galvin, the Chamberlains, and the lawyers. He waved the news people outside. A court reporter held a microphone close by while Metcalf showed Galvin over the car. So big was Metcalf that, when he leaned inside, it seemed clear the vehicle was designed for a smaller race of people. He pointed here and there. Chalk marks made rough circles on the lining of the doors and on the carpets where he had found blood. The nail scissors were found in a pocket of the console between the absent front seats. A chamois was behind the driver's seat, a towel in the wheel well. He had come upon blood on the brackets which held the front seats to the floor, on the hinge, and around the bolt holes. He held up a steel plate. This he had cut from the roof of the front footwell on the passenger side. He had found blood there, the shape of a fine spray. He heaved into the passenger side on his back and lay with his head in the footwell. He pointed up. The vivid inference was this: the baby had been held down there under the dashboard, still spurting blood. 7. Sturgis beckoned Joy Cool over to the car. She clipped across the concrete floor on quick, high heels, a dark-haired little woman in a pink dress. She laid a fresh white handbag on the bench. She was both excited and confident. Mrs. Cool was a biologist with the Health Commission in Sydney. She had worked there for 4 years in the forensic science section. When the Northern Territory Police moved the Chamberlains' car to Sydney, it became her job to examine it for blood. She worked with Metcalf. He gave her the nail scissors, the camera bag, and 2 army hats. They swabbed the inside of the car and parts of the outside, then Metcalf dismantled the seats, and they examined those and the carpets. Wherever the stains were sufficient, she tested it for human character, for fetal hemoglobin, and made an attempt at grouping. The way the tests came out, she identified traces of blood in both inner compartments and the zipper of the camera bag. The army hats bore none at all. Those stains were something else. She found more in the console in the car, on both door handles, the seats, and carpet. On the driver's side, the carpet showed the presence of blood, but also the presence of soap, disqualifying it for further testing. But there was an edge of this carpet which gave up fetal hemoglobin. So did the towel, the plastic container in which the chamois was stored, and scrapings taken from under the passenger side glove compartment. Beneath the passenger seat, and on a 10-cent coin she found there, the blood was human and fetal. There was enough volume here for an attempt at grouping, which suggested Group O and PGM1+, but only on the probabilities, before the sample ran out. She was able, in a separate test, to dribble blood from that seat on the mounting underneath, producing the pattern she had found there earlier. To make it work, she needed 5 milliliters, and someone had to be sitting in the seat at the time. Mrs. Cool had, throughout, instructed Galvin and the lawyers in a straightforward tone, although Kirkham noticed that the tests on which her conclusions relied did not figure much in her explanations. Kirkham was familiar with this style of scientific testimony. The absence of the middle steps, the laboratory techniques, made the evidence seem more like fact and less like opinion. It gave the illusion of infallibility. She led the party from the car back to the bench where the seats lay. This was a surprise to Kirkham because it was here that the demonstration had begun. She lay the passenger seat on its side. Parts of the black upholstery were ringed with chalk. She scanned it with busy eyes. "I could probably illustrate the strength of the blood reaction," she said, "even though I've swabbed most of it off." In a case already on the bench, she found 2 small chemical bottles and a white pad. The pad was the size of a cocktail coaster. She swabbed part of the vinyl seat, laid the pad out flat, and held up the bottles. "I'll see if it will still work," she said. Kirkham couldn't believe she would risk a finale like this unless she was sure. The reporters crowded in more closely, a trespass which Sturgis didn't seem to mind. She applied a few drops of chemical. "Other contaminants will give a first-stage reaction." She waited a moment, but the pad remained truthfully white. "Blood gives this 2-stage reaction, an immediate bright blue." She poured on a little of the other and held the pad aloft. It began to shade near the center and darkened, at first a swelling jewel, now a turquoise butterfly, vibrant and magical. She smiled. It was that simple. 8. There moved then, through the witness stand, a procession of testimony which gave Rice and Kirkham the best indication so far how busy the police investigation was while the oblivious Chamberlains were engaging campus life at Avondale. Botanists and mineralogists had flown to Ayers Rock to collect samples of vegetation and bags of arid sand. Technicians in Sydney and in Adelaide dug holes in baby clothing with knives, scissors, and teeth from the jaws of dried dingo skulls. At the south face of the rock, an entomologist watched, for hours, the behavior of desert flies as they crawled over a cloth he had moistened with blood. Cox, the portly sergeant from the Adelaide Police Laboratory, had come up with 2 methods of cutting a baby's jumpsuit which approximated the damage to Azaria Chamberlain's. He demonstrated this to Galvin. He folded part of the fabric in 4, another in 2. He used a pair of curved scissors, cutting this way and that. He let the folds fall and displayed the damage proudly, betraying the amount of time it must have taken him to perfect the design. In a loud aside, made from the bar table, Rice said, "Any grade 2 child could do that." It put him in mind of paper figures joined at the fingertips. Then Sturgis asked, "You noticed that when the cuts were made, little particles of thread and fibre fell off, is that so?" "Yes," Cox said. "The top surface has a loop pile, and those loops, when a scissor cut is made into the material, cuts through the loops, a number of these little loops will fall off. In the vacuumings from the Chamberlain car that were handed to you, you discovered similar loop particles?" "Yes." "And subsequently, the camera bag was vacuumed?" "I had previously vacuumed the camera bag. I then looked at the vacuumings, and I found 3 particles of thread, little tufts of thread." In cross-examination, Rice went in hard. He held up the Chamberlain's nail scissors. They were small and old. "Were those the scissors you attempted to use in your first cutting tests?" "Yes," Cox said, "and they came apart." "They were wobbly to start with?" "Yes. And they were weak, were they not?" "They hadn't been put together properly," Cox complained. "Whether they were or not, they were weak." "Yes." Rice moved on to the scissors Cox had used in court. "The pair of scissors you eventually used, the ones you made your demonstration with before his worship, you call that a similar pair, do you?" "I could not get an identical pair." "Do you call it a similar pair?" "The nearest I could get." "They are larger in size, for one thing?" "Yes." "Greater in strength, for another?" "Yes." "And far more efficient for your purposes?" "Yes." The tufts of fibre found in the car and in the camera bag represented a greater challenge. "Mr. Cox, your theory is that scissors were applied to the garments after bleeding?" "Yes." "And that the areas affected were heavily laced with blood?" "Some areas, not all areas." "Well, you had better define which areas." "Areas of the collar were heavily." "Laced with blood?" "Yes," Cox conceded. "But the arm was not. Only in what I would call discrete areas. Most of it was unstained, on the arm." "Most of what was unstained?" "Unstained of blood. The area through which the holes appear where the cutting has occurred is unstained of blood." "But certainly not so in the collar, is that right?" "No, that is stained." "Very heavily?" "Yes." "What about the tufts, as you call them, from the black camera bag? Were they examined by you?" "Yes." "And there was no trace of blood on any of them?" "No." "That's right, isn't it?" Rice said, by way of underlining it for Galvin. Cox nodded. "I could not detect, by the presumptive test normally conducted, the presence of blood." When Rice sat down, he settled back, pleased. He'd not had so much fun in a long while. 9. The best place Malcolm Brown could think of, searching for Professor Cameron, was the casino, since that was where Sturgis was staying. Word was about that Cameron would testify tomorrow morning. Sturgis would keep him close by. Brown wasn't after an interview, and he knew better than to hope for one. Brown wanted to see Cameron somewhere other than in court. He wanted to get a feel for the man. He paid off the cab and went inside. Most of the crowd in the busy foyer was making for the restaurants and the gambling rooms. Brown headed in the other direction to the cocktail bar where the house guests drank. It was gilded and plush. Sturgis was there already, on a stool at the bar. Brown chose a corner table and ordered a double scotch. A double scotch represented, for Brown, 4 gulps. He was uncomfortable in places like this, and now he was the only man in the room wearing a suit. A baggy pocket yielded a copy of the Sydney Morning Herald. He opened it out. He was through his second drink when Cameron walked in. The professor was thick-set, balding, and shorter than photographs suggested. His ruddy tan indicated that he might spend a good deal of time in places other than the British Isles. He said something at which Sturgis laughed. Cameron looked pleased. It was Brown's guess that Cameron would be considered a fine raconteur. Brown had already researched something of Cameron's standing as a forensic pathologist. The man had a classy reputation. He was professor of forensic medicine at the University of London, director of a similar department at the London Hospital Medical College, and a consultant, it seemed, everywhere else. He lectured to police trainees in London, Bristol, Sussex, Kent, and to military police. He was a specialist in the injuries of battered babies and infantile deaths. His frequent papers were widely published, and all this was probably not the half of it. There was a suggestion, Brown remembered, that Cameron liked celebrated cases. He was thought a skillful witness, wily and resistant to cross-examination, and Brown now found that easy to understand. Sturgis listened while Cameron did most of the talking. When Cameron laughed, the eyes remained hooded and remote. The smile did as it was bidden. There was a strong coincidence here of the urbane and the competitive. Brown folded his newspaper and walked out. Tomorrow, he could expect some excellent copy. 10. Cameron sat in the witness box, crossed his legs, and leaned with an arm on the rail. So long was his curriculum vitae that Sturgis handed a typed copy to Galvin rather than read it all out. Then Sturgis said, "I would like to pass on to your sources of information. On 8 June 1981, at the London Hospital Medical College, did you receive from Mr. K. A. Brown of Adelaide, a forensic odontologist, certain items?" "I did." "Now, as I proceed, you will wish to refer to notes and reports you have made, and also photographs you have had taken, is that correct?" "I would like to," Cameron said. "Yes." This was a moment for which Rice was well prepared. He and Kirkham hoped they had found a roundabout way to flush out, from Sturgis and Galvin, copies of the scientific reports which would, in any other inquest, have been provided at the beginning. "Your Worship," Rice said, "I have seen nothing at all, as usual in this case, by way of reports. I know my friend's stance on this. He is under instructions not to reveal anything to me, but I now reiterate my formal request that I be, at least at this stage, apprised of the reports on which the witness proposes to rely." Galvin called on Sturgis. "Mr. Rice will have everything made available to him at the appropriate time," Sturgis replied. "As your Worship well knows, in a coronial inquiry the information is revealed to the court." By this he meant that the information is not made available to witnesses, an interpretation which caused Kirkham to sorrowfully shake his head. Sturgis went on, "The very proper practices of the court will be strictly adhered to." Looking down at Rice, Galvin said, "Do you want to take the matter any further?" It was a source of frequent wonder to Kirkham that Rice remained courteous in trying times like these. Not that Kirkham would himself have lost his temper, boyish though he looked. Advocates learn early not to upset the tribunal on whom their clients rely for a just decision. Nevertheless, charm was another thing altogether, and Rice had an inestimable amount. The argument Rice was putting rested on his right to examine a document which a witness needs to prompt memory. As the legal rule has it, a witness should exhaust memory first and then ask for permission to refer to notes. The notes must be contemporaneous, which is generally interpreted to mean that they should have been written closely enough to the time of the event as to be reliable. An advocate in Rice's position is entitled to examine them, and examine the witness about them to make sure these conditions are met. The procedure slows the progress of a hearing, and Galvin was now being warned, in stylishly polite terms, that this was a stunt Rice could pull every time a witness asked to rely on notes. "I do not wish to do so," Rice said, with a pleasant smile, "but I must ask that if the witness is going to refresh his memory by reference to notes, may I have the opportunity of looking at the notes to determine what my attitude will be?" Kirkham watched Galvin to see how he would take this. The coroner fingered his moustache. He'd got it all right. He turned to Sturgis. "Mr. Sturgis, we are going to have to meet this at some stage." "Yes," Sturgis said, "if your worship pleases." "I agree that I do not have the power to interfere, but I think we are coming to a stage where surely something should be made available." He paused. "Otherwise, I'm going to be forced to run a technically correct course. Your worship, all these reports will be made available to my friend's inspection. I will give him a copy of the report, but the complaint is that he has not received these reports days or weeks beforehand." But this did not meet the obvious and immediate point. Galvin said, "What is going to happen now?" "He can have a copy of the report." Cameron called for Azaria Chamberlain's jumpsuit. He turned it over. Given a normal opening of a canine mouth and working from the dingo skull in my possession, I found difficulty in finding an area of skin exposed in a child that remained to be grasped without damaging the material of the neck of the garment. Examination of the jumpsuit, which I was presented with, confirmed that bleeding had occurred when the jumpsuit was buttoned up to the top, and that the neck had been cut at or about or shortly after by a cutting instrument such as scissors or a knife. But on closer examination, it's more consistent with scissors. One of the interesting features was that I could not detect any evidence of dragging on other areas of the jumpsuit, which indicated to me that it was not a member of the canine family that had carried the child, or if it had been a member of the canine family, it would have to be a large member of the canine family, such as a Great Dane. For to carry a child of this size by the head or neck, without dragging, would necessitate the body being held at least 20 inches or more off the ground. In other words, if it had been grasped by the neck, the feet would have dragged, and I would have expected drag marks in the form of tearing or marking on the feet, in the jumpsuit particularly, on rough terrain. Kirkham scribbled a note. Sand is rough terrain. This garment was subjected to exposure to the sand, or the dust, that is found on it, and that staining is uniform. It's not as if it was done after the garments were folded. It's done when something was inside that garment. So, assuming that the garment was buried, Sturgis asked, your opinion is that the body of the baby was in the garment at the time it was buried? It would have had to have been. A court orderly set up a projection screen. Sturgis had the courtroom darkened. A stills projector stood ready on the bar table, and the man who walked towards it was Ruddick, a colleague of Cameron, and the medical photographer at the London Medical School. While Ruddick shone pictures of the baby's clothing on the screen, Cameron stood in the half-light, outlining the important patterns of bloodstain with a glinting wand and its concurring shadow. His voice was fluent and continuous. Sturgis was letting him run. A slide came up showing two views of the jumpsuit side by side. The fabric glowed, the stains were black. An identification tag below said, ultraviolet fluorescence. Cameron said, that is the front of the jumpsuit, and that is the back. The tip of his wand circled smudges on the back, close to the left armpit. There are marks on the back of the cloth here, consistent with fingerprints. 4 fingerprints of a young adult right hand on the underneath, or over the left shoulder blade. He said a young adult, Sturgis said. I'm differentiating that from a child. A child of 4 or 6. It's far too big a print. When the lights came up, Cameron moved on to a print of the same shot, life-size. He slid across it a transparency showing the outline of a young female's hand. Rice looked worried and perplexed. As it seemed to him, so confused was the array of smudges here that any attempt to select a form was a disturbing exercise in sophistry. Cameron handed it up to Galvin. Act the superimposition yourself, he said. Galvin moved the transparency this way and that. I'm sorry, I can't see it at all now. Work principally, I would suggest, on the middle finger. But the coroner was not doing so well. It is not an exact fit, Cameron said with some exasperation, because it is of another handprint. He held the jumpsuit up and read from his report. As to the possible causes of death, in the absence of a body, one must assume an unascertainable cause of death. Having said that, however, in the presence of the bleeding on the jumpsuit, and from its amount, and various other findings at that moment in time, it would be reasonable to assume that she met her death by unnatural causes, and that the mode of death had been caused by a cutting instrument, possibly encircling the neck, certainly cutting the vital blood vessels. After that, the news reporters were anxious to get out of the court and on the phones. This was the story they had waited for, a cut throat, although it fell a little short of the vivid decapitation they had been led to expect. But they had to stay where they were, for the moment, in line with an earlier order given by Galvin, which prohibited movement while a witness was in the stand. With disinterest, they watched while Rice attempted a cross-examination. He did not delay them long. Without research, he was without thrust. Still, he was determined to illustrate, through Cameron just how unfair and unusual the procedures at this inquest were. Professor Cameron, you were instructed to retain absolute confidentiality in all respects so far as your examination of the material submitted to you was concerned. Cameron conceded this was so. And you have maintained that, of course, without question? Indeed. You knew that you would be cross-examined on matters relating to your examination of the material? I was led to believe that, yes. I just want to put this in the right setting, if I may. Rice stole a quick look at Galvin. You have been cross-examined time and time again, I suppose? Indeed, yes. Is it true to say that before you had been cross-examined, someone else has had an opportunity of examining the material as well as yourself, so that opposing counsel is at least acquainted with what has been examined by you? That has been the normal practice. And, Rice said, you can understand the fact that in my position here I have not, for whatever reason, had that opportunity? I sympathize, Cameron said, and raised a laugh from the gallery. 11. It didn't draw a laugh from Malcolm Brown, who leaned forward in the second row to see how Lindy Chamberlain was taking this. Throughout the evidence, he had watched her making notes, but now the pad lay on her knee. She was biting a lip. Her face wasn't in such good shape anymore. The cheeky college girl had gone, and the usurper was a tired little woman used to hard times. Something of Brown's own was also taking a beating. It was his pride. Professionalism was a thing he strove for and admired in others. Now he feared he had become too sympathetic to the Chamberlains. Since the time first rumors were abroad of fetal blood in the car, most news reporters convicted them then and there. And he had done that himself, God knows. The trouble was, every time he met the Chamberlains face to face, he didn't see in them the shadows of cruelty and guile. The most affecting instance happened when he arrived in town for the hearing. It was late afternoon, and he had just booked into the Oasis, a motel near the riverbank. The driveway filled suddenly with bounding photographers intent on an approaching car. The lawyers Dean and Tipple were in the front seats. The rear doors opened, and Michael and Lindy got out. They were unsmiling and pale. Flashbulbs gave them expressions of shock. Lindy's unsteady hand waved away the microphones. Brown, from the steps, caught Michael's eye. It was Brown who turned away. He had found in Michael's gaze a bewildering amount of trust. He was a man who made decisions step by step, often by talking to himself, and sometimes very loudly. The task, and he saw it clearly enough, was to write his stories straight, whatever the state of his sympathies. His pieces in the Sydney Morning Herald had around 750,000 readers, and he owed them accuracy. When he compared his pieces on the inquest with those of competing newspapers, it seemed he was somehow isolating the Herald from the mainstream. All this seemed to add up to a need for caution. But he had been reporting around the courts for many years now, and this one made him angry. Andrew Kirkham was no longer at the bar table. He had flown back to Melbourne for treatment of some ailment or other, as Brown had heard, and Rice was carrying the load alone meantime. Brown watched Rice deal with Cameron's coeval, Sims, a chubby odontologist who found no marks of teeth on the baby's clothes, and with the Sydney professor of textile sciences, Chaikin, who, in the voice of an excitable New Yorker, testified that the collar and the shoulder of the jumpsuit were cut rather than torn, and showed how loops and tufts were shed this way. Chaikin was voluble and difficult to pin down, but Brown thought Rice did better against Sims, who conceded that his experience with dingoes was limited to the recent examination of one dried skull. During recess, Brown wandered out into the foyer. He was beckoned by a tall, gentle woman who was standing with her displeased husband by the door. They were Adventists, friends of the Chamberlains, and had given him tidbits of information in the past. The woman's tone was low and breathy. "What do you think of your Mr. Rice now?" she asked. Brown didn't bother with the attribution. He said, "He's doing as well as anyone could, considering." "Oh, no, we don't think so," she said. I think you'll find none of us are happy with him at all." Brown supposed she was referring to Adventists at large. He excused himself and headed back. He guessed that there was something deep in the nature of Adventist belief that led these folk to hope for some sort of courtroom messiah. Sturgis put 2 women from Western dry cleaners through the witness stand in quick time to prove the patterns of blood on Lindy Chamberlain's tracksuit, a child's parka, and bedding. Lindy's friend Jennifer Richards, whose name had become Ransom by a second marriage, took a terrified few minutes to identify the tracksuit and quit the court without a backward glance. There was now a day and a half left in this part of the hearing before the Christmas break. The way Brown calculated it, Sturgis would try to finish the testimony in the current session, letting the legal argument and summations carry over into the next. If he was right, there were no surprise witnesses to come now. It left only Charlwood. 12. It was startling just how closely Charlwood's evidence of the Chamberlain interrogations accorded with the Chamberlain's own testimony about them. Any differences were of form rather than substance. This did not make great copy for the news writers, who then had to beat it up, as they say, into something exciting. But it spoke well for the Chamberlain's truthfulness, or for Charlwood's truthfulness, or for both. So unusual an occurrence as this degree of agreement, in the experience of lawyers, that Rice was suspicious. He wanted to be sure Charlwood was holding nothing back. First he called for the detective's notes, then, arms belligerently akimbo, got down to it. "Mr. Charlwood, did you, on any occasion at all, ever record any conversation you had with either of my clients by means of any instrument or device?" "Yes," he said. This caused immediate interest in the press benches. It was the first anyone had yet heard of a recording. Then Charlwood shook his head. "When I say I recorded the conversation, a tape recorder was in use during some of the conversation I had with them. Unfortunately, the quality of that tape was such that it was unable to be transcribed." "Which conversations do you refer to as an attempt at tape recording?" "Yes, I refer now specifically to conversations that took place during the house search on 19 September 1981. The conversations that I had with Mrs. Chamberlain in the motor vehicle on the way to Toronto Police Station, and at that police station with her and Mr. Chamberlain, wasn't recorded." "Are you saying that the only conversation that was recorded, or attempted to be recorded, was that at the house?" "Some of the conversation at the house, yes." Rice was really pushing this. He said, "Just so that we have absolute clarity about it, no attempt was made to record any other conversation with them? Or was there an attempt made which was aborted for some reason or other?" Charlwood raised his eyebrows. "You are referring now to any conversation you had with them?" "I had a tape recorder in the motor vehicle, but it just wasn't started. The tape never commenced." "Did you have it in mind to record that conversation?" "Yes, I did at the time, yes." "Was there electrical interference, or some such thing, which rendered the operation of the tape recorder useless?" "No, the tape just never operated." "So," Rice said slowly, "you attempted to record it, but that was the reason why you could not record that conversation, was it?" "It just never operated. That's correct, yes." "Did you, at any time, tell either Mr. or Mrs. Chamberlain of your intention to record any conversation you had with him?" "No, I never." Rice stood silent for a moment. There was something dissatisfying about the way these answers had come out, but the reason, whatever it was too elusive. "Thank you," he said, and sat down. 13. This was Christmas time, the season of warm, windless evenings and long dinner parties. In restaurants, big tables were popular. The lawyers from about town took one and sat around after the meal, talking. The inquest made an appearance in conversation only late in the night, perhaps because Jerry Galvin was sitting there. Not everybody at the table thought there was enough hard evidence to show that the baby was killed by one of the parents. "Do you know this?" Galvin said. "The police discovered a baby's coffin at the Chamberlain's house." A lawyer, of skeptical bent, said, Why hasn't someone given evidence about that if it's true? It's in the police report right enough, Galvin said, which brought the argument to a close. 14. The summer recess provided the legal teams with 5 weeks in which to assemble their concluding arguments and submit them in writing. Written submission was Sturgis's idea. A week before the inquest was due to begin, Malcolm Brown interviewed Rice in Adelaide for the Sydney Morning Herald. Rice was annoyed because he had still not received a copy of Sturgis's arguments, and time was running out. The law department was still playing it hard. Rice asked Brown not to quote him, but Brown wrote about it anyway. When the court opened on 1 February, with the Easterners astonished at the heat outside, Brown got there early, sought Rice out, and apologized. Rice was abrupt, but seemed to have got over the worst of it. He was now angrier about the way other reporters had treated the Chamberlains when they arrived, chasing them all over town with carloads of photographers. Brown saw that Andrew Kirkham was back in the team, waiting at the bar table. Behind him sat Lindy in defiant red, and Michael in a pinstripe shirt and tie. Neither of them looked up as the gallery filled. Sturgis called the biologist Joy Cool back to the stand. "After you had concluded your evidence, you were given a black vinyl camera case, is that so?" This was the camera bag Michael Chamberlain had given to Charlwood. She held it up. "The camera bag was turned inside out, compartment by compartment, and the screening test for blood was performed over all surfaces. How long did these examinations occupy you?" 4 days, she said. "In the front zippered compartment, most vinyl surfaces give me positive reactions for the presence of blood. Strong reactions were observed along the base of the bag." "You are dealing with what you describe as the front compartment?" "The front zippered compartment. The zipper was extensively tested, tooth by tooth." She described blood on the teeth and on the clasp. "Consistently positive reactions were found on that groove and from around this side of the zipper clasp," to which she pointed, "and precipitin tests made from an extract of those areas identified the presence of fetal blood. The middle zippered compartment also gave me strong positive reactions." She pointed to the bottom, to the flap, the right-hand corner, and then to the groove of the clasp. "An extract prepared from that reacted as human hemoglobin. The outside of the bag was subjected to examination, and the buckle on the outside gave me very, very strongly positive reactions for blood around the outer groove, around the top part of the buckle." "This is where the buckle attaches to the vinyl." "That is correct." The rust on it she discounted. "An extract prepared from around that outer groove also identified the presence of human fetal blood." The cross-examination was Kirkham's task now. He took her to the screening test for blood, the orthotolidine. "Would you agree, first of all, that the reaction can be obtained by substances other than blood?" "Not the same reaction." She went through the alternatives. "Plant peroxidases tend to give a much greener coloration than blood does. It is a slower reaction. Chemical compounds which give false positives generally give a positive first-stage reaction, which blood never does. The color development from a blood-type reaction is very, very distinctive, particularly in the hands of an experienced operator, and I consider myself an experienced operator." Kirkham asked, "May you get a positive reaction from milk?" "Yes, occasionally." "Child's vomit?" "Yes, but vomit would always contain traces of blood." "And therefore what? Give blood reactions?" "Yes." "Did you do any tests to exclude the presence of child vomit in the orthotolidine tests that you did on the bag?" "I'm sorry, there was not enough matter present to do any sort of test like that." "So in the circumstances, you are prepared to assume that it must have been blood?" "I have not assumed." "Despite the fact that you could not exclude, by way of testing, that it was the other agents, is that correct?" "I have not assumed. I have not assumed that it is blood. I have reported that a blood reaction was obtained. However, attempts to prove the presence of blood and determine the species were unsuccessful. I have written that in my report." "I have not seen your report yet, and I am going to, in due course, have a look at that," Kirkham said, with a glance at Sturgis. Are you conceding, then, that what was on the bag, and here Kirkham was talking about what was on the surfaces of the bag, may not have been blood? I have stated that, yes. This left Kirkham with the samples she had identified as human and human fetal blood. These came from the car, the towel, the chamois container, the scissors, and the camera bag clasps. The task called for detailed questioning about every test and every step of every test. Kirkham asked Mrs. Cool for her worksheets and began to take her through each notation, item by item. He began this at around 11 a.m. and was still going when court adjourned for the day. He began again in the morning. The spectator gallery was noticeably less crowded. The news people were bored and irritable. Questioning like this was unreportable. There was just no copy. Kirkham questioned her until midday. It was an exercise in research rather than in advocacy. To Malcolm Brown it meant this: Kirkham was now preparing for a trial. 15. Arms perched on the lectern, Sturgis began his summation. Half-moon spectacles sat low on his nose. He cleared his throat often and sipped from the water tumbler. Clearly the child, Azaria Chamberlain, came to a death at the camping area, or near the camping area, or at Ayers Rock, on 17 August 1980. The cause of her death is revealed by the condition of her clothing, discovered a week after her death. She must have suffered an extensive and a fatal wound or wounds to her neck or her head. Your worship has to consider the manner of death. Here there are only two possibilities: that she was killed by a dingo that also took her away, or that it was a case of homicide. I have submitted to you that, reviewing all the evidence, your worship will conclude that this was a case of homicide. The dingo theory cannot be supported by the evidence produced in this inquiry. I have submitted to your worship, in my written submissions, that in view of all the evidence that has been called here, your worship will place Mrs. Chamberlain on trial on a charge of murder, and that your worship will place Mr. Chamberlain on trial on a charge of being an accessory after the fact to that murder. Galvin caught early what was happening in the gallery. News reporters were beginning to stand as if the show was suddenly over. Some were still scribbling as they rose. Galvin raised a hand and said, "Ladies and gentlemen of the press." No one heard him. "It is going to be hopeless for me to give the proper concentration on this if we're going to have people in and out. I know you have deadlines, but I also have a much more important job to do." By this time, the benches were half empty. "It will just have to stop." Malcolm Brown stayed where he was. He had plenty of time before deadline. In any case, he was more interested in the silent drama in front of him. He was sitting directly behind the Chamberlains. While Sturgis spoke, they faced steadfastly ahead. Every time Sturgis uttered the word murder, tremors ran down Lindy's hair. The written arguments which Sturgis had given to Galvin were kept from the press. Reporters had to glean what they could as he spoke, linking one orphaned point with another. The story came gradually clearer. Sturgis had abandoned the early police theory that the baby was slaughtered somewhere on the slopes of the rock. She was killed in the car, or somewhere close to the car. Lindy Chamberlain had cut her daughter's throat and told her husband about it later. The body was hidden in the camera bag and then buried. The clothing was exhumed and laid out near Maggie Springs, damaged to simulate an attack. The evidence of the Lows and the Wests and the Whitakers seemed far away. It brought to Brown's mind a conversation he'd had with someone when the hearing began. He was talking to Frank Morehouse, who was writing a piece for a weekly, but also had in mind a film and was keen to isolate the themes. "The first inquest was about dingoes," he had said. "This one is about blood." Rice did not take long to make the same point. Reciting from the pages of his own written submission, he read to Galvin, "There is no attempt to discount the dingo hypothesis by any dingo expert." He laid the paper aside. "After all, Dr. Newsom gave evidence in the first inquest, and whether Dr. Newsom was studiously avoided by the Crown or not, I do not know. Nonetheless, Your worship has the benefit of his observations, and the absence of any further attempt to discount the dingo theory was not resorted to by the Crown. Rice was now well used to speaking of Sturgis's case as if it were the Crown case in a prosecution. And so far as Newsom is concerned, I will be referring to his evidence as we proceed. But the whole fortnight of the inquest, Galvin said, meaning the Barrett inquest, was about that, I would have thought. Pardon? The whole fortnight of the inquest was about it. Yes, of course. But you are saying, on that specific aspect? No attempt has been made to discount the hypothesis by a dingo expert. That is what I am saying. It has been attempted by other means, but no one has been heard as a witness before your worship. During a recess, Rice and Kirkham pushed through the foyer towards the conference room. Lindy Chamberlain, impatient, tugged at Rice's arm. She was speaking loudly enough that reporters were encouraged to edge closer. Plainly, she was giving Rice some vehement instruction, but no one caught more than the words, "the boys." The journalists stood around and talked it over. A rumor, then currently popular, attributed the slaying of the baby to one or the other of the Chamberlain boys and concealment to the parents. Someone now flipped through a notebook and turned up an item from Dr. Andrew Scott's testimony. Of blood on a boy's parka, Scott had said. Alternatively, the pattern is consistent with the wearer of the parka carrying a bleeding child. The intriguing point was that the Chamberlains didn't have to prove anything. To avoid trial, they needed only to suggest other plausible culprits. Here was an exciting possibility. The reporters filed back inside. They might be about to witness a neat, evasive trick. Rice paused and rearranged his papers. Gestures like these were harbingers of an important topic. He picked up a copy of Sturgis's submissions. He said, I quote, "So far as Regan, Mr. Chamberlain, and Aidan are concerned, not only is there no evidence that either or any was responsible, there is positive evidence that each was not responsible." He held the papers high. "So there is a clear and unequivocal assertion as to any participation at all. So all the rumour and speculation, which are rife, about some child having something to do with this, is put at rest by the assertion of Mr. Sturgis himself. Who better to make a comment such as that?" The reporters were looking at Lindy Chamberlain. So this was what she had instructed Rice to do, scotch the rumour. Someone passed a note along the front bench to Malcolm Brown. It read, "It's all over." He scribbled and passed it back. He'd written, "Long ago." 16. Galvin took a little less than 2 hours to decide. He came back into court carrying a single sheet of paper. Rice and Kirkham knew what was coming. He had sent them a message. "The evidence is, to a large degree, circumstantial. It is my view, having considered all that evidence, that a jury properly instructed could arrive at a verdict. I therefore consider that it is a proper matter for a jury to consider on the two matters that are argued for by the Crown, and I propose to proceed on those two suggested charges." He turned to Rice. "It will be in order for your clients to remain seated while we do it." Galvin held the sheet steady and prepared to read the arraignment. Sturgis slipped his folded spectacles into a pocket. Excitement was gone from the faces in the spectators' gallery. It was extinguished by a curious and perverse dread, although this was the event they had come here to see. 17. Grasshoppers exploded against the pavement. Television crewmen sat on the steps, out of the sun, watching a monitor. The picture had nothing to do with whatever the daydreaming cameras were gazing at. Here they were watching Australia and the West Indies at cricket. The first newswriter through the door came at a run. "Get ready," he said. "He's done it." They plugged in the cameras and switched the monitors over. Everyone wanted to finish it off and go home. It made banner headlines in every city daily. The Daily Mirror in Sydney, which was representative enough of the first coverages, ran, "Chamberlains, a not guilty plea at trial. Lindy and Michael Chamberlain will plead not guilty in the Alice Springs Supreme Court on 19 April. Mrs. Chamberlain was committed for trial, charged with the murder of her 10-week-old daughter Azaria in August 1980. Coroner Mr. Jerry Galvin also charged her husband Michael as an accessory after the fact in trying to shield his wife. "Son's not involved," says QC. Azaria Chamberlain's 2 brothers were not involved in her death, Mr. Phil Rice, QC, told Alice Springs Coroner's Court. Mr. Rice said he agreed with a submission by Mr. Des Sturgis, counsel assisting the coroner, that the boys Aidan and Regan were not responsible. The Radio Talks department of the ABC had a Sydney Law School academic quickly to air. There, Professor Ralston was already worried about prejudicial pre-trial publicity. He called for a prohibition against reporting of preliminary hearings and of coronial inquests. "It is now very difficult to obtain a fair trial for the Chamberlains. The loss of freedom of the press is counterbalanced by the preservation of justice." One East Coast radio station saw the issues quite differently. Its reporter rounded off his bulletin with this sentence: "When the trial goes to court, the world might find out just why Lindy Chamberlain cut the throat of her tiny daughter." 18. Malcolm Brown checked his luggage in at the airport desk. The terminal was hot and crowded, but he was not yet persuaded he should take off his suit coat. He made for the shopping counters. He had called his wife from the motel, and she reminded him to pick up something for the children. He bought a plastic crocodile and a fluffy buffalo. He chose them because they would fit in his pockets. He picked through the crowd looking for his Herald photographer. The reason he was doing this was something of a sore issue. His office had phoned through. He must get an interview with Lindy Chamberlain. Another time, he would have been flattered that they thought he might pull it off, but he really didn't want to try. He had thought about it and called back, but his boss told him to do as he was bidden and rang off. He found the photographer at the ticket counter. It was a sure bet that the Chamberlains were around here somewhere because the 2 Sydney flights left within a half hour of each other. Everyone seemed to have the same idea. A reporter had climbed on a chair to get a better view, and cameramen stood at the tarmac gate. Brown beckoned his photographer outside. They walked through the baggage depot and into the bleaching heat. A goods gate led to the tarmac. Brown had guessed well. There was a sedan parked in the lot here. The driver was no one he recognized. The couple in the back were the Chamberlains. Brown was good at forcing surprise interviews this way. He had a reputation for it, and a break like this usually made him feel quite high. But the Chamberlains were, somehow, not a quarry to feel proud of now. All he could think was, guilty or not, the worst thing that could happen to anyone had happened to them. He drew the photographer away. "I don't see them around here," he said, and headed inside to the bar. Necromancy. So to trial. Always running from something. 1. Spread over a small table, which took up much of the side wall of a room in the Medway Wing, a building in Kent, was a copy of the London Daily Mail. The man reading it was pale, a habitual pallor now, accustomed to nervousness, and over the last 4 years had developed a squint. The news report in which he was interested was headed, "UK Pathologist in Dingo Baby Case." He was preparing to write a letter about it on ready-ruled grey paper using a ball pen from which the sharp clip had been removed. If at this moment you were to ask him his name, he would come to attention and recite, "B22204 Godfried." This room was his cell at the Midstone Jail. He was in for rape. He addressed the letter, "To the lawyers for Pastor and Mrs. Chamberlain, Alice Springs, Australia." It was the best he could think of. "Dear Sir, I've just read in the morning paper today a report on the inquest into the death of the little girl Azaria Chamberlain. I feel I must write to you as I notice that Professor James Cameron is giving evidence at the inquest. Sir, I speak from experience of having had this man give evidence against me at my trial, and at this moment in time a police inquiry of my allegations against him is in process. It is not sour grapes saying this about Cameron. I can back my allegations up. I've said this before to other people, and he knows of what I said. Sir, to prove that he is, and there followed here an opinion about Cameron which was unmistakably prisoner Godfrey's very own, I've made inquiries on my personal behalf, and have to date found cases in which he has been involved which, to put it mildly, made his evidence stink. The first is where he gave evidence, forensic, in a trial in which, after his evidence, 3 boys were found guilty of murder and manslaughter. However, after serving over 3 years in prison, these boys, whom I do not know, were proved innocent and eventually awarded over £60,000 between them. The second case was a man who was robbing a supermarket and on coming out of the supermarket was shot dead by the police. The police said that the robber pointed a gun first and was shot dead in self-defense. A pathologist confirmed this by saying the robber, Michael Calvi, had been shot once from a handgun in the stomach, from which wound he died. That pathologist was again Professor James Cameron. Calvi's wife called for an independent autopsy by another pathologist, whose findings were that Calvi had been shot not from the front, but from the back. These 2 cases can be proved. Mine I'm still working on, but will be proved sometime. I want you to look at Cameron's evidence carefully, and you will see it does not add up, and to save others unnecessary suffering. Yours sincerely, James Godfrey. Both items of which prisoner Godfrey wrote were now celebrated causes in Britain, the Confit case and the Calvi. He was astonished that Australian lawyers had not heard of them, at least the news reports indicated nothing of the sort. What amazes me, he wrote to someone else, is why the pathologists in Australia did not come up with any evidence in the dingo case, but on coming to England, out of all our pathologists in Britain, who but a Professor James Cameron? This man has caused so much heartache. He enclosed in the Chamberlain letter a photocopied extract from Lord Fisher's judicial inquiry into the Confit case. The passages criticizing Cameron were heavily underlined. To the envelope he attached the postage he thought sufficient for surface mail. It ought to take around a month to get there. He closed the flap, and it was ready for the mailbag. This was the event of his week. Prisoner Godfrey expected to be in this room, and in rooms like it, for the next 11 years. 2. It is not a usual course of action for barristers to do their own legwork, but, for a brief of these dimensions, Andrew Kirkham thought it reasonable enough. So on 18 July, which was a Sunday, he filled a satchel with his papers, his wife Jenny packed his bag, and he caught a plane from Melbourne for Brisbane. He was making the trip in good vein, although he was at the same time losing money over it, because advocates earn most in court. His humor was more a response to the need for a team effort in this case than it was to any simpler professional duty. Just how much ground they had to cover had come clearer in the closing days of the inquest. Michael Chamberlain had put it well. He gave one short press interview. To a reporter he said, "We have a lot to do," and walked away. What heartened Kirkham most about that utterance was not its accuracy, but its brevity. Someone had at last convinced the Chamberlains that they should stop talking. The defense's task was already far too complex. Most murder charges resolved their problems sooner or later to a single paramount issue, an act of self-defense, say, or accident, or mistaken identity. The Chamberlains was exceptional. Here it was like mending cracks in a piece of glass. You could go after them this way and that, only to find it was none of these which eventually shattered the pane. What they needed was a broad and coordinated effort. The choice of team they had now settled on was largely Kirkham's. After the Chamberlains decided against engaging Philip Rice for the trial, a process which Kirkham kept a firm professional distance from, they asked Kirkham to recommend someone else. He took a week or so mulling the problem, setting the criteria. Rice was born in the Northern Territory, and there had been some advantage having a hometown player, but most of the advocates Kirkham knew best lived in Sydney or Melbourne. He wanted a leader who was not, as he thought of it then, a three-ring circus master. They needed, to use the phrase of the times, someone cool. So the team leader was now John Phillips. Kirkham had not, in his years at the bar, appeared with Phillips, or against him, but knew many who had. Now that the news was out, press profiles of Phillips dwelt most on his list of murder trials, which numbered around 150. For more human interest, they described him as an opera buff and a passable amateur baritone. Kirkham thought of him in entirely different terms, as a very elegant street fighter, swift and deceptive. If anyone else was a runaway surprise in the team, it was the Gosford solicitor, Stuart Tipple. Kirkham's early impression, from their first meeting in Alice Springs, had not been encouraging. Tipple was introduced as the church's solicitor. It seemed an adequate assessment. He was a quiet young man, with a mustache which had very little character beyond neatness, and the tidiness about him spoke more of proprieties than toughness or pragmatism. Kirkham clearly remembered the thought. What could a guy like this know about life? It was the surly face of life of which Kirkham was thinking, and he couldn't imagine that Tipple had caught sight of it too often. The surprise was not so much that Kirkham had somehow got it wrong, but that Tipple was now showing a capacity for the technical, the scientific. The way hematologists and pathologists spoke, the jargon and formulae which for everyone else called for rote learning, made deep sense to him. It seemed that his neatness was an asset. So the division of intellectual labor they decided on made Tipple responsible for the scientific evidence. Already he had gathered an arresting assemblage of pathologists and surgeons with whom to confront Cameron's adventurous opinions, an odontologist ready to rebut the doctors Brown and Sims, textile analysts who were examining automobile carpet and baby clothing, and working in laboratories at Newcastle University, the professor of biological sciences who was simulating the tests on which the prosecution relied to show fetal hemoglobin in the Chamberlain car. But Kirkham saw tactical dangers in all this. They might be drawn too far to the scientific front to be able to fight on the practical. Every case was a combination of the logical and the emotional, or as Rice had been fond of putting it, the scientific and the human. This was why Kirkham was heading for Brisbane. He found the Seventh-day Adventist headquarters in Eagle Terrace, and a plump woman at the desk fetched Pastor Kennaway. Kennaway was the communications director, a lean man in his 40s, his eyes lined at the corners by whatever responsibilities he bore here, but with a yet undefeated grin. They sought out an empty room. The pastor knew what Kirkham wanted to talk about. Michael Chamberlain's camera bag was once Mervyn Kennaway's. He told Kirkham now, "I carried it everywhere, rock climbing and bushwalking, for 5 years, and I gave it to Michael somewhere around March 1980. 5 or 6 months before Azaria disappeared. Around then." He couldn't think of any way it might have been stained with blood before, but fibers were a different matter. "I carried T-shirts in it, that sort of thing, when I took it to the beach, a towel maybe, plenty of cleaning cloths, tissues, and so on. You know Michael Chamberlain was a keen photographer. We both were." This recollection brought with it some amusement. "It was a sort of well-known joke. We took our cameras and gear everywhere." "Did you ever see him drive with a camera bag under his legs?" "I can't say that I have," Kennaway said slowly, "but I can well imagine it." He looked up at Kirkham. "You're not a photographer yourself, I suppose?" "No." Evidently, then, an explanation wouldn't be much use. When Michael Chamberlain was posted to pastoral duties in Bowen, Innisfail, and Mount Isa, Kennaway called in often and stayed as a house guest. He had, just 6 weeks before Azaria died, offered the infant's prayer for her at Sabbath service. "We don't have baptism at that age," he said. "It's a small service. I held her. She was a pretty baby. The tininess. She was 2 weeks old. Lindy lavished attention on her. The boys called her our Bubby. They were all so delighted." The next service he held there was the memorial. Kirkham asked, "How did the parents take it?" "Heartbroken." Pastor Kennaway had lost his own child, who was then 15, a few years before. No outbursts, you understand, but heartbroken. On the flight out, he held Kirkham by the sleeve. "There is nothing wrong with the Chamberlains, you know." Kirkham took him to be making not one statement now, but two. There was nothing in Adventist belief that would condone the slaying of a child, and there was no aberration in the Chamberlains. "We are the same as you in this," his plea said. To see Ronald Bellingham, who lived in Warwick, Kirkham chartered a light plane 200 kilometers west to Toowoomba and drove a rented car from there on. Bellingham owned a roadside garage. While he talked, he kept wiping his practical hands with a rag. The family was touring Ayers Rock at the time the Chamberlain baby was taken. The day before, the Saturday, they were walking the road near Maggie Springs. A dingo followed them a while, and they were pleased to see such a shy animal so closely until it padded up behind and bit at Bellingham's heels. It bit through the sock. Since it would not go away, Bellingham took a snap while the family stood shoulder to shoulder behind. The dingo circled about, intent on some ploy which only became clear when it lunged for young Michelle and tugged at the pullover she had tied at the waist. They beat it off, flagged an opportune tourist bus, and got out of there. Kirkham liked the uncomplicated way Bellingham told it. He liked the rueful mixture of astonishment and affright. He decided Bellingham ought to be called as a witness. On the flight into Mount Isa, 3 hours northwest from Brisbane, he had the smokestacks in view all through the approach. He took a cab to the hospital and spent a few minutes with Dr. Weller. Weller had examined Azaria after her fall from a shopping trolley at the supermarket and pronounced her unharmed. He thought Lindy Chamberlain an affectionate mother, but he didn't have the vividness Kirkham was looking for in a witness. Dr. Irene Milne was altogether different. She was gray-haired and vigorous. In her voice, authority was not incompatible with grace. She was Lindy's obstetrician, but was a little late at the birth, she smiled. When she got there, Azaria was already well into the world and doing fine. Kirkham asked, "So that was a normal birth?" "Certainly." "You saw them how often, the mother and the child?" "Every day, for the 5 or 6 days they were here, then about every 4 days." "And normal growth rate?" She thumbed through the medical records. "Yes. When I saw her last, 7 August, the baby had got up to 9 pounds 2 1/4 ounces. "And Lindy Chamberlain, how do you remember her attitude to the baby? Was she loving, caring, offhand?" "Not at all offhand. It was her third, you know, her only girl." "I want to be careful about this," Kirkham said. "The prosecution is faced with an absence of motive so far as we know. They might try postnatal depression." "Mr. Kirkham, I am familiar with the dangers of depression. If a mother shows any sign of the baby blues, we don't let her out of hospital." A circumstantial case is one in which an essential element of the crime, and sometimes more than a single element, is proved by inference instead of by direct evidence. So circumstantial was the case against the Chamberlains that it seemed to establish a new category, as if it had speciated, as plant or animal biologists describe a changeling which begins a new class in the established order of things. Here, not only was the prosecution without eyewitnesses to identify a slayer, there was no body to display the fact of death, no weapon to illustrate the manner of it, and no motive to betray deliberation or intent. Of all the deductions, of all the inferences to be drawn, Kirkham thought motive the most curious. It was not an essential ingredient in the definition of murder. It was made important by the other omissions. The way the case was shaping, there was no reason for this mother to kill her child. All the evidence was the other way. Sacrifice in the wilderness, the dispatch of a retarded child, postpartum depression, all were untenable now. The defense could disprove each of them at will. It occurred to Kirkham that the prosecution may choose to ignore motive altogether. The old rumors might then steal in and out of the trial, just as they had in the press, beyond testimony, the beguiling creatures of bigotry. He booked into a Mount Isa motel and rang Western Dry Cleaners from there. He wanted to talk to the pressers Beeman and Hansel, who had cleaned blood spots from the Chamberlain's clothes and bedding. The call was put through, but each of the women refused now to meet him. This was a surprise. When he'd telephoned from Melbourne, they were happy enough. They gave a reason for the change of plan. The police had told them to be silent. Kirkham's last interview was the most important and the most far away. He took the evening flight to Cairns on the northeastern seaboard. Cairns is closer to New Guinea than it is to the southern states. When Kirkham got there, the air was dank and warm, a condition difficult for a southerner to associate with a midwinter's night. In Cairns lived the man whom the defense team now privately referred to as the Bleeding Hitchhiker. The name he was more generally known by was Keith Lenehan. The Chamberlains had found him by the side of the Cook Highway in the dry season, as winter is called here, of 1979, the year before their holiday at Ayers Rock. Lenehan's car had overturned, he was injured, and they took him to the Cairns Base Hospital. Lenehan walked into the foyer of the hotel in which Kirkham was staying at noon and on time. Kirkham led the way into a lounge, although Lenehan made mention of thirst because it was Kirkham's practice to work first and drink later. Lenehan was not dressed for the lounge, but he didn't appear to notice. He wore shorts and a work singlet. His arms were long and his chest was moist. His feet seemed held to the floor by the weight of his boots. He was not as tanned as Kirkham expected of North Queenslanders. This was explained when he said he had come into town from a factory where he made pool tables. His style of speech was sparse and laconic. When Kirkham asked him to describe his automobile accident, he said, "I wrecked it," and about the injury to his head, "I was a mess." After a few minutes' persistent work, the story Kirkham got was this. Lenehan crawled away from his buckled car through the settling dust and made it as far as the roadside. All he could do was sit. He couldn't see too well. He held his head, and when his hands came away, they were sticky with blood. It matted his hair, ran the length of his face, and was soaking his singlet. The sight he made evidently did not excite sympathy in anyone driving past until a yellow hatchback pulled off the road. The driver and his wife were first aiders, so they said, and they loaded him into the car head first through the tailgate. He lay stretched out there, head between the two front seats. The hospital was 3/4 of an hour away. Lindy Chamberlain, he knew who she was now, was sorry she couldn't staunch his blood. "Which front seat was your wound closest to?" "The passenger's. See, I was on my back. The blood was coming from here." He tapped the right side of his head. "There was plenty." This was all Kirkham needed for the present. They moved into the bar. Kirkham bought the beer in a brace of pots, and then another. They went through 6 rounds before Lenehan's pace showed signs of slowing. He seemed to inhale beer rather than swallow it. He declined a 9th on the ground that he was already late for work and walked out with an unperturbed gait. Kirkham went up to his room for a nap. The Bleeding Hitchhiker's hemoglobin patterns were already known. He had provided a sample when Michael Chamberlain asked him last month to a local pathologist. Analysis then showed around 1 or 2% fetal hemoglobin, the proportion expected in a normal adult. This brought it nowhere near Mrs. Cool's assessment of the blood in the Chamberlain car, which stood at 50% fetal. But information already coming out of the work at Newcastle University now threw doubt on her tests. Fetal hemoglobin in the blood of a baby 10 weeks old should amount to no more than 25%. Moreover, Andrew Scott, in Adelaide, had found this was the level present in Azaria's blood. So something was wrong. The prosecution had found what it needed to find. This time, perhaps, it had found too much. And Kirkham's diary note, written on the southbound flight to mark the end of the journey, read, "All those interviewed to date believe the Chamberlains innocent." 3. She always seemed to be running from something. This time it was from the Sydney sun. Through the curtains in the front room she could see the car and recognized the men in it. It was the second time this week. Now they were parked 3 houses down Avondale Drive and, in a ludicrous attempt at disguise, had changed cars. Somehow they had got onto her schedule. Class began in 15 minutes. She let the curtain fall and walked back to pick up the telephone. It was already off the hook, and she said, "That's them for sure." "Shall we do it again?" asked the woman on the other end. "Thanks. Lindy said. "I'm sorry. No trouble at all." She waited until she heard the sound of a motor, threw on a coat, and ran out the back door. She bobbed through the side fence and climbed into her friend's car in the driveway of a neighboring house. At the bend in Avondale Drive, they were doing 80, and the press car pulled in behind, tailgating all the way to the campus. Lindy put on sunglasses and turned up the collar of her coat. She had a hand on the door handle as they swung into the parking bay outside the administration buildings. A light drizzle was falling on the roadway, and the cars slid to a halt, as though they were interconnected. She let the door swing open and jumped. She could hear the shutter and the camera drive from somewhere behind, ran the path under the trees, past white-faced students, and clipped up the steps. She knew the photographers would stay with the car. They were devilish people, and their business was devilish, in the plain sense of the word, the way people meant it around here. At the top she was breathless and dizzy, unused to her matronly weight now. She pushed through the glass doors. The foyer was undergoing some sort of motion. She steadied a wall with a hand and caught her breath. With alarmed fingers, she kneaded a sudden tightness in her belly. 4. It was the most publicized pregnancy of the year. Columnists tried to guess the date of birth and the zodiac sign which would thereafter guide the development of the baby's character. A television crew caught the family at the Avondale fun run and got in everybody's way while it filmed her in side shots, so far as was possible with the crowd, the better to show her expanding outline. News reporters followed up every Adventist contact they had, but no one was talking. The timing was such that the pregnancy should be round and indisputable by the time the trial opened in Darwin on 13 September. The way reporters calculated it, this was some manner of gauche ploy, a plea for jury sympathy. Kirkham knew the fact was otherwise. The birth was due on 8 November. It would have been a simple matter, as Kirkham considered, to announce that date now, let everyone count back the days, and conclude that the date of conception was sometime shortly after the end of the second inquest. At that time, the trial was listed for April. She could have hidden a 12-week pregnancy. Lindy shrugged it off now. She said it was a family matter and no one else's business. People could think what they liked. She wouldn't give them the satisfaction. Anyhow, if she wasn't meant to have a baby, then God would not have allowed the conception. It was as simple as that. 5. People kept sending in information about dingo attacks. They had a long list already. Now Peter Dean had a letter telling of one around Tennant Creek in the 60s when a small Aboriginal child was killed and carried off. Dean yet hoped to track the story down. Stuart Tipple was sent a news cutting which described the death of a lost 2-year-old white boy of the family Ford, taken by a dingo 35 miles to feed its young. The cutting was from the Sydney Morning Herald, dated 1902. A current story from the London Observer, although it dealt with Los Angeles, read, "Californians declare war on the coyote." One morning last summer, 3-year-old Kelly Keene wandered away from the house. Her father came outside minutes later to find only her sandal. Up the road, he saw a coyote, about 4 feet in length, dragging the baby along, its jaws clamped on her neck. "It was like it was killing a sheep," said Robert Keene. He chased the animal 30 yards into the brush before it dropped its prey. His daughter died of a broken neck. Coyote control has triggered bitter argument. On one hand is a broad public demand for more trapping. On the other is the anger of environmentalists who claim the danger is being grossly overrated. "We have to reinstall a fear of man in the coyote," said Lila Brooks, head of California Wildlife Defenders. "We must drive them back to where they belong, not kill them." This report was of no direct evidentiary value, but, all the same, Kirkham thought, it was a pity it hadn't made any of the newspapers here. It carried a reverberation, peculiar and troubling. There were enough similarities between the Chamberlain story and the Keene story that it seemed as if the seeds of the one event had blown into alternative and diverging streams of time. 6. A press release from the law department in Darwin arrived at the Sydney Morning Herald and was passed on to Malcolm Brown. It identified the barristers briefed to prosecute at the trial. There were 3. Des Sturgis was no surprise, although if the government had wanted to maintain appearances, particularly the appearance of impartiality at the second inquest, he might have been excluded. Evidently no one cared about that now. Brown didn't know Tom Pauling at all, but cuttings from the file room described him as a Darwin barrister who had once served as a magistrate. The other was Ian Barker. Barker was now at the Sydney bar, a small jaunty man much prized by press reporters for his asides, which were witty and often reportable. Throughout the 60s, he lived in Alice Springs. The following decade, he lived in Darwin. He was then the Northern Territory's inaugural Solicitor General. The law department had chosen, for its prosecution leader, a home-ground player. 7. The luggage waited by the door. The car stood in the driveway. Aidan stopped sniffling long enough to tell his mother that she looked pretty in her big, bright frock. Both the boys were tearful because they knew where their parents were going. They understood the nature of the moment. Lindy said she wouldn't tell them a lie. They must be brave about this. "We might not be allowed to come back," she said. Cliff Murchison was a preacher even more than he was a father, and had made his daughter a scriptural gift. Lindy had the idea that, whatever the scientific evidence, she would be judged on the way she gave her testimony in the witness box. She was terrified it might all go wrong. So preparing for the family service, her father searched through his trembling notes for an apposite verse. He considered Psalm 82, "How long will ye judge unjustly and accept the testimony of the wicked?" and Psalm 35. False witness did rise up. They laid to my charge things I knew not, but passed them over in favor of something more positive and lifting. He found Matthew 10, verses 18 to 20. "And ye shall be brought before governors and kings for my sake, for a testimony against them and the ungodly. But when they deliver you up, take no thought how or what ye shall speak, for it shall be given you in that same hour what ye shall speak. For it is not ye who speak, but the Spirit of your Father which speaketh in you." "The Spirit," said Avis. "Amen." A whole different town here. 1. The road from Darwin Airport into town doubles as the northern tip of the Stewart Highway. It carries here an extraordinary jumble of traffic, too much to expect near a city of, after all, not much more than 40,000 people. Territorians call it the track. The track runs the continent all the way to the south. Along the northern half, the 1,300 kilometers from Alice Springs to the outskirts of Darwin, there are only 9 intersections of a status serious enough to be marked on the map. Not one of them is a crossroad, and the closest to Darwin, the Arnhem Highway, ends somewhere between the Alligator Rivers. So a good proportion of the city's traffic is driving along the top end of the track at any time. Sports cars, family sedans, four-wheel drives, pickups, road trains. It is the only road connecting Darwin with anywhere else. North of the airport, the track is multi-laned like a straightened ring road. Traffic going in is separated from traffic going out by long road center plots. The plots have been grassed over. By September, the grass is dry, and the road trains raise a haze of fine dust. Malcolm Brown sat in a taxicab inbound. It was hot. The driver was obese, so fat indeed that he kept his thighs akimbo to make room for the steering wheel, and he fanned himself with a magazine, although the cab was air-conditioned. This part of the highway runs through the sort of city approach you would find anywhere, past auto shops, factories with sawtooth rooflines, beer hoardings, and not until it becomes a coast road does it enter the Darwin Southerners think of, the lush, garlanded, and fragrant hillsides, the streaky currents below in the harbor, the soft breeze that blows here from the Timor Sea. The driver was inquisitive. When he found out why Brown was in town, he said, "The reporters are mostly staying at the Darwin." By this he meant the Hotel Darwin. Brown didn't bother to tell him that was precisely why they were headed for the motor inn. The mention of the Chamberlain trial seemed to make the driver suddenly troubled and thoughtful, but it wasn't until they pulled up outside the reception office that he put any of it into words. "She's strange, that one," he said, and left it at that. "If it happens, I report it," is something like the motto Brown would choose for his coat of arms, should he have one. He began reporting this trial before it began, in the press room on Sunday afternoon, at the media briefing. For the duration of the trial, the second floor of the building next to the courthouse had become the press room. 50 or 60 news gatherers, the number depending on how the support crews were defined, were here from press, radio, and television networks all over the country. The long room would seat perhaps 40, which was fine since most of the photographers would be working outside. It had been proclaimed a court precinct, pro tem. They had here writing tables and chairs, notice boards, and a coffee bar. They had a telex terminal and, along the length of a wall, telephones stood in enfilade, the charges for which would be billed directly to their employers. Proceedings in the court next door were covered by closed-circuit television cameras, one to show the action at the barrister's table, another the witness stand and the bench. The receivers were set up here in the press room. A pair of screens was mounted at each end wall. Although they could report the trial adequately without leaving the room, there were, in the court gallery, seats set aside for journalists, but it was not considered they would be in much demand. The windows on this floor looked over the bright courthouse plaza, and down there, white ropes and stanchions made a corridor along which the Chamberlains would walk to court, unhindered by public curiosity and in full view of the reporters and the photographers in the press room. The official whose duty it was to look after the press suggested that any dissatisfaction with these facilities should be directed to him. This invitation he delivered with an admirably straight face. An aide from the chief minister's department said he didn't want to read it suggested anywhere that the government was putting on a show, but when Brown wrote it up later as an opener for his coverage, he found it hard to keep a tone of distrust out of the piece. He used the line, "There is official recognition of the fact that the trial is going to be a center of publicity." It seemed, in the circumstances, a fair compromise. But he decided to have nothing to do with the press room and whatever it stood for. Anything he wrote from there would come out like a review of a stagey television drama. Echoes knocked around in his mind a while. The cab driver's "She's strange" was one. It was a cipher for distrust, perhaps for hate. People like that used to wait outside trials at the Old Bailey, at the gates of the Fleet Prison, or gather early in a town square before muffled carpenters had completed the gallows. There were crowds then. Now the curious stayed at home. They were spectators at home. The government aides were wrong. Brown didn't expect full houses at this trial, a few passing in and out on the hour as though it were a newsreel theater. For the rest, it was left to the presses and the broadcasters. There was a curious duality of roles here. Onlookers are important to an event, and every one of the journalists at this trial represented a crowd. Each stood for numbers ranging from a few thousand to 1 million apiece. Each was to provide an audience with the spectacle, and somehow just as importantly, provide the spectacle with a crowd. The cab driver's opinion of Lindy Chamberlain echoed, in Brown's experience, the thoughts of most people all over the nation. It recalled another happening, this time in Sydney. A lunchtime party of reporters took a cab to a restaurant. They were talking about the Chamberlains. The driver straightened the argument out, simply but with great deliberation. "They ought to burn the bitch," he said quietly. 2. He set off for the courthouse at 9 next morning. The pavement was already hot underfoot, but he guessed this was the only part of the day cool enough for walking comfortably anywhere. By the time he got there, he wished he owned a hat. The centers of administration in Darwin are set, as they are in most capital cities, among parks and gardens. It is as though the symmetries of governance should take a place among the other blessings of nature. Because the blessings of nature are tropical here, the park between the police department and the chief minister's offices is also a garden of green fronds and soft clouds of insects. Red poinciana petals litter the footpath. The grounds around the courthouse opposite are grassy, and most of the trees are palms, spaced well apart like a new plantation on old ground. The view beyond is to the harbor, chalk blue now, an indication that the tide is ebbing and strong. None of the buildings around here has the elegance of age, a result of the merciless cyclone of 1974 which, on Christmas Day, blew much of the city as flat as a junkyard. The new courthouse is handsome. It is only 2 stories high, hard-edged and modern, but tall fluted columns and dark glazing convey well enough that the rooms inside are chambers of judgment. On the flagpoles by the steps hang the ensigns of the nation and the territory, waiting on breeze. This time of year, they will wait until afternoon. The session was an hour away, and television crews were unloading gear from rented automobiles and laying cables. A Channel 7 van took up part of the grass. On the forecourt steps, alone, sat a telephone. It was a smart salmon pink and would have been at home in the most flippant movie producer's suite. Impossibly, it rang. The man who ran to it was blonde-haired and bouncy. It was Gary Tate. He picked up the handpiece and said, "Darwin Footpath." The call was from Brisbane. Tate had set up office on the pavement. Just inside the sliding doors, the corridor was thick with journalists. The common idea seemed to be to catch the arrival of the Chamberlains, then watch the session next door on the video. Meantime, they were renewing friendships. Most had covered the inquests. Press, television, and voice reporters, photographers and technicians, among them a stringer from the London Daily Mail who was at the same time writing a book, an American who was ordinarily the cricket writer for the London Times, a lonely and impenetrable German, and the Pacific correspondent for Newsweek. Here was the flavor of a reunion of an elite, an assumption that the networks had sent their best. And there was an attractive reasoning in that, for during the inquest most city news presses had sold around 40,000 copies more every day than they were otherwise accustomed to, and this quantified boon was taken as a cue by everyone else. 3. Under the rules of court procedure in this country, people summoned as jurors are not examined about bias. The responsibility for fair-mindedness lies with the jurors. They are reminded of this by the judge, in this case the acting Chief Justice James Muirhead, who sits now on the bench in crimson robes and grey wig, and thereafter it would take a provable incident of misconduct or prejudice to raise the matter again. The defense is permitted to challenge, without explanation, 12 of those called as jurors at a murder trial. This throws something of a burden on a lawyer's capacity for judging character quickly. A challenge must be made after the juror's name is called and before the juror takes a seat in the jury box. It allows appraisal for about 40 seconds. The system is eased along to some extent by a list of jurors' names, addresses, and occupations given to the lawyers before the case begins, and the one Kirkham and Phillips now have in front of them lists those of 142 people. Kavanaugh, their legal aid contact here, has written brusque comments against 13 names he knows, and he considers that 12 of them would harbor dislike for the Chamberlains. Kirkham wonders if this is some sort of omen. So crowded is the courtroom that there is no space for spectators or reporters. Phillips and Kirkham expect the selection process will take most of the morning. The judge grants exemptions to 2 women who have insufficient English, to another whose father is ill, to 2 men in businesses too small to run without them, and to the wife of a police prosecutor. A nervous government clerk who fears she wouldn't make unprejudiced judgments is told to stay, but her name might not come up again in the ballot, and Kirkham makes a note to challenge her if it does. A jury list of this size is supposed to reflect the social complexion of the region it serves, but it never does, and no one is really surprised. The people who now pack the court represent, at best, a median in the spectrum. Various selection processes account for this, some of them informal. Doctors, lawyers, and felons are exempt. Workers on short contracts and itinerant job seekers have no place here, although they might make up 15% of the Darwin population at times. Judging by the faces in court, the Chinese, whose traditions in Darwin go back to the labor gangs of the 1870s, do not register in the numbers they might. There ought to be more than 3 here. The 2 Portuguese will be hurried arrivals from Timor very likely, and some of the Dutch names, a surprising dozen or so, could belong to families who migrated here after Indonesian independence. The bulk of this panel anyone would call Territorians. Curiously, the majority of Territorians is less well established in Darwin than are the minorities. This, too, is a result of the cyclone in 1974, when 3/4 of the city's population fled south or east, and many stayed there. Most folk who live in Darwin now have lived here less than a decade. It shows. The urge that brings them here is the will to prosper, itself a fierce spell, and not unlike the need for conquest. They are peppy and ungentle, not at all a people of the tropics. They cut frangipani for their vases, but do not wear it in their hair. Among the 123 jurors in this panel, there are no blacks. Most aboriginals are thought, by registration clerks, too elusive to be worth the effort, but not all the fault lies here. There are plenty of indications that blacks hereabouts hold the Society of Europeans in no high regard. A bold message of that nature is written in a public toilet which is no longer much frequented by whites. It is printed at face height above a urinal. The walls are otherwise free of graffiti. An improperly rendered plural accents the derisive tone, and it seems the verb is meant in its widest sense. It reads, "All white mans fuck each other." The selection is done now, and the jury box is full. The defense used 11 challenges to pare the panel down to these. The prosecution used 7. Kirkham feels a familiar brief shadow. Are these the faces of the open-minded, the fair, the prudent? 9 are men, 3 women. The women have chosen to sit together. As he looks them over, a barrel-bodied man with bristly hair who sits at the end of the front row gives a grin. Phillips leans closer to Kirkham. "I think we've done well," he says. "I like them." 4. When the court was cleared of unchosen jurors, the spectators waiting in the corridor were allowed inside. Those reporters who didn't want to begin their coverage of the event from the video room came in with them. Malcolm Brown took a seat in the front pew. He soon gave away the idea of describing the jury for his readers. His decision had nothing to do with contempt of court. This jury would become the most publicized in the country's history, but each face seemed to him as unremarkable as he might find on any peak-hour suburban bus. He made the note. None under 30, none over 50. The courtroom was muggy. This was consonant with the rising tension, but was caused by overloading of the air conditioner. The Chamberlains, sitting on benches in the elevated dock against the wall, seemed short of space. They were flanked by prison officers. Michael wore a dark tie, but no jacket. He was damp at the armpits. Lindy was wearing her hair short. Her cheeks were heavy, which set her eyes more deeply and gave her a look of distrustfulness and exasperation. She held her shoulders squarely, but this conveyed an attempt at comfort rather than resolve. Below, she was squat and burdened. Now and then she lifted her gauzy skirt and billowed air around her legs. Michael was as still as a snapshot. 5. Barker got to his feet. This was the moment. He hitched his gown at the shoulder. The gown was frayed just there from years of that gesture. Brown made a quick note. Curly gray hair under the gray curls of his wig. When Barker spoke, he sounded like a narrator opening an intricate play in which the audience must be given the plot before the drama begins. A baby was killed at Ayers Rock on 17 August 1980 during the evening between 8 and 9 o'clock. It was a Sunday. The child was then just under 10 weeks old, having been born on 11 June. She was called Azaria Chamberlain and was the daughter of the accused Michael Lee Chamberlain and Alice Lynn Chamberlain. The body of the child was never found, but, having heard the evidence concerning the baby's disappearance, you will have no difficulty determining that she is dead and that she died on the night she disappeared. As to the manner and cause of death, one cannot be precise because the body was never found. However, what will be proved, largely upon scientific evidence of the baby's clothes, is that the child lost a great deal of blood, in all probability from injury to the major vessels of her neck. She died very quickly because somebody had cut her throat. The Crown does not venture to suggest any reason or motive for the killing. It is not part of our case that Mrs. Chamberlain had previously shown any ill will towards the child, nor do we assert that the child was other than a normal, healthy baby. The Crown does not, therefore, attempt to prove motive, nor does it invite speculation as to motive. We simply say to you that the evidence to be put before you will prove beyond reasonable doubt that, for whatever reason, the baby was murdered by her mother. This was already a better opening than the news reporters could have hoped for. Everyone was worried, in the reporting of this case, that the evidence was now so well known that no amount of skill could make it sound fresh. It occurred to Malcolm Brown that Barker might have considered he had the same problem with the jury that reporters had with their audiences. So Barker was making it fresh. The trick for Brown now was in his choice of lead. He wanted to begin his piece with a quotation which would show, at the one time, the vigor of the opening and the pith of the case against the Chamberlains. Then Barker said, "Shortly after the event, the mother asserted, and therefore continued to assert, that the dead child had been taken from the tent by a dingo. The Crown says that the dingo story was a fanciful lie, calculated to conceal the truth, which is that the child Azaria died by her mother's hand." Brown knew he would lead with, "a calculated, fanciful lie." 6. Barker's opening ran all day, and the defense team took the transcript back to the Travelodge Motel in the evening and worked it over. The job they had in front of them was not unlike the task of a football coach. The Crown had now laid out the pattern of expected play and nominated the stars in the lineup. Phillips ran his finger down the list of prosecution witnesses. There were two newcomers, the doctors Baxter and Culliford. Barker had himself already identified Baxter as Joy Cool's supervisor at the Sydney laboratories. Culliford was a London police biologist, a specialist in blood identification. "A big name," Tipple said. "A big name, but he cannot have seen the tests carried out in Sydney." Phillips guessed Culliford was to be called to block any criticism of the way Joy Cool worked the electrophoretic experiments. This would also account for Baxter's presence. Well, the defense would produce some big names too, when it came time to take to the field. They picked over the transcript looking for weaknesses in the way Barker had chosen to present his case. A prosecutor is not compelled to disclose all the evidence available, but it was the best guide the defense had so far. Phillips quoted, "The accused was absent from the barbecue area for some minutes. It is a bit hard to be more precise than that, but it was long enough, the Crown says, for the child to be murdered." "The Lows put it 5 to 10 minutes, Kirkham said. "I don't think we can get it down from that." Striking, he thought, how the case against the Chamberlains had altered since the inquest. Then they were defending accusations that the baby was long selected for death, was dispatched to Jesus from the slopes of Ayers Rock with sacrificial rites, that the parents had somehow mocked up, perhaps with a doll, an impostor with which to hoodwink bystanders until night-time, and their barbecue at the tent side was the finale in a pitiless play. So much had the police case modified to accommodate the emergencies of incompliant evidence that the defense was having a hard time arraying its armaments to face the changing angles of attack. As the accused went back to the barbecue area, the dead child was in all probability in the car, and it is possible her body was in the camera bag. If that's so, where was the camera gear? Tipple said. No one remembers seeing it anywhere else. Phillips rang down to the bar for a bottle of Calvados. When it arrived, everyone but Tipple took a glass. Phillips read on. Michael Chamberlain apparently heard a noise which might have been a cry coming from the direction of the tent. The accused, Alice Lindy Chamberlain, then straightaway commenced to walk back to the tent. There would be evidence that Mrs. Lowe also heard a noise, but at this stage, of course, on the Crown case, it was impossible that it was the baby. Phillips knew how high a hurdle this was for the prosecution. He had, in May, flown to Hobart to talk with the Lowes. If the jury saw in Sally Lowe the qualities Phillips found, honesty and homely sincerity in just about equal parts, the prosecution case ought to end right there. She won't back down, he said. It was a cry, and it was a baby's cry. He read, It was now just after midnight. For a substantial period, both accused had been left on their own near the car while the searchers progressed far out into the sandhills. So there was ample opportunity for them to have cleaned at least some of the blood from the front of the car. Tipple generally left matters of advocacy to the advocates, but now he leaned forward in his armchair. That is a very weak part of the case, I've always thought, he said. They were away from the women at the tent once, maybe twice, and nowhere near the car. Barker is puffing it up a bit much, Kirkham said. We'll have to pare it down to size. But it was his guess that the prosecution would treat the point by ignoring it. Following what seemed to be a line of connected disquiet, Kirkham turned to the passage, You are going to be invited to find that it was not mere coincidence that the baby's clothes were found near the part of the rock where the photograph of the lichen was taken. Something was wrong here with the sequence of the prosecution case. He worried at it until the answer came. The Crown case is now that the killing was not premeditated, more a spontaneous act, he said. That photograph was taken long before the baby died, but they are still using it as if it betrays a plan. And there was a connection here with motive, if he could find it. He recovered the words, The Crown does not attempt to prove motive, nor does it provide speculation as to motive. He knew this was double talk. Barker was going to leave the jury open to any enticing fancy. We will raise motive, Phillips said slowly, so that we can demolish it. There were tactical problems in this, which he seemed to be solving somewhere in the pale cage he was making with his hands. If we call Dr. Milne on some pretext or other, say, on the way to the baby, we can then use her to exclude the only feasible motive there is now, postnatal depression. Phillips drummed his fingers and said, But we've a long way to go before we reach that point. He poured another round of Calvados. He was overweight, in the way a thin man gets big, all below the shoulders. He was no pacer about the room, but he was edgy. Kirkham knew they were all edgy. They wanted the evidence, and therefore the contest, to begin. 7. The easy morning was the gift of a fading sea breeze. Malcolm Brown crossed to the park where, under the palms, a picket line of photographers and a television crew were taking shots of two leggy girls in shorts and T-shirts. When he got to the forecourt, he found it empty, so he knew that the Chamberlains had arrived early. This accounted for the photographer's interest in the girls in the park. He headed inside. Had Brown been more interested in things like this, he would have found that these girls were not posing for glamour shots. They were modeling T-shirts printed across the hummocky bust with slogans of hometown support. The word said, "The dingo is innocent." The girls were happy to pose in any manner that best drew the eye to the message, and, between bouts of interest the photographer showed in them, leaned against the palms and chatted with passers-by. They spent time yesterday afternoon this way. They preferred the city side of the park, where there were plenty of onlookers. This was also the route the jury took to the courthouse. Brown found out about it from a Melbourne Age reporter who predicted that the Southern dailies would lead with the story unless better copy came up. When the session opened, Phillips got to his feet and made his complaint to the judge. He spoke as if he were an outsider who might be ignorant of local customs, but could not find neutral words to describe them. "It is difficult for any rational person," he said, in a mystified but polite voice, "to understand the mentality and motives of these people, and I do not suggest that this stupidity would in fact influence a juror, but it is clearly enough calculated to do so, Your Honor." Justice Muirhead ordered the demonstrators to desist and, in their fortunate absence, threatened them with jail if they did not. It was just the sort of action Brown would have anticipated on the information he had of this judge, a genial and diligent lawyer from whom everyone expected a fair and mannerly trial, and his order halted the offense without causing an irrevocable fuss. Brown's problem now was the reporting of the event. He couldn't ignore it since it would be all over the competing dailies, so he did what he thought ought to be done with shameful and contaminating human actions. He wrote it as an occurrence of little account and prepared to bury it deep under something else. 8. Sally Lowe looked as if she hadn't slept. Justice Muirhead told her she could sit while she gave her testimony, and she seemed grateful. She'd had her hair styled into cascades of phossy curls, and her smile was nervously bright. She was handed a map of the Ayers Rock camping ground and took time to find on it the position of her tent and the barbecue. Pauling, whose witness she was, said, "I want to take you to Mrs. Chamberlain going back from the barbecue to the tent with the baby and Aidan." "Yes, that point in time," she said, finding the groove in her memory. "Right. Mrs. Chamberlain had the baby in her arms and Aidan was close behind her. I recall them walking along the footpath area towards their tent. I don't recall anything much after that. I have forgotten most of it, and I was involved in conversation." She shook her head. "The next I recall is them coming back along the same path. About halfway along the path, I suppose. I recall seeing them again, and they walked back to the barbecue. Mrs. Chamberlain had a tin of something in her hand, and I saw a can opener, or perhaps something else, in her other hand. Aidan was behind her. And the next I recall, he was beside me, between myself and the second barbecue, which Mr. Chamberlain had been using, and Lindy was just inside the railing, near the barbecue." "Are you able to tell us how long Mrs. Chamberlain was away from the barbecue area?" "Well, it's a fairly short period of time, but I've stated before, 6 to 10 minutes would be roughly correct. 5 to 10 minutes away." Pauling asked her to keep going. She said, "Well, she was just standing there. I heard the baby cry. Quite a serious cry, but not being my child, I didn't sort of say anything. Aidan said, 'I think that's Bubby crying,' or something similar. Mike said to Lindy, 'Yes, that was the baby, you better go and check.' Lindy went immediately to check. I saw her walk along the same footpath that they'd been on." "What happened next?" "She was in the area on that footpath closest to where the car and the tent were, only inside the railings, and yelled out the cry, 'The dog's got my baby!'" "Yes?" "That dog's got my baby!" We froze for a minute. Mike and my husband Greg ran in the direction she was looking to the south side of their car, out in that general area. Then, as they went off searching, one of them shouted about a torch, and Greg said to get the torch from the car, which I did. I had my daughter on my hip. "After the police arrived," Pauling said, "a major search got underway?" "That's right. People came from all directions." Pauling asked her if she had then entered the tent. "Yes. Aidan was close by me after the men had started searching, and he was very upset, and said that the dog had got his baby in its tummy. And I cannot recall why now, but I took him to the tent, and I had some thought in my mind of getting him to sleep. He showed me where he slipped, his sleeping bag, inside the tent. I had my daughter. I was holding her with me at the time. I knelt at the front of the tent and leaned in a little way. I think Aidan got in when he showed me where he slept. I saw a few spots of blood around the area at that time. After he showed me where he slept, I think my eyes caught sight of the bigger pool of blood in the tent." Where was it? I was leaning in from the middle of the tent, so it would have been a little off to the right, and it shocked me a bit, because it looked as if it had soaked into something padded, but was still wet on the surface. So although the area itself wasn't large, I took it to be quite a lot of blood. Can you describe it? About 6 by 4. Here she was talking in inches. A squashed circle, I suppose. I recall it as a dark, red, wet pool of blood. Phillips took the cross-examination himself. The Crown had spent less than 20 minutes with Sally Lowe and, in an act of further relegation, presented her to the jury through the most junior prosecutor on the team. They were treating her testimony as though it was insubstantial, as if it led nowhere of any persuasive interest. For Phillips, she was the most important of all the campsite witnesses. I suppose it is clear enough from your evidence, he said, but the fact is that prior to meeting the Chamberlains in the way you did, you had no contact with them, directly or indirectly. No. And no connection whatsoever, for example, with their church. No. He was determined to show that no bias lurked in Sally Lowe. He pushed further. And in the 3/4 of an hour, where had the acquaintanceship got to? First names, was it? Yes, first names. He retrieved from the bar table a copy of Barker's address and asked her to listen to the passage he was about to read. At this stage, the Crown says the baby was dead. Her husband, Michael Chamberlain, apparently heard a noise which might have been a cry coming from the direction of the tent. The accused, Alice Lynn Chamberlain, then straight away commenced to walk back to the tent. There will be evidence that Mrs. Lowe also heard a noise, but at this stage, of course, on the Crown case, it was impossible that it was the baby, because the Crown says that the baby was then dead. He asked, addressing the jury more than the witness, "Do you understand the importance of the evidence you can give to this court?" Clearly she did, and seemed about to complain that it was the prosecution case she didn't really understand, so Phillips said, "The Crown is saying that it is impossible you heard the baby when Mrs. Chamberlain returned to the barbecue." She shrugged. "I disagree with that. Not only do you disagree with it, but you are absolutely certain that it is the time you heard the baby, are you?" She nodded. Evidently, the dispute was inexplicable, beyond the reach of words. "Would you say yes, please?" said Phillips, who didn't want any ambiguity about this. "Yes," she complied. "All the Chamberlains, Aidan and Mrs. Chamberlain and Mr. Chamberlain were present. My husband, myself and child. And we heard the cry. The cry came from the direction of the tent. It definitely came from the tent. Beyond any doubt? I'm positive. You knew well, from your own child, the sound of a baby crying?" "Well," she agreed, "I come from a big family and am used to babies. I can tell the difference between a baby and an older child. Apart from your own baby, and rearing it through the same stages as Azaria Chamberlain, what other babies of that age have you had direct contact with prior to August 1980? I come from a family of 9, and they always seem to be having children. I'm just familiar with babies and children. You are quite satisfied that the sound you heard was a baby crying out?" "Yes, positive. I think it has been suggested to you in the past that it might have been the little boy Regan, who I think was then 4, crying out in his sleep. Do you reject that suggestion completely?" "Definitely. It was a small baby." "What about this suggestion that Mrs. Chamberlain stood up with the baby, took it over to the car and sat in the front seat and cut its throat? In the 3/4 of an hour you were with her, was there anything, that indicated to you that such a thing was likely to happen?" Sally Lowe smiled. "No. In fact, the opposite. She sort of had a new mum glow about her. It's hard to describe." "A new mum glow? Did she appear a loving mother to you?" "Yes. Definitely yes." "Was she in a sullen, truculent, surly mood?" "No. She was a little tired, but she still managed to be quite cheerful and happy." "Was there anything in her appearance and her demeanour, on her return, that indicated anything abnormal had happened?" "No. She seemed to be solely concerned with feeding Aidan some more food." "Was she covered in blood?" "No." "Did she have any blood on her at all that you saw?" "Well, I didn't look all over her, but just looking directly at her, I didn't see any blood, no." She has told the police that the reason why she returned with Aidan to the barbecue was that he wanted something extra to eat, and she selected a can of baked beans and returned to the barbecue to heat it up. You can at least confirm, can you not, that she returned with a can in one hand? Yes, and a can opener in the other. Yes, I'm not sure, but I believe it was a can opener, yes. Mrs. Lowe, I would like to read you some more passages from the prosecutor's opening address. Mr. Barker told the court that, as to blood in the tent, there were just insignificant traces. Phillips flipped through the transcript, and he again referred to tiny traces of blood in the tent. Can I ask you this? The floor of the tent was covered, was it not, effectively, with articles of bedding, clothing? Yes, you couldn't see any part of the— She waved a hand. Of the fabric of the tent itself. That's right. Was this area of blood that you have described a tiny trace? No, I wouldn't have said that. That was what convinced me that the baby was dead, from the amount of blood I saw. Did you also see some spots of blood? Yes, that's correct. Spots on a sleeping bag? Yes, there were spots on Regan's sleeping bag to the right in the tent. If forensic scientists later found 11 spots on a sleeping bag, that would be consistent with what you saw? It wouldn't surprise me. Sally Lowe could remember clearly, she said, the number of times the Chamberlains had walked away from the vicinity of the tent while she was there, which was until 10 o'clock. They had left her once. Several ladies comforted Mrs. Chamberlain during the time you were there? Yes. You can only recall one occasion Mrs. Chamberlain was with her husband? She agreed it was only one. On that occasion, they were in a lighted area? Yes. You could see them? Yes. They were never out of your sight. They were quite visible, because you could see them crying. Everyone in the defense team had liked the idea, when they talked it through, of reading Barker's address back to the witnesses. It did more than merely clarify the realities of the evidence. It put prosecution witnesses directly at odds with the prosecutor right from the beginning and in plain view. Phillips kept it up. He quoted, "For a substantial period, both accused had been left on their own near the car while the searchers progressed far out into the sandhills, so there was ample opportunity for them to have cleaned at least some of the blood from the front of the car. Do you follow that?" Yes. Limiting yourself to the time you can speak about, did you ever see anything remotely like that, either Mr. or Mrs. Chamberlain cleaning the inside of that car? No, she said, aggravated enough to add, and the car was here. She placed the car, with a gesture of proximity, alongside the witness box. You could see inside the car, too, from the light. Page 55, Phillips said, so that Barker could follow his own words. Sometime during the night of 17 August, the body of the child, still dressed in its clothes, was buried in a very shallow grave on or near to a dune not far from the campsite. It is the case for the prosecution that there was ample opportunity for this to be done when the search moved away from the area close to the camp. Follow that? Yes. Was there anything done by the Chamberlains during the time you were there to suggest they were burying a body? No. Did you ever see them take any object out of the car and disappear into the scrub? No. You can be quite categorical, can you not, that nothing of the sort occurred during the time you saw them away from the car? Yes, she said, grim and sorrowful. Justice Muirhead picked up the point. From the time you heard the baby cry, he asked, until you went back to the motel that night, did you at any stage see anybody open the car doors? No. You yourself did not open them? No. At any stage, did you see the headlights or any lights attached to the car, inside or out, illuminated? No. The only light was from the barbecue area and then later from the police vehicle. Am I right in saying you never saw, after you heard the baby, anyone in the car? No one, she said, shaking her head. No. Neither Phillips nor Kirkham had expected the judge to intervene so early. It seemed, on balance, a happy sign. I do not think the prosecution suggests otherwise, Phillips said, with a glance at Barker. But there is no doubt the baby was alive during the time the mother was nursing it at the barbecue, is there? Yes, the baby was definitely alive. Because you saw it kicking, did you not? Yes, she said. Sally Lowe knew this issue had a long and malevolent history. The Northern Territory Police, who had interviewed her in Hobart, seemed to be interested in nothing else. That memory prompted her to volunteer now. Also, the expression it made on its face. Mrs. Chamberlain has spoken, in conversations with the police, about a dingo which was present when you were all at the barbecue. That's correct. According to what she has said, the dingo at one point came very close and pounced on some little mouse that was hopping about. Was there a dingo close to you at the barbecue? Yes. One followed me back from the rubbish bins at one stage, just sort of fairly close behind, but keeping in the background. Then I believe the same dog appeared again, and it did make a dive for something under the bush, and someone made a comment about a mouse, but I didn't see the mouse. As to the duration of the baby's cry, Phillips said, that cry, as you listened to it, appeared to be cut off? That's right, she said. Going from experience with other babies, yes. It seemed to you to stop suddenly. Yes. And that was something you noted? Right, she said, as if, at long last, someone had got the point of all this. 9. From the way Greg Lowe kept rubbing the side of his gingery beard, it was clear he was more than usually uncomfortable in court. Around the newsroom, the story ran that the prosecution could disable his testimony at any time it chose. At the barbecue with the Chamberlains, he'd been drinking. The story was amusing because everyone remembered it was Lindy Chamberlain who berated him over his can of beer and so made the incident memorable. It was a neat irony. Lowe's discomfiture had nothing to do with beer. He had a problem no one here knew about. Pauling got close to it when he asked, "How long was Mrs. Chamberlain at the tent?" "For a maximum of 10 minutes. I'd say about 8 to 10 minutes." "What did Mrs. Chamberlain do then?" Lowe hesitated. This was right where the problem lay. He had spent many sleepless nights revisiting these 8 to 10 minutes. It now seemed he could stand by the fireside at will. He was talking to Mike. Sally held Chantel on a skewed hip. The tips of his ears were cold. The night would freeze later. He watched Lindy carry Azaria to the tent, bend, shuffle inside. He hadn't taken much notice from there on. But the next scene in his memory showed this. Lindy in frock and parka, bare-legged, pushing out through the tent flap, standing. The police case, since the time of the second inquest, had her murderously carrying the baby to the car. But when he saw her there now, her arms were indisputably vacant. The baby was still inside the tent. He knew well the difficulty he faced. In Hobart, he had taken the problem to a local lawyer. The lawyer had, in the event, posed more problems than he solved. The lawyer advised Greg Lowe to give his testimony exactly as he had at the first inquest. He would be justified in including his present recollection only if someone asked him about it in precise and inescapable terms. What did Mrs. Chamberlain do then? Was Pauling referring to the beginning or the end of the scene? Greg Lowe kept his gaze on the floor. She returned to the barbecue with her son, he said quietly. Did something then happen? Pauling asked. Well, we were heavily involved in conversation, and Mr. Chamberlain made some comment to his wife like, "Was that the baby?" She went to check on the baby. She got about 5 yards away, from my recollection about 5 yards away from the barbecue site towards the tent, and she came out with an outburst. "That dog's got my baby." Did you hear anything like a baby crying? No, I didn't myself, no. Mrs. Chamberlain said, "That dog's got my baby." What happened next? She chased in a direction where she was pointing, where she said a dog had gone, and then she veered back towards the tent and checked the tent to find out whether the child was still in the tent or not, but by this time, of course, the outburst had raised a hue and cry, and Mike and I raced from the barbecue across to the tent and asked which direction the dog had gone, and we proceeded to search immediately. Kirkham cross-examined him about the statement he had made to the interviewing police. As to what she called out, you remembered 2 things, did you not, when you were talking to the police? One was, "The dog's got my baby." That dog's got my baby, yes. And you also indicated to the police that she said something to this effect. Somebody please stop that dog. Yes. It has been suggested, Kirkham said, that Mr. Chamberlain's behaviour during the time of the hue and cry lacked urgency. The prosecution is claiming that, you understand? Greg Lowe nodded, grudging and brief, as if more definite assent might align him more closely with the prosecution than he wanted. Tell me this. Is this how you described some of his conduct to the police? Kirkham paused here to emphasize that the police had long known about the behavior he was about to comment on. He read, Mark and I must have searched for about half an hour, going at full pelt through the scrub. That's right. We kept covering different areas and then coming to the tent to see if there was any news. Yes, that's right. What do you say? You were there. What do you say about this suggestion that Michael Chamberlain lacked urgency in his conduct? Well, when the hue and cry first was given, Mark and I just froze for a few seconds. And then it was at full pace to get a torch and to find out which direction the dog had presumably gone, and then we raced as far as we could up the sandhill to check it out. And then we broadened our scope of search. Did he in any way, to your observation, lack endeavour in seeking his child? No. I must point out, though, that Mark did go back to console Lindy on several occasions. Kirkham knew that Greg Lowe thought this was a helpful offering. Thank you, Kirkham said. It is suggested by the prosecution that there were opportunities for the Chamberlains, or one of them, to clean blood from the front of the car during the search. Did you see either of the Chamberlains engaged in any such operation? No, I didn't. There were quite a lot of people around at that time at the tent site, and I'm sure if anything like that had happened, it would have been noted. Kirkham turned to the jury box. I hope the jurors can hear your evidence, he said. Greg Lowe walked from the courtroom, shambling, splay-footed, resigned to a helpless suspicion that nobody seemed to put much store by ordinary folk anymore. 10. Each witness so far seemed to have a different grasp of timing and sequence. It was as if Lindy Chamberlain's cry from her tent so unsettled time and shuffled events that the usual methods of judging these things were no longer apt. No one was having more difficulty with this than Judy West. A handsomely graying woman now in her 50s, she was thought calm by those who knew her well, even serene. The calmness, to which work on the farm and the strict application of meditation both contributed, was not of long standing. Judy West used to suffer dark bouts of disabling nervousness. It was a pit she climbed out of painfully. Now she seemed to be standing again at the edge. Trouble had begun when she arrived in Darwin. The constable who met the Wests at the airport took them to a room in the police depot for a pre-trial conference. Barker was there, and the legal officer O'Loughlin, but Pauling did all the talking. Evidently, the Wests were Pauling's responsibility. He began by saying, The Crown is impartial, you understand, but we've got a good case here, and we are out to prove it. Some contradiction lay deep in there, but she had let it pass. His pen hovered over a pad. You say you heard a dingo outside your tent on the Sunday night. I did hear a dingo. I heard it growl, she said. The regret that she had done nothing about it at the time had long pursued her now. And you later heard Mrs. Chamberlain call out. She said she had. She knew Sally Lowe thought the cry began, Michael, Michael, but the words that rang in her own ears were, my God, the dingo's got my baby. How long was that after the dingo growled? I don't know, 5 to 10 minutes perhaps. Then she recalled Bill and young Catherine went to see what had happened. Once they'd located everybody, Michael Chamberlain had asked for a torch. Pauling asked, How long after you heard the cry did Michael ask for a torch? She ran through succeeding pictures. Bill and Catherine pulling on their shoes, the path from there outside to the barbecue, finding the shivering Aidan, who said that a dingo had taken their bubby, crouching to hug him close, the sudden appearance of Sally Lowe, and Lindy, white-faced, and then Michael, who had lost his car keys and was calling for a flashlight. Talking in actual happening time, as she thought of it, was implausible. Everything took an age. About 15 minutes, she said, which seemed to please Pauling more than it ought. "Did you stay long with Mrs. Chamberlain while the search went on?" "Until the bush nurse took them off to a motel." "You saw Mr. and Mrs. Chamberlain walk away together while you were there." "Which time do you mean?" she said. Barker and Pauling exchanged glances. "That happened more than once?" Pauling asked. "Twice, for about 10 minutes each time," she said. "No more." He had asked her to recall what they did when they came back to her. "The first time," she said, "Michael asked us all to pray together. He put his hands on Lindy's head and said a prayer. The second time, I told Lindy Regan cried, and I'd shushed him to sleep." "So you had been inside the tent. What did it look like in there?" "Everything was lying about. There was a trail of blankets strewn from the cot at the back to the flap at the front. I remember some blood. I was kneeling on a little blanket, a baby rug, and there was a fine spray of blood on that." "When Mr. and Mrs. Chamberlain walked away from the tent, at either time, were they carrying something? A spade? A bag? Anything?" "No." The scene in her mind was nothing like that. She was watching two bereft people who loved each other walk arm in arm, back and forth through the low scrub. She did not lose sight of them for more than a minute. They needed to be alone. They were not far away, but beyond consolation. "No," she said. "They had nothing." They told her she could go. She heard Pauling and Barker talking as she reached the door. "That's when they buried the body, right enough," Pauling was saying. She went through it all again in the attentive courtroom. For the first time, she began to suspect just how much was amiss. Pauling asked her to demonstrate for the jury the gestures Michael Chamberlain made looking for his car keys. "He was patting his pockets," she said. "He seemed very distressed." She stood and tapped her own hips and vest. "He seemed to have a coat on." "What was it he was saying?" "I think he wanted a torch, and it was in the car, and he couldn't find the keys. But it was most unusual for him, because he was a very organized person. I knew we had a torch in the tent, so Bill offered it to Michael, and he said yes, he'd like it, so Bill went over to the tent and brought the torch back for him." "Can you give us any idea how long after you had heard Mrs. Chamberlain cry out that you had this conversation with Michael Chamberlain about the torch?" 10 to 15 minutes, Judy West said. She heard an indrawn breath from somewhere behind her. The dock was behind her. The breath was from Michael Chamberlain. It was then she realized that 10 to 15 minutes might represent an error of more than usual importance. It fell to Kirkham to retrieve some ground. "Can you tell the jury what time you arrived at Ayers Rock?" "The Friday in the afternoon, about 5 o'clock. "On the Saturday, did you see a dingo in close proximity to your tent?" "It would be about sundown," Judy West said. "Catherine and I had climbed the rock. She'd had a shower and was sitting outside the tent." "Did your daughter call out to you in a loud voice?" Judy remembered that Catherine, who was then 12, had screamed rather than called. "Yes," she said. "Did you see a dingo in the immediate vicinity of where your daughter was seated?" "Yes." "What did you do?" "I chased it away. It wouldn't go. It just stood there, and I was quite frightened. It moved in the end, but it was just like shooing off a dog." "How long did you have to exert yourself to shoo the dingo away?" "Not long," she said with a smile, "because I did not want it there." She was familiar enough with the ways of courts to know that she mustn't give the reason for this, since it relied on hearsay from Catherine. The dingo had grabbed Catherine by the arm and pulled. "In which direction did it proceed?" "It went around behind our tent, east, towards what has been described as the sand dune to the east of the camp." That was indeed where it had gone. A story doing the rounds about town, which Tipple had lighted upon, spoke of these witnesses as if they were all friends of the Chamberlains. So Kirkham asked Judy West, "Did you ever meet Mrs. Chamberlain prior to arriving at Ayers Rock?" "No." "Did you have a conversation with Mrs. Chamberlain at the barbecue?" "Yes." "Can you recall the details?" "When we went over to have a look at the baby, she told me she'd called her Azaria because it meant Blessed of God." "It meant?" "Blessed of God, and that she'd had trouble originally when they'd rung her parents about the baby, because the parents thought it was a boy called Azaria, so she had to explain she'd had a girl called Azaria." Was there any conversation about the desire of the Chamberlains to have a girl? They said they'd always wanted a girl, and she was very much the baby they wanted. Mrs. Chamberlain was wearing a parka that was covered with travel badges, and she told me she had done the same thing. She'd sewed travel badges on a parka of Michael's and for the two little boys. Wherever they went, she bought badges and sewed them on, and she'd started a parka for the baby that already had 2 badges on it. Justice Muirhead said, "Mr. Kirkham." The judge had caught something everyone else had missed. Lindy Chamberlain, on her bench in the dock, was hiding her tears with her hands. "We will take our afternoon break now." He rose from the bench, but they still hadn't got it. "I think Mrs. Chamberlain is not well," he said. Kirkham pressed the topic. "Were you able to make any observation of the manner in which she was caring for her child, Azaria?" "The baby was wrapped in the cot, and she offered to pick it up for me to have a look. I said no, not if she's asleep, but she said it was time for the baby to be picked up. She had a great care for the baby." "Did you see that attitude change in any way?" "No, I never did." "The next occasion I think you saw Mrs. Chamberlain was again at the barbecue in the evening of the Sunday. Was the child awake?" "Yes, she was sitting. Mrs. Chamberlain was dandling her on her knee." "Did Mrs. Chamberlain appear in any way grouchy or unhappy?" "No. She was a bit tired, I thought, but she wasn't grouchy or unhappy." "Were you in the concluding processes of washing up when you heard the growl you have told us about?" "No. I'd given coffee to Catherine, and I'd sat outside myself, drinking coffee. Then I moved into the tent and was just sitting inside the door when I heard the dog growl." "I do not want to put words in your mouth," Kirkham said, "and if I am wrong, please tell me immediately, but did the sound appear to come from the general area to the rear of the Chamberlain's tent?" "About halfway." "Halfway what?" "Between our tent and the Chamberlain's." "Would you be able to describe the growl?" "It was a low, deep growl. It was the sort of growl our dogs give when Bill is killing on the farm and he gives them—" Kirkham stopped her there. He wanted to sharpen the jury's attention for this. "You may have a little difficulty making the jury hear you. It is a growl like your dogs give on the farm when Bill is killing, you say?" "Yes. Bill will give them a bit of offal while he is killing, and one dog will be sort of scared that another dog will get a bit more, so it growls to keep it off." The judge said, "A type of threatening growl, is that it?" "Yes," she said. "You told the coroner at the first inquest," Kirkham said, "that Mrs. Chamberlain's cry seemed to come fairly quickly after the growl of the dog, although you could not estimate the precise time. Was that true?" "Yes." This was the growl which had convinced Dr. Newsom at Wildlife Research and Les Harris at the Dingo Foundation that 2 dingoes were at the tents. Phillips and Kirkham planned to call Harris to testify about that. The growl was important for another reason. It gave a presence, vivid and menacing, to the dingo which left its prints in the dust at the Chamberlain tent. "You were, apart from occasions I will ask you about in a moment, in Mrs. Chamberlain's company from the time the alarm was raised until the time she and her husband departed for the Uluru Motel?" She agreed she was. "There were times when I went away," she said. "I went to the barbecue at one stage to make some Milo." She recalled that occasion clearly, for Lindy had refused the Milo, saying if she drank it, she would throw up. "And I went to our tent a couple of times for blankets. It was very cold." "They were visits of short duration, minutes?" "Yes." "Are you able to say whether either Mr. or Mrs. Chamberlain removed anything from the car in your presence?" "No," she said, thinking back. "Not to my knowledge." "Indeed, you were standing at times against the car, leaning against the car, I suggest to you, and so were other people." "Yes." "And the light was sufficient so the people leaning on the car from the outside could see the interior?" "Yes," she said. "When you first saw Mrs. Chamberlain, after the alarm had been raised, can you recall what she was wearing?" "She was wearing the same clothes she was wearing when she was at the barbecue in the morning." "Which was?" "Sneakers and socks, with a short dress or a skirt." "I would just like you to describe the light for the members of the jury, if you would not mind." "It was a gas light on a long stainless steel pole." "Was Mrs. Chamberlain standing in that light?" "Yes." "Did you see anything on her clothes or her face or her person which would suggest to you that she had a child's blood on her?" "No." She shook her head. This was all the vehemence of which Judy West was capable. She wished she could express it more truly, but the choice for her was between calm and calamity, and she held to calm. Justice Muirhead brought her back to Michael Chamberlain's loss of his car keys. "Your assumption from that, I suppose," he asked, "was that the car was locked?" "Yes." "Did you see it unlocked that evening?" "Not until they'd packed up and set off for the hotel." "They were setting off for the motel." "To the best of your knowledge, it remained shut during the entire period?" "Yes," she said. Kirkham asked, "Did any of the police or the rangers say anything in your presence to Mr. or Mrs. Chamberlain that night to indicate that there was little hope of the child remaining alive?" "No." Then she remembered something. The bush nurse, when she arrived, asked Mrs. Chamberlain if she was feeding the baby, and when Mrs. Chamberlain said that she was, she indicated that she'd give her some tablets to dry up the milk. "Did you urge the Chamberlains to leave the area and go to a motel?" "Yes." "And did other people?" "I know Mrs. Whittaker urged her to go, and the bush nurse." Judy West well knew the importance of all these questions. Neither of the Chamberlains had the chance or the time to slay their baby or to bury it secretly. No one who saw them when Azaria vanished thought they lacked urgency or grief. Those suggestions arrived with the press. The one advantage she could attribute to her own experiences of sorrow and anxiety was that she knew grief when she saw it. It seemed they had done with her now. The judge was saying she was free to go. The first 5 paces of her route home took her by the dock. She looked up and risked a hesitant smile. It occurred to her then that the expression in Lindy Chamberlain's eyes had not changed at all since the desperate moment of loss. 11. The law department had booked part of the Telford Territory Motel for prosecution witnesses. Stuart Tipple went over there to interview the family of Whittakers. He came back nervous, told Phillips and Kirkham there were problems. Max Whittaker, for all the practicality to be expected from a high school engineering teacher, was open-hearted but hesitant, changed the direction of his recollections mid-stride, and delivered what was left of them in brutally dislocated sentences. The daughter Rosalie was graceful but shy. Amy Whittaker's capacity for recall was prodigious but excessively exact. She was a short, determined, and tough-minded woman, a much-qualified nurse who had turned to professional social work. Tipple thought her a gifted observer of emotional detail, but he worried that she might be fussy and overcautious in the witness box. There was another thing. She had looked at him as if he were some sort of mountebank. Although she was clearly a religious woman, he suspected she might not like Adventists. She seemed to him detached, distrustful. As it turned out, Amy Whittaker was, in her stern and precise way, quite spectacular. Of the manner in which Michael Chamberlain burst into their tent, she told Pauling, "A man appeared in the doorway. Michael Chamberlain. He said, 'You have a Christian record playing. What does that mean?' After a few seconds, I said, 'We are Christian people.' Michael said, 'If you are Christian people, can you be praying? A dingo has taken our baby, and she is probably dead by now.' My husband addressed a remark to him which I didn't hear, in response to which Michael turned and indicated outside the tent. My husband and daughter immediately grabbed torches, clothing, and ran out. Because Max and Rosalie had already gone, he raised his voice to follow them out, and I heard him saying, 'I am a minister of the gospel.' He turned to me and again made some request for prayer. I assured him I would pray, and he left the tent." "Did you remain in the tent for some minutes?" 5 or 6 minutes. Amy Whittaker had kept her promise to pray. She then walked the row of tents looking for the Chamberlains. "Did you then approach some women in that area?" "Yes, I saw a group of women standing. 3, as I recall. She had no trouble choosing the afflicted mother. I simply put my arms around her and I said, 'God is good.' Did Mrs. Chamberlain say anything? She said, 'Whatever happens, it is God's will.' And then she pulled her body back from me and looked at me directly and said, 'It says, doesn't it, that at the second coming, babes will be restored to their mother's arms?' I took her by the arm and I led her over to the low fence. I sat her down and sat beside her, and there was another woman who sat on the other side, the right side of Lindy, Judith Wist. During the balance of the evening, you spent some time with Mrs. Chamberlain? A considerable amount. Did she indicate anything about the area in which she believed the search should take place? There was one period in the night when she was quite agitated because she believed the searchers were not looking in the right place. She said, "They're not looking in the right place." These are phrases I recall, but they may not be in the right sequence. "The baby is just out there. It must be out there, under the bushes somewhere, and they're not searching. They should be looking in that area." I recall something else she said. "I will have to live with this the rest of my life, and I don't want to think that the baby could have been out there and simply because we didn't look in the right place, it would die." Did you make a suggestion to Mr. Chamberlain, following on the conversation? I said to him, "Look, take Lindy out there and let her see for herself that the baby is not there." How long were they away? 15 to 20 minutes. What was the lighting like where they went? I think there were a few car headlights, but the area into which they went would have been pitch black. It was out in the bush. This incident was of arresting interest for Phillips and Kirkham. On the prosecution case, the Chamberlains walked into the scrub to bury their baby. Now it seemed that, at least on the first of two occasions, they went out there at the suggestion of Amy Whittaker, who watched them set off. Pauling asked, "When you were accompanying Mrs. Chamberlain, did she say anything to you about the dingo?" I recall her telling me that as she was coming across from the barbecue towards the tent, she saw a dingo outside the tent flap. I think she said she then entered the tent, looked for the baby, and it wasn't in the bassinet. The big clothing was disheveled, and she thought first of all maybe the baby had fallen out, and she searched around but couldn't find it. After Mr. and Mrs. Chamberlain had been away for the 15 to 20 minutes you describe, did Mrs. Chamberlain say anything more to her husband, in your hearing, about how the baby could have disappeared? She did look up at him, hopefully at one stage, and she said, "Is it possible someone could have entered the tent and taken the baby away?" He looked down at her and said, in a gentle tone of voice, "But what about the blood?" "You suggested they go to a motel for the night?" I had several times asked what their plans for the night were, and perhaps suggested they go, but they said no. It was after the nursing sister came, and she renewed attempts, that they agreed to go. Did you assist packing up things in the tent? I didn't enter the tent, but Lindy was giving me articles to take to Michael to pack in the car. This would be something like 12:30 to 1 o'clock, packing the car. I ferried articles across. Pauling asked if, while they were emptying the tent, she had seen the baby's bottles. "They were in a white plastic ice cream container," she said, and added that she recalled another with teats. "Was there any liquid in it?" Yes, she remembered liquid being emptied from the bottles. It was not easy to guess what the prosecution was up to with this point. Barker had not, in his opening, anointed the teats or the bottles with any significance. Nevertheless, Kirkham made a note. "Did anyone switch on the lights of the car?" "The interior of the car was lighted." "How?" "Well, I assume because the door was open." "The first time you noticed the door open was when you were packing up, is that so?" "Yes. I don't recall seeing the door open at any other time." So well had Amy Whittaker's testimony suited the defense that there wasn't much Kirkham had to do. "Firstly," he said, "did you observe a dingo in the vicinity of your tent shortly before Mr. Chamberlain arrived there?" "Yes. I was washing up with my daughter, facing towards the sand dunes, and I saw the dingo enter under the fence, directly across from me, and it passed to my left in the outer periphery of the light." In relation to the Chamberlain tent and car, can you tell us in which direction it was travelling? Was it towards them? "It was travelling towards them in the time it was in the circle of light, but once it went beyond the light, I don't know where it went." "When Mr. Chamberlain arrived at your tent, what was his demeanour?" "You want my impression?" Kirkham nodded. "My immediate impression was that he looked strange," she said. "He appeared to be a man rigidly controlling some emotion that he thought may have been in danger of overcoming him. When you went down to speak with Mrs. Chamberlain, it was with the intention of giving her what support and comfort you could?" "I guess I was wondering if there was anything, in a professional way, that I could give." Because Amy Whittaker held a university degree in social work, double certificates in nursing and midwifery, and had taught nursing, Kirkham asked her, Are you able to recognize signs of shock in a person? Her answer was untainted by doubt. I am certainly well qualified to do that. When you saw Mrs. Chamberlain, did she, to your mind, exhibit signs of shock? Well, she was certainly numb, and she certainly appeared to be rigid, motionless, and oblivious to some extent of her surroundings. Those signs would be consistent with a person in shock. When you spoke with Mrs. Chamberlain in the course of the evening, did she describe to you the clothing the child was wearing? Yes, because she was concerned about the exposure and saying that the baby only had a singlet and cotton jumpsuit and an old cardigan. An old cardigan? An old cardigan. I recall the cardigan because it offered to me some comfort that at least the baby had one warm garment on. People did come along, on and off, most of the night whilst you were there? Yes. Every time they came, there was always the hope that maybe this time there would be something certain. Mr. Chamberlain, on a number of occasions, approached vehicles coming up and asked for news. Is that so? I saw Michael several times go towards a car. As it came down the road and stopped, he would go off to the car. She had delivered to them with that scene the Michael she knew, dutiful, uncertain, alone. Kirkham couldn't have hoped for a better line to finish on. 12. Witnesses were excluded from the courtroom on Justice Muirhead's order until the time came to testify. Orders like this are issued in the hope that the witness will then give evidence without knowing anything of the testimony already offered, but when Murray Haby was called by the constable at the door, he walked in with a rounded complement of knowledge. He had kept up with the newspaper reports, and the television bulletins were full of it. This didn't matter much in Haby's circumstances, because his story did not compete for veracity with anyone else's, but it made him wonder just how efficacious these lawyers thought their orders were. The Haby family had arrived in the camping ground at Ayers Rock about an hour before the Chamberlain baby vanished. Before setting up camp, they had eaten an evening meal in the van, lounging about the main cabin, and it was to this time that Pauling directed Haby's evidence first. "Were you sitting with your family in the combi van with the door open?" he asked. "At about 8 o'clock, after you had finished your dinner?" "We were still in the middle of the meal. While we were having the meal, a dingo came up to the van. We had the sliding door open. It came up, and I took a couple of photographs of it." It was the opportunity of more than one which had astonished him at the time. The Habys had been on the road 3 months, mostly spent in the outback, and he'd expected the dingoes here to be as shy as they were everywhere else. This one had stuck around while he'd set up the camera and fired off 2 shots. "It was dark," he said, "so I used a flash." "At around 8:20 p.m., did a woman approach your combi van?" So far as Haby could guess, it was in this conversation that the prosecution was most interested. "Yes, it was Mrs. Chamberlain." "Tell the jury, please, how she approached the van." "She was walking fast. She said, 'A dingo, or a dog, has taken my baby. Have you got a torch?' She repeated something similar again because I sort of looked at her in disbelief, I suppose." Haby remembered that disbelief vividly and verbatim, his thought at the time. It was, "Pull the other leg, it rings out a tune." He was appalled now to think how close he had come to uttering it. He had suddenly seen that she was serious. I asked how did she know. She replied that she saw a dog, or a dingo, coming out of the tent when she was walking to the tent, and she looked in and found the baby was missing. I then said, "Did you see the dingo, the dog, carry the baby out?" Did Mrs. Chamberlain reply? She replied, "No, it wasn't carrying anything." I asked, "Which way did the dingo go?" "The one she saw." Haby had clear recall for this, too, for he had begun to suspect by then that the dingo with the baby might not be the one the mother saw. This would make the tracking difficult. "I'm not sure of the exact words, but she said, 'Up there,' or 'in that direction,' and she pointed up the sand dune." Murray Haby had not given evidence before. He was not called at either inquest, and suspected that for some reason the evidence he could give was not popular. Beyond that, he had not thought a lot about it. But now he didn't much trust the prosecution. His wariness had come about at an interview before evidence began, with the prosecutors. Pauling had asked him then to recount his part in the search for the baby. He described leaving Lindy Chamberlain standing on the roadway. He had headed for the dune, happening on tracks here and there, too many tracks. He guessed a fugitive animal might make for high ground, and that was the way it worked out. He found a track on the slope which looked to him fresh, and he followed it. It led to a depression in the sand where something had rested. A bundle, maybe. When he plied his torch there, he caught a pattern in clear relief. Whatever the bundle held, the material covering it was either woven or knitted. He followed the trail on, but it faded away. When he backtracked, it took him all the way to the roadside scrub near the Chamberlain tent. In conference, Pauling's response to this story was not as Murray Haby expected. Haby, a schoolteacher, had some grasp of legal ways. He knew about the adversary system in criminal courts, the just fight between antagonists, but wasn't too sure it represented a methodology he was happy with close up. Pauling asked him now to show the jury where his combi van was parked, and Haby marked the map with a careful oblong and his initials. "Now, Mr. Haby," Pauling said, "you had been asked for a torch and pointed in the direction of the sand hill. What did you do?" "I went back to my vehicle and got a torch, and then proceeded up the sand dune. There were 2 other torchlights flashing around on the dunes. I looked around on the lower part, and we called to each other a couple of times. Had we found anything? And the answers were no. Then I thought, well, if there was a dog carrying something, it would have to cross the ridge of the sand dune, so I'll go up the dune. And I went to the top of the sand dune and walked along it until I came across some tracks." Here was the point beyond which he couldn't go without first deciding how much he should say. It had irked him, since the time he'd read the newspaper accounts from the inquests, that no one had bothered to report to the awaiting parents the discoveries made on the dune. And now the Chamberlains were criticized for seeming too quickly dispirited. He couldn't see that this was at all justified, and it worked on him like a fortifying anger. He decided to tell it as it had happened. "There were a lot of tracks down lower," he said, "but this track stood out because it was a little bigger than the others and quite easy to follow, and came along to an area where obviously it had put something down, this dog or this dingo, and it left an imprint in the sand which, to me, looked like a knitted jumper or a woven fabric. And then it obviously picked it up because it dragged a bit of sand away from the front and kept moving. And I followed it around past the Anzac Memorial to where a car park comes off that road to the south of the sand dune, and lost it in the car park." Murray Haby thought himself a man of moderate courage, but when Pauling told him to pause there, he wondered if he was in trouble. Instead, Pauling asked about the size of the impression in the sand. "To use the imperial, about 7 inches by 5 or 6, Haby guessed. "The shape?" "A rough oval shape. It had defined edges. There wasn't a mark as if somebody had put down this and left a straight edge." He held out a finger stiffly. "It was sort of a depression like that," he said, showing a concave palm. "Was there the impression of anything attached to it, or not?" "No, it was just the one oval shape. And there was a drop of something there, something moist, like saliva had spilt there beside it." The judge was interested in the location of the trail. Haby said, "I didn't follow it back as far as I could have. I only went a little way north," which was in the direction of the camp, "to where it would have been directly opposite the tent." "Did you go and tell somebody?" Pauling asked. "Yes. I spoke to a ranger and a policeman and told them what I'd found, and I took them back up to the crest." All he could truthfully say was now said, and he felt the better for having breathed on the scales of justice a little himself. Part of the fact, anyway. 1. There must be an argument in complicated cases for sometimes presenting commutative testimony, as it might be called, allowing witnesses to speak of an event until the evidence of it is exhausted, then recalling them when it is time to speak about other happenings. The way we do it now, leading the witnesses to the stand seriatim, in a picket line queue, puts more store by convenience than comprehension. They pass through like actors who deliver all their words during uninterrupted, lonely appearances, leaving it to the audience to reshuffle the lines into appropriate scenes. Constable Frank Morris's narrative, for example, spanned a period beginning an hour after the baby vanished and ending the day after Wally Goodwin's discovery of Azaria's clothes. This represented 9 days, and it overlapped, somewhere or other, with the testimony of 15 other witnesses. Barker seemed anxious to bring the big, agreeable Morris quickly to the first conversation the constable had with Lindy Chamberlain. Phillips and Kirkham understood the reason well enough. The Crown said she was then in the process of fabricating a story and had not yet got it straight. Morris said, "Mrs. Chamberlain said that, originally, she was at the barbecue site and she'd seen a dingo near the tent. It had what appeared to be something in its mouth. She hadn't taken a great deal of notice of it because she'd seen dogs and dingoes earlier in the day around the campsite, around the rubbish bins and tourists feeding them to get photographs, etc., and didn't take undue notice until she returned to the tent site a short while later and then suddenly realized that the dingo, or dog, must have taken her baby. She then called out for assistance and called out that she needed lights and torches, etc., so as to illuminate the area to try and locate the dingo and the baby." Doing his best to describe the mother's demeanor, he said, "She appeared to be weeping, upset, and one thing Mr. Chamberlain did make mention of, at the time, was that he thought he should stay with his wife under the circumstances." The memory the Chief Ranger, Derek Roth, had of a similar conversation at the Chamberlain tent was this: "Mr. Chamberlain stood behind Mrs. Chamberlain with his hands on her shoulders. The pastor had said, 'Our baby girl has been taken by a dingo, and we are fully reconciled to the fact that we will never see her alive again.' He then asked me, 'The dingo would have killed the child immediately, would it not?' Roth asked Lindy Chamberlain what had happened, and he recalled she'd said that she had seen a dingo come out of the tent, and she had been worried and gone inside to find that the baby had disappeared. He had asked her then, 'Did you see anything in its mouth?' She had answered, 'No, the dingo wasn't carrying anything.'" Morris had returned to the tent between searches to check his facts. "On this occasion," he told the jury, "she said that the dingo had nothing in its mouth. I said back to her, 'But you made the statement earlier that the dingo had something in its mouth,' believing that the woman could have been upset and could easily have made a mistake. She stated she did not recall making that statement earlier." Morris later came close to conceding the mistake might have been his. In cross-examination, Kirkham asked, "You told the coroner in the first inquest that your conversation initially with Mrs. Chamberlain was very brief because you were more interested in getting on with searching. That's correct. You also told the coroner that you could not recall exactly the conversations that occurred between you and Mrs. Chamberlain. Not word perfect, no. But the real point was this. In fact, you did not make any record of these conversations until, I suggest to you, 26 August. That is also correct," Morris said. 2. During the nighttime search, Morris had been shown dingo tracks and the marks of something dragging. "Very shallow, as though something had barely touched the ground. The aboriginals pointed it out. If they hadn't, I wouldn't have possibly been able to detect it with my own eyes." Asked by Phillips if he observed any indentation in the sand, with a weaved pattern, Morris replied simply, "I don't recall." Ranger Roth's memory was better. He remembered it well. "You likened the impression you saw in the sand," Phillips said, "to a crepe bandage?" "Yes, sir." "Is a knitted garment equally valid, Mr. Roth?" "I think it could very well be, yes." "Whatever the object was, it had some weight to it?" "Yes, sir." "The dog or dingo pad marks associated with this drag mark, did they run on either side of it?" "Yes, I ascertained that the following day, really more than that night." "Mr. Roth, the clear inference you drew was that the object causing the drag mark was being carried by the animal in its mouth?" "That was the clear inference, yes. But of course, you know, it could have been an object carried by anything." "Did you find more than one area where the object had apparently been put down?" The answer was a surprise. Yes, sir, 3 areas. So unremitting was Barker's pursuit of the detail of the searches, and he kept Morris at it for 2 hours, that Phillips knew it had more to do with the requirements of drama than of logic. Then he got it. The dune had been covered a multitude of times, in Morris's phrase. For 3 days they scoured the wider landscape. The inference was this: if there was anything to see out there, they'd have seen it. So Phillips asked, in cross-examination of Derek Roff, "Because you knew that dingoes bury their prey, you took pains, did you not, to indicate to the searchers that they should look for signs of anything having been buried?" "Right, sir." "Nothing of the sort was found in the searches you were involved in?" "No. It was very difficult because the country, you know, was obviously torn up from tourist activities before enduring. But the fact is," the white-bearded ranger shrugged, "we found nothing." The shrug meant, "It's a big country." The constable had seen tracks in the dust around the side of the tent, the right-hand side as he faced the entrance, by torchlight. The next day, while he was there with the hurriedly arrived Inspector Gilroy, he watched the inspector lift the sagging wall to uncover other prints. They were at the corner where the bassinet was. Morris described them, in answer to Kirkham, as "right at the very base of the tent, would appear to be dog tracks or dingo tracks." Roff had seen one paw print there, a dog track, a dingo track, outside the tent, he said, at the same corner where the baby's basket had been. Gilroy remembered 2 at the entrance to the tent, and others at the rear corner, a size similar to, or perhaps a little smaller than one would expect from a Labrador or a German Shepherd. He had them photographed, but when the negatives were developed, the shots were blank. But Gilroy had caught sight of something on the tent wall which everyone else had passed by. There was, midway along the right-hand panel, a stain. Phillips asked if it was blood. "I saw a dark spray," he said. "It could have been blood." "Where was it?" "From memory, perhaps 15 or 16 inches from the ground, in the middle of the tent." This was very likely the blood which Dr. Andrew Scott could not analyze for species or group. But it was, Phillips thought, useful nevertheless. It added to the defense's list of significant coincidence. 3. "Mr. and Mrs. Chamberlain were in the office," Morris said, speaking of the Uluru Motel office early in the morning, "and Mr. Chamberlain was making telephone calls. I heard him say something along the lines of it was God's will the baby is gone, and not to worry, they were bearing up to the situation. After he hung up, I told him that we didn't have any success with the search during the night, that we had been up at first light, and that we would keep them informed of any developments. I believe he was, once again, pleased with the work the rangers and everybody was doing." Not long afterwards, Morris had Michael Chamberlain complete the form, "Information as to death." Lytle Dickinson, the licensee at the Uluru, who was later to drive the Chamberlains to the camp so that Michael could take a photograph of the tent for the Adelaide News, was right there in the office. He remembered Michael Chamberlain was then calm and cool, speaking very clearly and precisely on the phone. The manager, Alan Barber, knew the telephone call was to Michael's mother. Barber was there for the beginning of it. "He said, our daughter Azaria was killed by a dingo last night, and we don't ever expect to find the body." Then other calls came in, and Michael Chamberlain took one from the Melbourne Herald. "Mr. Chamberlain made mention of the fact that he had not taken much notice of the signs erected at Ayers Rock telling people not to feed the dingoes, and he hoped that this tragedy would make people more aware of signs, not only at Ayers Rock, but elsewhere." Phillips and Kirkham suspected that Michael Chamberlain was more unsettled by his feeding of the dingo at the barbecue than he cared to admit. It explained his preoccupation later with warning signs and with photographs. After all, his pastoral calling was in public health and safety education, which was another piteous irony. 4. He said, "I would like to take a photograph of the dingoes that were shot, a close-up, especially of the head and jaws, so that people could understand exactly how this could have happened." The testimony was Gilroy's. The conversation he recalled was between Michael Chamberlain and the police at the Aboriginal compound the morning of Tuesday, 19 August. Morris and Rolfe were there. Morris's version was very similar. Rolfe creased his tanned brow, which produced only a vague remembrance of the incident. Michael Chamberlain had wanted to know, as they each recalled, if it might be possible to arrange a memorial to Azaria, like the plaques which marked the deaths of others at the Rock, but no one could give him an answer. The Chamberlains were, just then, on their way home with Aidan and Regan. Gilroy thought their departure a perfectly reasonable decision. Morris, troubled, wasn't so sure. 5. Morris was not prepared to concede that, after Wally Goodwin led him through the bush to Azaria's disheveled clothes, he had at once picked them up. "The clothing had been tampered with by myself," his quaint phrasing ran, "after receiving an instruction to do so, which came by radio telephone from police at Alice Springs." 4 studs at the top of the jumpsuit were already unclasped, and he then opened the others. He arranged the jumpsuit and the scattered nappy to simulate the way they were when he saw them first, and immobilized it all in photographs. Wally Goodwin would have none of this. 2 years of misinformation was, he thought, more than enough. His face got ruddy and derisive. He was having trouble holding his temper. Of Constable Morris's first sighting of the clothes, Goodwin said, "He stood and glanced at them for a few seconds, then he bent down and picked them up." When he was asked if Morris had first made a telephone call, he answered, "He couldn't have, because he was with me all the time." Of the studs on the jumpsuit, he clearly recollected that the entire front was open. "And I thought part of the leg as well." And as for the police photographs, they were nothing like the way the clothing was found. In Wally Goodwin's deep belief, there was nothing about the appearance of the clothes which suggested an animal had not left them there, but he guessed he wasn't permitted to say anything so relevant. 6. Stuart Tipple was keeping a list, begun some time ago now, of the demonstrable errors in the development of the police investigation. His interest was more partisan than jurisprudential. More and more, he was astonished at the way the prosecution had been able to recover from its own mistakes. By any standards, the list of errors and refuted assumptions was remarkable. How wrong the investigators were, believing the baby was dead long before nightfall, was attested by families of Lowes and Wests. Everyone now agreed that the parents were distraught, even disabled by grief, at the campsite. James McComb, called by the Crown to prove that the dingo Lindy Chamberlain had seen at Maggie Springs was not like the one she described at the tent, proved equally well that the dingo was there, although this was disbelieved earlier by detectives who thought it an obvious deception. The bush nurse, Bobby Elston, called to prove that Michael Chamberlain drove to the motel with his camera bag under his legs, allowed that they were driving to the motel at her insistence, although the parents had wanted to stay near the search. The phenomenon did not end with the lay witnesses. Forensic biologists in Adelaide had been given clothes and bedding to examine for hairs without being told that animal hairs had been taken off in Darwin and were still there. Dr. Scott ran his test on the jumpsuit, looking for traces of saliva, not knowing that Goodwin and Rolfe remembered rain falling the night before it was found, or that the baby might have worn an outer garment, a jacket. Damage to the baby's rug, assumed to be inflicted by a knife or scissors, was later found to be the work of wool moths. No one considered that a dingo might extract a baby from a jumpsuit without first opening the garment wide, until a dingo managed the feat with the carcass of a goat at the Adelaide Zoo. So long was the Chamberlain's tent held at the Darwin Police Depot that blood sprayed along the wall could no longer be identified. Michael Chamberlain was suspected of withholding a child's parka from the investigation until it turned up in an Alice Springs police room where it had been all the time. Photographs of paw prints at the Chamberlain's tent came out of the developing vats unhelpfully vacant and were not mentioned at the inquests. The imprint of a knitted fabric found by Murray Haby on the dune was neither photographed nor guarded and disappeared under the tramping of feet, forgotten. And Morris's photographs were no longer of the way the clothing was on discovery, as everyone had assumed, but snapshots of the way his memory worked. It seemed now that the Crown could not call a witness to support its present case who did not also illustrate in some way how enthusiastically wrong the prosecution had been in the past. It added up, in Tipple's view, to culpable mismanagement and an action for damages, certainly writs for defamation against press and broadcasters, once this trial was all over. Given the publicity, it could be the biggest libel action ever. He thought it would serve the bastards right. 7. Derek Rolfe walked out of the courthouse, thoughtful. The paving was hot and glossy, the glare humbled the eyes. His safari jacket hung open. He was pleased to be out of the courtroom, to have finished with it all, but he was walking slowly, as if he were not certain any longer of the right direction. The disquiet he felt now had begun before the trial, at a conference with Ian Barker. He liked Barker, thought him skillful and pragmatic, a straight thinker. They were talking about the gully in which the baby's clothing was found. Barker wanted to know whether it was a place frequented by dingoes. "Dingoes were there, right enough," Rolfe said. "Tracks all over the place." He knew of the botanist Kushel finding Periateria fragments through the clothes. Rolfe wasn't much impressed by that evidence and decided to straighten it out before it went too far. The vegetation there was crushed where the animal had scrubbed the garment around, just fooling about, skylarking. Barker shook his head. "There wasn't any vegetation then." "Of course there was. Morris's snapshots will show it." Barker laid the photographs out on the desk. "There," Rolfe said. The bottom corner of one print had caught a patch of green, a dark runner, an annual of some sort. Rolfe tapped it with a sure finger. "My memory is not that bad," he had said, smiling. Now he was walking away from court without having uttered a word about it. He stood at the curbside wondering if he should alert the defense in some way, young Tipple perhaps. Then he wiped his mouth with the back of a hand, picked a gap in the traffic, and crossed the road. He much preferred the candid desert. Enough magnifications to see by. 1. For the Sunday edition on 11 September, Malcolm Brown had written a color piece so that weekend readers in the South might get to know something of Darwin and the manner in which trials are administered here. For 19 September, he wrote another. He latched the door, turned the air conditioning to maximum, switched off the Muzak, and wrote at the vanity table under a lighted mirror or weighing down the edge of the bed. He was writing to inform his readers. He was writing because not every reporter could get published this way, and he'd like to show he could do it. He was writing for some reason unconnected with any other, some reason inaccessible to him right now, and he hoped it might come clearer as he went along. It could happen only at the top end. When photographs of an Ayers Rock dingo were tendered in evidence this week and were described as the dingo blown up, the jury rocked with laughter. Selected on Monday, the 9 men and 3 women were well presented, apparently conscientious and objective. But for a jury to break into all-out mirth? To Southerners arriving in Darwin for what has been described as the trial of the century, it is just one instance of the jarring oddities the frontier North has to offer. It does seem odd that a barrister could walk into a Supreme Court with unpolished, Brown had written filthy but soon discarded it, shoes, or a Crown law officer could sport a tattoo on his biceps, or a female court orderly, who may be efficient and professional, could wear a dress split most of the way up her thighs. The presiding judicial figure is quiet, droll Supreme Court Judge James Henry Muirhead, who ensures punctual adjournments so he can have a hallowed cup of tea. As Azaria's pathetic clothing was produced, Lindy Chamberlain sat expressionless, her dark eyes occasionally darting across to the bar table, and Michael Chamberlain, quite ashen, sometimes turned away and winced. Only one friend, Mrs. Irene Heron of Queensland, has come here to be with them, although their Gosford solicitor Mr. Stuart Tipple is as much a friend as a lawyer. Michael Chamberlain's brother Peter, who accompanied the Chamberlains at the second inquest, is not here. At the end of that inquest, he returned to New Zealand, broke down, and cried for 3 days. If the couple could have taken any heart last week, it was from the impressive performance of their barrister, John Phillips, QC, who vindicated his reputation as one of the best criminal lawyers in Australia. The reference to Phillips was prompted by an incident 3 months before at Avondale College while Brown was at dinner there with the Chamberlains. They were exploring the terms on which Brown might ghost a book for them after acquittal. Phillips had just been engaged to lead the defense. It seemed that Michael Chamberlain was only then finding out how high Phillips' reputation was, and the discovery was somehow cause for dismay. "When we are acquitted," Michael complained, "people will say it's because we had a smart lawyer." Brown remembered saying, with surprising gentleness considering his astonishment, "Just get acquitted." The dingo skull, used for demonstrating the dingo's biting action, click-clacked throughout the court and looked more ghastly than ever. The humor of Ian Barker, QC, leading the prosecution, who said that well-mannered humans don't eat that way, scarcely relieved the atmosphere. When Brown finished, he poured a whiskey from the store of miniatures in the refrigerator and read the piece through again. He was no closer to the source of his disquiet, but he knew enough about his own writing to see that his obsession lay more now with those who populated the environs of the case than it did with either of the accused. 2. The witness on the stand was Charlwood. When he gave his rank, Brown noticed a promotion. Charlwood was now a detective sergeant first class. The first class was new, but it didn't help him to look any the more comfortable. He fiddled with his fingers and smoothed his slim mustache. The jury was excluded because Phillips was objecting to the detective's use of his notes, and this was a preliminary issue. The notes were taken from tape recordings Charlwood had made during his conversations with Lindy Chamberlain at Mount Isa, in person and by telephone. Phillips' task was to show that Charlwood had recorded her unfairly, unlawfully, and the conversations were not relevant enough to qualify. In this country, the mere unlawfulness of recording is, alone, not enough to disqualify its use. "You had not the slightest difficulty getting her," Phillips asked, speaking of Lindy Chamberlain, "to agree to come to the police station that afternoon?" "No," Charlwood said. "And you entertained every belief that she would come down and talk to you?" "Yes. My purpose in returning was to pick her up." "Tell me this. On that day, did you suspect she may have killed her child?" Charlwood paused. "No," he said. "That is a truthful answer, is it?" "To your question, yes." "It never entered your head that she may have killed her child?" Phillips was now looking at the judge more than at the witness. Clearly, Phillips thought that the secretiveness of Charlwood's recording was incompatible with the answers the detective was giving. "I felt she may have known more about the death than she had told," Charlwood said carefully. "Did you feel she might be involved in a homicide in some way?" "In some way." "Tell us about this tape recorder you used at the home. Where did you have it?" "In my pocket." "There was no problem at all about putting the tape recorder on the table and saying, 'Mrs. Chamberlain, I want to tape this conversation so that we have a record of it?'" Charlwood seemed to have no immediate answer. "No problem at all about that, was there, Mr. Charlwood?" "I never entertained the idea, nor did I put it forward. I don't know whether there would have been a problem or not." "The tape recorder remained in your pocket without any decision on your part that it should remain there, is that what you are saying? It just happened to be in your pocket?" "No, it never happened to be there. I placed it there, and I activated it, and stopped it." "And you activated it in a way which she would not pick up, did you not?" "It wouldn't have particularly worried me, had she?" "Kindly answer the question you were asked. You activated it in a way that you hoped she would not pick up. Yes or no, please?" Charlwood looked a little more defiant now. "No," he said. "How long was the tape that you had in your pocket? How long would it run?" "One side runs an hour." "Did you change it?" "Yes, it was changed at some stage." "At the house?" "No." "At the police station?" "Yes, the tape there was changed." Where was it at the police station? From memory, either on the desk or in a drawer in the desk. Are you suggesting you took it out in front of Mrs. Chamberlain and changed it? Whether she was there or not, I do not know. You tape-recorded 2 telephone conversations with Mrs. Chamberlain, did you not? Charlwood agreed he had. Did you regard your action in taping those phone calls as being above board? Yes. I did not have any pangs of conscience. Were you in complete ignorance, do you swear to his honour, of any legislation relating to the taping of telephone conversations at that time? At that time, I was not aware of legislation. You know of no Act of Parliament, either of the Territory or of Federal Parliament, which related to the taping of such conversations? Phillips asked with some incredulity. Do you swear that? At that time, yes. You gave evidence at the first inquest? Yes. Did you tell the coroner in the first inquest about these secretly taped telephone conversations? After a derisive pause, Phillips added, which you regard as being completely above board? No, I don't think the subject ever came up. You gave evidence at the second coronial inquiry? Charlwood nodded. Did you tell the coroner at that inquest about these secretly taped telephone conversations that you regard as being completely above board? No, not that I recall. When did you first tell a lawyer connected with this case about them? I haven't told a lawyer at all. Because Phillips conveyed by silence that more was expected in answer to the question, Charlwood went on, I passed information through my superior, and I believe that he passed it on. You told your superior that the record of the conversation I'd had with Mrs. Chamberlain existed, yes. When? About a fortnight ago. Did you tell the coroner at the first inquest that you had secretly taped the conversation at the home? Not that I recall. Now, kindly turn your mind to the second inquest, Phillips said, finding a page in the volume of transcript. Were you asked this question by Mr. Rice? Mr. Charlwood, did you, on any occasion at all, ever record any conversation you had with either of my clients by means of any instrument or device? Charlwood conceded he might have been asked that question. Did you reply, yes, when I say I recorded the conversation, a tape recording was in use during some of the conversation I had with them. Unfortunately, the quality of that tape was such that it was unable to be transcribed? Yes. Charlwood was still conceding, but he wasn't conceding much. From memory now, we were talking about, specifically, conversations I'd had with them in Kurimbong in 1981, and that was the situation. I will just reread the question to you. Mr. Charlwood, did you, on any occasion at all, ever record any conversation you had with either of my clients by means of any instrument or device? That is the question you were asked, is it not? Yes. A good display though it was by Phillips, it was not enough to convince the judge that Charlwood was evasive, or it enticed Lindy Chamberlain unfairly to answers she might have considered unreflective if she'd known they were important enough to be recorded, and the judge decided the point against the defense. As the law allowed, Charlwood could have his tape recordings, but the glimpse this exchange had given of secrecy from the early days of the investigation, of stealth only now coming to light, illuminated for Malcolm Brown what it was that made him so unquiet writing about it. It was displacement he felt, a chill sense of foreignness. Brown had worked as a police roundsman around Sydney a good while, but up here it was taking him a long time to work out what the local game was. The Chamberlains might simply never know what they were up against. 3. A freelance reporter from 2-Day FM carried another jug full of beer back into the garden and filled the glass on the table in front of Sergeant Cox. The other drinkers were left to pour their own. It was twilight. The garden was cool, and the mosquitoes were not yet enough to drive everybody inside to the bar. The portly Cox looked pleased with the esteem in which he was held here. His diligent experiments with scissors and jumpsuit had suffered in importance as soon as the prosecution engaged a textile scientist from Sydney, but Cox was still an insider, and reporters looked on him as a possible source. The relationship between press and police is often described, on both sides, as symbiotic, In media circles, symbiosis is thought of as a biological interdependence stimulated by alcohol. No one wanted to leave while there was a chance it might pay off. Someone asked Cox why it was the Crown, rather than the defense, which called Keith Lenehan to the witness stand. Lenehan, who had given evidence that day, was the bleeding hitchhiker. It seemed to the journalists at the table that the Crown had provided a plausible source of blood in the Chamberlains' car without getting anything in return. "No one can say we're not fair-minded," Cox said. He might have believed this was the reason, but it did not represent the whole truth. It was important that the prosecution prove Lenehan's blood type, and essential that it prove he was not a sufferer of thalassemia, an anemia characterized by high and continuing levels of fetal hemoglobin in the bloodstream of an adult. "So far," the radio man said, "all you've done is convince everybody that Lindy is innocent." His use of her Christian name implied nothing like compassion for her, as they all understood. No one now referred to her any other way, even in newspaper headlines. Lindy was a name now more familiar to the nation than the first names of footballers and tennis stars. Talk turned to the judge. "He was right onto that towel," a TV reporter said. Cox nodded. While Lenehan was describing the fashion in which he had lain in the back of the Chamberlain car, his damaged head between the two front seats, Justice Muirhead interrupted to ask if he had been given a towel. This was the towel which later showed the presence of human blood. The bleeding hitchhiker had said no towel, but the question seemed to show that the judge was interested in following up leads like that. Cox said, "Early days yet. He's a judge. He'll get there." He wiped the beer froth from his lip. "All the witnesses so far might just as well have been called for the defense. But," he said portentously, "the tide is about to turn." And he laid a contented hand on his belly. 4. But the tide was still ebbing for the Crown while Myra Fogarty was on the stand. She had left the police force soon after Dennis Barrett's criticism of her in the first inquest and moved to Miami, Queensland. She had come into a modest inheritance and was now soft-haired and light-hearted. Pauling, whose witness she was, had her identify the tent, the baby's 2 purple blankets, and Michael Chamberlain's sleeping bag, which were the items she had examined in Darwin for blood and hairs 2 years before. She remembered, she said, locating bloodstains on the tent floor, on the larger baby blanket, and 3 on the sleeping bag. When she cut the stains from the sleeping bag so she could send them to Dr. Andrew Scott in Adelaide, "Feathers went everywhere," she said, and giggled at the memory. She had vacuumed the bag and the 2 blankets and sent the debris she collected that way down south, by which she meant the laboratories in Adelaide. The tent she shook over a paper sheet to see what fell off. In the shakings were fibers she thought were hair. She mounted them on slides and dispatched them to the Adelaide biologist, Harry Harding. These fibers, as Dr. Harding was scheduled to testify in 3 days' time, proved to be 5 human hairs and 3 strands of wool. Kirkham went gently with her in cross-examination. He thought she'd had a rough enough passage through the inquest. At the time she was ordered on to the Chamberlain case, Myra Fogarty's experience in forensic investigation was barely 3 months. "I am not being critical when I ask you this, because I do not think I was a very good barrister at 3 months, he said. "But is it true that you had no training in the examination of clothing, from the forensic point of view, during those 3 months, apart from the on-the-job inspections?" "That is correct," she said, and agreed she'd had no formal training in the detection of blood or the identification of hair either. "You were not told what sort of hair to look for?" "No." "You were not looking for short, white animal hairs?" Kirkham was making a point of this description because Dr. Harding had found hairs just like that on the baby's bloodied clothing. "No," she said, by way of agreement. He asked her in what manner of packaging the tent and bedding was sent to her from Alice Springs. "In a large box, is that so?" "That is correct." "You took out the blankets and the sleeping bag, and subsequently took out the tent?" "Yes, possibly a day or 2 later." Kirkham was concerned to show that there might have been any number of animal hairs overlooked in so cursory an examination. "Miss Fogarty, there was debris from the various items left in the bottom of the box, was there not?" "Yes." "Did you vacuum that up?" She twirled a tress of her hair with a finger while she thought. "No," she said. "Do you know what happened to that?" She supposed it might be somewhere around the police depot still. Looking at the jury, Kirkham said, "A very trusting presumption." Evidently Myra Fogarty thought so too. "I left the section shortly after," she said. "How thorough was your inspection of the tent, Miss Fogarty? Did you spend a long time looking for signs of blood on it?" "I spent a fair amount of time looking for blood, because that was what I was told mainly should have been on there, but I couldn't really do as much as I wanted." "Do you think some spots of blood could have escaped your notice, then?" "For sure, yes." She shrugged. "Like you said, I'm not trained really to look for them." Hoping perhaps to make up some lost ground, Pauling asked her, "You told us you found 4 hairs. What did they look like?" "Gee, they looked like human hair," she said. "I really couldn't tell. They looked like hair, or what I thought hair should look like." "You had no special training in distinguishing dog, cat's fur, human hair?" "No." She laughed. "The only thing I did was pull a few hairs out of my own head," which she mimicked now with tweezered fingers, "so I knew what human hair looked like under a microscope." Malcolm Brown, watching this from the press pews, thought Myra Fogarty seemed so pleased to be out of the police force that she was never far from laughter, and he noticed that she had handled her sunglasses throughout as if they were some sort of Sunny Aid memoir to remind her that her dutiful appearance in this court was fleeting, transitory. 5. Peter Dean, whose responsibility it was to coordinate evidence about the behavior of dingoes, had not been able to locate the family of holidaymakers at Ayers Rock from whose car a dingo had dragged their 3-year-old daughter. The incident was important for 2 reasons. It had happened only a few weeks before Azaria Chamberlain vanished, and the dingo had gripped the child by her neck. Ranger Ian Kaywood was the investigating officer, but until recently was out of the country. When he got back, he told Peter Dean that there was no record of the family's name or address. So Phillips made application to the judge for permission to advertise, in the newspapers, a plea that the family contact the law department. It took Justice Muirhead only a few minutes to dismiss the application, but while he was talking it through he said, "There is an abundance of evidence as to dingoes, their capacity to get very friendly and to get very vicious, to go into rooms and to go into tents and upset rubbish bins and behave like piss. It seems that the jury will have to approach this case knowing that." Of the capacity of a dingo to carry off a baby, he said, "It is not like saying it could not happen, or it does not happen. The evidence is entirely the reverse in this case." Phillips did not press it further. The way he heard it, he was being told that, when the time came for the judge to direct the jury, this was a point the defense wouldn't need to worry about. 6. Barker was about to tender, as evidence against the Chamberlains, their testimony at the Galvin inquest. In the normal course of things, the transcript would be handed up to the bench and that way become part of the Crown case. Phillips and Kirkham wanted to block it. They both recalled Barker's opening address to the jury in which he'd said, "It would not be fair to closely and critically analyze everything said by somebody obviously under stress," but neither of them believed he meant this stone literally. Barker was too tough to pass up an opportunity to score, and the more the Chamberlains had talked, the more scoring points there were. The defense would have had an easy time of it, Kirkham thought, if the Chamberlains were criminals, tight-lipped and case-hardened. It was a difficult application for Phillips to make without sounding too critical of the coroner, Jerry Galvin. But the point he must make was that Galvin had allowed the Crown to summon the Chamberlains for public interrogation while taking steps to make sure that they did not find out, in the meantime, what the case against them was. There were not too many ways to beautify that procedure. "But not your clients," Justice Muirhead asked Phillips, "have said, Well, under those circumstances, we're not going to wander in a maze, and we decline to give any further evidence on the ground that it might tend to incriminate us. There was that opportunity. I say there wasn't, Your Honor, because one just has to reflect back on the utterly unique way this proceeding was carried out with the publicity. Do you say that the matters which would properly concern counsel in that situation would perhaps be almost peculiar to this particular case? Yes, Phillips said. In view of the prejudice, the conclusions that may be drawn by refusal to give evidence, the potential consequences to their clients of taking such a public course may have been irreparable. Barker, over 2¼ vigorous hours, argued that Galvin had acted lawfully and, because the Chamberlains could have taken early refuge in silence, their testimony was now admissible. In the event, Justice Muirhead did not disagree with that, but judges, in criminal trials, have a discretion to exclude admissible but unfair evidence. Of the Galvin inquest, he said, "As matters turned out, the general rules of evidence were substantially adhered to, save perhaps that counsel assisting the coroner and examining the accused did so forcibly and at times inquisitorially. But it was done according to law. At this time, the accused were the focus of national interest and national curiosity. Counsel involved in the inquest must well have known the extent of that interest. In looking to the future, the possibility of prejudice to their clients by a refusal to answer further questions about a largely unknown subject matter was a very real, albeit almost a novel consideration. What were the prospects of their clients receiving a fair trial by an unprejudiced jury in the Northern Territory, according to law?" That about sums it up, Kirkham thought. When the judge ruled the testimony out, Kirkham whispered to Phillips, "Well done." It was not only the triumph which made him feel good, it was something closer to retribution. He hadn't been able to think about the way that inquest was conducted without it causing him a fresh reddening of anger. 7. In the media room next door, news writers were unhappy with the amount of available copy. The legal argument was unreportable, not only because it was inexplicable in the column space or the airtime these journalists had to work with, but because Justice Muirhead had prohibited publication in case the jury came to hear about it that way, off duty. So the journalists could report only the evidence, and the way Professor Barker had ordered the witness list was making the reporting task difficult. As Dudley Doust, the American-born correspondent for the London Sunday Times, put it, the prosecution had reached the middle-order batsmen who were there to dig in and consolidate. Doust liked sporting terms because he was normally a cricket writer. He was referring now to those witnesses who might not do the prosecution much harm if they failed to score. Doust's metaphor was troublesome, as Malcolm Brown saw things, because it implied tail-enders to follow. This, on any view, was not the case. Brown, who had once hoped to pummel his way to a career in prize-fighting until a horrified promoter eased him out of it early, preferred the language of the ring. They were watching, Brown said, the preliminary bouts. He meant it didn't matter a great deal who won them. The defense was clearly not so troubled now by Dr. Harding's evidence that hairs found on the baby's bedding were cat, more probably than dingo, since he was even-handed enough to allow both possibilities and, anyway, Myra Fogarty had shown just how little care was taken to preserve anything passing through her untutored and vigorous hands. The gingery dentist, Kenneth Brown, whose nervousness in the witness box was betrayed by repetitious clenching of the eyes, conceded that some of the damage to Azaria's singlet might have been caused by the teeth of a dingo. In any event, it was he who had attributed, to some manner of blade, marks in the baby's blanket which were caused by moths, and the press at least found it hard to take the rest of his evidence to heart any more. The soil analyst, Torlock, who, in his slow campfire voice, likened the sand in the baby's clothes to sand he dug near the campsite, on the sand dune, and near the ranger's dwelling, didn't enhance the logic of the investigation. All those areas were searched so often for signs of digging that it seemed impossible the body had been interred there either by a dingo or by a grave-digging Chamberlain without discovery. Dr. Andrew Scott's identification of blood on bedding and garments suited the defense as much as it did the prosecution. The absence, during testing, of saliva on the damaged jumpsuit was nowhere near so forceful if the child had been wearing another outer garment or the clothing had been rained upon. As the evidence was coming through, some favoring the prosecution case and some the defense, it made for tricky reporting. Not uncommonly, a journalist will sit through 30,000 words during a day in court and must trim that down to 400. A précis exercise of that heroic magnitude requires the reporter to decide which way the story ought to be slanted. Many choose to weight it in favor of the party calling the witness, prosecution or defense. Hard decisions of this nature cause competing journalists to criticize each other roundly. One argument like this was settled in the media room with the words, "We're supposed to be reporting the prosecution case, right?" 8. Friday night. Brown had more than enough copy. Michael Chamberlain ill after bloodstain evidence. Michael Chamberlain was suddenly taken ill in the Northern Territory Supreme Court yesterday as a forensic expert gave evidence about bloodstains on the jumpsuit of his daughter Azaria. Near the close of yesterday's hearing, Dr. Andrew Scott, a forensic biologist from Adelaide, was describing patterns of blood. Dr. Scott said he believed the blood flowed heavily from the neck downwards and had soaked through the singlet. Mr. Ian Barker, QC, for the Crown, then asked what blood related to a hole in the left sleeve of the jumpsuit, and Dr. Scott indicated a stain. Suddenly, Mr. John Phillips, QC, for the Chamberlains, rose and said, "Mr. Chamberlain is not feeling well." Mr. Chamberlain, who had sat for 2 weeks revealing little emotion, slumped forward in his seat, bending over his knees. Justice Muirhead adjourned the hearing until Monday. Mrs. Chamberlain rose from her seat and stood by her husband as 2 correctional services officers approached. They then left with the officers through a side door of the court. Earlier, Detective Sergeant Barry Cox gave evidence of tests he had conducted with scissors on a baby's jumpsuit. Sergeant Cox said that if he cut the jumpsuit in a particular way, using curved scissors similar to the pair found in the Chamberlain car, he could obtain the same incisions as appeared on Azaria's jumpsuit. He had tried to reproduce the incisions using a scalpel and a razor blade, but had been unable to obtain the same result. Sergeant Cox said he considered scissors the most probable implement to have made the incisions. He also found that, cutting a jumpsuit, he could produce tufts and loops of material similar to those found in the Chamberlain car and in Michael Chamberlain's camera case. Brown phoned it through to Sydney, leaning back then on his bed, holding a tumbler of whiskey. Fashioning the piece had taken him 3 laborious hours. It was not the writing, for he was a fast writer, but the choice of material which took the time. The space to which he was restricted had never seemed so tight. There was plenty of rich incident in Philip's cross-examination of Cox, for example, which, if the piece were longer, produced an entirely different result for the reader. Philip's first question was, "Sergeant Cox, do you consider yourself an accurate person in your duties, including the giving of evidence?" "Yes," Cox said, adding by way of credentials, "I would have to be to perform the type of work that I perform." "Do you consider you have a proper, scientific approach to your duties?" Cox agreed without hesitation. It was the sergeant's opinion that fibers through the collar and sleeve of the baby's jumpsuit were severed by cuts rather than by tearing. "These were all consistent with having been cut," he said confidently, and it was to the word all that Phillips now directed him. "Is the sentence you included in your statement for the first inquest correct? I examined the fibers under a microscope and observed that the majority were cut, not frayed or torn?" "Yes," Cox said. Explaining the shortfall between majority and totality, he offered, "The cut in the collar, the fibers that I could examine, had straight cut edges. That was my opinion back in 1980, and again today." "Are you saying now you could not examine all the fibers in the collar?" "Some of the fibers have withdrawn back in," Cox said, meaning back into the weave. "The fibers that I could examine were distinctly cut." "Are you saying now you could not examine all the fibers in the collar?" Phillips repeated, pursuing the point because withdrawal of fiber into the weave is also a characteristic of tearing. "Yes or no?" That is correct. Do you not think you should have made that clear to the jury? Cox thought about it. Possibly, yes, on reflection, he said. With people on trial for murder, Phillips said, not requiring an answer, his voice tight, angry. Is there anything you would like to tell us, in the interest of fairness, about these loops you found in the camera bag, Mr. Cox? Philip was talking about tufts of cut cotton which, in the sergeant's view, came from a baby's jumpsuit. Anything you would like to add to your evidence? No, Cox shrugged. Nothing that strikes you as important? Cox couldn't think of anything. Did they have any indication of blood on them? Phillips said, helping him out. No. What about the loops that came from the car? Would you like to add anything to your evidence about those? The line of questioning did nothing, evidently, to give Cox the clue he needed. No. Any indication of blood on them? No. Did you test them? No. Surprised by this answer, Phillips reached for a volume of transcript. You were asked about the loops from the vacuuming at the second inquest, were you not? This jogged the sergeant's memory enough to have him recall examining all the loops from the camera bag and the car for any vestige of blood, and finding none. He remembered testifying at the inquest that he'd found nothing which gave the reaction to blood. It was this phrase, reaction to blood, which interested Phillips. All attempts to prove the presence of blood inside the camera case had failed, but the prosecution still insisted it had once held the dead infant or its cerements. The loops which were found in there were important, particularly if they were unstained, bloodless. So he asked again, Did you test them for blood? No, I'm not an expert in testing for blood. How were you able to give that evidence? Phillips was referring to the evocative term reaction again now. Under a microscope you can see the appearance of blood, and I did not see any trace of any blood. Therefore I gave the reply, I could not see any blood on any of the loops and fibres, or threads or tufts, that I'd removed from the car or the bag. Phillips brought his hand down hard on the table. That is not what you swore at the inquest at all, Mr. Cox. What you swore was, and he opened the volume again, nothing that gave the reaction to blood. And then, they didn't give a reaction, that is the point. That is what you swore. The sergeant played with his necktie, as he had done throughout, while he was thinking. He tucked the fall behind his belt buckle. Then what I said at the inquest, if that is how it was recorded, is inaccurate, he said. It is not the first time you have given inaccurate evidence in your career, is it, Mr. Cox? Phillips said softly. I don't consider that I've ever given what I'd call inaccurate. Do you remember a case of Van Beelen? Sergeant Cox remembered that case, as did several of the reporters in the gallery. Van Beelen was tried in Adelaide for the seaside murder of a schoolgirl in 1971. Cox was on the scientific investigation team. He was then specializing in the identification of hair. Strands identified by Sergeant Cox as characteristic of Van Beelen's hair connected Van Beelen with the slaying. Cox had committed enough mistakes in the course of his scientific labors that the state's Chief Justice, sitting on appeal, bothered only to list a few and then referred to them as these and other errors. The case was sent back for retrial. Now Phillips wanted the jury to know about it in detail. You gave sworn evidence, didn't you, of the thickness of some hairs? Cox conceded he had. And you gave 3 times the correct thickness in your sworn evidence. I gave evidence 3 times of an incorrect measurement. While this was an admirable deflection of the attack, it wasn't the truth. You didn't give evidence 3 times, Phillips said with increasing volume. I suggest you gave evidence of 3 times the correct measurement, triple what it should have been. The sergeant confessed it was so. In that case, did you produce slides and photographs? Yes. Your evidence was wrong, was it not? There was evidence that some of the photographs had been mixed up and were in the wrong place, yes. Phillips repeated the question slowly, as if instructing a child. Was your evidence wrong? Yes. Did you also swear in that case that a sample of hair came from a red and black jumper when in fact it came from the accused's head? Cox could not remember that one. In the same case, did you swear that a particular exhibit contained a number of slides of dog hair? Yes. In fact, it contained a combination of dog hair and human hair. Cox scratched at his head, but the association did nothing for his memory. He could not recall confusing the hair of a dog with human hair. Phillips let the topic go. He'd done enough damage. "I want to ask you about this vegetation material you said you saw," Phillips said, referring fragments of leaf which Cox and the botanist Kuschel had picked from the baby's clothing. "You swore it was of a broadleaf plant?" "Yes." "Embedded in the fiber?" "Yes." "You talked about a lot of other material," Phillips said, lingering on the phrase, emphasizing quantity. "Green, broadleaf material." He turned to Barker. "I call for that material to be produced." "It is produced," Barker said, as a clerk laid 3 vials on the table. This was the first time the prosecution had produced them. Phillips held them aloft. Here was the debris which had convinced Cox and Kuschel that someone had deliberately and forcefully rubbed the clothing in Parieteria debilis to counterfeit dragging and rough usage. "This is how much was involved?" "Yes," said Cox. The quantity in any of the vials wouldn't have covered a fingernail. Barker took the point fast. "Your Honor, I would like to say of these exhibits that my attention was drawn to them, and I intended to produce them. I showed them to Mr. Phillips." "I accept that Mr. Barker had not seen them when this witness was giving evidence," Phillips said pleasantly, and went on passing the vials up to the jury. Brown could fit none of these exchanges into his copy. He knew that not one of the other dailies would run them either. The readers of newspapers had nothing on which to judge the reliability of the testimony they were reading about. They could only assume that evidence like Cox's went through unscathed. This raised questions of newspaper philosophy which Brown didn't enjoy mulling over. And here was another curious thing. Outside the adjourned courtroom, he could find no other journalist who thought Phillips had diminished Cox in any way. Brown had shaken his head and walked away. The telephone rang, and he rolled over on the bed to reach it. The call was from his wife Inga in Sydney. "How's it going?" she asked. "I don't know," he said. "I can't judge things like that anymore." 9. Chaikin, the professor, was a great performer. He walked to a table near the witness stand on busy and resolute feet, so not to lose anyone's attention for a moment. It was time for him to demonstrate to the jury what happens when fabric is cut with scissors. An orderly handed him a square of black cloth. He already held a spare jumpsuit in hand. Scissors were somewhere in his pocket. He wanted to show now that a Bond's jumpsuit cut by these scissors would dislodge tiny loops of toweling like those found in the Chamberlain car and in the camera case. He smoothed the cloth over a board on the table. It was a satin square, a profound blackness, like the boards conjurers use to show off their glittering tricks to best advantage. He shot back the cuffs of his shirt as if to show nothing was hidden there. He held up the garment, turning it this way and that. It was entire. He produced the scissors. Professor Chaikin had been away from the United States a long time, but his voice still belonged to New York, and now it seemed that he might be just as happy busking a routine like this on a sidewalk somewhere off Broadway, alert to any sign of the cop on the beat. "If you take this fabric and cut it," he said, and the scissors flashed, "some fall off, and that is—" He shook the garment once, twice. "There!" Tufts fell like stardust. The laughter which followed was confined to the media room, where the journalists were watching the show on video. Chaikin flourished a hand, triumphant, and the audience here broke into applause. They were as delighted as he was. "The great Chaikin," said someone. Sergeant Cox, who was following the evidence from a seat here rather than in the courtroom, thumped his thigh with a fist. "There's no one like him," he said, grinning. "Just no one." 10. The professor held the chair of textile technology at the University of New South Wales. He was a small, talkative man with troublesome, wavy hair and such enthusiasm for work that, as was often said around the textile school, anyone else would tire of a problem long before he did. In October 1981, 2 policemen called to see him. They were Sergeant Cox and Constable Metcalf. They brought with them Azaria Chamberlain's clothing, damaged and bloodied, a stained towel, and a small blanket. The visit was no surprise. Chaikin was often consulted by police investigators in celebrated cases. Cox spread the infant's jumpsuit and the singlet over a bench. "The central question is," Cox said, "whether these holes are cuts or tears and how they were produced." 2 ancillary issues, how the slim incisions in the blanket were caused and what sort of action had stained the towel, were quickly resolved. The eye of a microscope found, in the fiber of the blanket, the same larval casings which Dr. Andrew Scott had discovered some time ago. "These are not cuts," the professor said. "Insects cause that." On the towel, most of the bloodstain capped only the elevations of the pile, and very little ran deeper in the weave. Something had been wiped on the cloth, but the professor could not determine what it was. Sergeant Cox was interested, for some reason, to know if it might have been the blade of a knife. "Sure," the professor said. "I don't see anything inconsistent with that anyway." He ordered a supply of Bond's jumpsuits and singlets and, when they arrived, got down to the business of identifying the characteristics of damage. He was familiar with the weave from which the jumpsuit was fashioned. Shopkeepers called it toweling. Nylon yarn formed the base, and cotton the loops. It was the cotton loop, fed loosely into the loom during manufacture, which made up the pile. Cotton is not as elastic a thread as is nylon, and here was the first problem. The commonest distinction between a cut and a tear is this: a cut severs the threads, leaving the ends in position. A tear pulls the ends out of alignment. But here, the nylon was both elastic and under tension, while the cotton was inert and loose. The nylon might withdraw, however precisely the cloth was cut. So the professor took to the weave with scissors and, under a microscope, watched the nylon thread migrate through the weave. He took the problem to the next level of magnification. Since the disparity between threads caused a reaction all its own, it seemed to follow that he should choose a plane at which he could compare nylon with nylon or cotton with cotton. A single thread is made up of fibers much the way a rope is. If he magnified a nylon thread, say, enough that he could see each component fiber, he should be able to judge the precision of alignment and distinguish a cut from a tear that way. The magnifications of which he was thinking were in the order of 1,000 or so, beyond the range of optical microscopes and well into the realm of the electron. He teased, from the damaged shoulder of the Chamberlain jumpsuit, the fibers he wished to examine and mounted them on a stub. His laboratories were well furnished with imported transmission microscopes, which shower the examined substance with electrons and display the picture on television screens, but they have trouble seeing materials which absorb moisture unless the materials are plated with gold and held in a vacuum. Coating these fibers would deform the ends he needed to look at. So he chose for this job an instrument developed here in his department, a scanning microscope, which used a backscatter of electrons to get around the moisture problem. The picture Chaikin had on his screen looked like a jungle. He searched through the turmoil of fibers horizontally, vertically. Altering the focus gave the pleasing illusion of strolling forward. Some of these fibers were aligned, some not. There was nothing conclusive here. It was not until he replaced the fibers from the shoulder with a stub taken from the collar that he found what he was looking for. The fibers were, as he recorded in his notes, pretty much in a plane. More important, here was a single fiber on which the end was clean, abrupt. To his mind this was a classic nylon cut, and his bet was scissors. He photographed the picture on the screen before he touched the controls. Such was the confusion in this minute territory that he might never find the locality again. The cotton singlet gave him trouble. The weave was ribbed, good for stretching around a fattening infant, but difficult to pierce with an implement, however sharp. The weave gave, unless the cloth was under quite considerable tension. A dingo's tooth, which he mounted on a mechanical arm, pecked away like a weary ibis, but had no success at all. He filled the singlet with the carcass of a freshly skinned rabbit. The skin ruptured under the tooth, but he could find no damage to the singlet. He stretched the fabric more tightly over the flesh, and only then did the tooth penetrate the pliant and hardy weave. Later in October, the detectives delivered another problem, together with several bottles containing cotton tufts, to the professor's laboratory. 25 tufts were, as his instructions ran, found in the Chamberlain car. 3 others were taken from Michael Chamberlain's camera case. He was asked if he could match any to the baby's jumpsuit. Under the optical microscope, they looked like fragments of cotton yarn. He snipped through a section of jumpsuit cloth and was rewarded with enough cotton tufts to convince him that he was on the right track. The tufts the detectives had sent him seemed, at 30 magnifications, to approximate the right size and shape, but he needed a tighter grid of comparison. He decided on 3 tests: fiber diameter, number of fibers in each thread, and evidence of twist. 3 tufts from the camera case plainly qualified. Of those from the car, he was satisfied that 5 could have come from the Chamberlain garment. Among the 20 rejects, some were partly synthetic, a possibility he had not thought likely earlier. These must have come from another material altogether. Following the line of reasoning through, it occurred to the professor that he might find severed tufts at the sites of damage on the baby's suit, imprisoned by the weave. He picked over the threads with a pair of tweezers. They were here all right. His work had shown another complication. New garments shed tufts of cotton, mostly from the seams, in the ordinary course of handling. It was a normal product of manufacture. How sinister, then, was their appearance throughout the car, or in a camera case? The arrival of a further 25 tufts from the Darwin Police Department seemed to highlight the point. He could classify only one of these as the sort of fragment he might expect from a Bond's jumpsuit. There was certainly a lot of tufts around, an uneasy excess of fortune. On 5 January, the biologist Joy Kuhl had arrived at the laboratory. She brought with her Michael Chamberlain's camera case. The professor led the way to a bench and set down the bag under an adjustable lamp. He laid back the lid. The interior was divided into compartments. He pushed back the walls, letting the light fall in. There was no debris here, but this was no surprise because the bag was vacuumed elsewhere, perhaps more than once. The professor was looking for hair. He could see fibers which clung to the surfaces of each compartment and lifted off with forceps as many as he could find. More came away when he patted the sides with strips of stationer's adhesive tape. He discarded those strands which were, even to the unassisted eye, vegetable. The remainder he took to the scanning microscope. The picture on the screen panned over crimped wool, more vegetable fibers, and hair. Hair viewed this way looked curiously metallic, like poles armored with plate. There was a good deal of hair from the bag, but he couldn't see what helpful inference could be drawn from this. Judging by length and diameter, half the hairs were adult. He found 6 he thought infantile. 3 he had taken from the middle compartment in the bag, the others from smaller pockets in there. They were smooth-scaled and slim, around a centimeter long, and the tapers showed they had never been cut. And there was another reliable distinction. The hair from an infant is cellular all the way through. It lacks the medullar, the hollowness, of adult hair. 2 others showed signs of much washing. He pointed them out to Joy Kuhl, jabbing a finger at the screen, where the edges of the scales, here and here, were jagged and agape, characteristics which set them apart from their fellows. He discarded them. Mrs. Kuhl suspected the bag was washed inside and out, but this seemed to him unlikely. The other fibers there showed no mark of it at all. The final assessment, color, was back in the demesne of the optical. 4 strands he described as a light straw yellow, one light yellow-brown, another mid to dark brown. The real question was, had he detected enough similarities to link all 6 with the same infant? Sturgis, leading the professor through his evidence now, put the question this way. Do you get variations in color when looking at hair from the one individual? That can happen, but in respect to that question, Chaikin said, frowning, I would not be able to say that all this hair came from the same head. 11. All roads lead to Chaikin, Tipple had said, explaining his failure to find anyone else so well qualified. So Phillips knew that whatever the defense needed to fortify its case, he must get from this witness now. "Professor, if I could ask you about your examination of the camera bag first, please." "Certainly. We propose to call evidence that the bag was not a new bag in the hands of the Chamberlains. It had been previously owned by another family. When the Chamberlains had it, it was not used exclusively as a camera bag, but was used for family excursions and so forth, putting clothing and that sort of thing in it. In those circumstances, do you find it at all surprising that you found baby hair in the bag?" "Well, I'd rather not comment on that. All I know is that there was baby hair in the bag. I wouldn't know how it got there." "Could you indicate just how many hairs a baby might lose in a day?" The professor consulted his notes. "On the average baby, there are 50 or 60,000. Babies start shedding at different times, so one cannot come to any definite conclusions. But when they start falling out, they fall out in large numbers. It can be measured in hundreds of fibers a day. Even at 100 a day, according to my indifferent mathematics, this baby would have had the potential to lose 7,000 in its short life, in 9.5 weeks. On the average, it could be calculated that way." "Professor, reference has been made to the apparently washed appearance of some of the fibers. Does that relate, in any way, to the possible washing of the bag?" Chaikin shook his head. "I wouldn't have thought so. Can I now ask you to turn your mind to the napkin? You said this: 'As far as the nappy is concerned, there were several indents and one tear when I saw it, and the material is a soft plastic, and I simply came to the conclusion that any method which involved the pushing of a slightly pointed object into the plastic would have caused those, and that's all I could conclude.' Is that right, Professor?" "That is correct. You are certainly not prepared to exclude that damage as being possibly caused by a dingo's tooth or claws, are you?" "I could not, no." The judge took the point. "You could not exclude that?" "I could not," the professor repeated. "No. We are told that Professor Cameron from England will be giving evidence, and he will offer the view that if a dingo were to have taken hold of this child by the neck, with the jumpsuit collar up, so that the fabric of the collar is between the child's flesh and the dingo's tooth, that would involve the infliction of damage onto the collar." Phillips paused, allowing Chaikin time to assemble the image in his mind. "Do you follow that proposition, Professor?" Testily, the professor said, "I follow it." "Your experiments would very strongly run against that proposition, wouldn't they?" Phillips had in mind Chaikin's work with dingo teeth, rabbit flesh, and cloth. "My experiments would tend to indicate that the proposition would not necessarily follow." Phillips said, "In fact, your experiments show that not only could a tooth press against a child's flesh, but penetrate it for some distance and still not cause damage to the jumpsuit or the singlet. Obviously, when it was being held, there would be an indentation, but subsequently that fabric would recover." "Exactly. Mr. Sturgis made the point, with your electron microscopy, that you did not examine every fiber end. You agreed with that?" The professor agreed again now. "On the other hand, what you did, Professor, was to zero in on any end which looked like a cut, did you not?" "We scanned the cut, and wherever it looked as if we could take a reasonable picture of either a bunch of fibers coming together or of an individual fiber that looked like it had a sharp end, we looked at those, yes." "You picked the best of the crop." "I wouldn't put it that way. I picked those where we could get a photograph which I believed exhibited the state of the yarns and the fibers along the edge." "You ended up with one," Phillips said slowly, "which had a classic appearance of being cut." "That is correct," Chaikin said bluntly, disdaining evasion. "Professor, you voiced a conclusion that for the holes you observed in the singlet to have been made, there would have had to have been some tension in the garment, is that right?" "Yes. If the garment was held and there was a continuous pushing into the fabric, this would then create the tension. Alternatively, you could hold it apart, and then there would be less extension required for you to get to the breaking point. Or an animal could create the tension by holding part of the garment with its paw or paws, for example, and the other part with its teeth. I wouldn't exclude that. If a child wore a new suit without it being washed, the potential is there for tufts to fall from it, is it not?" "Correct." "How many loops would be produced from a new suit, Professor? Quite a few?" In manufacturing a new jumpsuit, some loops would fall off, some would be loosely held, and some would be tightly held. On the average, for every inch of cut, about 15 loops would fall off, 10 or 15. Is it fair comment to say that a new suit would probably have quite a few cut loops, as distinct from one or two? Oh, yes. As Phillips judged things, there now remained only one item on which the professor's evidence was inarguably damaging to the defense: the single, classic nylon cut of a fiber at the collar of the baby's jumpsuit. In stating the opinion that you have, that it was not a dingo's tooth that produced the damage, you do that without ever seeing a live dingo bite anything, don't you? That's correct. Without ever having examined the clothing of a person who has been bitten by a dingo. I have, as I said, carried out experiments with dingo teeth on this particular fabric. Will you please answer my question? You state that opinion without ever having examined the clothing of a person who has been bitten by a dingo? That's correct. We propose to call evidence that a dingo is capable of biting through metal like a chain. I certainly wouldn't dispute that, the professor said, because I have never experimented with dingoes biting through metal. But may I say this, that has absolutely no relevance to whether a dingo could bite through these nylon fibers. Phillips didn't press the argument. At best it was a jury point, as lawyers say. The hope is that juries prefer the practical to the theoretical when the time for decision comes. Phillips sat down. He'd done better overall than he'd thought he might. He couldn't expect his luck to hold forever. 12. Every news writer is afflicted with the need for brevity, and the trick for a radio reporter is writing something not much longer than a telegram, retouching it on air with the colors of the voice. Exaggerate the inflections more, Murray Nicholl said. So much that you'd be ashamed to hear yourself talk like that anywhere else. He was instructing Tracy Bowden, his partner. Bowden was suffering an unusual lapse of confidence. She was a good voice reporter, a fact everyone knew, it seemed, but herself. Her delivery was at the one time serious and melodious, which precisely reflected the sort of woman she was. Just keep going over the top, Nicholl said. They worked for the Macquarie Network, Bowden for Sydney, Nicholl for Adelaide. The normal run of bulletins called for reports and updates during the day, each around 30 seconds broadcast time. These they covered separately, using the telephone link between the media room and their home state studios. The evening bulletins allowed time for much longer reviews. Bowden and Nicholl made them together, alternating voices. They called them duets. The performance required lower background noise than the busy media room allowed, so Nicholl converted one side of his bedroom at the Darwin Hotel into a studio. By 6 o'clock any evening, the array on the vanity bench comprised a tray of electrical cables, switches, and relays, a stack of shorthand notebooks, a typewriter, a completed script of about 350 words, a partly consumed 6-pack of beer, 2 microphones, a tape recorder, and an amplifier. A cable from the amplifier was taped with adhesive strip along the wall, left the room through the gills of the air conditioner, leapt to the crown of a palm tree, skirted the swimming pool by way of a tall lattice, and made the footpath outside where it disappeared into a plug. From here the signal journeyed more legitimately to capital cities on the eastern and southern seaboards under an arrangement between the Telecom Authority and the Macquarie Network, which Nicholl didn't have to worry about. Into a microphone, Nicholl said, "Murray Nicholl here. Anyone alive out there?" The first voice through the speaker said, "Sydney here." "In Melbourne, Murray." After a pause, Nicholl said, "4BH is tied up with the games, huh?" The city of Brisbane was then hosting the Commonwealth Games Carnival. There was no answer. "Adelaide?" he asked. "Bugger it, Adelaide?" 5DN Adelaide was Nicholl's home station. "We're here," Adelaide said. "Don't get your beard in a knot." This cheap shot was accurate enough. Nicholl's slaty beard had a hard time of it whenever he was agitated. "Brisbane here. We need 30 seconds. Give you 30, Nicholl agreed. Brisbane didn't need that long. "BH is rolling now." Other studios said they were rolling too, meaning that from here on, Nickel and Bowden were on tape there. "Roger stations, here is your intro." This was to be the introduction used by the studio news broadcaster as a lead-in. "In the Darwin Supreme Court today, Sydney textile and forensic scientist Professor Malcolm Chaikin gave evidence in the Chamberlain murder trial." He allowed a few seconds blank space. "Okay, here we go. 5, 4, 3, 2, 1. The professor, head of the Textile Sciences Department at the University of New South Wales, said he had examined the clothing worn by the abducted baby under a high-powered electron microscope. In his opinion, damage to the material could not have been caused by a dingo. The professor believed the fabric was cut with an instrument, most probably by sharp scissors. Tracy Bowden came in on cue. "The courthouse—" Sorry, coming again. Take 2 from scissors. 3, 2, 1. The courtroom was in near darkness during what was virtually a lecture illustrated with projected slides showing the cotton and nylon weave from which the clothing was made. He showed the jury a photograph of the one fiber which he described as a classic nylon cut. This time the performance ran the full script. By the end, Nickel's stopwatch showed 2 minutes 50. "This is Murray Nickel." "And Tracy Bowden." "From Macquarie National News, Darwin." "Okay, playmates, that's it." 4BH, got it. Melbourne said, "Thanks," and Sydney said, "Good night." 5D and Adelaide stayed on. "Murray, it seems from this far away that the prosecution is pushing it uphill. One cut fiber, you know. Can they hang her on that?" Nickel thought for a moment. "They might," he said. "We've got the blood to come." The plain fact was that nobody wanted a fizzer. 13. The lunchroom in the Darwin Hotel was rigged out in the style of the South Seas. Bamboo tables, green foliage. Lazy punkahs stirred the air. The reporters had joined 2 tables together to make room for Charlwood, Metcalf, and Professor Chaikin. The professor was still excited enough to recount anecdotes from his day in court. "Phillips said dingoes could bite through chain. I pointed out that you could break a chain with a hammer but not necessarily damage a singlet." Someone yawned. Chaikin was old news already. Charlwood evidently caught the drift. "We still have aces up the sleeve," he said. The prosecution played a new card that day in the form of Rowan Tew, whose name did not appear on the witness list. Rowan Tew's job was the fitting of audio equipment to automobiles. On 7 November 1980, while he was working at Floyd Hart's Highway Sound Center at Mount Isa, Pastor Chamberlain delivered a car there, a yellow hatchback. Tew did not see the pastor, but he saw the docket, which called for the fitting of a stereo deck. Everyone knew who the Chamberlains were. The proprietor, Mr. Hart himself, carried out much of the installation, then told Tew to finish it. The job took 3 hours. Tew began cleaning up. It was then he noticed dark stains on the center console. It looked like blood. Now, Rowan Tew had a peculiarity. There was very little feeling in his right arm since an occasion on which he had cut it. He was then going through a plate glass window. Thereafter, he could injure himself quite badly without noticing. Looking around the pastor's car now, he saw another stain on the driver's door, near the new speaker. His first thought was that he had cut himself working. He checked his arm over, but it was not he who had bled. His story gave the reporters something new to write about, but no one in the press room could find much point in it. The real question in this trial was not whether there was blood in the car, but whose it was. Malcolm Brown could only guess that the prosecution had thrown Tew in for the same reason a boxer feints with a left, just to keep the other fellow a little off balance. 14. Then Phillips found out someone had broken into the Chamberlain car before the trial while it was in the police compound. Metcalf was the witness. He testified to his discovery of the blood stain on the ceiling of the passenger footwell. This stain was, by now, famous enough that everyone called it the arterial spray, and on it hung the suggestion that the baby was held down there and slaughtered. When he found it, Metcalf said, it was still sticky to the touch, a recollection which tested the credulity of the defense team because the blood was then more than a year old. But there was some sort of pattern under there, right enough. Metcalf produced the steel plate, which had been excised from the car, and passed it up to the jury. This was the one stain which, if it was blood, could not be accounted for by either the bleeding hitchhiker or the transfer of blood from bedding in the tent the night the baby disappeared. Phillips was not prepared to concede that the stain was blood, but he was determined to show that there might be more than one way it could have got there. In cross-examination, he reminded Metcalf of an extraordinary event. 4 months back, the law department officer Mick O'Loughlin went to the Alice Springs police compound to take some material from the car. With him were a solicitor from the defense, the pathologist Tony Jones, and 3 police, including Metcalf. Inside the car they discovered part of a plastic syringe. It was of a size used by veterinarians. The instrument was lying on the floor. Metcalf said it was not there when the car was last inspected. Since the time of his last visit, the cage around the car was locked, and only O'Loughlin had the keys. Because Phillips was so clearly keen to show that the arterial spray might be accounted for by a syringe or something like it, the prosecution put O'Loughlin in the witness box to explain what had happened. Then the story came out. The mystified O'Loughlin had returned to the police depot next day to look around for signs of entry. He saw ragged cobwebs hanging from the roof. Someone had climbed in, over the top of the cage. Under the car, the dust was scuffed. Someone had crawled underneath, heading for a gap in the cabin floor where the gearbox once was. That gap would admit the passage of an arm up to the shoulder. No one could explain the happening further. Phillips decided against pushing the issue any harder, but it remained a disquieting phantom, eerie and inexplicable, like a shadowy face at a window pane. 15. The Seventh-day Adventist pastor for the Darwin congregation was an ex-cop. Malcolm Brown sometimes saw him walking home after court. He was Graham Olson, a burly but still athletic man in his middle 40s, a long strider. Pastor Olson lived in the manse beside the church, and the Chamberlains were billeted in quarters behind. Brown's motel was at the same end of town. Meeting the pastor, en route, was easy. It was Olson's job to shield the Chamberlains from the sightseers who often loitered on the footpath outside the house, and from the press. When the telephone rang, it was Olson who took the call. If the door chimed, he answered it first. But the more he talked to Brown, the clearer it was that he didn't much like the Chamberlains. It seemed to come down to the way they spoke. They thought Sergeant Cox a fool, and said so, and they spoke of the police force as if it were some agency of devilment. Olson had known Barry Cox a long time, and had once worked with Police Commissioner Macaulay. He didn't like to hear the police spoken of that way. Brown wondered how long it might be before Olson gave him some useful information. In the event, it took about a week. Olson told him the date on which Lindy Chamberlain expected the birth of the coming baby. If the pregnancy ran full course, delivery was just 5 weeks off. The information gave Brown a clear break. As gossip currently ran, there was any number of willing contacts at the Darwin Hospital ready to call some reporter or other the minute Lindy Chamberlain entered the maternity ward. Brown wasn't worried. The arrangement he now had with Olson was more reliable and closer to the action than anyone else could hope for. The code, "The bird has flown," would mean that Lindy was on her way. The message Brown most hoped for was, "The bird is fluttering." Brown broke the news of the expected date in a story which the Sydney Morning Herald headed, "November 11 is the day for Lindy's baby." There was no point to a heading like that, unless everyone already knew they were reading about the most infamous mother in national history. It was the sort of story which confronts the reporter with the cruelties of the trade. Next day, before the session began, Brown watched Lindy walk into court. She was carrying a pillow. She caught his gaze and shook her head sorrowfully. Then she smiled. Brown took this exchange to mean that she understood a fellow had to make a living somehow. The molecular structure of truth. 1. The courtroom floor was now cluttered with the merchandise of testimony. When Joy Kuhl was called into court as the 35th witness, she picked her path between stacks of photographs, maps, plastic containers, automobile parts, floral mattresses, blankets, hats, baby wear, camping equipment, and clothing. Everything was labeled like the possessions of a family about to be sold up for enough to cover a judgment debt. Constable Metcalf set up a silver screen against the wall. A projector already lay on the table. Kuhl sat, not in the witness box, but alongside the screen, wand in hand. She smiled at Metcalf, smiled at the jury. She smoothed her skirt. She was ready to deliver, with Sturgis as prompter, a home course in the identification of blood. Sitting behind Phillips and Kirkham now was a man whom Phillips had identified to the judge as Barry Betcher, a professor of biology. Betcher was tall and stiff-limbed. His baldness was of the sort which seems to have been caused by an expansion of the temples rather than by loss of hair. While Kuhl gave the jury a glossary of the terms they should get used to, Professor Betcher found a notebook and set a briefcase over his lap to use as a writing bench. In the next recess, Metcalf joined the pressmen chatting in the corridor. None of them knew Betcher, and someone asked, "Who is the guy?" "An egghead," Metcalf shrugged. "No one we're worried about." 2. Betcher was the head of biological sciences at Newcastle University. Indeed, he had been the chairman there since the biology school opened 10 years ago. His doctorate was in genetics, and his special interest was blood. He spent much of his time researching the relationships between the components of blood and genes and pursuing problems of one sort or another in immunology. A good deal of his work had to do with the mechanisms by which immune reactions are inherited, the way those reactions work, and with the structures and identification of blood. He wrote papers in genetics and immunology at a great rate. He edited, or helped to edit, journals of biology in Australia, South Africa, and the U.S. He sat on 2 international committees which were concerned with immunology in reproduction. Because immunological reactions are important to researchers who want to distinguish proteins in blood, he produced antisera to specific proteins, enough of them that, if asked how many, his most accurate estimate lay somewhere between 20 and 50. He taught the practices of immunological testing and the principles which justified them. He taught scientific method, the principles which justify any conclusion. He supervised graduate students. He administered his department. If there was any time left over, he made for the campus pool. He often swam so many laps then that students wondered if the professor had simply forgotten to stop. He was not especially pleased when someone passed another chore his way, but it sometimes happened, and it happened again on an afternoon in March 1982, when a young man came to the laboratory and asked to see him privately. The young man was quiet and apologetic. He had graduated in science here 3 years before, as the professor recalled, and was a Seventh-day Adventist from the community at Kurenbong, which was not far south. When mention was made of the Chamberlains, the professor knew he was about to be asked to review the biological evidence. The documents arrived at the end of the month, and he took them home. There were about 20 pages of foolscap entitled General Worksheet, reports of the forensic biologist Joy Kuhl, on which she brought her conclusions together, and a transcript of the scientific testimony at the second inquest. The worksheets displayed sketches of some of the items she tested for blood: a small knife on which she had found no blood, scissors, a 10-cent coin, parts of automobile seats and doors, and a camera case. On some pages, she had sketched the immunological tests she carried out, showing the position of the wells holding the testing solutions, the antisera, and marking the bands of reaction against the blood she was testing. It was all plain enough. The tests she used were appropriate and well known. The blood she was testing reacted in some instances as fetal blood, in others simply as human blood, but it was all old blood, denatured, some of it cooked in an automobile by 13 months of Australian heat. It was bound to cause problems. The unsettling thing was that the problems it seemed to cause were not those he would have expected. He came back to the puzzle a week later. He had in mind now to turn the problem about. It had occurred to him that more was known about the dead child than that it was simply an infant. They knew which infant it was. He picked through the worksheets and the transcript again, making notes as he went. Azaria Chamberlain was 9.5 weeks old when she died. The blood of a normal infant that age should contain hemoglobin of around 30% fetal and 70% adult. Indeed, as he read in the inquest testimony, Dr. Andrew Scott had judged just those percentages in the blood on Azaria Chamberlain's own clothing. Here was, at the least, a reliable starting point. He went first to 2 tests which were not immunological, that is, they didn't rely on the blood sample's immune reaction to anything. They were molecular sieves, plates made from polyacrylamide gel, through which the hemoglobin is moved by an electric current. When the current is switched off, the hemoglobins have swum as far as they can, separated because the molecules of the adult component are different in size from the fetal, and the gel is graded so that just this happens. It is not a test designed to identify how much of each there is, but the strength of the bands gives a good indication. If the blood sample was Azaria Chamberlain's, Becher would expect the fetal band to be much less marked than the adult, about half strength. But here, Kuhl had found them equal. He turned to the immunological tests. Here, Kuhl had tested the blood samples for reactions against several antisera. She used anti-HBF, which is the anti-fetal component, and anti-HBA, the anti-adult. She had included an anti-species, for example anti-pig or anti-sheep, for use as controls to show that the test was working properly, for if there is a reaction against anti-pig or anti-sheep, the whole thing has somehow gone wrong, and the test is scrapped. Importantly, she had often added a known sample of cord blood drawn from the umbilical cord of a newborn and comprising around 80% fetal hemoglobin, 20% adult. He checked the results of tests which included a cord blood control. Cord blood contained nearly 3 times more fetal hemoglobin than did Azaria Chamberlain's blood. He would expect the reaction between the testing solution and cord blood to be around 3 times as strong as the reaction between the testing solution and any sample attributed to Azaria Chamberlain. But it was not. In 9 results out of 17, the strengths were the reverse. In 8, they were, just as inexplicably, equal. In no case were they the way he might have expected. There were other ways he could check it out. He looked at the manner in which the blood attributed to Azaria Chamberlain reacted against an anti-fetal testing solution and the way it reacted against a wide anti-hemoglobin solution. Only 30% of Azaria Chamberlain's hemoglobin was fetal, so only 30% of it would react against the anti-fetal solution, whereas all of it must react against the wider anti-hemoglobin. But there were incidents here, in the work notes, in which the vehemence of the reactions worked precisely the other way around. No, something was very wrong. Why had these results not alerted Mrs. Kuhl? He scanned again the transcript of her testimony. He found her saying this: "I was getting very strong reactions against the fetal hemoglobin and much weaker ones against the adult hemoglobin, which is very consistent with gradual changing of the blood from the fetal to the adult condition." So there it was. It seemed she anticipated, in the blood of a 9-weeks-old baby, more fetal hemoglobin than adult. She got the reactions she expected. Some results seemed, even on the evidence of her own tests, to show the presence of adult blood, not fetal. One of the samples taken from the floor well of the motor car reacted only against anti-adult antiserum. So did the zip clasp on one of the inner compartments of the camera case. Was there blood of more than one origin in the car and the bag? Or was none of it fetal? Since he had no sample of Azaria Chamberlain's blood to work with, he took adult blood, cord blood, and a mixture of both, and proceeded to run similar tests. He chose the mixture of cord and adult to simulate the blood of a baby of 9 weeks. He chose testing solutions of the brands Cool had used. He used the same dilutions for his samples. And things went wrong. First, he found that the dilutions Cool had used weren't appropriate. They were often too strong. There were just too many antibodies in there, warring. The fallen were everywhere. Often they hid the real regions of battle, of hard resistance, and the lines of precipitation weren't clear where they ought to be clear. He rediluted and tried again. The manner of test he was running called for a thin plate of gel into which he punched small wells to hold the testing solution and the blood samples apart until it was time to oppose them, each advancing towards the other, emboldened by an electric current. Now he found that reactions between the testing solution and the sample sometimes gave 2 bands of precipitation instead of 1, and elsewhere the lines formed between testing solution and the wells holding each of the samples had joined into 1 band involving all blood specimens. The testing solution which seemed to be giving him trouble was an anti-fetal antiserum. It was made in Germany. Its validity as a testing solution depended on the claim that it would cause a reaction with fetal hemoglobin and with nothing else. The term which describes this reliable narrow-mindedness is specificity. The testing solution, if it was specific, ought to cause a reaction with the fetal component in infant's blood and not with the adult. The reaction should occur, in the sort of test he was running, in 1 battle line of precipitation. It was showing 2. The testing solution was, for some reason, reacting with the fetal component and with something she hadn't identified. He wrote to the German manufacturers asking if they knew that this could happen. They replied with a tight letter directing him to the Australian agents, but added this: "The observed precipitation line of the unknown component is most likely due to denaturation." They had misunderstood him somewhat. He had not yet experimented with denatured blood. But the blood which Cool examined was denatured by age and heat, whether it came from Azaria Chamberlain or from Lenehan, the bleeding hitchhiker. He experimented with denatured blood. The older blood was, the less was it sensitive to the testing solution, but the fetal and the adult hemoglobins lost sensitivity at much the same rate. So denaturation alone could not be blamed for any change in the ratio of fetal to adult hemoglobin in old stains. The ratios Cool had found were wrong for Azaria Chamberlain, and they were as wrong for her denatured blood as they were for the fresh. It remained now to show that the testing solutions Cool used at the Sydney laboratories were identical with those he had faulted at Newcastle. By this he meant not only the same manufacturer, but the same batch, and he needed to know the code. He thought an inquiry of this nature ought to come from a solicitor, so Stuart Tipple wrote to Mrs. Cool asking the batch numbers for the testing solutions she had used in each test. The refusal came back in polite terms. They would have to make do without it. On the work so far, Betcher thought the ample irregularities in Cool's results invalidated them all entirely. Whatever batch of testing solution she used to identify fetal hemoglobin, there was sufficient detail in her own worksheets to show that the solution was not specific. It was enough. And there was another advantage yet to come. Cool had so far displayed only diagrams of the way her test plates reacted. No one in the defense team had seen the original plates. They ought to be somewhere around, color-stained and preserved. Phillips was determined to insist that she produce them at trial. 3. "Now, Mrs. Cool," Phillips said, pointing to a gel plate she had brought to court, "that is a demonstration electrophoretic plate." "Yes," she said. She had produced it as a teaching aid. It had nothing to do with the test she had run for this case. He had Kirkham hold up 2 photographs. She had used them as examples of testing technique in her testimony. Phillips asked, That is a demonstration photograph of a gradient gel, and of the other, a demonstration photograph of an Octolani plate? She agreed to both. What about the real thing? He went first to the plates. What about the actual electrophoretic plates that you ended up with at the end of your tests? Do you produce those? She shook her head. No. What about the actual Octolani plates that you ended up with at the end of your tests? Do you produce those? No. What about the actual gradient gel that you used in your tests? Do you produce that? No. What about the plate that you used for attempt at a haptoglobin grouping? Do you produce that? No. They are in Sydney, are they? No, she said. They were not in Sydney. They were not in Darwin. Where are they? They have been destroyed. The plates are destroyed. Yes. All of them? All of them. Whose decision was that? Who was to take responsibility for this? I don't see it as anyone's responsibility, she said. It is standard procedure in our laboratory. Did you take any photographs of them, or did you direct that any photographs be taken of this evidence before you destroyed it? No, we have not the facilities for that, she said abruptly, as if that ought to dispose of the matter. Her gaze followed the slow passage of Philip's hand, which was now reaching across the bar table. He picked up one of the items she had produced already. He let it dangle, aloft, from his fingers. There was hardly the need for a question. It was a photograph. To produce my visual aids, she said. Yes. Now, at the inquest, did you swear this? Human fetal hemoglobin is different from adult hemoglobin. While a baby or a fetus is in utero, it does not have any adult hemoglobin? Yes, I did. That was demonstrably false. I used that statement for the purpose of making things clear and simple. It was not a false statement. I'll say false in the sense of incorrect. It was incorrect scientifically, she said. It was used as an indication of the relative amounts. You are perfectly entitled to give any explanation which you have, Philip said, tugging irritably at his robe. But the fact is, scientifically, that statement is utterly incorrect. Scientifically, she said, it is not correct. Yes. She considered that the bloodstains found in the Chamberlain car were old enough to be from the dead baby, but not old enough to be from Linehan, who had bled in the car 14 months earlier. She conceded her experience with old stains was little. She conceded she had never worked with stains which had survived a summer. She conceded that the age of blood could not be determined accurately. But she stuck with her opinion nonetheless. Phillips knew he must find a way to shift her. Are you suggesting that we should, as it were, shut the door as it's September 1979? That would have been consistent with my opinion, yes. These stains could not date from August 1979. Do you swear that? It is an opinion, based purely on experience. I can't swear that. Do you swear they cannot date from July 1979? Once again, no. I can't swear that. Do you swear they cannot date from June 1979? No, she said curtly. They had come to the end of it now. The hitchhiker had bled on 17 June 1979. Because the testing plates were no more, Phillips had only Mrs. Cool's demonstration plates, photographs, and diagrams to work on. He had Tipple set up an overhead projector, and it threw the pictures up on the screen. An orderly darkened the court. Phillips stood by, pointing to this well and to that, wherever the bands of reaction were unexpected. He wanted to show there were often two bands where there should have been one. Here are two bands, Mrs. Cool, he said, pointing. A band and a smudge. The slide made way for another. There is a band and a faint impression of a second band? No, she said. I can see only one band. He sought out more. That is a band, is it not? It is not a band. It is an artifact in the staining procedure. Professor Betcher muttered and scribbled in his notebook. These were demonstration plates, and they were demonstrating something wonderfully important. The plain fact was, Cool's batch of anti-fetal testing solution had gone wrong here, too. She was a remarkable witness by any standards, Malcolm Brown thought. She was resilient and spirited. She let go no point that she could possibly retrieve. When she was pleased with an answer, she beamed at Metcalf, who stood in court throughout. In the hottest exchanges with Phillips, she made disparaging faces, and no one was in any doubt how silly she thought his questions were. For the most part, her eyes ignored him, and she answered directly and confederately to the jury. The press was having trouble turning the secrets of the bloodstream into anything like readable copy. The reporter sitting next to Brown whispered, "God knows how much of this the jury can understand." "It doesn't matter," Brown said. "It's not the point." Professor Betcher closed his notebook. He felt a flush of self-consciousness, of foolishness. He had been naive. He recognized now that he had been waiting for the point at which Cool would recognize her errors. He had expected her to recant. The pencil in his distracted fingers had somehow snapped, and he slipped the pieces into a pocket. He had awaited the messianic triumph of science. She had a parting shot for Phillips. Barker had returned the topic to the camera bag. "Did you form a view whether anything else had been done to it at some stage?" "Well, to me it looked like it had been through a washing machine, but I guess that's—" She trailed away a moment. "The vinyl was cracked, very flaky. It was in very poor condition." Angry at the mention of washing machine, Phillips was about to object, but Justice Muirhead got there first. "I think we've got far enough on the camera bag," the judge said. Phillips insisted the jury be told to disregard Cool's remark. Justice Muirhead agreed. There was no opposition from Barker. "I must say the washing machine was not something I had heard of before," he said, and sat down. 4. Joy Cool looked tired but happy. She wore sunglasses and sipped her drink. They were sitting in the garden bar under the wide umbrellas, a half-dozen reporters and 2 detectives. It seemed some current of nostalgia was rising in her. "I said it was an artifact of the staining process, and, in a way, it was true. But it was all Baxter's fault." Baxter was in charge at her laboratory. "Baxter had overcooked the plate. He left it in the drawer for an hour and a half. He forgot about it altogether, and it collapsed." She grinned. "But I wasn't going to tell them that." She turned her recollection to the jury's excursion to view the Chamberlain car. The court had convened in the police yard where the car lay dismantled, while she pointed to the location of bloodstains. "And all the time, she," here meaning Lindy Chamberlain, "was there behind me, staring. She just stares. She is, you know, a witch. I could feel her eyes burning holes through my back." Murray Nickel took this reference to be a joke, but the turn of conversation was unsettling. He raised his glass to her. "And happy birthday for yesterday," he said. "I didn't know." "And the jury," she said. "No, someone on the jury had a birthday too, and they wanted to sing Happy Birthday to Joy." She waved the glass. "When they found out it was mine." 5. Professor Betcher sat in court throughout Joy Cool's evidence. He sat through the testimony of the Sydney biologist Baxter and the Englishman Culliford. Baxter, Cool's supervisor, had inspected the test plates at the laboratory. He remembered agreeing with her opinions at the time, although he could now clearly recall no more than one of them. He was too self-confident a young man to let this worry him. When he was asked, "Is the experienced biologist likely to confuse a reaction from household bleach or heavy metals with a blood reaction?" he replied, "Not while I'm around," and his knuckles whitened as he gripped the rail. Culliford had not seen the test plates before they were destroyed, and, so far as Betcher could tell, Culliford seemed to be here at all only because he had developed one of the tests Cool had used, the crossover electrophoresis. Betcher wondered why a law department would bring a man halfway around the world to say that. The notes Betcher were making included, "With regard to the specificity of the antihemoglobin F antiserum that the FB, his cipher for Cool, forensic biologist, had used in the tests, it was agreed that, if the antiserum would react with something other than hemoglobin F, the conclusions reached by the FB from results of tests involving the antiserum would not be valid. This was agreed to by the FB and by the OE, Culliford, overseas expert." Really, this appeared to be the nub of the problem in accepting the interpretation that the reactions between test samples and antihemoglobin F antiserum could be accepted as being due to anti-gamma globulin chain antibodies rather than to the contaminant I had found, anti-alpha globin chain antibodies. He considered this plain language clear to the most casual reader. It meant, everyone agrees now that, unless the testing solution was specific to fetal hemoglobin, the tests were worthless. In the media room next door, journalists abandoned the video screens. Their task, making all this catchy and explicable, was hopeless. They needed another diversion until things got better. Jeff DeLuca had hit on an idea. He was running a sweep. Everyone crowded to one end of the room, waving banknotes. Tickets were $1 a time. DeLuca drew up a chart. Each line was marked with a date, like a calendar for October-November. The stake would go to the person who drew the day on which Lindy Chamberlain's baby was born. Winner take all. 6. Evening was the only feasible time for running in this climate. Brown saw Kirkham running the grass reserve between the high-rise hotels and the foreshore, so Brown ran there too. He fell in beside Kirkham. They ran a length, which was around 1 kilometer, and started back. Kirkham asked how Brown thought the defense was doing. "You're holding your own," Brown said between breaths, "but the blood evidence is not easy to follow just now." There was a breeze, northwest, off the Timor Sea. Seed pods high in the trees, slim and papery, whirred like locust wings. There were blacks below the cliff somewhere, singing. "Well, you ain't seen nothing yet," Kirkham said. His singlet hung heavy with sweat. "If we can show the anti-fetal serum will react with other things, we destroy the basis of the Crown case." He glanced sidelong at Brown. "And Malcolm," he said, "we can." Then he sprinted away, enlivened. 7. At a corner table, Dr. Tony Jones was dining with a visiting lawyer. They were talking about the trial. Jones was the government's pathologist in Darwin, a heavy man with a gruff beard and serious eyes. He was the first pathologist to examine the Chamberlain infant's clothing and was now the next scheduled witness. The lawyer asked Jones what he knew about the pathologist James Cameron. "Well," Jones said, as if he did not much enjoy the question, "you've got to understand that these chaps belong to a certain school of forensic science, the Spilsbury School. They're keen on what they call courtcraft. For them, the courtcraft is as important as the science." The lawyer said, "You don't like that?" "Let's just say that I think tactics are for lawyers, science is for scientists," Jones said. The evidence Jones was to give sometime tomorrow was not nearly so far-reaching as everyone expected of Cameron. As Jones judged the bloodstains, they might have come from a crushing injury to the baby's head or damage to the neck, and he could not exclude, with any certainty, the jaws of a dingo. He did not see a convincing handprint on the clothing as Cameron did. The arterial spray was Jones' own term for the stain over the footwell in the Chamberlain car, but he could not see that he could fairly push judgments like this into the realm of certainty either. "The scientists shouldn't become too adventurous," he said, "too competitive." His gaze was on a long table near the center of the room, where Charlwood and Metcalf were eating with the press people. "The trouble is, we're all so human." He shrugged, his eyes dark and uneasy. "I've never seen a case more governed by human frailties." 8. He thought Kirkham had finished with him. Then Kirkham asked, "Doctor, would you be kind enough to look at this?" An orderly carried to the witness stand an oblong metal plate. Jones took it. This was very like the plate Metcalf had cut from the footwell of the hatchback Torana, at least from the same sort of car. He turned it over. Here were droplets, dark and blebby, like those he had called the arterial spray. He nicked at one with his finger. It was dry and hard. "Can you observe an apparent spray pattern?" Kirkham asked. Jones did not bother to hide his surprise. "Yes," he said, "I can." "Does that spray pattern appear to you similar to the spray pattern you have described?" "It is a fine spray of similar character," he said carefully, He expected someone would tell him more about it now, but Kirkham sat down. Jones stood there, turning the stain one way and another, wondering what the hell it was. 9. No one in the defense team had any idea what it was either. Michael Chamberlain had, in March, checked around the locality looking for a Tirana, model LX SL, with a spray over the passenger footwell. It seemed a foolish and unlikely chase, but nobody had the heart to dissuade him. Then he found one. It was in Maitland, owned by a clergyman by the name of Roberts. The spray pattern was unmistakable. The supplier couldn't say what had caused it, although the best guess was some circumstance of manufacture. Chemical analysis was no use, since no one could say what the stain might look like afterwards, so Phillips and Kirkham decided it should go to the jury, unexplained, but entire. 10. Malcolm Brown's shorthand description of the London odontologist Bernard Sims was, "The proportions heavyweight wrestler, long retired." Sims, answering Barker's inquiry about how many dog attacks he had investigated, said, "Perhaps about 24 altogether. A number have been written up. One of them in which ultraviolet photography was used to elucidate dog marks on a man's arm 6 months after they occurred, and a case a couple of years ago in which a boy of 10 was savaged and killed by 4 Alsatians. And I think you have the unpleasant task," Barker said, "of examining the bodies of people who have died naturally but have subsequently been attacked by dogs. The family pets," Sims said. "If the person has died of a heart attack in the front room and no one knows they are there, the family pet has to survive, so it usually eats the owner." Brown added to his memorandum about Sims the words, "has lost all repugnance for the horrible." Sims passed a photograph, by way of an orderly, to the jury. It showed a punctured human arm. The wounds were clean and oval. That is typical of a dog bite, an Alsatian dog. "Under what circumstances," Barker asked, "would you expect a dog merely to close without tearing or twisting? It wouldn't be usual if the dog was going after its prey, going after food, because it would tear and twist. Probably only trained dogs would go in and grip." Barker handed up Azaria Chamberlain's garments. "Is there anything about the damage to that jumpsuit consistent with a dog attack?" "In my opinion, no. There are none of the typical hole and tear marks I would expect to find in the relationship of the 4 canine teeth." He held up the left sleeve. "To the arm, that is not the sort of shape one would expect to have from a dog bite. One would have at least 2 canines, or 4 canines, going in and causing a dragging, and it wouldn't be as regular an outline as that." "What about the collar?" "Again, that seems to be too linear. The family of the dogs wouldn't have sharp enough teeth to do that." He dismissed any possibility that a dingo might have taken the child by the neck. "The difficulty would be of a dingo being able to get into the neck alone without leaving any damage to the clothing. What sort of bleeding would you expect if the dingo had savaged the child's face?" "Copious," Sims said. "And there would be spurting. The facial artery comes out onto the side." He put a finger to his dumpling cheek. "Here. Can you imagine a situation where the dingo was able to fasten its teeth on the child's face and carry it off? It wouldn't be able to. The facial tissues would be ripped away." Frowning, Justice Muirhead asked why this was so. "The facial tissues aren't as tough as ours," Sims said. "The musculature of the child's face wouldn't be able to support the weight of the child. The features would come away." He held up the dingo skull. The jaws fell open. He took up a doll, which was dressed as a baby, and which he said was the size of a 3-month infant. "The dog I examined, which was larger than this, was only able to open its teeth 9 centimeters, between the points of the upper canine teeth and the lower." Plainly, the head of the doll would not fit into the jaws of the skull he now held. Kirkham took over. "Do you suggest the dingo is not capable of seizing the head of a child?" he said, pointing to the doll. "That size in its mouth?" "The entire head?" Sims asked, incredulous. "The entire head. I don't believe it is capable of it. The opening of the mouth wouldn't allow it to get that sort of purchase. If, for example, the head of a child with a circumference of 40 centimeters was placed in the jaws of a dingo, there would be a disarticulation of the jaws." Yes, the dingo articulation, the dog articulation, is a simple hinge joint. Using lay terms, Kirkham persisted, if a dingo seized the head of a child with a 40-centimeter circumference, the jaws would be dislocated? Yes. Kirkham handed him a photograph. It showed the Dingo Foundation president, Les Harris, holding a russet dingo by the collar. In the animal's mouth was the head of a doll, like the one Sims was holding. It was a sleeping doll. One eye was lazily closing. So much of the head, crown first, was accommodated by the jaws that the canine teeth reached very nearly to the doll's ears. Do you concede, having seen that photograph, that a dog could perfectly easily encompass the head of a child, Azaria Chamberlain size, with its jaws? If that— Sims paused, staring at the photograph. If that doll's head has not been forced into the dog's jaws, he said, hunching a shoulder, I would accept that. Kirkham sat down, grinning. It would do no harm if the jury saw just how pleased he was. He risked a glance their way. A bristle-headed young man at the end of the front row, who generally sat forward with his heavy arms on his knees, caught Kirkham's eye and winked. 11. The journalists were bored with eating at the hotels night after night. Murray Nickel gathered a group together, and they set off downtown. With him was the writer Frank Moorhouse and Lindsay Murdoch, who looked like a football coach but wrote for the Melbourne Age. Most of the others were photographers. They found Christo's, a crowded Greek place in a lane off the mall, which served spicy seafood and resined wine. They had agreed to embargo, in conversation, any mention of the trial. The pact lasted through the first 2 bottles of Retsina, but did not survive the third. The day's testimony had included Mrs. Elston, who was once the heir's rock nurse, Bobby Downs. The prosecution called her to prove that Michael Chamberlain had driven from the campsite to the Uluru Motel, insisting that his camera case ride on the floor under his knees. She said the case seemed tightly stuffed with something. She then demonstrated by jamming it with wadding. What I don't understand, said McNeil, a press photographer, is where was all the camera gear? If the bag was full of bleeding baby, someone would have seen the lenses and the other gear somewhere in the car. Murdoch chose the moment to voice doubts of his own. The real point is, she doesn't get blood on her clothes, he said. She gets out of the car clean. Nickel was troubled for altogether different reasons. He thought this sort of argument did not reflect the hidden indices of guilt or innocence. They inhabited the shadowlands of a police investigation. You had to be very close to the sleuthing to get anywhere near the real story. The fact is, he said, the police found, at the Chamberlain's house, a baby's coffin and the clothes Lindy used to dress the kid with. The dresses were black. No mother in the country would keep black clothes for a child. He waited for this to sink home. It's a devil's child. Who told you that? Murdoch asked, skeptical. A cop? Not a cop, a scientist, Nichols said. He tapped his temple, signifying serious consideration. A forensic scientist. No one pressed him further. If Nickel wanted to protect his sources, that was his affair. Moorhouse, the story writer, was taken with a quite separate aspect. A scientist peddling black magic stories, he said, refilling glasses. It has a nice congruence. When this conversation was later recounted to Malcolm Brown, he said he'd heard something about a black dress, but the coffin was a new one. Brown had no reason to disbelieve rumors of this nature beyond the fact that they made him uneasy. He knew Charlwood still believed the child may have been slain hours before anyone saw her at the campfire, despite all contrary evidence. So ineradicable a belief seemed like an early touchstone of the investigation, an orthodoxy, a superstition. 12. Be in court for Cameron, Kirkham had told a friend, and the friend told Malcolm Brown. They guessed it meant the defense had surprises in store. The public gallery had filled, which had not happened for some time. Cameron was a celebrity. He looked confident and sturdy. His face and head had ruddied more since the second inquest. Brown had heard tell the professor was currently one of the consulting physicians with the British team at the Commonwealth Games in Brisbane, in whose performance he held a passionate interest and wouldn't be staying long in Darwin once his testimony finished. While Cameron was sworn, Kirkham took, from a stack of files on the floor, a thick folder. It was an astonishingly bright shade of green. It lay on the table, closed, an item of some presence, as if it drew the eye, not because of the vivacity of the color, but because it held matter of exceptional gravity. Cameron's curriculum vitae was the record of an impressively vigorous man. Barker read it out, pausing for the professor's assent less and less frequently, as though there was a danger the list might never finish. Cameron presently held 2 professorial posts at schools of medicine and an appointment in forensic medicine at a school of law. He consulted to the Royal Navy and to the Army, and lectured at the London University, the University College, the Royal Free Hospital, and to classes at 4 police academies. He had practiced at hospitals in Scotland and England, edited journals, and contributed a plethora of articles on pathology, criminology, child abuse, infanticide, cot deaths, forensic dentistry, and as a digression, Barker asked him, amused, "You have written about the Turin shroud?" The professor conceded he had somehow found time to do that, too. By Brown's wristwatch, it had taken Barker 6.5 minutes recitation to get this far. "Have you carried out many autopsy examinations?" "In excess of 50,000, Cameron said. "Cases reported to the coroner requiring a medico-legal autopsy." Brown made a quick calculation. Cameron could get through 50,000 at the rate of 5.5 cadavers a day on average, assuming he had not taken so much as a day's rest in 25 years. Most coronial autopsies took upwards of an hour to perform, sometimes a good deal longer. It seemed he must mean by carried out something much more like supervision. Cameron turned the rumpled jumpsuit over in his hands. "I saw no evidence on any of these garments to suggest that any member of the canine family was involved. I cannot say anything about dingoes. I speak about the canine family in general." "In your opinion," Barker asked, "is there evidence suggesting to you that the child was not killed by a member of the canine family?" "There is evidence to suggest it was killed in another method. It suggests there was an incised wound around the neck. In other words, a cut throat." "Caused by?" "A cutting instrument across the neck, or around the neck." "Held by?" "Held by a human element." "What do you say about the possibility of a dog or a dingo having savaged the child in the head?" "I do not think there is enough evidence on the jumpsuit alone to support that theory." "What happens if a dog bites a child's head?" "A lot depends on where on the head it bites. It would be very difficult for me to imagine a dog grasping the head from above. That would be the only way in which I think a dog could possibly grasp a child without damaging the collar. But in so doing, I would have expected extensive bleeding, but not around the collar of the jumpsuit." "Why?" "Because when you get a head injury, you get rivulets of blood draining down and missing the collar. It goes down the front and down the back. Depending on which way the head is bending, certainly, you'll get bleeding around the back of the collar, depending on how the child lay afterwards, where there's pooling of blood." He traced the blood pattern with a finger. "I would have anticipated that it could only be described by a cutthroat type of injury." "Had the child been lifted and moved by a dog, what do you say about saliva?" "I would have anticipated saliva from any member of the canine family lifting a garment." 13. Station 2-day news break. At the Chamberlain trial in Darwin today, the court was told the baby's clothing found after Azaria's disappearance bore the marks of blood-stained human hands. James Cameron, London professor of forensic medicine, showed projected collar slides of the infant's jumpsuit and singlet made from photographs taken in his laboratories using ultraviolet light. He pointed out to the jury smudges on the stained clothing which indicated to him the pattern of bloodied fingers and another he thought may be a thumb. Lindy Chamberlain, charged with the baby's murder, watched as the professor took up a life-size doll and held it to demonstrate the grip that could produce the marks he found. He said the stain gave him the impression of a hand, belonging to a small adult. 14. When Phillips got to his feet, Cameron paid no attention. He sat facing the judge. He recrossed his legs. He shot a cuff. He presented impeccable relaxation. Phillips reached for the green folder. He thought the professor knew what was coming. "Professor Cameron, I would like to ask you some questions about a famous English case called the Comfort case, in which you were involved." "Yes?" "Because I want to suggest to you it illustrates some of the difficulties in giving forensic opinions in court." Phillips took up a document. He didn't need to read it. It was a convincing prop. "Professor, let us go through the history of the Comfort case so the jury will follow it, please. In April 1972, the body of a man called Maxwell Comfort was found at a house that had been set on fire, and he had apparently been murdered." "That is so." "You attended in the early hours of the morning and examined his body." "Correct." 3 young men were charged with his murder." "Yes," the professor said, but it seemed he could wait it out no longer. "If you could go back. On that occasion, I refrained from taking a rectal temperature." "I will come back to that later. I will give you an opportunity to say what you want to about what you did," Phillips said, almost pleasantly. 3 young men were charged with Comfort's murder?" "Yes." "Tried at the Old Bailey in November 1972? "That is correct." "You gave evidence for the prosecution?" "Yes." "One of them was convicted of murder, another of manslaughter, the third of arson?" "Yes." "They were all sent to jail?" "All." "The case of these 3 lads was referred to the Court of Appeal?" "Yes." "Professor Tier gave evidence on behalf of the boys?" "Among others." "The report of a Professor Simpson was produced?" "That is correct, yes." "You indeed gave evidence yourself?" The professor agreed he had. "At the end of the evidence, the Court of Appeal," Phillips began, but that was as far as he got before Barker interrupted. "I object to that," Barker said. "What the Court of Appeal did has nothing to do with this witness." "I'm just going to say what the results of the appeal was," said Phillips. "That is what I object to." "Very well, I'll note the objection," the judge said, "but I will allow the question." 15. Whatever the facilities of the Maidstone jail, they were generous enough that prisoner Gottfried could lay his hands on back issues of the London newspapers and of the local press, the Kentish Times. His selection of cuttings about Professor Cameron's roles in the Calvi and Comfort cases reached Phillips and Kirkham a few weeks before trial. The Calvi, in which an escaping hold-up man was shot through the back by an apprehending policeman, did not impress Phillips as material of promise, but Comfort was, on any reading, rich with disquieting incidents of scientific misjudgment. Maxwell Comfort had lived in the upstairs room of a house in Catford. He was dark and lithe, a Seychellian, and a practitioner of the martial arts. He was taut-muscled and swift, but many frequenters of London night spots knew him as Miss Shell and would have been surprised to see him dressed in anything but sequined gowns or slinky cocktail frocks. He was saving for a surgical change of gender and worked nights, mostly out of rooms rented by the hour. Catford was then having its share of fires. Early one Saturday morning, not long after 1 o'clock, firemen were called to a blaze in a house in Doggett Road. They got there in time to put it out. This was the house in which Maxwell Comfort had his room. He was found on the floor. He was dead, his face bloated, strangled by some manner of cord. The fireman who lifted the body found it was already stiff. A Dr. Bain, called to the scene, diagnosed rigor mortis as complete. Detectives picked up 3 boys for questioning. They were each teenagers and intellectually retarded. They very much liked setting fire to things, and 2 of them had lit several of the fires that afflicted Catford. At around the time the firemen put out the blaze at Doggett Road, the 3 were caught burgling a shoe shop not far away. Interrogation by the police was very successful. The boys confessed to the killing and the arson. Although they couldn't seem to keep the details straight for any great length of time, they kept them straight for long enough to sign confessions at the police station in front of their anguished parents. the confessions were repudiated the moment they set foot on the pavement outside. The oldest boy, Colin Lattimore, then remembered where he was earlier that night. It was a belated memory, but his parents considered it a good effort in the circumstances, because the last time psychologists tested him, he was able to score only 66 points in an IQ test. He recalled he was at a youth club. The police checked it out. It amounted to an unshakable alibi. The people who ran the club were Salvation Army workers, and they remembered him well. He had left at 11:30. On the medical evidence, Confit most probably died somewhere between 8 and 10 p.m. At trial, the Crown was at pains to delay the possible moment of the murder until midnight, giving the boys time to commit it. The pathologist who examined Confit's body at the mortuary early the same morning was called by the Crown. The pathologist was Professor Cameron. Cameron testified that rigor was commencing at the time of his examination at the mortuary. Confit's death, he said, might have occurred as late as midnight. The confession stood. The boys were convicted, one of murder, another of manslaughter, the third of simple arson. An appeal was lost. An inquiry by Lord Fisher called Cameron back to the stand. He was asked if he had known, when he testified at the trial, that Dr. Bain found rigor mortis complete at the scene of the fire. He said he had not. He was asked if he had known a fireman found the body stiff to the touch. He said he had not. He conceded he had not taken a rectal temperature of the body against his own usual practice and his teaching. He explained that by rigor was commencing, the words he used at the trial, he meant rigor was fully present. Lord Fisher did not find that enough had gone wrong with the trial to warrant releasing the convicted boys. By this time, they had been in jail 3 years. Then Maxwell Confit's housemate, Winston Good, killed himself with a handful of cyanide. Good was himself once a suspect, discarded by the police when the boys confessed. It was now found that Good was Confit's lover and was in the house the night Confit was slain. Parliament authorized another inquiry, this time before 3 Lords of Appeal. At this hearing, Cameron was in court while Professor Tier, an eminent pathologist, put the most probable time of Confit's death at around 8 p.m., 5 hours before the fire. Professor Cameron gave evidence again. "I would have thought the time of death less likely to be near the midnight mark," he said then. The parliamentarian and commentator Christopher Price appraised the scientific errors this way. "It was mostly Cameron's fault. The law trusts forensic medicine to produce accurate, clear, unambiguous evidence in serious cases of this kind. Professor Cameron's evidence was inaccurate, vague, and equivocal. Perhaps this says something about the psychology of expert witnesses in the courtroom. Once allied to a particular side, a feeling of team loyalty tends to overshadow their expertise." The boys were pardoned, sent home. 16. "Your Honor, I do object to this," Barker said. "Yes, I know you do, Mr. Barker," the judge said kindly, "but I will allow it." "I suggest," Phillips said, pressing Cameron, "the Attorney General announced in Parliament that he was satisfied the boys were innocent, did he not?" "Yes," Cameron said, "that is correct. And the boys were awarded some £60,000 compensation because of their imprisonment?" "That's right. The problem illustrated by the Confit case is that, when you gave evidence at the trial, you did not have a completely correct understanding of all the attendant circumstances, did you?" "I think that would be an unfair criticism," Cameron said, "of the police." It was a good parry and made Phillips smile, but he was determined to resist distractions. "But that is the fact. You did not." "The whole substance of the Confit case was that I did not take a temperature at the scene and was therefore only able to give as accurate a time of death as I would normally give if there was such a thing as an accurate time of death. There have been so many variables in the case, and I saw them. Because of the type of case it was, I did not feel there was any justification in doing a temperature. Your difficulty was, when you gave evidence at the trial, you did not know what the police surgeon Dr. Bain had found." "That is correct. And you did not know what the fireman had found." No, that's correct. Consequently, Phillips said, when you gave evidence at the trial, you were not armed with the correct knowledge of all the attendant circumstances. I agree entirely. Now, I want to suggest to you, Professor Cameron, that you have done the same thing in this case. Phillips leaned across the bar table as though to get closer to an antagonist. You formed the view that you have expressed here that a dog or a dingo did not have anything to do with the disappearance of this child. Really, you first formed that view at the time you wrote your report, did you not? That is correct. And your report was introduced into evidence at the inquest? Yes. And indeed it largely, but not entirely, forms the basis of your evidence today, does it not? The professor agreed it did. You believed at the inquest that the proposition that a dog or a dingo could take a child out of a jumpsuit like that, leaving only 2 press studs open, was quite incredible, did you not? That is correct, yes. And you voiced that at the inquest? I did indeed. You believed that when the clothing was found, only the top 2 studs were undone, Professor? That is so, yes. Phillips read him passages from the inquest. Constable Morris testified there that the jumpsuit was open except for studs at the crotch, and Goodwin testified the garment was entirely open. Will you now agree you were acting, even up to the second inquest, under a completely false impression as to the state of the studs that were undone on that clothing when it was found? Putting it that way, the professor said. Yes. The fact that you believed only 2 studs were undone was an important factor in causing you to conclude a dingo or a dog had nothing to do with it, because you regarded it as incredible that a dog or a dingo could get a child out of a jumpsuit and undo only 2 buttons. The professor conceded it was true. Have you given evidence under any other false impressions of this case, Professor Cameron? The professor answered, Not that I know of, but his voice was no longer sure. You were not aware that you were wrong until this morning, were you? Well, he began, but was interrupted. It was the judge. His understanding was wrong, he said. My understanding was wrong, Cameron said, depending on the variability of the other statements, referring to Constable Morris and Wally Goodwin. But Phillips would have none of it. You can vary them as much as you like, but neither of them ever said only the 2 top buttons were undone. I accept that, the professor said quickly. I accept that. I would like to show Professor Cameron photograph 10B, Phillips said, and passed it up. This was the colored photo of the clothing arranged by Constable Morris to represent the way it was found. Do you seriously suggest that this shows the clothing in a neat bundle? I was told the clothing was found in a neat bundle. I know you were, but do you seriously suggest that photo shows the clothing in a neat bundle? Parker objected. The clothing was found by Goodwin, he said, not Morris. Phillips amended the question. But you were told the clothing was found in a neat bundle? Correct, Cameron said. Yes. He was told by the odontologist, Brown, and by the police. You said in your report, suffice to say, I have never known a member of the canine family leaving clothes in a neat bundle. That is correct. Did you put this in your report? On reading all the evidence, it would suggest the last time the child was seen by an independent observer was 15:30 hours on the day of the alleged disappearance of the child, although there is evidence given that the child moved or was seen to be held by the mother. Nobody actually saw the child, apart from an alleged kicking motion seen at the barbecue site. Did you put that in your report? I put that in my report. Your beliefs expressed there were part of the process of forming your opinions, were they not? Yes. And 15:30 hours, if I can remember back to my army days, is 3:30 in the afternoon? True. Did you read the deposition of Mrs. West properly? I'm afraid I don't attach names to a thing. It is clear, from Mrs. West's depositions, that an independent person saw the child as the sun was setting. Judy West had said she saw Azaria, who was then unwrapped and dressed in a little pink dress, at sunset. Yes, it would appear, but no exact time was given. Phillips almost laughed. The sun would not be setting at 3:30, would it? No, the professor shrugged. I don't know when it was. Do you agree that your conclusion, having regard to Mrs. West's deposition, is a false assumption? It is a false assumption if one negates, as I have apparently negated, Mrs. West evidence. Have you made any other false assumptions before you gave evidence, Professor Cameron? Again, not to my knowledge. Not to your knowledge, Phillips mused. Did you swear this at the inquest? I rely entirely on Dr. Scott's negative evidence in that there was no saliva present. Phillips was referring now to the child's clothing. Correct. Did you read Dr. Scott's deposition properly? Yes. Phillips read a passage from Scott's testimony which ended with the words, "Of course, there is no guarantee that there is no saliva elsewhere." That, Phillips said, is a completely different thing from swearing that there is no saliva present, is it not? There was no saliva present on the samples taken. That is what he said. Of course, there is no guarantee that there was no saliva elsewhere. I would accept that. A nappy was one of the articles found by Mr. Goodwin? Yes. I suggest a Constable Noble referred to bits of scattered nappy. I remember that. He referred to larger pieces of torn nappy. Do you remember that? Yes. Mr. Goodwin, the finder of the clothes, referred to a nappy lying next to it, that is the suit, with a few tear marks in it, and the plastic liner with the insides exposed. Yes. Constable Morris, looking at one of the photographs, said, "Of the bits of nappy on the ground, I think they would be pretty much where they were found." Did you read all that? Yes. Did you say this in your report, and I will just read the material part now. Suffice to say, I have never known a member of the canine family pulling off a nappy intact. That is what you reported, was it not? That is correct, yes. You reported that without seeing the photographs? Yes. What? On the basis of what Dr. Brown told you? No, the professor said. The appearance of the nappy when I examined it. The answer nonplussed Phillips. All he could assume was that the nappy had somehow reconstituted itself by the time it got to London. Phillips took the topic to the stains on the jumpsuit. You indicated an area which was on an ultraviolet photograph of the back of the suit and pointed to a possible, more diffuse area there which gives the impression to me of the heel of the hand with extended fingers, right? Yes, the professor said. I corrected it and said it wasn't the heel. It was that part of the hand. He tapped the side of his palm. And referring to the other marks, you suggest they could be the fingers of the right hand, but you couldn't be dogmatic about it. Correct. So we are talking of impressions and suggestions based thereon, are we not, Professor? Or to be more to the point, that is what you are talking about? That is a play on words. Well, they are your words, and they are my impressions. Arising out of the Confit case, Phillips said, you would be one of the first to agree that blood from an injury can take up apparent patterns of objects quite by accident? The professor tugged at his chin. I don't see the connection with the Confit case. Perhaps I will explain, Phillips said. An English barrister, Louis Blom Cooper, who was then pursuing new facts in the Confit case, came across photographs not shown at the boy's trial. They were photographs of Confit's neck, showing the wounds of strangulation. It seemed to him that something was written there in blood. He couldn't quite make out the word. The photo was too fuzzy. Then he found that Confit's neck was not destroyed. It was chemically preserved. Professor Cameron had it in his laboratory. New photographs were taken. The prints were enlarged by 300 magnifications and showed a pattern on the skin. Professor Cameron said he could make nothing of them. They were random. Blom Cooper was convinced otherwise. He saw the word wank. You looked at the photo, did you not? Phillips asked Cameron. It was blown up 300 times, and there was an apparent W, but if that can be inferred as a letter— He shook his head. Next to the apparent W, was there a letter A? According to the eyes of this particular attorney that you're referring to all the time, yes. Whether he was right or wrong, it did have the appearance of an A, did it not? It was good courtmanship. I'm sorry, the judge said, leaning forward. I did not hear you, Professor. It was good courtmanship, Cameron said, louder. Whether he was right or wrong, there was a general appearance of those letters on the throat, was there not? Phillips persisted. That is correct, yes, on the photographs that were blown up. 300 times, interjected Barker, who seemed as irritated as was the professor. The veins in the parchment skin had dried and had given an artifact, Cameron said, which Mr. Blom Cooper agreed with. By sheer accident? Phillips asked. By sheer accident, producing that apparent word? For his satisfaction, yes. Then Phillips got down to the connection. I want to put it to you again. Would you not agree that blood from an injury, purely by accident, can take up apparent shapes of objects? They must have a contact point, by or against an object. It can occur purely by accident, an apparent pattern of an object? A pattern of an object can occur, certainly, yes. By accident? By whatever means, accident or not. Phillips was happy that it was so. And when the defense team got back to the motel room that night, they toasted, in Calvados, Prisoner Godfried. 17. They knew the prosecution had, with Cameron, expended its last witness. Tomorrow Barker would close the Crown case. So heady were they over the state of things now that they sat around late in Phillips' room talking about the chances of a no-case ruling. There is a saying that the high point in the conduct of a defense occurs the instant the prosecution case ends. The cruel and humorous implication is that, most often, a defense goes downhill from the moment it begins. Such fears make an application like this beguiling, but it is a tricky enterprise. The evidence must be so insufficient that it could not, on any arguable view, justify a conviction. Phillips said slowly, "But that is not what we have here." They knew he was right. This case was somehow both too complicated and too simple to be dismissed now. Phillips made interlocking circles on the table with a moist glass. "I think we will just have to win this one the hard way." 18. For Kirkham, this was a familiar dream. He was running a foot race, a 4-lap mile, a distance to which he was not suited unless the early pace was favorable and he could surge home fresh. He made it through the last lap and into the straight, feeling good. As he sprinted for the tape, it vanished. The groundsman tolled a bell. The final lap had only just begun. 2 Timothy, chapter 4, verse 7. 1. The defense opened its case to the jury on the morning of 13 October. It was a hot Wednesday. The public gallery was packed tight. The defense is not obliged to nominate its list of witnesses, and the team had kept the secret close. Most journalists privately predicted that neither Chamberlain would be allowed, by their barristers, anywhere near the witness stand. Malcolm Brown thought this assumption took little account of Lindy's own headstrong opinions. Phillips, standing, turned his chair about so it gave him something to lean on. "Mr. Foreman, ladies and gentlemen of the jury, I want to begin by mentioning some legal matters of fundamental importance to this trial. Very shortly, you're going to see and hear witnesses for the defense, and it is of critical importance that, when you are listening to and looking at witnesses for the defense, you never once allow yourself to slip into an attitude of mind where you say, in effect, to the witness for the defense, 'Come on, you convince me that the Chamberlains are innocent.' You see, as His Honor will tell you later on, persons accused of crimes like these, under our law, never ever have to prove their innocence. That is the law. His Honor will tell you more than that, I've no doubt. His Honor will tell you that an accused person does not have to prove a single solitary thing in a criminal trial like this." He was spending time on the responsibilities of proof for an unsettling reason. He had discussed it with Kirkham. They were both uneasy. They agreed that in this case, more than any other, the accused might have to prove innocence. Brown's gaze drifted to the Chamberlains. Lindy was not sitting on the pillow. It rested on her lap. She needed an embroidered kerchief. She kept trying to clear a persistent discomfort in her throat, as though ready to say something. This morning she wore a sun frock, white and blue, frilly and meticulously pressed. Brown nudged Morehouse. "Lindy is going to testify," he said. Within a minute, Phillips confirmed it. Both Chamberlains would testify, he told the jury, as would a considerable number of other witnesses. He did not name them. He nominated, instead, the prosecution witnesses whose testimony they would confront. Issue number 1 involves the opinions of Mrs. Cool, supported to the extent they are by the opinions of Dr. Baxter and Mr. Culliford, to the effect that there was fetal blood in the Chamberlain car and on the camera bag. We dispute those opinions, and we will be calling expert evidence to the effect that those opinions are not valid. The second issue relates to the opinion of Professor Cameron that the blood staining around the neck of the jumpsuit means that the child's throat was cut by some sharp instrument, suggesting a human agency. Allied to that is the impression suggesting the imprint of bloodstains on the jumpsuit. We dispute that opinion and that impression, and we will call expert evidence that Professor Cameron's opinions are not valid. The third main issue revolves about the opinion of Professor Cameron, Mr. Sims, and Dr. Brown, suggesting no canine involvement in the disappearance of the baby. We dispute those opinions, and we will, again, call evidence to the effect that those opinions are not valid. And finally, as I see the main issues at any rate, there is the area of the opinion of Professor Chaikin and Sergeant Cox, suggesting that the damage to the clothing is occasioned by a bladed instrument. Ladies and gentlemen, we dispute those opinions, and we will call expert evidence to the effect that those opinions are not valid. You will also hear evidence from lay people as to dingo attacks and behavior at Ayers Rock, mostly involving children. Fortunately, it would appear in each case considerably older than Azaria Chamberlain. Not helpless children, but children that were able to do something, and I think in practically every case it was in daylight, and a parent of the child concerned was nearby and able to intervene. But you shall hear evidence as to the conduct of the animals in that connection. Every one of the jurors was with him. The 3 women sitting together in the front row, the garrison of serious men, the foreman with lined and reliable eyes. So attentive were they all that it seemed their gazes were not in the least individual, but served one concise and cohesive system of reasoning. Phillips felt a sudden surge of confidence, and recognized in it the signs of danger. You do not want me to spend a couple of hours telling you what the evidence is going to be, do you? You would like to hear the evidence, so let us go ahead and do that now. The deep fall of his gown swept out as he pointed to the witness stand. I call Mrs. Chamberlain. She lifted the Bible and took the oath. To Malcolm Brown, sitting on the press bench, her voice seemed small and shaky. She settled on a chair in the stand, slipped the pillow behind her. She didn't look sturdy anymore. Her eye sockets were bleak and blotchy, in pitiful contrast with the effort she had made with her spotless frock. It was as if, so close now to the end of tribulation, she might be in peril of losing her grip. Brown wondered how Phillips would handle the problem. He wasn't left guessing long. Phillips drew her through a few questions accounting for bloodstains in the car, the boy's injuries, bandaged pathfinders, the baby's vomit, the bleeding hitchhiker. He allowed her to explain, briefly, where in the tent her tracksuit pants lay, then changed the subject. Her description of the baby's disappearance he restricted to a précis. Brown saw what was happening now. Phillips was rushing her through. An obedient orderly handed her the jumpsuit. In her hands, the limp thing was melancholy, dismally vacant, a cerement which represented a death so old now that as she laid it open, the rusty neck gave a wisp of coppery dust. Her mouth was ashen. The judge asked if she felt all right. Yes, thank you, Your Honor. Perhaps I can approach it a different way, Phillips said. Without opening any of those articles, do you confirm they were the clothes your child was wearing, apart from a matter I will ask you about in a minute? Yes. Right, said the judge. Put the clothing back. Please state what other article Azaria was wearing. She had a white knitted marquee jacket. She closed her eyes too late, and the tears stumbled down. With a pale lemon edging. A movement in the jury box caught Brown's attention. A woman had lowered her face to her hands. The woman next to her, and a man behind, were also in tears. The judge called a recess. The orderly, holding a tumbler of water, helped Lindy Chamberlain from the stand. The jury filed out. The women dabbed their averted eyes with kerchiefs. A jury weeping was an event with which Brown had no experience, but he was too skeptical a reporter to jump to ready conclusions. Which tragedy were they really mourning? After recess, Phillips called for the life-size photograph of the jumpsuit. It was one of Professor Cameron's exhibits showing the smudges of blood. He stood Lindy Chamberlain in front of the jury box. He asked her to align her own index finger with the mark which had impressed Cameron. He turned it towards Barker and then to the jury. Her finger was longer by half an inch. "I object to that," Barker said. "The hand is flat." "I was going to make sure that it was put on the notes, Mr. Barker," the judge said. "Is there a mark definable, Mr. Phillips?" "You can see the finger extending beyond the mark, Your Honor." "Because the hand is flat," said Barker. "How many black smudges or splotches do you say you see in that light?" Phillips asked Lindy Chamberlain. She counted them off from the photograph. There were 4. "Now just hold your finger up." Phillips had come to the real point of all this. The mark which Cameron had identified as the length of an index seemed to have been made by someone whose stubby finger was blessed with 4 phalanges. The rest of the world has 3. Phillips abandoned her to Barker. The accused cross-examination is said to be the loneliest time for defense counsel. Disabled by fears that objections will seem like confessions of weakness, they sit on the sidelines guessing the patterns of opposing play like footballers ordered from the field. Barker took off his gray wig and reset it, straightened. A spur of hair at each temple gave him an impish look. All suggestion of good humor had gone. "Mrs. Chamberlain, should we take it from what you said about Mrs. Ransom that you accept you told her to see that stains were clean from the pants?" Mrs. Ransom was once Jennifer Richards, the friend who had taken Lindy's tracksuit pants to be dry-cleaned in Mount Isa. "I accept that there must have been some conversation about something with the trousers. I don't recall any of it." "I understand you do not recall it. But do you accept what she said about having stains cleaned from the pants?" "Yes, I just said. If she says that's what I said, I accept it." "Do you accept there was blood on the pants?" "No." "You do not?" "No." "Do you deny there was blood on the pants?" "I've never seen blood on the pants at all." He asked her to recall the testimony of Mrs. Hansel, the dry cleaner. "Do you remember she indicated with her hand a sort of splashing motion?" "Yes." "She said they ranged in size from about her fingernail." He read from the transcript. "Sort of tapering off with little drips, sort of, and went down to very small points, very small blobs, just splattery, between 1 to 3 dozen all told, and they were tapering off and running down towards the bottom. Do you remember her saying that?" "Yes." "Do you accept that is what she saw?" "Yes." "Do you deny it was blood?" "I have never seen any blood on them myself. There could have been blood on them because they were in the front of the tent." "Is that the way you would account for it, if it were blood?" "Well, that's the only explanation I have." "Is that how you account for the blood on the tracksuit pants, if that be the case?" "Yes." "Notwithstanding that it was seen to be only below the knees and only on one side?" "I don't know how they were folded or placed in the tent. It's the only explanation I have." "You would discount the possibility that it came from you?" She took a breath and said grimly, "That is not my blood, Mr. Barker." At the bar table, Kirkham lowered his head. It had not taken Lindy long to make the transition from nervousness to anger. "Did you have any blood on your shoes at any stage?" "My own opinion is that there was blood on my shoes. It hasn't been confirmed by any tests, though." "When did you become aware of the blood on your shoes?" "It was the first time I went to wear them after I got home. It would have been a week later." "When was that you became aware of blood on your shoes?" "I said, about a week later." "How do you say the blood got on your shoes?" "I think it would be from crawling over things that were in the doorway and things in the tent." "I'll take it from what you said about the possible application of blood on the tracksuit pants and the other blood you saw, that you accept that the baby was bleeding in the tent?" "Yes," she said. "Yes." And according to you, there is no other way of accounting for the presence of blood in the tent? She could not think of any. Kirkham's train of thought was running in the opposite direction. He wondered how Barker was going to account for the spray of blood Judy West saw and the pool recalled by Sally Lowe. The topic reached the dingo she saw emerge from the tent. Barker asked, "Do you recall this animal going around the car, that is, on the southern side of the car?" "No. As I said, I only watched it with my eyes for a couple of feet or so, and after that it was guesswork as to where it went." "Did it just disappear?" "I didn't watch where it went at that stage. I went into the tent." "Do we take it that it had progressed at least to some part of the car?" "Well, it had gone somewhere," she said with sarcasm. "I don't know where it had gone, Mr. Barker." "Did you see it again at all?" "I saw a dingo standing by the car on the southern side. The trackers told me that it was a different animal." She shrugged. "It was the one I chased, though." Then Barker said with some surprise, "There were 2 dingoes there, were there?" "According to the trackers, there were 2, she said. Although a second dingo seemed now to have made an unscheduled appearance in her testimony, Brown remembered he had heard the suggestion somewhere before. He located it in his memory of the first inquest. Dr. Newsom, the zoologist from Wildlife Research, said he thought 2 dingoes likely on his reading of the events. But the evidence was new to this trial, and the additional animal stood there, shadily, like a convenient and evasive figment. "When it was shaking its head," Barker said, referring to the dingo she saw leaving the tent, "was it somewhere on top of the 2 parkas, is that right?" "Somewhere in that area." "Apparently, if it be blood, shaking blood onto your slacks?" "Yes." "Onto Aiden's parka, do you know?" "In my opinion," she said carefully, "Aiden's parka had blood on the inside of it, but I don't think there had been any scientific results on that." "You know that none has been detected, do you not?" "I said scientifically. I don't think they've picked it up." "You account for the blood on Regan's parka from the shaking?" She conceded that without argument. "You know, do you not, that Dr. Scott closely examined the tent for blood?" "Yes, I believe it was Dr. Scott." "You know he found a small spray on the southern side of the tent?" "No," she corrected him. "I understand there was a couple of small sprays." She waved her hand to indicate the right side. "Along the southern side of the tent." "But then you know he said it was most likely that it was human blood?" "I know he said he couldn't detect what it was, apart from the fact that it was blood." "If this dog, carrying the baby, ran to the south of the car, the sprayer sprays on the side of the tent could have very little to do with this case." "If it had gone around the car," she agreed. "But if it had gone in between, that would be a different matter." "You suggest that is a possibility?" "Yes," she said. "I think it's a possibility, yes." "That it went between the tent and the car?" She nodded. "When did you first consider it as a possibility?" "When I heard about the sprays on the side of the tent." After a moment's pause, she added, "During the first inquest." "Before that, your view was that it had gone around the car?" "I thought that's where it had probably gone, yes." "Because you saw it there," Barker said slowly, emphasizing it for the jury. "I saw a dingo there," she said, laying an emphasis of her own on the comparative singular. The day ran out before Barker finished with her. Phillips and Kirkham went back to the motel room. They had an aperitif or 2. They talked the day over. Phillips thought Lindy was going fine, considering the circumstances. The circumstances he had in mind included the making of 3 full statements to the police, God knew how many press and television interviews, and the delivery of testimony at 2 inquests. Despite the number of times she had described the event, Barker was finding it difficult to pick up many contradictions. "In the legal history of this country," Phillips said, "there can't be another accused who has talked so much." So true did this line seem to be as he uttered it, that he made a note to say something of the sort in his closing address. There was a knock at the door. It was Lindy Chamberlain and Stuart Tipple. The legal team was not permitted, by ethical rules, to talk with her about the evidence, but it was permissible to discuss the way she gave it. Her demeanor in the witness stand worried Kirkham. When she was annoyed with Barker, she sounded like a fishwife. I know it's difficult for you, Kirkham said, but you must hold your temper. You sound too harsh, too angry. I am angry, she said. What do you expect? It's not going to go over well with the jury. Try to be more, he cast around, demure. She was angry all over again. I am the way I am, she said. The jury will have to get used to it. Plainly, she was not prepared to take notice of him. He glared at her. Kirkham's eyes are generally described as piercing blue. Whatever goes on in there in the midst of fury, it is not the abode of warmth. Understand this, he said in a glacial voice. When this case is over, I'm going to climb on a plane and get the hell out of the place. You could be staying here for a fucking long time. Her hand flew to her mouth as if the words were her own. She began to cry. It occurred to Kirkham that she was the sort of woman who might never have been sworn at before. And before court next morning, an astonished Michael took Kirkham aside. What did you do to my wife? He said. She was still upset when she got into the witness stand. She shakily held a kerchief. As Barker took her through every item she could recall in the tent, she was pale and reflective. Kirkham thought the quality of reflectiveness, however involuntary it was, could work well. It might keep her temper in check. Evidently Barker was in the mood for lists. Having exhausted the contents of the tent, he began on the stains in the Tirana. You have heard quite a lot of evidence, have you not, about the presence of blood in the car? She nodded. You have heard quite a lot of evidence about the orthotilidine test? Yes. And you heard Mrs. Cool say that she received positive reactions for blood from the carpet from the driver's side? Yes. And the driver's seat? Yes. If it were the case, do you know why there would be blood on the driver's side carpet? No. It could have come from a number of places, I suppose. I don't know. What places would you suggest? Children crawling around the car, she said. Or people moving? She put a helpful hand to her temple. Or from people Michael had fixed up with injuries? I don't know. Who did he fix up with injuries? Oh, we often used to stop for road accident victims. Often, Barker said, managing to convey disbelief. Yes, she said. Phillips made a note. Ambulance certificates. This was to remind him to make clear, in re-examination of her, that she and Michael were practicing holders of St. John's ambulance certificates for first aid. How many road accident victims has he carried in that car? Barker asked, besides Mr. Lenehan. I don't mean he carried them in the car. I mean he stopped to assist at the accident site, and then he... Yes? Well? He had to get back in the car to drive. And do you think he might have carried the blood with him? He could easily have done that. It is quite possible to have some on your hands when you get in. This line of questioning was beginning to trouble Phillips. Barker was treating, one by one, the locations at which orthotolidine had reacted with something. Orthotolidine gives a positive reaction to many things other than blood, like milk, vomit, and rust, for example. A positive reaction merely indicated that the stain was worth testing further. This critical distinction seemed to be getting lost somehow. Barker said, And you heard about the positive reaction to the crossbar under the passenger seat? I can remember a crossbar. I'm not sure which seat it came from. You heard about the reaction to the stain on the 10-cent coin? Yes, she said. She recalled the coin was found under the seat. And the floor? And the bracket? And the hinge? She remembered all these. What do you say about all that? I don't know that I've got any opinion on it particularly. Phillips relaxed a little when Justice Muirhead interrupted. You're not being asked, Mrs. Chamberlain, whether you accept the validity of the findings. Phillips thought, he's on to it. It is merely that, the judge said. If there were positive reactions, what have you to say about it? Well, she said, I don't know that I've really formed any opinion, Your Honor. Barker kept on with it. Can you account for the presence of blood on that side of the car? I know Mr. Linehan's blood was on that side of the car, she said, and a number of other incidents I have related here in court, but other than that, she shrugged, I don't know anything about it. The blood around the console, can you account for that? If indeed it was blood? He could have gotten there when Regan hit the dashboard, I don't know. When was that? A couple of months after we bought the car in 1979. Regan was about 20 months old. What about the window handle? Well, that could have easily got there when I got back into the car after attending to Mr. Linehan. The chamois? That's been used on a number of occasions to clean up the car. Barker took his time delivering the next one. What about the spray under the dash? I'm not convinced in my mind how that got there. Can you offer us any suggestions? Phillips wondered how she was going to handle this, the arterial spray. Her gaze drifted to the exhibits sprawled about the courtroom floor. Somewhere there lay the plate Michael had found with a similar spray from another Torana. It was inconceivable that both were blood, and possible that neither was. She seemed to be choosing her words carefully. It would only be pure speculation, she said. You prefer not to speculate, Barker said. You just had no idea how it got there. She was firm. I'm not going to speculate on how it got there, she said. You would not suggest it came from Mr. Linehan, would you? No. A nosebleed? She dismissed that too. Not under there. What about the towel and the wheel well at the back? That had been used to clean up the car and wipe down the car on various occasions. One of the car towels had been on my knee when I was nursing Mr. Linehan. The scissors? I don't really know whether there's any blood on the scissors or not, she said, adding that if it was blood, she didn't know how it got there. The camera bag? There could have quite possibly been some blood on Michael's hands that night from collecting the gear out of the tent, she said. Zip up his camera bag, it could easily get on the zip. What gear did he put in it that night, do you know? In the car? All the stuff out of the tent. In the camera bag, Barker meant. He wouldn't have put any gear in the camera bag, but he may have zipped it up before he traveled. There were large areas in both the front two compartments which reacted to the positive screening tests for blood, the orthotolidine tests. Now, if indeed that reaction was for blood, can you account for it? Here Phillips thought it time to enter the argument. Your Honour, I do not want to intervene, but did not Mrs. Cool specifically say that after 4 days she could not prove the presence of blood in the bag? I think Mr. Barker may be restricting it to the orthotolidine test, Justice Muirhead said. That last little piece that slipped in, Phillips said, got into the area of actual blood. The judge turned to Barker. Could you restrict it? I said, if it were blood, Your Honour. If it were blood, and if the orthotolidine test did give a positive reaction, the judge said, by way of spelling out the ground rules. Put the question again. She said screening tests of the vinyl surfaces gave consistently positive results in both the front compartment and center compartment. You cannot account for that? If it was nasal secretion or something like that, I could understand it. Nasal secretion? Well, it had held used handkerchiefs, and I carried used children's clothes in it, and things like that. On the night of 17 August? I wouldn't expect so, on the night of 17 August, but it had been used for some 4 months by us before that, and it was about 5 years old when we got it. You see, Barker said, you heard it put that other substances can cause a positive reaction, did you not? She had. And that one of those substances could be vomit, provided the vomit contained blood? Yes. The baby had vomited in the car on about 5 occasions, is that right? Yes. Did it ever vomit blood? To your knowledge, the judge added. She had projectile vomiting. I've never analyzed it to see what's in it, but it's rather painful. On each occasion you were holding her? No, she recalled. On at least one occasion, Regan was. Regan was burping her. Do you suggest that the vomit could account for the presence of blood? Barker corrected himself. For the positive reaction in the camera case? Well, this is... She waved her hand as if to clear away some misunderstanding. There are things that had been at different times in the camera bag. You say vomit? The face washers, she said, were used to wipe up vomit at some stage, but whether they had blood in them, I don't know. She made a face and lowered her eyes. All the messy complications of motherhood were beyond explanation. I'm just saying it's possible, she said. You know there was no blood on the fly screen, Barker said, meaning the fly screen on the tent. I presume there wasn't, because it hasn't been mentioned. Did you say this dog had its head halfway through the fly screen, shaking a bleeding baby? I said it was emerging through the fly screen. Shaking its head vigorously? I couldn't tell you now whether it was shaking its head as it was going through or before it was through. Its obvious movement was shaking the fly screen at some stage. It was all in a matter of a few seconds from the time I first saw it to the time I was in the back of the tent, very, very fast and moving. Your evidence is that you saw it shaking its head vigorously and it was moving the fly screen in the process. I don't know whether its head was shaking the fly screen or whether what it had in its mouth was hitting against the fly screen. And what it had in its mouth, Barker said with increasing volume, we know now, according to you, was a bleeding baby. Her reedy voice broke halfway through the answer. That's my opinion. Pardon? That is my opinion, she said, taking care. Well, is there any doubt about it? Not in my mind. Is it merely your opinion, or is it something you know as a fact? It is something my heart tells me is a fact. She was screwing the kerchief tight. Other people don't think so. Does it surprise you there was no blood on the fly screen? No, there was blood on the pole. It doesn't really surprise me there was none there. It would depend which angle the animal was. She took a breath. Or which angle the wounds were. Mrs. Chamberlain, you say this child was in the mouth of a dingo which was vigorously shaking its head at the entrance to the tent. That is what you firmly believe, is that right? That's right. The dog having taken Azaria from the bassinet? Her reply was a thin and dismal sound. The words wouldn't come. Justice Muirhead said, Take it steady, Mrs. Chamberlain. You saw blood on the parka? Barker said. Yes, she said through her fingers. The judge asked, Would you like a spell, Mrs. Chamberlain? No, she said. I'd rather get it over with, Your Honour. I do not want you to have to answer questions when you are feeling distressed, the judge said. He suggested a 10-minute break. No, I prefer to go on, she said. This has been going on for 2 years. I want to get it over with. Barker, who did not seem to be taking any pleasure in this now, obliged her. You say the blood on the parka must have come from the baby? Yes. When it was in the dog's mouth? Somewhere around that time. What other time could it have come from the baby? Look, Mr. Barker, she said. I wasn't there. I can only go on the evidence of my own eyes. She was close to wailing now, in need of some amnesty, but not prepared to accept it. We are talking about my baby daughter, she pleaded, not some object. We will adjourn for 10 minutes, the judge said, firmly. I would like to remind you of some evidence given by Constable Morris, Barker said. He told us this. Mrs. Chamberlain said that originally she was at the barbecue site and she'd seen a dingo near the tent. It had what seemed to be something in its mouth. She hadn't taken a great deal of notice of it, because she'd seen dogs and dingoes earlier in the day around the campsite, around the rubbish bins, and tourists feeding them to try to get photographs, etc., and didn't take undue notice until she returned to the tent site a short while later, and then suddenly realized that the dingo or dog must have taken her baby. Barker lowered the transcript. Did you hear him say that? I don't recall his evidence greatly. It is not, to my knowledge, what I told him. It may have been the impression he got. Did you tell him you had seen a dingo near the tent, and it had what appeared to be something in its mouth? I told him I had seen a dingo in the tent with, appearing to have something in its mouth, yes, she said, wary. Is this the case? When you first saw the dingo, you did not take much notice, because you had seen them around the camp earlier in the day? Yes, that's probably it. From the first half-second or something like that, I thought it had a shoe. I didn't really take much notice. That's why I just yelled at it to get out of the tent. When you say much notice, you mean that you did not feel alarm? The judge asked. Yes. Barker said, Did you tell him that you did not take undue notice until you returned to the tent site a short while later and then suddenly realized a dingo or dog must have taken the baby? Not to my knowledge. Do you deny telling him that? I said I don't remember telling him that. Do you deny telling him? Barker insisted. I just don't remember telling him anything about it. I don't know whether I did or I didn't." "You might have told him?" "It's possible," she conceded. "But I don't see why I would have, because it doesn't connect with any of my memories of what happened." "Which is totally inconsistent with your evidence, is it not?" "Yes," she said simply. "You know Constable Morris, do you not?" "I do now, very well." "I'll suggest to you that he came back to try and find out what the baby was wearing. I can remember him running across at one stage and saying, 'What was the baby dressed in?' and me saying, 'White,' and him tearing off again. There just wasn't an opportunity to give him a full description. He had to let the searchers know basically what they were looking for." "Did you tell him again that you saw the dingo near the entrance to the tent?" "I could have, quite possibly." "Did you tell him the dingo had nothing in its mouth?" This was a discrepancy to which Barker had returned more than once. "I think we've been over this a number of times before," she said. "I told him I saw nothing in its mouth." "Did you correct him?" To my remembrance, Yes, I know we had several discussions on his impression and my impression." "You do now remember the conversation, do you?" "I know that when he came to see us just before we left, he was still confused." "He was confused," Barker repeated, doubtful. "By the way, did you tell him the baby was wearing a matinee jacket?" "I did mention it, but I don't know if he was close enough to have heard. He was on the move." "You heard him say here that you did not say anything about a matinee jacket at the time." "It was quite possible he was too far away to hear." Phillips thought it high time he straightened this out. "Your Honor," he said, "I object to selected passages being put. My recollection is, when he was cross-examined, the constable clearly said that he may be mistaken." "He said that it was not verbatim," Justice Muirhead said. "He made no notes." Unwilling to let the point go, Phillips said, "More than that, with respect to Your Honor, he said he may be mistaken about that." "I was not trying to argue with you, Mr. Phillips," the judge said, amused. "I was kind of basically agreeing." "I would like to remind you of what you told Inspector Gilroy the day after all this happened," Barker said. He held up a transcript of Gilroy's tape recording. "Now what you say there, do you not, is that you found the baby was missing when you entered the tent, not when you were running towards it?" "I think it's just a matter of how it's put." "Is it? What you say there is, do you not, you called to your husband that the dingo had the baby when you emerged from the tent, not before you went into it?" "Well," she said, "I did both." "You did both. You dived into the tent, did you not, and saw that she was gone? Is this what you told Gilroy?" "Mr. Barker," she said, "that interview was a short interview, to give them some facts to work on. He told me they were coming back to take a statement with all the details in it. I don't pretend that everything in there is exactly one after the other as it happened. I was totally confused and still in shock when that was taken." "Is it the case that what you say here," he waved the document, "cannot be relied upon?" "I'm saying that it may not specifically be lined up, one thing after the other. It may be jumbled. I'm not saying it's incorrect. I'm saying it may be in the wrong order." "I'll suggest to you that it is not merely a matter of jumbling. It is simply incapable of being reconciled with what you say here. Do you understand that?" "It isn't," she said. "In my mind, Mr. Barker." Kirkham and Tipple exchanged glances. Her voice was, once again, brittle, ungenerous, and combative. "Did you see, as you approached the tent, that the baby had gone?" "Yes." "Why did you not tell that to Gilroy?" "Well," she said, "I thought I had." "Why did you say to him, 'I dived straight in the tent first to see if there was anything I could do. I never thought of him taking her'?" To know that something's true and to accept it are two different things. This glimpse of turmoil suddenly seemed to hold as much immediacy now as it had then, and she covered her face with her hands. The judge told her to rest a while. Then he said, "Mr. Barker, she did say, when she was discussing with Gilroy the next day, that it may be jumbled up. I don't know whether—" He waved a bothered hand. "I do not want to limit your cross-examination, of course. It is not as if we are dealing with—" He did not finish the sentence. Unease had no form in law. "Go on," he said. Barker went on another hour. Phillips and Kirkham knew they were close to the end of it when Barker asked, "Mrs. Chamberlain, may I respectfully suggest to you that the whole story is mere fantasy?" "You have suggested that before," she said. "Mrs. Chamberlain, is it not the case that your husband declined to search actively on that Sunday night because he knew that the baby was dead, and he knew that you had killed her?" "No, definitely not." "And is it not the case that this is why you declined to actively search?" "No." "I suggest to you that the reason that you and your husband stayed near the car whilst people were searching was that, for some portion of that night at least, the child's body was in the car." "Definitely not." "You invented the story of the dingo removing the child from the tent." "I definitely did not invent that story," she said. "It's the truth, Mr. Barker." Her face had dried, streaky. The pillow had slipped from behind her, but she did not trouble with it. When Barker sat down, he took off his wig, and his pate glistened. She sat straighter. She had somewhere found reserves enough to outlast him. "I have fought a good fight. I have finished my course. I have kept the faith." 2 Timothy, chapter 4, verse 7. 2. The defense team went back to the motel that night, for the most part happy with her testimony. Phillips was surprised at the amount of time Barker had spent examining Lindy about the stains on her tracksuit pants. Phillips thought it merely served to illuminate the weakness in the Crown case, since the campsite witnesses testified that she wasn't wearing the trousers until late in the night. "Barker must be the only man in the world who puts her in them when the baby vanished," he said. Kirkham was still perturbed about motive. "Not once did Barker put to her any reason why she would kill her own child. It seemed it was simply to be assumed she might. Plainly, the defense would have to call Dr. Milne sometime to show she was suffering no psychological malady postpartum. Otherwise," Kirkham said, "it's a lightin' issue, a sleeper." He didn't like it at all. Then the mood in the room took hold of him. He poured a drink. There was no reason to be this jumpy. Malcolm Brown knew enough about Lindy Chamberlain to guess she would ascribe credit to some form of heavenly sustenance. He also knew enough about the ways of the world to doubt that she had made as good a witness as she might think. In medieval times, when the adjudication was by water, those who sank were the innocent. They were acceptable to the elements. They spluttered and were acquitted. It was a social mechanism designed to exact public sympathy. There wasn't much around for Lindy Chamberlain. She might have done better to sink. He walked to the mall next morning and bought the Herald at a news stall. He found his piece was entitled, "Lindy Denies Cover-Up." He thought it a harsh heading. It did not reflect the tenor of the copy. But the error underscored something he had been thinking about the case for some time now. No one seemed capable of understanding anyone else. The mall was busy. He was used to the odd glances his awkward gait drew. Brows seemed to have been constructed from parts which were over-tightened in the process of assembly. He folded the paper, forced it into his suit pocket, and lumbered doggedly on. 3. Like festivity organizers everywhere, social club committees in Darwin had a hard time devising themes for the annual ball, and the club which held its fancy dress extravaganza over the next weekend asked that guests exemplify, as best they could, in their costumery, bad taste. It turned out a lively affair, festooned and frolicky, the last gala before the wet set in. There were the usual impersonations of spiky punks. Here and there an ambitious hippie made a dreamy appearance, and those who came as raucous drunks did not seem at all out of place, but it was clear, early, that the judges of costume faced a problem. Around a third of the merrymakers were dressed as Pastor and Lindy Chamberlain, the wives bellied with padding, the clergy swinging camera bags they draped with swaddling clothes. The ball ran until the early hours of the morning. Couples wandered home, happy, replete, trailing streamers. A still dawn, lighting the courthouse in Mitchell Street on Monday morning, uncovered a basket someone had delivered to the terrace steps. To the duty constable, it must have looked like a foundling. It was a white bassinet. A doll lay inside, headless, gory. He whisked it away before the press got onto it. 4. Rather than dissension, Stuart Tipple would have called it something like constructive argument, but the fact was that the team was not entirely agreed on the final shape of the defense case. Tipple, thin-faced and anxious, favored leaving open to the jury a suggestion that a human agency might account for the disposal of the infant or its clothing. After all, this was the finding at the first inquest, and he thought Coroner Barrett had come closer to the elusive truth than anyone else so far. Kirkham was keen to reshape the case by bringing the discussion back to dingoes. When the arguments were about dingoes, we won, he said. He wasn't too happy about human intervention. Phillips, beetle-browed, ruled it out altogether. Look, he said, the baby was taken by a dingo, and our clients think it was disposed of by a dingo. Anything else is just too complicated. Otherwise they were, as Phillips said, ad idem. Their witness list stood at 26, the Chamberlains aside, easily arranged into 4 categories. Testifiers to the Chamberlains' good character or to their evident sorrow comprised Lindy's Mount Isa friend Natalie Goss, Pastor Colin Lees from Avondale College, Pastor Mervyn Kennaway, who was also the one-time owner of Michael's camera case, a perplexed teacher David Haslam, who thought the Chamberlains decent, kind people of the community, and the Ayers Rock tourists Gren and Jack Eccles and gray-haired Flo Wilkin, who remembered Lindy Chamberlain as a perfect little mother. Kirkham proposed to bring in the tiny obstetrician Dr. Irene Milne somewhere under this heading, although her real usefulness lay in that part of her testimony which militated against postnatal depression. Justice Muirhead had ruled already that testimony about the behavior of dingoes must be restricted geographically and temporally, so the witnesses John Cormack, Erica Lesh, Ron Bellingham, Elizabeth Fisher, and Lorraine Hunter, all of them vividly harassed and still indignant, were testifiers only to attacks around Ayers Rock within the few weeks before Azaria Chamberlain's disappearance. This group should begin with the dingo expert Les Harris, Phillips said, so the jury might know what sort of predatory animal we are dealing with, before the more anecdotal evidence of the others. Their answer to the arterial spray, the spattered plate Michael Chamberlain had found in a Tarana in Maitland, was to be proved through its clergyman owner, Weber Roberts, and by Mrs. Jennifer Jones, the Justice of the Peace, who supervised its removal for evidence. This, then, left the scientists, of whom there were 8. Phillips thought the order in which they were to be presented would determine the thrust of the defense. They should lead off with Barry Betcher and splinter some bulwarks with a first brute salvo. Findlay Cornell, a biochemist working in immunology, ought to be able to damage the prosecution a good deal further by testifying that Mrs. Cool's phosphoglucomutase estimate was, in the result, dubious because the blood was so old. Arnold Russell, a chemist who for 10 years had worked with the Melbourne Coroner's Court, had tested samples of carpet from the Chamberlain car and, where Mrs. Cool found a soap reaction, he could find no soap at all and could detect only as much detergent as you would find in drinking water. The Royal Melbourne Hospital pathologist, Dr. Rose, would prove the astonishing pliability of an infant's head, like a ping-pong ball, he said in an interview, which a dingo could crumple without swamping the tent with blood, and the neurosurgeon Professor Keith Bradley would show that the pattern of bleeding on the baby's jumpsuit was of the sort to be expected, quite definitely, from puncture wounds to the neck, and did not at all suggest a cut throat. Hector Orams, an oral pathologist, was in quiet admiration of the scissor-like action of a dingo's carnassials and of the keen, slender canine teeth. He could not distinguish the damage to Azaria Chamberlain's clothing from damage which could result from a masticating dingo. Of the 2 remaining pathologists, Professor Nairn considered Mrs. Cool's blood test inexpertly carried out and insufficiently controlled, and Dr. Vern Plucan, the director of pathology at the Geelong Hospital, could find little anywhere in James Cameron's testimony with which a responsible pathologist could agree. Lucan and Cameron were once colleagues in the production of a forensic medicine textbook. Tipple especially liked that conjunction, a sweet, insolent touch. 5. The prosecution brought Simon Baxter back into court to listen to Becher. Tipple saw that it was Dr. Baxter, rather than Barker, who was making the copious notes. Phillips said, "Professor, had you received prior to this trial a copy of Mrs. Coole's work notes?" The professor said he had. "Had you been supplied, too, with a copy of her deposition, her sworn evidence, made at the second inquest?" "Yes," he nodded. "Yes. During the course of this trial, I think everyone is aware, you were present during Mrs. Coole's evidence?" "Yes," he said, adding that he was also in court during the testimony of Dr. Baxter and Mr. Culliford. "Professor Becher, in your opinion, should it be concluded, on the results of any of the tests performed by Mrs. Coole, that fetal hemoglobin was present in any of the samples tested by her?" Barker was on his feet in a second, objecting. Justice Muirhead didn't seem pleased with the interruption. "What is the basis of the objection?" he asked, as if nothing had suggested itself to him so far. "Is my friend putting it to the witness as a conclusion which ultimately has to be drawn by the jury, or is he putting it to the witness as a conclusion which he would draw as a scientist? Because whatever the witness may think, the jury are entitled to draw what inferences they like on the evidence." Phillips thought this more an early reminder to the jury of its sovereignty than a form of objection, but he held his peace. "Mr. Barker," the judge said, "I assumed it was put to him as a scientist by way of opinion after hearing her evidence and looking at her worksheets as to whether, as an omnibus question, the conclusions as to fetal blood can be scientifically sustained. It all seemed perfectly plain. I think that is all he has asked." "I think it should be clear, that's all," Barker said, and sat down. This was the most important and comprehensive question the witness would be called on to answer, so Phillips wasn't too displeased at the opportunity to repeat it. "In your opinion, should it be concluded, on the results of any of the tests performed by Mrs. Coole, that fetal hemoglobin was present in any of the samples tested by her?" "No," the professor said. "It is my opinion that such a conclusion should not be reached from the results presented by Mrs. Coole. The antiserum known as antihemoglobin has in it antibodies that react with both the alpha and the beta molecular chains which are found in hemoglobins. The alpha chains are found in all hemoglobins, adult and fetal. The beta globin chain is found only in adult hemoglobin. Fetal hemoglobin contains both alpha and gamma hemoglobin chains, and if one is testing a blood sample that has some fetal and some adult material in it, one expects that, if you obtain a reaction with anti-fetal hemoglobin antiserum, that should be directed only at the gamma chain, which is found only in fetal hemoglobin. If you perform a test on the same sample with an antihemoglobin serum which is specific for the alpha chain, which is found in both adult hemoglobin and fetal hemoglobin, you would also expect to get a positive reaction." Something about Becher was unsettling Stuart Tipple. The professor's concern with the molecular precision of things was making him sound pedantic and prolix. He had no gift for easy sentences. Although he addressed his careful words to the jury, he was clearly unable to produce a smile at the same time. The muscles in his neck squeezed out beads of moisture. He was carrying a heavy load. It was as though the professor had assumed the task of restoring to its proper level the entire reputation of science. During recess, the Melbourne Age reporter Lindsay Murdoch took Malcolm Brown aside in the corridor. "This is impossible," Murdoch said. "What is the guy saying?" No one in the media room could translate it into copy. Brown filled him in as best he could. Brown's grasp of immunology and molecular structure wasn't all that wonderful either, but he knew from Kirkham that Becher was demonstrating the failure of Coole's testing solution. Brown had understood the real point. It's not so much a series of unrelated errors, but a repetition of the same mistake. "Pity the jury," Murdoch said, as he wandered off. Station 2-day newsbreak. Proceedings in the Azaria murder trial were dominated this morning by a courtroom battle between defense witness Professor Barry Betcher and the prosecutor Ian Barker. Professor Betcher testified that serum used in the Chamberlain case by prosecution analysts was defective. This serum is widely used in government laboratories and is manufactured in West Germany. Under persistent cross-examination, the professor conceded he was an academic biologist and not a specialist in criminal investigations. But he also told the prosecutor that Mrs. Joy Cool, called in the case against Lindy Chamberlain, seemed not to understand fully the principles behind the test she used to identify fetal blood in the Chamberlain family car. "Professor," Barker said, with a sudden distaste for the title, "you heard Mrs. Cool give evidence." "Yes. You heard her say that in her experience she has examined a wide variety of forensic exhibits?" "Yes." "That she regularly gives evidence in courts in New South Wales?" "I believe so." "That she works in a laboratory that handles some 600 criminal cases a year?" "Yes." "There is no doubt, is there, that Mrs. Cool has vastly more experience than you in forensic biology?" "I will agree that Mrs. Cool has vastly more experience than I have in dealing with forensic samples." Phillips and Kirkham knew what to expect from this line of questioning. Barker was about to imprison the professor in an ivory tower. "You heard evidence, did you not, from Dr. Baxter?" "I heard Dr. Baxter's evidence." "Do you suggest Dr. Baxter does not know what he is talking about?" "No. I think that Dr. Baxter has had wide experience. I think he came here and spoke correctly of his observations." "You wouldn't doubt his competence?" "His competence as a technician?" the professor asked. "As a forensic biologist?" "I've no reason to doubt his competence as a forensic biologist." "He told us that the anti-sera at that laboratory is routinely tested, did he not?" "He told us that in one respect," the professor conceded, "but he also gave us information in another. He, I think, told us that the anti-sera are tested against the material that they supposed to react with, but I think he also informed us that if the anti-sera contained unwanted antibodies, they would not be detected in the tests they do." "You heard evidence from Mr. Culliford, did you not?" "Yes." "You heard him tell us that he's been actively engaged in the identification and grouping of blood?" "Yes." "Probably the world's leading forensic biologist?" "I don't believe I would argue with that. He's certainly very well known." "He invented the crossover electrophoresis test?" "Yes." Barker read, from the transcript, passages in which Culliford had said he found nothing in his reading of Mrs. Cool's methods or conclusions to cause him to doubt them, either in the finding of hemoglobin or of the phosphoglucomutase grouping, which she judged inconsistent with Lenahan's. "That," Barker said, "was Mr. Culliford's opinion of her work, was it not?" "Yes." "An opinion with which you, I take it, disagree?" The professor did not get as far as an answer. Justice Muirhead said, "You say you did find fault with the methodology, do you not?" "With the conclusions derived from her results, Your Honour." "You are critical of her interpretation of what she saw?" "Yes." "And her scientific examination? Am I right in saying you believe she was misled by believing that the anti-sera was specific, where you say it was non-specific?" The professor nodded. This was the crux. "You don't know whether it was specific or non-specific, do you?" Barker said. "Apart from what she can tell you and what Dr. Baxter can tell you." "Unless one of the two batches I used was the same batch that Mrs. Cool used." "You've given a great deal of evidence arising from your use of a particular batch of anti-serum." "2 batches of anti-serum." "Which is not the same as the anti-sera used by her in this case." "I don't know that," the professor said. "You didn't inquire, did you?" "No, I haven't inquired." "You made no attempt to get, from her, a sample of the anti-serum she's spoken of in this court, did you?" "No," the professor said. "I did not contact Mrs. Cool." It was not the professor but Tipple who, before trial, had asked Mrs. Cool for the batch number of her testing solution, and Tipple was refused. Although Betcher believed that Cool's own demonstration plates showed the anti-sera plainly misbehaving, the defense would have been on stronger ground if it knew which batch to experiment with. Phillips considered that, If anyone should be blamed for this, it should be Mrs. Cool. Your Honor, I'm sorry to intrude, but our instructions are that Mr. Tipple was in touch with Mrs. Cool about this matter. You can re-examine, the judge said, directing Phillips to bring it up again with the professor when Barker finished. I don't think this witness knows anything about it, Phillips said. That's the difficulty. I'm not going to stop the cross-examination, the judge said. If the antiserum she was using was specific to fetal hemoglobin, that's the end of the matter, isn't it? Barker said. I wouldn't like to say it was the end of the matter. It's the end of the matter with regard to specificity, yes. It rather destroys the thesis upon which your evidence rests. There are two theses upon which my evidence rests. You say you got an unexpected result? That is, the two bands? Yes. You tried to relate this to her work, to suggest that her antiserum was also defective because of the two bands? Is that what you are saying? Partly, yes. When I saw Mrs. Cool's demonstration slide here, it indicated to me that, on that slide, there was the same sort of phenomenon I'd observed previously. You heard her evidence in that regard, that the two bands were of no significance. Yes. You heard Dr. Baxter's evidence in that regard, that the two bands were of no significance. Yes. What Mr. Culliford said was, if it has been shown that the antiserum is specific to fetal hemoglobin, then it has no necessary bearing on the issue. It is a positive result. Do you agree with that? Yes, and I would take particular note of the last comment there. If it has been shown that the antiserum is specific to fetal hemoglobin. That is what was shown to Mrs. Cool's satisfaction by her own testing, was it not? And to Dr. Baxter's satisfaction? I believe Mrs. Cool understood that the testing had been done by a laboratory technician, and she was assuming the antiserum was specific. But she then tested it herself, didn't she? 200 times. The professor remembered that she had said something like that, but the number of times was of no moment. She was testing the suitability of the reagent to work under those circumstances, which are different from the circumstances under which she worked on the test samples that she was studying in this case. That was a roundabout way of saying she was testing with fresh blood for a reaction to old. Well, Barker said, with a deprecating smile. That's your view, is it? That is my view, the professor said. By size alone, he was ill-fitted to a witness stand. The rail hardly reached to his hips. He seemed remote, precarious, the odd man out, made the odder by an awkward and inflexible conviction that he was right. 6. The barmaid was new to the hotel. She wore her hair in an erect ponytail and was, very probably, working her way around the country mixing drinks. A reporter asked her to mix him a highball. He wanted lemon juice served in a flute with a double shot of vodka and a few drops of red grenadine over the top. This drink he had devised in the media room watching Professor Betcher in the witness stand on video. The barmaid added the grenadine to the brimming glass, drop by drop, using a drinking straw like a pipette. She asked what the drink was called. A tube precipitin, he said, watching the colors form. The grenadine spread into a ring, crimson and glowing. It hung halfway down. There's the reaction, he said. She walked to the other end of the bar. She thought he was drunk. At a table in the garden, reporters were drinking with Dr. Baxter, Mick O'Loughlin, and 2 detectives. Everyone was in shirt sleeves. Baxter seemed to be carrying the conversation which was, until then, about the Commonwealth Games. A copy of The Bulletin magazine lay on the table. Someone picked it up. This was an issue in which the reporters were reported on. A piece about scientific testimony at the Chamberlain trial described, in comical terms, puzzlement and confusion in the press rooms. The reporter flipped the pages through but couldn't find it. Baxter needed hardly a second's reflection. Page 67, he said. Sean Flannery, who had put in as perplexed a day as anyone else, was keen to know what the prosecution thought of the evidence so far. Flannery was a voice reporter with Radio 2UE Sydney, a short, feisty man with a professional reputation for tenacity and a personal reputation for trouble. He asked Baxter how he thought Betcher performed in the witness stand. Baxter inspected his fingers a moment, then looked up, rueful and amused. "Extremely well," he said. Not everyone thought so. At the Travelodge, Kirkham and Tipple were at the swimming pool. Phillips was preparing for a run on the foreshore, a new habit encouraged by Kirkham. None of them was happy with the day's work. As far as they could guess, the jury missed as much of it as had the press. Overkill, Kirkham thought. The most disappointed was Stuart Tipple, who was commonly believed to understand the blood evidence better than any other lawyer on either side. Tipple had said of the professor, "He'll hit them for 6. It simply hadn't worked out that way. Tipple sat at the end of the pool, legs awash. The sun sank behind the trees, but the air was still hot. Jennifer Kirkham, who had flown from Melbourne with the children for a few days, splashed with them at the far end. Cherie Tipple, an Adventist girl who might have the longest legs in Christendom, sat in a deck chair nibbling soap powder out of a packet, a foible she attributed, laughing, to her pregnancy. The professor was swimming endless laps in pursuit, somehow, of relaxation. He had not yet sought anyone's opinion of his testimony. Tipple knew it would come. It came when the professor's swim ended. He hauled out of the water, seal sleek and contented. "How do you think I was today?" he asked. Tipple slapped the professor on the shoulder. The fact was, a courtroom was a theater of combat so foreign to the man that he couldn't distinguish success from failure. "Great, Barry," Tipple said. "You were just great." 7. Early Thursday morning, 14 October, Les Harris opened the cage at the back of the house and tethered the dingoes to exercise chains in the yard. They ran the periphery, snouts high, sniffing. Harris replenished the water bowl. He brushed 2 tidy rolls of scat into a pan and inspected them for health. When he went inside, the dingoes trotted to the mesh gate at the driveway where they generally watched him leave for work. Harris left the house by the front door, carrying his suitcase. He passed the mesh, and Kua, a big rufous male, let out a howl of disappointment. The animal either understood the significance of luggage, or it was picking up clues from its owner's demeanor. By the time Harris's flight landed in Darwin, it was late in the afternoon. He checked into a motel and met Kirkham at the legal aid office in town. Harris had brought with him copies of everything he had sent to the coroners, to the solicitors, to the barristers. It represented years of learning and observations of dingoes, captive and wild. Kirkham laid it all aside. He had seen it all before. "Most of these points are duplicated already," he said. He was referring to the testimony of the ranger Derek Roff. The defense needed to prove now the expanse of a dingo's bite, how it hunted and fed, the manner in which it carried its prey. The way Harris normally dealt with differences of opinion was to press on with his own. He said, "The most important point is this. Food is the absolute imperative for a dingo, and the circumstances at Ayers Rock were so perfect that if a dingo did not carry that baby off, it would be atypical, even incomprehensible. The probability is nearly 100%. "The judge won't allow testimony like that," Kirkham said. "Probability is for the jury." The ways of the law never failed to make Harris irritable. He wrote that night in his diary, "Briefing with Andrew Kirkham. He is looking for confirmation of jaw openings, nothing else. Andrew maintains they have already won everything else, motivation of predation, the recorded killing of children by Canis Philippus and Latrans, natural candid, cf. dog, possibility, etc., 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 and won't risk losing any points. No one has made any attempt to investigate the one claim made by Lindy Chamberlain, and now she's being tried for murder, and still no one is paying any attention to the basic claim. Why?" He spent the next day walking around town. When he left Melbourne yesterday, the weather was crisp. Here the air was like steam. He wiped his gingery beard, and his palm came away wet. The newspaper reports added to his chagrin. Professors Betcher and Bradley, Dr. W. Mackay rose, specialists in this and that, from universities here and there. It looked as though the case wouldn't get back to dingoes for another 3 days yet. He wrote, "There are now more PhDs in Darwin than in the halls of a university. The case, which began 2 years ago with a single claim that a dingo took the baby, is now only 0.01% dingo. It is now a battle of the professors over everything but dingoes." That evening, Harris was taken to dinner by Annie Warburton, a quiet ally to the Chamberlain defense, a solicitor with the Legal Aid Office. They ate at the Darwin Sailing Club, not an elaborate place as yacht clubs go, but it had a serene view over the waters of Fanny Bay. They sat at a table with other lawyers. This was a happy arrangement until the conversation turned to the trial. A local lawyer, who did not believe a dingo would carry a baby off and had never heard of an Aboriginal child dying that way in the bush, made the mistake of saying so. The several accounts of what next happened vary a good deal, but Harris recorded in his diary, "I tried to explain to him that the comparison was not valid. Unfortunately, it was the end of a long, hot, intense day, and I was less than patient. His response was to shout at me, calling me a pseudo-expert, using some less than polite terms, scoop up his wife from the table, and storm out. This unnerved me quite a lot. Here was a man whose professional livelihood depended absolutely on being very analytical and not missing a detail. If this was his response, what chance did the Chamberlains have?" He was called into the courtroom mid-morning Tuesday after, he noted, an applied chemist and a biochemist. Kirkham opened with his qualifications: Dingo Foundation president, field observer, guest lecturer to the Wildlife Department, the Forest Commission, National Parks, and the Conservation Ministry. Harris was permitted to offer some anecdotal material about a dingo's surprising capacity for the destruction of inanimate things, for example, shearing in two a steel cable using the sharp carnassials, and of livelier objects, like a 20-pound swamp wallaby which Harris had seen a dingo kill and then carry away without discernible effort. He was an engaging storyteller, and Kirkham had him entertain the jury with accounts of dexterity and cunning, while Kirkham watched Barker for signs of objection. Then Kirkham got down to it. "I am more concerned," he said, "to explore the situation in relation to stationary or slow-moving prey. Stationary or slow-moving prey is usually taken head-on because that is the way the dingo has constructed the situation, and, if we're talking about small mammals, it will take the entire head. It will seize the entire head in its jaws, and in one motion it simply closes its jaws, and it will crush that skull. Usually they will accompany this with a sharp shake, which is calculated to break the neck of the animal at the same time." He was given a photograph of a doll wrapped in blankets lying in a bassinet, in the position in which Azaria Chamberlain was said to have been, Kirkham said. Only the top of the head was visible. "With your knowledge of dingo behavior and capacity, are you able to offer an opinion as to whether a dingo would be capable of grasping and carrying the child?" "Yes, it would," Harris said, without hesitation. "There is enough showing that the dingo would make the assessment that it was a mammal and therefore viable prey. I would envisage that a dingo would, immediately after the instant of identification, make seizure, which would be of the entire head, and it would close its jaws sufficiently to render that mammal immobile. As a continuous operation, it would then continue by making off with the acquired prey. It would have made the seizure by head, and it would be unlikely that it would change its grip in any way. That would have been enough to immobilize the prey." Kirkham asked if the dingo was likely to have spent much time in the tent. "No, particularly not in those circumstances. The beast was not likely to hang around while it had food in its mouth. A dingo, a pair of dingoes, will have a territory, and they take their lifetime's food supply from that territory. What makes the Ayers Rock area unique is that there has been an artificial food supply provided by tourists, and a number of dingoes forage in one area, and that is very rare. To our knowledge, it doesn't happen normally in dingo society. Danger of competition should, he said, cause the dingo to make off with its prey quickly." With your knowledge of dingo attacks, would you expect to see a large amount of blood? Kirkham was referring to the floor of the tent. Barker said, "Object to that?" And the judge asked him why. "Your Honor," he said, "the man is not a pathologist dealing with the body of a baby." Then he added something which annoyed Phillips, since it was said in front of the jury. "We have already been told that the dingo grabs the head, crushes, and shakes." Phillips asked that the jury and the witness retire, then complained that, if Kirkham's question was ruled out, an exceedingly unfair situation will obtain for our clients. It concerned him that Professor Cameron, whose knowledge of dingoes is minimal, suggested there would be blood in the bassinet if a dingo had taken the baby. Of Les Harris, he said, "This man, in our submission, is clearly qualified to speak about dingoes." "There's no doubt about that," Justice Muirhead said, but ruled that Kirkham should restrict questions about blood to observations of animals in the wild. The ultimate question of blood must be a question for the jury. When the jury and the witness came back into court, Kirkham asked Harris if he'd observed the letting of much blood from a kill in the field. "No, there's been very little, and it's characteristic of a kill in the field that little bleeding takes place." He put it down to the fact of death, the failure of the heart. "We've heard evidence that a dingo in the Chamberlain tent was seen to shake its head in the vicinity of the entrance," Kirkham said, and asked if that was inconsistent with behavior Harris would expect. "No, that's quite consistent, because they are observed to also shake it after they have made the seizure, and the shake is obviously intended to—" Here he shot a glance at the Chamberlains, who were staring at the floor, "to break the neck." In cross-examination, Barker was happy enough to encourage Harris in his praise of a dingo's strength. This was a clever twist, the implication being that the beast would not need to hang its burdened head, as Lindy Chamberlain saw it, or cause the drag marks Murray Havey found. Nevertheless, Kirkham thought, Harris is doing very well. He seemed to have two missions: to show how likely it was that a dingo took this infant and, at the same time, to re-educate the nation in line with the teaching of the Foundation. It was a task of some magnitude, a little like opening the window of an air-conditioned room, hoping to cool the world. Harris flew back to Melbourne and to the Foundation Committee, uneasy that he had not been able to convey even a fraction of what we knew to be relevant. Kirkham thought they had got away with a wonderful amount. 8. In Philip's room at the Travel Lodge, the defense team had a last conference with Professor Richard Nairn before he was scheduled to testify. Nairn was a neat man, in his early 60s, the professor of pathology and immunology at Monash University. He was drawn into the Chamberlain case by Phillips. To his office at Monash, Phillips had sent copies of Coole's testimony and work notes with a request that he comment. The comments came back in around a fortnight. In Nairn's view, the work Coole conducted with tube precipitans, with electrophoresis, and Ochterlony tests, all of them immunological techniques, did not establish the presence of fetal blood at all. The reasons he gave supported Becher. The testing solution was not specific. The peculiar significance of Nairn's opinion was this: he had worked in laboratories in the production of antisera and knew what could be expected from them. It was always of critical importance, he said, to retest the antiserum daily and, ideally, as part of the test run on the sample to be identified. Not only had Nairn worked in laboratories where antisera like this was manufactured, he had worked in the very laboratories in Germany which produced the antiserum Coole had used in this case. When the conference was done, and the professor had gone, Tipple confessed to Phillips that Nairn made him nervous. There was an air of the generous witness which Tipple didn't like. He seemed in some way intellectually eager, a fine trait in a scientist, a weakness in a tough courtroom. Barker would break him in minutes. "Don't be fooled," Phillips said. He had begun to laugh, a private joke evidently. "Richie Nairn is a gutter fighter." Sitting easy in the witness box, a trim, well-shaven, dapper man with precisely combed hair, He didn't much look like a fighter of any sort. If he had given his occupation simply as gentleman, no one would have been surprised. His only concession to nervousness was the need sometimes to ask Phillips for the question again in case he'd not got it fastidiously right. He explained methodology to the jury in concordant tones and as if they were carrying out the exercise together in the way Cool ought to have done it. For example, a sample could have been taken from the baby's clothes. Such a model would have made a perfect control to see whether your serum is working. And then you would want to know, what kind of concentration am I working at? Demonstrating the sensitivity of the serum. With what small quantity will it react? When you have demonstrated that, you then have to ask yourself, what is the specificity of the serum? A sacred word. How will it react? Will it react only with one thing and with no other? And you have to test that out with a model. The third thing you must do is to say, the system of testing that I'm going to use is such and such a system. And you test. You put in the model samples you have made, and you put your serum in, which you have shown to be sensitive enough, and you demonstrate that they are specific, and you demonstrate their specificity by those reactions, the reactions of identity or non-identity, and then, when you are satisfied that your system is working perfectly, you have the perfect sera, you have the perfect models, then you put in the samples. In this case, so as not to make it too hypothetical, the samples from the Chamberlain car you put into your test system. Only then do you put your samples from the car into your test system. That avoids wasting them if the thing doesn't work, and it makes absolutely sure that you have got the chance of doing things like recognizing the absolute identity of one thing with another. Fetal hemoglobin with your control fetal hemoglobin, adult hemoglobin with your control adult hemoglobin. The process seemed orderly, authentic, harmonious, even charming. Having in mind, perhaps, the same ivory tower for Nairn to which he had already consigned Professor Becher, Barker asked, "May we take it, Professor, that you are not a forensic pathologist?" "In one sense I'm not," Nairn said amiably. "In another sense, I am responsible for the forensic pathology teaching in my medical school and have been for the last 20 years. "Of forensic biology," Barker said. "A great deal of it is to do with identification of blood from trace samples and old stains, isn't it?" Nairn's agreement with this was not unqualified. "Most of their work, of course, is on fresh stains." "All your work is on fresh stains, isn't it?" "By no means. All my work is on all sorts of tissues. Some of it is very old. I've actually made a study of the aging of animal tissues." He got no further. "I was talking about blood," Barker said. "Including blood, as an example of an antigen. Have you ever done it to assist in a criminal case?" "I've never actually been asked to identify blood in a criminal case," the professor said carefully, "other than by just looking at it, but it doesn't differ in any way from the identification of any other human or animal tissue. Blood is a tissue. It doesn't differ. It just happens to be red. People can see it, and it comes out easily. But the principles are precisely the same." His smile was a beam of pure reason. "You have never ever before been involved as a witness in a case of suspected homicide, is that right?" "No, it is not right," the professor said. "I've been an expert witness in 4 cases of suspected homicide during the last 6 years. In Victoria," Barker was now referring to Nairn's home state, "is there a forensic science laboratory?" "Yes." "Does that employ biologists?" It employed biologists, though Nairn confessed he didn't know exactly how many. "Does it concern itself with mayhem or wounding, suspected cases where blood requires to be examined for forensic purposes?" "Yes." "By forensic purposes, we mean for the gathering of evidence for presentation to a court?" Nairn agreed with the definition. "This is the speciality of the forensic biologist, is it?" The implication was clearer now. Barker meant to distance Nairn from any involvement with the practical. "Yes. As a matter of fact, the forensic pathologist to that group attended a course I gave 16 years ago," the professor said, thinking back, "to learn how to do it." Richard Nairn had taken his first degree in 1942. This was at the medical school at Liverpool University, UK, and he graduated with honors, intending to go on to higher degrees. But that was the third year of the war. The Royal Navy lost HMS Eagle and then Manchester, both sunk on convoy to Malta, and a convoy to Russia repulsed, off Norway, the heaviest German air attack anyone afloat had set eyes on until then. This seemed reason enough to choose the Navy in which to see service, and Nairn spent much of the rest of it as sea-going surgeon lieutenant to a flotilla of minesweepers which cleared passages for fleets in convoy between Europe and the Far East. For peacetime, his choice was pathology. His higher doctorate came in 2 years and a Ph.D. in another 5. By 1963, he was a specialist in immunology, a fellow of 2 Royal Colleges of Pathologists, and took up his chair at Monash. He added another Royal College, this time of physicians in Australia, and the Royal Society of Edinburgh. He lectured and researched now in London, Toronto, Cleveland, Ohio, and the University of Texas. How much of your day is spent teaching? Regretfully little, teaching undergraduates. I would suppose 2 hours a week. How much on administration? 2 days a week. How much in research? My research happens to be immunological, and my professional work and immunological work would make up all of the rest. He added, in case it seemed rather a lot, my week, of course, being a 7-day week. I'm happy to inform you that you are not the only person who so suffers, Barker said. How much of your time is devoted to the identification of blood? This was becoming a familiar theme. As I said, very little, rather more in the last few weeks, since I wanted to make myself competent in being able to give opinions in this court. It seemed like an opening. Barker said, When did you commence to make yourself competent? I began to make myself competent 25 years ago, the professor said. When did you commence to make yourself competent to give evidence in this court? When I was first asked to give an opinion about certain aspects of this case, about mid-July. I have repeated all of these things in my own laboratory. And before that, was very little of your time devoted to the identification of blood? Nairn wagged an amused finger. I don't accept that blood is any different from any other tissue. A great deal of my time has been devoted to the identification of human and animal tissues, some of it forensically in the identification of remains. I am considered to be possibly the final consultant in this in many cases. When we confine our discussion to blood, Barker said. Justice Muirhead seemed to think the dispute was not getting very far. I think what he was trying to point out is you can't really confine your discussion on immunology only to blood when you are looking at questions of experience and endeavour. He seems to have managed it so far, Your Honour, Barker said in a gritty voice. Barker turned to matters of specificity and the testing solution. If you tested your anti-fetal hemoglobin antiserum against over 200 samples of adult blood, and if you did not receive a positive reaction to any of them, that would be a good practical method of determining that it was not specific to any component of adult blood? The professor shook his head. Not necessarily. It would depend entirely upon what test you were using, what concentration of adult blood you were using. But 200 tests by a competent biologist in which no positive reaction was obtained? Barker was referring to Cool. I have already referred to the inferiority of quantity over quality. 200 bad tests are poorer than 1 good test. I know your opinion of forensic biology as a science, Professor, Barker said, but Nairn would have none of it. Antisera can alter on storage. They are kept frozen, and then they are taken out again for another time, and this is why all testing has to be done at the same time when you make the test. It can't be based on what happened last week, even yesterday. Professor, if they are done properly by someone who knows what they are doing, that would be rather an adequate series of tests, wouldn't it, for the purpose? Were they done on the same day? Nairn insisted. Or is this a series of tests done in the course of a month? He smiled, waiting. There was no answer from Barker. He sat down, as Tipple noticed, heavily, looking weary, ragged. He let out a sigh that might have been in him a long time. It seemed exasperation was all he had left. 9. In a burst of confidence, long since out of date, a detective had told journalists, "The moment a defense witness steps off a plane in Darwin, we'll know about it." Evidently, the intelligence system was not working well. The prosecutors Barker and Pauling were now openly complaining that the defense was taking them by surprise with each additional scientist. During a recess, a Southern journalist took Phillips aside at the door to the conference room. "John," he said, "I need to know when we are likely to finish. Family reasons, you see." He then asked Phillips the number of witnesses yet to be called by the defense. The correct answer was 3, but something in the man's eyes suggested caution, and Phillips doubled the figure. The grateful journalist headed off, a progress Phillips watched through the space in the partly closed door. The man changed direction, once he was alone, and made for the police room. "Spies on our tails," Phillips said, grinning, to Kirkham. 10. If the police intelligence system was going to recognize anyone, it ought to have been Vern Plukan. He was not by nature commonplace. A stocky, graying man of striking energy, he was well used to interstate and international assignments and, if he was not first off an aeroplane, he was not far behind, an impatient gatherer of luggage, an imperious hailer of taxicabs. Any policeman watching for a myopic boffin was way off. He was well known to the medical and scientific communities, at least those of the southern and eastern states, as a forensic pathologist, physician, and biochemist. He was director of pathology at the Geelong Hospital, a consultant to others, and senior examiner in forensic medicine at Melbourne University. He belonged to the societies of his profession in Britain and the United States, and Americans who read their forensic medicine journal carefully would find his name familiar because he was on its board of directors. When he climbed into the witness stand, Phillips began to read the curriculum vitae. Plukan had provided a summary for the purpose, which they were able to get through in 12 minutes. Then Phillips said, "Dr. Plukan, I'd like now to refer you to some evidence given by Professor Cameron." Plukan did not present himself as a tolerant man. It was as if he wouldn't bother with that manner of deception. His voice was abrasive. Many of Cameron's opinions, when Phillips read them out verbatim, seemed to stimulate in the doctor something between disappointment and anger. Phillips and Kirkham hoped he would be able to keep any excess of it in check. Quoting Cameron's examination of the baby's clothing, Phillips read, "The only way in which one can reproduce this pattern of bleeding is by a cut wound across the neck." "From my experience in my study of his clothing," Plukan said, "I would say that Professor Cameron's statements are completely unfounded." "Have you seen circular patterns of bleeding on clothing like this from head injuries?" Cutthroats and head injuries were wounds familiar to Plukan. He was a pathologist to coroners and to busy hospitals. He had seen patterns of blood from head injuries there which were not dissimilar to those on Azaria's clothes. He looked relieved to be able to agree with Cameron over something. The jumpsuit was, most likely, fastened up to the neck while the child bled, and the collar upright. But their comity did not last long. He showed photographs of a dead child Azaria's age, its head over the gaping jaws of a dingo skull, to dispose of Cameron's belief that no canine could take a child that way. When Phillips read out another, "The child would have had to have been alive for the bleeding to have occurred," Plukan showed that the dead bleed, too, holding up a photo of a man 2 days dead in a gloomy mortuary, whose blood had then seeped away to the floor overnight. Asked if he would expect, as Cameron did, more blood in the Chamberlain tent if a dingo had taken the child, Plukan said, "I wouldn't necessarily expect, if it was taken by an animal with a firm grip, that blood would immediately come out." He threw open his hands to show the airy and abundant possibilities. "Depending on the vessels punctured at the time, if it is a vein punctured, a tooth could well form a plug. It depends on how tight he gripped." "Does extensive bleeding necessarily follow from severe crushing injuries to the skull of an infant?" "I've seen extensive crushing injuries of a child's skull, also adult for that matter, without any real, obvious external injuries." He was talking of children run down on highways, of a child dropped 20 feet on its head, and of 3 others, he said, striking his palm with a fist, killed by the blows of a carpenter's hammer. In the video room next door, the air was gray and bitter. The air conditioning could not cope with the cigarette smoke. No one could open the windows. Monitors at both ends of the room showed a duplicated Plukan inspecting Cameron's photographs of Azaria Chamberlain's clothing. He looked, on the screens up here, like a contestant in a television quiz show. "You have 10 seconds starting now," Lindsay Murdoch said, wiping sweat from his chin. Plukan said, "I've looked at this very carefully, and, with due respect to Professor Cameron's opinion," respect did not seem about to overwhelm him, "to me, I can find no evidence whatsoever that would convey to me, even on this highly contrasted ultraviolet fluorescent photograph, the imprint of a hand." He shook his head, marveling. "I've attempted to, but I can't." From the top of another screen, the judge asked, "You expressed the opinion, do you, that the blood further down the jumpsuit in the area of the chest, of the tummy, is direct flow blood?" "Yes, it could all be direct flow blood." Plukan shrugged. "I can't see anything to convey to me that it is any different from the top, other than it's less concentrated." When Phillips sat down, Murdoch said, "He's finished." Plukan's testimony had taken less than an hour. Barker rose, his back to the screen, but not to cross-examine. "I seek leave," he was saying, "to have the cross-examination of this witness deferred until tomorrow." In tones of complaint he added, "Your Honor, I have 3 times asked Mr. Phillips to give me some indication when he was calling a professional or technical witness, and some indication of the general area of the evidence." "We can go on to someone else," Phillips suggested, without rising. Justice Muirhead asked if Phillips objected to the doctor's deferral. "Not at all," Phillips said, and Plukan stood down. The court took the morning's recess. Radio journalists telephoned voice reports through on the interstate lines, and the rest took a coffee break. The monitors caught the lawyers again at the bar table and the return of the judge to the bench. The witness stand was empty, and it suddenly occurred to Murdoch that there was here an opportunity for the defense to keep Barker under pressure. "Phillips might throw Michael Chamberlain at him right now," he said, "just to give him a hard time." "Chamberlain will go last," someone still at the coffee bar said. "There are 3 more scientists yet, I happen to know." The monitor quietened. Then Phillips called Michael Chamberlain. 11. 3 press artists sat in the gallery sketching Michael Chamberlain while he testified. The one next to Malcolm Brown was a slim young woman with short, dark hair. She was a freelance, and Brown had bought some of her drawings for the Sydney Morning Herald. He thought she was excellent. Of her name, he only knew the syllable Jo. She also sold flowers and seldom wore shoes. She came from Perth, circumnavigating the continent in some fashion which did not always involve proceeding forward. Today she was in jeans and a T-shirt and sketched, with a felt pen, an umber paper she took from a folder. She made 4 drawings of Michael Chamberlain and discarded each of them. When Barker got up to cross-examine, something in her subject's face must have changed, and she worked more quickly, but she rejected another 2 before she passed one to Brown. The scene she had created was truthful, although it did not, in fact, exist. Brought from other places in the courtroom to do duty here, with a grave escutcheon of government and an ominous shadow of the jury box. The witness stand imprisoned him to the chest. Whatever sudden understanding had informed her pen, it had got him right this time. Exerted brow, a hesitant underlip, and a gaze resigned to all manner of expected wrongs. Barker said, "What did your wife tell you had happened to the child?" "That a dingo had taken her." "When did she tell you in detail, Mr. Chamberlain, precisely what she had seen?" "We talked about it on and off during the evening." "What did she tell you?" "I don't recall exactly the conversations we had." "There is no doubt, is there, that your wife was the last person to see the child alive?" "No doubt," Michael said. "And do you tell us that you are unable to say Just what she told you about the child's disappearance? In no detail can I tell you. He lowered his eyes. We prayed, he said. Did you think then that the child had died? I knew she was in great danger. From what? Dying. Of what? Dying. He was unsure of anything else. What did you think was going to cause her death? Either exposure or bleeding. You didn't know from where she was bleeding? No. You didn't inquire whether your wife could help you find out? No. Why? It didn't occur to me. The fact was she was bleeding and she was in danger of death. Could it be because you knew that the dingo did not take her and that she was dead at the hands of your wife? This time he met Barker's gaze. No, he said softly. Sister Whitehead said, The evil one is the accuser of the brethren, and it is his spirit which inspires men to watch for the errors of the Lord's people and hold them up to notice. Did you say to Constable Morris something like this on the occasion he came back to make some inquiries? It was the will of God? There was nothing that you or I or anybody else could do about it? I don't recall saying it. Do you deny it? I'm not going to deny it. It's something you believe? I believe in God's will. Did you believe it was the will of God when you told Morris? God's will is over all. I suggest you couldn't see then, and you can't see now, why your wife would not have seen a baby dressed in white being carried in the mouth of a dingo out of the tent and past the front of it. I believe my wife's account, Mr. Barker. I suggest the whole story is nonsense and you know it. No, Mr. Barker. How do you account for the damage to the collar of the jumpsuit? I can't account for it. Did your wife cut the sleeve? I don't think she did. Did she cut the collar? I don't think so. Did you bury the jumpsuit with the child in it? No. Did your wife? I don't think she did, Michael said, lips pursed, candid, and close to missing the point of his own words. There was no spirit to his answers, only form. Brown now recognized in this a phenomenon from his days in the fighting ring. There sometimes comes a moment when an opponent, outmatched and damaged, concludes that nothing worse can happen to him than has already. He simply discards the seriousness of his plight. Brown had seen it in the eyes, in the tardy and incautious face, in the shockingly undefended mouth. Brown had to force himself to hit it. Next morning, Brown walked to the courthouse with Pastor Olson. Olson said the Chamberlains were planning to move, on the last day of the case, to a secret destination from which they could slip away quietly from the press after acquittal. From the way Olson spoke, it seemed he now thought acquittal a possible course of events. Brown wondered if this also reflected the thinking of Olson's friends in the police force. When Brown got to the courtroom, it was unattended. From waiting journalists came rumors of a suicide overnight. A court orderly, estranged from his wife, had shot himself through the head with a revolver. Although the incident had nothing to do with the case, Brown couldn't shake off the feeling that no sorrowing human being ought to work in a place like this. Everyone sat around, hushed and gloomy, until court resumed. Mr. Chamberlain, Barker said, your wife, I suggest, told you that the story of the dingo was false very soon after the child was killed. No, he said. His voice was limp. It seemed he might not have slept much overnight. Did she not? She did not. She told you she was going to suggest that the dingo at the tent was the same as the dingo she saw at the rock, Barker said, meaning the dingo Lindy and the McCombs had seen near the Cave of Fertility. Could you repeat that, please? She told you that she was going to suggest that the dingo at the tent was the same as the dingo she saw at the rock. I didn't remember that, Michael said, wearily. He seemed now to understand little, not the questions, not the answers, not the dangers to come, not the manner of enemy he faced, not the ways of the world around him. He had none of the equipage of combat. So bereft was he that Brown now saw the prosecution's sudden paradox. It was in danger of showing that Michael had neither the wit nor tenacity to carry out the long and complicated deception with which he was charged. Had Phillips and Kirkham foreseen this all along? If sacrifice had anything at all to do with this case, Brown thought, The offering was Michael Chamberlain. Barker asked how it came about that, the day after the baby vanished, Lindy Chamberlain had suggested they take the troublesome boys on a drive to Mount Olga. Did she say, "Why don't we go to the Olgas so the boys will stop playing up," or something like that? No, that wasn't said. What did she say about the boys playing up? This was a conclusion Michael had to come to alone. Because our children had to go on with life, normal as much as possible, and it was just to keep life as normal as possible. Look, Barker said, didn't it occur to you that there might have been a remote possibility, however remote, that the child was still alive on Monday morning? Miraculous, Michael said, by way of confession. Barker recognized the tone. You believe in miracles, don't you? There are plenty of precedents for them, aren't there? It was a neat dilemma and took some moments' thought, but all the pastor could come up with then was, I'm also a realist. Nothing seemed further from the truth. When Michael Chamberlain stood down, Brown watched him walk slowly to sit beside his wife and watched them hold hands in the quiet space between the chairs. In his face was fatigue, relief, even a little ludicrous pride, but not a line of bitterness or rancor, and Brown recalled a time he had asked the pastor about emotions like those. It was at Kurenbong. They'd had lunch, and Brown was leaving. He stood with Michael in the driveway. The day was overcast, autumnal, although the season was spring, and brittle leaves blew across the grass. The trial was not long off. Brown asked Michael why there was no bitterness in him now, no outrage. I must not commit the sin of bitterness, Michael said, if I'm ever to see my daughter again. He was thinking of paradise. 12. Station 2-Day, newsbreak. Pastor Michael Chamberlain finished giving evidence to the Darwin Supreme Court this afternoon after 6.5 hours in the witness box. The defense then recalled the forensic pathologist Dr. Vernon Plukan, who had previously given evidence opposed to the prosecution's expert from London, Professor Cameron. In cross-examination by prosecutor Ian Barker, which at times became a shouting match, Dr. Plukan said the patterns of blood on baby Azaria's clothing could not support Cameron's opinion that the baby's throat had been cut. Dr. Plukan also said he had found microscopic traces of congealed blood in the damaged fibers of the jumpsuit collar. This showed that the clothing was damaged while the baby's blood was still fluid and not, as the prosecution believed, long after she was dead. Then, at the end of this 27th day of the trial, John Phillips announced that the evidence in defense of Lindy and Michael Chamberlain had closed. 13. News bulletins foreshortened the proceedings somewhat. After Barker finished with Plukan, having made the most of the doctor's short temper and unrelenting resistance to compromise, one brief witness remained. This was Lorraine Hunter, a nurse whose young son was bitten by a dingo at the Ayers Rock camping ground the day before the Chamberlain baby disappeared. Phillips closed the defense evidence at 4:20. It was a Friday, so Justice Muirhead released the jury for the weekend. Phillips then handed up to the judge a series of submissions. One asked for a no-case ruling, others that he should direct the jury it would be dangerous to convict as the evidence stood. Justice Muirhead said he would consider them later, but he looked doubtful. He should act firmly on the assumption that the matter will proceed to its ordinary conclusion, he said. Phillips seemed disappointed for only a moment. He hadn't expected it would come off anyway. It was more an expression of their risen spirits. He was hopeful about the fourth submission. This asked the judge to strike manslaughter from the list of possible verdicts. The defense was ahead. He wanted no half measures in the jury room. 14. Cameramen backed down the courthouse steps, shooting, crouching like supplicants in front of the descending Chamberlains. Brown watched them go. They had 3 hours left now before their last Sabbath of the trial. It was hard to tell how pleased they might feel. They were not giving much away anymore. Brown had heard it said that Lindy was ready to sue everybody in the police and in the media just everybody, once the trial was over. Tipple ushered them into a little red sedan, and they pulled out into the traffic. Lindy had turned her face from the flashbulbs. Barker came through the doors, and reporters caught him on the top step. Today was his birthday, as they all knew, and someone asked how old he was. 47, he said. Going on 100. When Barker broke from the journalists, he offered Brown a lift to the motel. Barker chatted as he drove. Brown rather liked him, liked the attractive mixture of jauntiness and gravity. Brown asked how the prosecution team thought the trial stood now. Don't quote me, Barker said, but we've got to be realistic. He thought the prosecution couldn't hope to nail home convictions any longer. We might have a chance for a disagreement, he said. He laughed. For another trial, the Crown could get someone else. I don't know if the Chamberlains could take another trial, Brown said, the will of God notwithstanding. If I had to take what Michael Chamberlain had to take, Barker said quietly, I'd be an atheist. Brown walked the remaining block to his motel. Because it was Friday, some of the light trucks and four-wheel drives passing by were loaded with camping gear. Weekends here are of some moment, treated as if they are longer vacations, the very reason many people choose to live in this part of the country. In a few weeks now, the wet will come in, the air will be damp to the touch, the creeks broken, the tracks bloated, foliage becoming the freehold of leech and mosquito, and no one will want to go anywhere. While Darwin gamblers waited on the completion of a new casino at Mindale Beach, they rode money on roulette wheels, blackjack, and two-up in the plush rooms of the Don Hotel. The restaurant there was crowded most evenings, and impatient diners could play the numbers while they ate. A party of pressmen and lawyers had taken a table. Bill Hitchings, a Melbourne reporter with a wide grin and a nose broken long ago, was there, alongside the prosecutor Pauling. They had been aware for some time now of a rowdy party at another table and were trying to take no notice. Evidently, some of the jurors had decided on a celebration to toast the close of evidence. They toasted it many times. An incident which caught Hitchings' eye was the quick departure towards the powder room of a woman over whose gown her partner had thrown up. Pauling must have glimpsed it, too, so intent was he on looking the other way. Then the event Pauling seemed most to dread happened. One of the jurors was heading over. He was unsteady. Cigarette ash streaked his shirt front. Not many hours ago, he had sat in court while the judge warned jurors against discussing the trial with anyone, but there was no doubt what he was about to do. His was the compatriot smile of inspired drunks everywhere. When his gaze adjusted from the general to the particular, he said to Pauling, I want to talk to you about this case, and looked seriously about for somewhere to sit. With as much good humor as Pauling could muster in the time available, he got to his feet, spun the man around, and set him on his way, a change in alignment that the juror acknowledged with a wave of his reluctant hand, which turned then into a finger beating time to some infectious dance step as he contemplated the amusements of the path ahead. Gay dog. Pauling flopped back into his seat. Jesus Christ, he said. Saturday morning Sabbath school took most of the hour from 10 o'clock, and, since Bible study was not only for children, it was often the same congregation which stayed on then for divine service at 11. The church stood on a neat and unfenced block with a grassy border. The apex of the roofline was high, the fall steep. Altogether, it made much the same shape as a pair of hands lightly pressed in prayer. They seemed to be somehow North American hands more than any other, perhaps because of the association between slender, modern gables like these and the snows of New England, but the affinity is just as strong inside, where the appointments are pine wood. The congregation, on 23 October, half-filled the church. Stuart Tipple, who would cut Sabbath short when he got back to work this afternoon, sat near the gentle Irene Heron, Lindy's friend. Michael Chamberlain sat with a space at his side for his wife. No one was certain if she would attempt the journey from the bungalow behind, considering the heavy and uncomfortable condition in which she was. This was the usual time now, while folk waited for the beginning of the service, for the church proclamations. Pastor Olson read from a list of imminent events. He stood with his feet planted wide. A bunch of keys hung from a clasp at his belt. Tipple thought about the indelible nature of a policeman's training. "Right," Olson said. "There's one more thing. The trial that has caused so much fuss in this town is nearly over. Those prosecuted under the due process of the law will be acquitted, and as they rightly should be. We have all prayed, and everybody will be pleased when it's over. Now, every one of us has suffered the jibes of people who thought they were guilty, but I don't want to hear about any paying back of old debts. No mocking, no unpleasantness, no unchristianly behavior. And the first test is right there, just outside that door." This brought an appreciative giggle because, outside, news hounds and press photographers had the building staked out. A carload of photographers returned Sunday night, fresh from Lim's. Lim's is sometimes called the cage because the concreted beer garden is surrounded by wire mesh to keep drinkers under control, either inside or out. The current attractions at Lim's were bouts of mud wrestling between slippery and very nearly naked girls, but the show was over. It advertised spaghetti wrestling for next month. The journey from Lim's to the Seventh-day Adventist Church had lasted long enough that someone in the back seat had rolled a joint, a surprise because it was considered perilous to carry dope interstate by aeroplane, and nobody did. The burning leaf smelled green and sweet. He passed it around. Asked where he got it, he said, "On a junket." He meant one of the trips on which the government here was sending pressmen at weekends, sailing, fishing, or shooting, anyway outback. One of these excursions was led by a local detective and guide. "I don't have any of my own," the photographer said. "I thought it would be a straight trip, just a drunk, you know. And then the cop," and here he named a detective they all knew, said to the guide, "Have you got any?" And the guide had nothing, and the cop said, "Have you smoked all the good stuff I got you last week?" Well, I could have fallen over, you know, so I scored later. He tapped his forehead wisely. "It's a whole different town here." When they pulled up outside the church, it was dark. They got out and looked around. The church was still. The door was locked. They heard music, fluted cascades and a fervent bass, but it came from the manse. So far as they could tell, it was not a recording. Someone was playing the organ. They considered ringing the doorbell and shooting film as it opened, a speculative expenditure of effort, but something in the music sapped resolve, and someone who was still thinking straight suggested they drive to Dick's Disco instead, in case it was raging there, and it seemed the best suggestion of the night. Phillips was working in his motel room. He had, on Monday, to address the jury before Barker did so. Because the defense had called evidence beyond the accused, it forfeited the right of last reply, of the final word to the jury. He worked sitting at a coffee table with the window drapes closed halfway against the glare until early evening, when he flung them apart for the dusky sun asquat on the Timor Sea. They'd been working like this for 2 days, and it was almost done. Kirkham and Tipple flipped through the transcript for passages of testimony he might read to the jury, indexing those he had already decided on. The transcript made 6 volumes now, at a guess 750,000 words. He'd made a list, selecting quotations from Barker's opening address he wanted to use. The prosecution might yet shift its ground, assume some other form, unanswerable, as soon as he turned his back and sat down. It had tried to do that from the day the investigation began. He wanted to nail the accusations to the wall, answer them line by line. He wrote, "This is the case we were called on to meet. This is the case we met." The themes divided with ease into 5. Support for the Chamberlain testimony by the campsite witnesses, corroborative trails and drag marks on the dune, dingo behavior at Ayers Rock, the Chamberlain's response to the tragedy, and the destruction of the prosecution's scientific case. There were 73 witnesses he must cover in some way, many in detail. God, It would take 2 days talking. 2 items deserved treatment separately from the main architecture of the speech. The arterial spray, which Metcalf found over the passenger footwell, stood out because it was upon this the Crown based the suggestion that here the baby's throat was cut. Well, Michael had found an answer of some sort with the duplicate from the Tirana from Maitland, and Metcalf found it sticky to the touch, so whatever it was, it didn't originate from Azaria Chamberlain a year earlier. He should spend the early time restoring Sally Lowe to the narrative. Any jury must have loved her, gentle, observant, manifestly honest. If she heard the baby cry from the tent when the Crown said it lay already slaughtered in the car, the case was over right there. Barker couldn't avoid meeting that. Phillips wrote, "Sally Lowe is an absolute bar to conviction." Tipple turned up the passage in which Barker said, "There will be evidence that a Mrs. Lowe also heard a noise at this stage. Of course, on the Crown case, it was impossible that it was the baby because the Crown says the baby was dead. So Barker will say she heard it in her imagination. If she did, she imagined it at just the right time, the time Aidan heard it. And when Michael, who the Crown said was not yet in on the secret, heard it. She examines it at a time when a dingo has freshly dragged something up the dune in the darkness, something which leaves furrows for Rolfe to discover, and when it is laid down, leaves the pattern of a knitted garment for Habe." Phillips wrote, "What are the odds against 2 independent witnesses searching the area Lindy Chamberlain indicated, making that find fortuitously? Astronomical." They were quite right, the way Phillips thought about it, to worry so much about motive. In any other circumstantial case, it would have been treated as an essential, a crucial step in the inferential path. His task was to make it so again. The problem had as much to do with the nature of human understanding as with the equations of logic. He didn't yet know how he would handle it, but he wasn't worried. He knew it would come. 15. One of the most fundamental facts in nature is the love of a mother for a child. A mother will make all manner of sacrifices for a baby. A mother will die for a baby. We all know that. It happens again and again. We know, too, from the evidence at this trial, that some mothers may harm or kill their babies. But we know from the evidence that's not contrary to nature when it happens, because we know the natural love of those mothers for their babies has been distorted and warped and removed by the effects of a severe depressive illness. So the killing by mothers of babies in that connection can be said to be motiveless killings, killings without reason. Now just listen to what Dr. Milne, Mrs. Chamberlain's doctor, had to say about it. Question: On the occasions you saw Mrs. Chamberlain, and I interpolate, we know there were many, daily in hospital and routine checkups thereafter, on the occasions you saw Mrs. Chamberlain, did she show any symptoms, even of the mild form, of postnatal depression? Answer: No. So the result is this, isn't it, that the defense, which doesn't have to prove anything, has proved beyond any doubt that Mrs. Chamberlain does not come within the category of mothers who might commit a motiveless killing. We know that's confined to mothers who suffer from this severe form of postnatal depression, and she didn't have a scrap of symptom, even of a milder form. So the question of a motiveless killing caused by illness is, in this case, gone forever. Now, what are the alternatives? There is only one alternative, and that's a killing with motive, a killing with reason. Here was an opportunity to wedge the Crown into a corner. The prosecution has had 2 years and 3 months to think of a reason. They can't. They can't supply you with a reason why she should do it. And we have excluded a motiveless murder on Dr. Milne's evidence. In this area of the case, the supply of a reason why this mother would kill her baby, the prosecution is bereft, bankrupt. But the defense isn't bankrupt. We have been able to obtain, from witness after witness after witness, 90% of them independent of the Chamberlains, proof after proof after proof of this mother's love for a baby. Ladies and gentlemen, if anything, we are suffering an abundance of riches. Listen to Mrs. Lowe. She sort of had a new mum glow about her. Listen to Mrs. West. They said they'd always wanted a girl, and she was very much the baby they wanted. And later, she had a great care for the baby. Mr. Eccles, the afternoon before the baby disappeared. She treated the baby like a true mother. Mrs. Eccles, a very caring mother, an affectionate mother. Mrs. Wilkins, who saw her near the climb. She was a perfect little mother. Mrs. Goss, she was very warm and affectionate mother. Pastor Kennaway, who performed the ceremony which is apparently similar to a christening. I'm convinced they loved the baby. Now what have we got? 10 people there, from north, south, east, and west of our country, every one of them telling you the same thing. And we have traced it from the time of the pregnancy through to the birth, through the 9.5 weeks and— Here Phillips pounded the table with the flat of his hand. Up until minutes of that child's disappearance. All these people tell you the same thing. This mother was not the sort of mother that Dr. Milne explains might commit a motiveless killing, a mother who had rejected the child. This lady, he pointed behind him, where Lindy sat now with her heavy legs supported by a chair, was a caring mother, a mother who loved the child, a mother who wanted her, who welcomed her, and who looked after her. And notice, it's a feature of this case, that people like that, all the civilian people there in terms of this woman's relationship with her baby, all support her up to the hilt. That is a feature of this case. Every one of them. So much for the question of a motiveless killing. Sydney Morning Herald. Crown's Azaria arguments laughable. QC. The words and actions of Pastor Michael and Lindy Chamberlain at the time of their daughter's disappearance in 1980 and in the events following were inconsistent with guilty knowledge, a QC submitted in the Northern Territory Supreme Court yesterday. Mr. John Phillips, representing the Chamberlains, said that in too many instances the couple's actions would have been illogical if they had wanted to cover up their baby's murder. He submitted, in his closing address to the jury, that there were too many people around in the 3.5 hours the Chamberlains had spent at the campsite after the baby disappeared for them to have done anything secretly. Discussing the prosecution case relating to Michael Chamberlain's camera bag, Mr. Phillips said that the scenario painted for the Chamberlains would have been, if not so serious, laughable. The defense had met and answered the Crown case. Mr. Phillips said the Crown's assertion that the Chamberlains would have had ample opportunity for secret burial of the body had not been borne out by the evidence. Brown caught Phillips outside court on the second day after the address finished. Phillips asked how it seemed to go over, and Brown said, "Excellent," which caused Phillips some embarrassment, as though he might be thought fishing for compliments. "It was a team effort," Phillips said. "We answered the Crown, scientist for scientist. I'd never seen a defense case better put together." Brown couldn't remember a more thorough one, certainly, but the phrase scientist for scientist seemed to miss some deeper and more elusive issue. He wondered if this were a scientific case at all. It had more to do with simpler beliefs. The astonishing notion of unfathomable evil had been around so long that Lindy Chamberlain wasn't judged by the same assizes as everybody else. She inhabited some closet of immortal experience, ancient and unnatural. 16. I said in my opening address, the Crown does not venture to suggest motive, nor does it invite speculation about motive, Barker said. That was my position then, and it is my position now. We haven't shifted. We don't know why this happened. All the Crown says is that you should find it did happen. The only question here, so far as Mrs. Chamberlain is concerned, is whether or not you are satisfied that she is guilty of murder. I told you quite openly at the start, we can't prove a motive, and I haven't come here to prove a motive. I've come here to prove a murder. And that, I respectfully submit, is what has been proved. Now let's examine the dingo story. I've said, and I said it 7 weeks ago, it's preposterous. It's been seized upon by the accused to explain what otherwise was incapable of explanation. Having told the lie, she was stuck with it. I'll suggest to you it has continued as a lie with various twists and embellishments since 17 August 1980. It was conceived as a lie, it was a lie told to Inspector Gilroy, it was a lie told to Sergeant Charlwood, it was a lie told to the coroners, and it was a lie told to you. What is this dingo supposed to have done? It managed, if her story is true, to kill the child in the bassinet, drag her from the basket, divest her of 2 blankets and a rug, shake her body vigorously at the entrance of the tent, then carry her off into the night in such a way that it left virtually no clues in the tent by way of blood or hairs or anything else. It left no blood or drag marks by the outside of the tent. It was able to pass by the child's mother in full view without disclosing that it was carrying a baby. It managed to kill the child while all the buttons on the jumpsuit were done up, and managed to carry the baby a long way. At the shortest, it walked some 4 or 5 kilometers, if the story is true, to the base of Ayers Rock, and if during part of that distance it walked through the bush, it managed to do so without tearing or pulling the fabric of the jumpsuit, collecting almost nothing in the nature of seeds or sticks or other vegetation along the way. So all in all, ladies and gentlemen, it was not only a dexterous dingo, it was a very tidy dingo. It managed to cut the collar and the sleeve with a pair of scissors, an unlikely circumstance, you may think, even if we're dealing with the most intelligent and perceptive of animals. And be clear, with respect, about this evidence. It remains unanswered. The overwhelming evidence is that the jumpsuit was cut by scissors. Supposing the dingo was on trial here, how could you possibly convict it on this evidence? Where is the evidence? Where is there one substantial clue, apart from the account given by the child's mother, pointing to a killing of this child by a dingo? There isn't one. The case against the dingo would be laughed out of court. This put Malcolm Brown in mind of a bumper sticker seen around town. It read, "Save the dingo." He watched Tipple whispering at the bar table to Kirkham. Tipple scribbled something on a notepad, tore it off, and headed for the door. He looked pale and angry. Tipple carried the note outside, past the cameramen lounging in the shade, then stuffed it into a pocket and made for the car park. The errand involved a trip to the hotel to fetch a volume for Kirkham. It was a welcome respite. Barker's gift for deadly humor seemed designed to appeal to some affinity for derision deep in the national character. He kept thinking, we haven't come this far with the case to be treated like a joke. When Barker finished, Phillips asked that the jury retire a moment while he addressed the bench. He had objections to make. First, Barker had told the jury that criticisms of Mrs. Cool and Dr. Baxter in this trial cast doubt on convictions in cases in which they testified elsewhere. Phillips said, "In our submission, there is a danger, once that is said, that the jury may feel that an acquittal would in some way operate professionally as a reflection on Mrs. Cool and Dr. Baxter. Of course, it wouldn't do any such thing." Justice Muirhead found a note of his own of the comment. "Have no worries about that," he said. Evidently, he had decided already to say something about it in his charge to the jury. "The second matter is this. It was said consistently, Your Honour, that the only basis for the dingo story, as it has been characterized, is Mrs. Chamberlain's evidence. It was said there is no support for her assertion that a dingo was involved at all. In a detailed final address, not a single reason was given why Mrs. Lowe's evidence of hearing the baby cry should be discounted, no reason whatsoever advanced as to why she should not be believed." "I will be dealing with that," the judge said. But Phillips thought he had not yet made the full point. "It's just not correct to say that it all rests on Mrs. Chamberlain, because if Mrs. Lowe is right, that is what you would call the absolute bar to conviction." "Yes, Your Honour." The judge found Phillips' agitation amusing. "Don't worry," he said. 17. At midday on Thursday, 28 October, Justice Muirhead adjusted his chair so he could face the jury box and said, "Mr. Foreman, ladies and gentlemen of the jury, it is common ground that Azaria Chamberlain, then only 9 weeks of age, died at Ayers Rock on or about 17 August 1980. In this court, her mother stands trial on a charge of murdering her baby and the father of being an accessory after the fact. Inquests have come and gone. The tide of opinion and innuendo has ebbed and flowed." The public gallery was full. Others waited in the corridor. Lindy Chamberlain leaned on her pillow. Her nervous fingers were never very far from her mouth. Michael stared at the floor. The judge turned the pages of his notes and spoke quickly, and those reporters who had shorthand judged the rate at 150 words a minute. The charge was expected to take 2 days, and by late afternoon, radio and television reporters were describing it as even-handed and straight down the middle. With no bias to reflect, newspaper editors had problems choosing captions. The Sydney Sun asked, "Do you believe that Azaria could be taken by the head without leaving bleeding?" The Melbourne Age chose, "Dingo cannot be ruled out, jury told." Running the foreshore reserve in shorts and sneakers, Malcolm Brown saw Phillips on the path ahead and caught him up. The air was sticky and slow. Brown asked how he felt about Muirhead's charge. "Okay, so far." Phillips seemed to be fitting the syllables to his laborious breath. "How are the vibes now?" Brown gathered he was being asked how everyone saw the likely outcome. "Fine," he said. "I think so too," Phillips said, turning for his motel. The way Brown cleared with Lindy Chamberlain the information he was given by her talkative friends was through Irene Herron. Brown now wanted to write something about the eve of the verdict and asked Mrs. Herron to carry the message. He didn't want to jeopardize any chance of an exclusive interview with Lindy later, so he had waited in the corridor after court for the answer. Mrs. Herron walked by without turning her head. "It's all right," she said. Chamberlain family making plans. Pastor Michael and Lindy Chamberlain are preparing to return to their home in Avondale College, Currambong, New South Wales, immediately after their trial in Darwin, if they are acquitted. Mrs. Chamberlain is due to give birth in less than 3 weeks, but the couple will try to obtain a medical certificate saying birth is not imminent and Mrs. Chamberlain is fit to travel. Alternatively, they will ask a doctor to travel with them. A source close to the Chamberlains said they preferred the idea of having their baby in New South Wales and would want to leave Darwin without delay. The couple are anxious to be reunited with their children, Aidan and Regan, who are staying with Mrs. Chamberlain's parents, Pastor and Mrs. Cliff Murchison. The boys have been following reports of the trial closely. The chef at the Hotel Darwin set up a charcoal grill in the garden bar. He turned purple buffalo steaks and pale fillets of barramundi with tongs, and a waitress sold tickets at a counter. It was a birthday party for a press photographer everyone called Spider, who seemed to be shouting all the drinks. The television crews had been here some time now, since the major bulletins went to air in the eastern states between 6 and 7. Journalists from morning newspapers with evening deadlines phoned copy through from the media room and got here late. Gary Tate, the head technician for Channel 7, was telling the crew of a rival station that he had asked Justice Muirhead for leave to televise the judge's charge. It was Tate who had televised Coroner Barrett at the first inquest. "Muirhead said he'd think about it, but then he knocked me back," Tate said. The rebuff hadn't made him at all glum. He considered he had the best transmission arrangements of any crew here. He had a high-frequency dish set atop the nearby Hooker building, for which permission had been denied all networks. Tate hadn't bothered to apply for permission. He had carried the equipment up there himself, disguised as a maintenance man. At a table by the pool, Sean Flannery from 2UE and Murray Nickel from the Macquarie Network sat with Barker, Pauling, and some court staff. Flannery had taken time off between courses to dive in the pool and, misjudging the depth, came up with a gored nose and an affronted expression. He sat around wet and dazed. When the conversation got to the trial, someone asked Margaret Rishbeth how long she thought her judge would go. Margaret was the judge's associate, a young blonde-haired woman who, while the judge read through his charge, handed him volumes of transcript and successive pages of notes. "He's got 120 pages altogether," she said, "and we're through 70 now." Nickel did the sum. "We might finish at lunchtime," he said. Concerned with the news breaks, too, Flannery said, "They could be out a long time." He asked Barker what the odds on conviction were now. "Pauling is still hopeful," Barker said, grinning. "He thinks we could get a hung jury." 10 against 2, Pauling said, but he wouldn't tell them which way he thought the 10 and 2 would vote. The party ran late. Someone played guitar and sang country and western. Those who furtively ascended the poolside stairs to the rooms above descended more serenely later, smelling of musky smoke. They made a conga line, chanting, until the tail-enders fell into the pool, helpless and splay-legged. They trod water in billowing shorts and floated half-filled goblets, of champagne now, from one to the other. The festivity had changed its substance. It was a celebration. Soon they could all go home. In Kirkham's room at the Travel Lodge, Tipple stood up from his chair, but he didn't look anxious to leave. He wasn't feeling so good, he said. "I know," Kirkham said. "I'll get tight in the guts, too." He'd told Tipple they had done everything now that could be done. "It'll be all right," he said. "You're too close to it to be able to see that." Tipple walked down the corridor to the elevators. He was too close to it, right enough, he thought. He came from the same New Zealand town, Christchurch, as did Michael Chamberlain years back. He remembered Michael's inaugural address as a young preacher. He even remembered the topic of the sermon. It was, "Should Adventists suffer nervous breakdowns?" Malcolm Brown couldn't sleep. He turned the air conditioner off, but within a half hour he was sticky, so he turned it on again. It occurred to him that a clattering fan had become the true sound of the tropics. He reached into the liquor cabinet and poured a heavy shot into a tumbler. He socked it down and lay back. When he drifted to sleep, whatever part of his mind that was still in touch with things now knew it was a mistake. He was entering a dream he'd had before. The first time was the night after the Galvin inquest, and then he'd had it 3 nights in a row. It always began the same way. He was somewhere so remote there was no periphery to the world. It was dark. He could see a pale bundle on the ground. What drew him closer was an appealing gurgle of childish delight. He could not help but look. It was a baby with a doll's face and glassy eyes, and it was gagging on its life's blood. He lay there until the sound of it was loud enough to wake him. 18. Reporters got to the video room early, around 8:30, because the court was due to sit again at 9. Brown went there to telephone the Herald so his editor would know the judge's charge would last the rest of the morning session, and they might get a verdict any time between 2 p.m. and midnight. He wanted plenty of space, front page. While they stood around drinking coffee, Mike Lester was taking bets. Lester was a television journalist. Tanned and pinched, he looked more like a strapper than a bookmaker. He was offering 5-4 on for acquittal and 2-1 against for a hung jury. Anyone wanting to ride money on conviction could begin by haggling at 10s. Brown had caught Lester's telecast at the motel last night and didn't like it. He told Lester, "You're favoring the defense case too much." It wasn't any of his business, but he was glad to have said it anyway. He wanted to see dignified, Queensberry rules professionalism everywhere. "Where's your objectivity?" he said. He thought the judge's charge impartial and punctilious, and ought to be reported that way. Lester's riposte sent Brown angrily for the stairs. "You're not listening between the lines," Lester said. Brown crossed the courtyard where television crews were laying out cable. Inside, the corridor was crowded. He shouldered through, short-tempered. The sketch artist, Jo, was selling her courtroom drawings. Those of the Chamberlains were sold out already. She discounted the others at 6 for $100 and was doing good trade. Nothing was going to convince Brown that he was not listening as intently between the lines as anyone else, but by mid-morning Lester seemed about to be vindicated by subsequent events. The judge said, "With the question of the experts, pay such heed as you are convinced the opinions of experts require. Where they differ, I direct you to tread warily, especially where the circumstances with which they are dealing are in doubt or in a state of confusion. That is to say, where the evidence is beset by many possibilities or contingencies, be cautious. You will not convict on circumstantial evidence unless it is sufficiently strong to be inconsistent with any reasonable hypothesis other than the guilt of the accused." He gave some examples and went on. "It is perhaps fair to say it is a case of novel and unique circumstance. Opinions are opinions, impressions are impressions. Bear those things in mind. We are not treading on the ground of unequivocal, unchallenged scientific opinion. To the contrary, the scientist's opinion on vital issues is divided. Don't forget that. Brown thought, without the scientist, the Crown is nowhere. We are back to the campsite. Some similar understanding evidently led the judge's reasoning. He said, I spoke to you earlier of the presence of foraging dingoes in the area, and the further evidence called by the defense has highlighted that evidence, and of the fact they could be menacing and dangerous. You may think, to put it simply, if ever there was a time when dingoes were becoming a problem, it was in August 1980. Is it but coincidence, fortuitous from Mrs. Chamberlain's point of view, that she put forward, as the Crown asserts, this false explanation for a murder just at that time, in August 1980? I turn for a moment to the evidence of character. It is common ground, ladies and gentlemen, that neither Mr. nor Mrs. Chamberlain have ever been in trouble with the law before. You have heard this. You have heard of their capacity to help people such as Mr. Lenehan. The judge read passages from the testimony of those in praise of the Chamberlains. It is trite to say that people do commit crimes for the first time. Of course they do. But when you are considering whether you are prepared to draw the inference, in this case, that Mrs. Chamberlain deliberately cut Azaria's throat in the car, you must, in considering that, bear in mind the character evidence as a factor which may help you in considering the likelihood of her committing this appalling crime and of her husband being an accessory after the fact of that crime. So you will consider all these things as a background to the allegations that this mother carried out a sudden homicidal attack on her baby. You will consider the evidence of those people who were there on that night, quite independent people, who saw them both and comforted them both after Azaria disappeared. It may be, as I've said earlier, that Michael Chamberlain and Alice Chamberlain were strong, but you may think, ladies and gentlemen, that the evidence justifies no conclusions other than that their subsequent sadness was at times manifest to others. You will bear in mind the preservation of that camera bag, the preservation of that car, the exposure of that car so early afterward to the opportunity of an inspection. I ask you that you'll bear this in mind. If your wife had murdered your child in that car, what would you have done over the ensuing months? Would you have still had the car? Would it have been thoroughly scrubbed? Would the scissors be still left in the car? He reserved to Sally Lowe the last word. Well, you saw and heard her, he said, and it is for you alone to determine what reliance you place on her memory and on her evidence. But I know you'll bear this in mind. If Mrs. Lowe heard that cry, and if it came from the tent, you may think that the only inference you can draw is that it was Azaria's last cry. And if it was, you may think that the only further inference you can draw is that Azaria was still living. She was not, and could not, if Mrs. Lowe is correct, have been, as the Crown asserts, then lying dead in the car. As the jurors filed through the jury room door, Phillips leaned toward Kirkham and let out a breath. You couldn't complain about that, he said. Brown wrote, So the case ends as it began, with a cry in the dark. The Lord should have been here by now. 1. Journalists stood around in the video room talking, smoking. The screens were empty. Radio reporters, who would be live to air all along the eastern seaboard the moment the verdict came through, jotted in their notebooks, trying out newscasters' phrases, useful alternatives, whatever happened. A reporter came in with a message from Kirkham. He wants an undertaking from us, the messenger said. That Lindy and Michael can walk out of the courthouse without being mobbed for quotes. He thinks we owe them a dignified departure if they're acquitted. He laughed. I said we'd consider it. It provoked more anger than consideration. Tell them nothing doing, someone said. A reporter from a Sydney tabloid suggested making the promise, and then we hit them anyway. Lindsay Murdoch didn't think that was on. Let them go, she said. We can turn up at the church later. Sean Flannery turned away and pushed through for the door. Don't count me in on any deal, he said. I'm paid to get interviews. This summed it up. In the pause that followed, everyone seemed to be thinking the same thing. The Chamberlains will want to talk sometime, and nobody wanted to blow the chance with some petty and fruitless deception. 2. Paul White, the newscaster for Channel 7, Sydney, was designing a wrap-up. The idea called for his narrative, a retrospective he would first establish from a stand-up in the witness box, over a cut-to-library film of the Chamberlains, cut back to pan along the vacated jury box while he quoted from the judge's charge, cut to the interior of the jury room. This last shot he needed to film now. The jurors were at lunch in a private hotel room, so the deputy sheriff, whose domain the court was, let the crew in for 10 minutes. When they had enough footage, White ran the tape back on the monitor in the truck outside. The shot in which White was interested took in the long room, the narrow table, crazy paved with notepaper and documents, the skewed and discarded chairs, and executed a pullback slow enough to give the impression of respectful withdrawal. Having in mind transmission a few hours from now, White wanted a sense of completion, to establish the occasion, ahead of time, as history. The retreating lens caught, lying on the near end of the table, a photograph. He stopped the frame where the photograph was clearest. This was a print of the last snap Michael Chamberlain had taken of Lindy, dandling Azaria on the slopes of the rock, the world aslant underfoot, the child mystified, the mother happy. White told the technician to end the scene on that shot. "It says something," he said. 3. Nothing was going on in other courts in the building. Orderlies closed the doors along the empty and resonant corridors. They left open only a side door, since the Chamberlains were in custody now, waiting it out in the defense conference room rather than the basement cells. The journalists had made for the Darwin Hotel, leaving behind a sentinel with a pack of beer, a promise of relief after a half hour, and a handheld CB. The arrangement called for another radio in the pool garden at the hotel where the waiting reporters lounged, and traffic on that frequency betrayed a third, placed somewhere on the noisy counter of a cocktail bar, through which they were ordering drinks. At around 5:30, Margaret Rishbeth, at a shady table with Nickel and 3 other radio journalists, checked her wristwatch. The jury had been out a little over 3 hours. "They were told to take a quick vote first," she said, "so they must be talking about something." Nickel was in a more cynical frame of mind. "They live here," he said. "They can't be seen to knock it over too quickly." The garden bar was getting crowded, and the waitresses busy. Murdoch sat with the photographer McNeil and Shears, the correspondent with the London Daily Mail. Murdoch said, "The verdict may come out on this Sabbath." The sun had gone off the garden. The frangipani smelled moist and fragrant, which seems here the soft nature of evening time. "The Chamberlains drove to Ayers Rock on this Sabbath," he said. A table in the main lounge was taken by 2 young lawyers and a counselor from the legal aid office. They had arranged to meet here the traveling entertainers Jan Wozitsky and Debbie Sonnenberg, who were busking in Darwin for enough to get by. Earlier, they had worked the mall, Jan playing harmonica and clacking spoons, while Debbie, whose body is articulated wherever she chooses, folded herself double into a costume and became, for all the purposes of illusion, a duo of high-stepping ballroom midgets with embroidered smiles. The last place they stayed for any length of time was Ayers Rock. Jan was saying, "The Pitjantjatjara think this trial is a waste of money. Of course the dingo did it. The dingo is a spirit of death." Margaret Rishbeth, called away to a sudden telephone call, walked back to her table. She had a message from the deputy sheriff. "The jurors will stay out at least until 7:30, she said. The waitress who arrived with their drinks had just come off shift at the Travel Lodge. She told them Phillips had ordered a 6 of champagne. "Not for now," she explained. "Just on hold." 4. Long before he got there, Brown could see spotlights on the courthouse. It looked like a military shrine for the fallen. The crowd he could see only in silhouette, but it obliterated the forecourt and spilled on the footpath. His fear as he crossed Mitchell Street was that he was unaccountably too late, but by shading his eyes he made out folks sitting in the gardens, quiet and asprawl. The glare came from luminaires, flood lamps mounted on grids, 6 of them, set to face the fastened doors. A high telecamera raked faces in the throng and lingered a moment on 3 women sitting on deck chairs playing cards, while another held a performing newscaster who was connected to a curbside TV truck by a thin microphone wire, which ran down the inside of his left trouser leg and crossed the pavement like a discreet surgical prosthesis. Brown supposed all this was on air right now, at home. He found Frank Morehouse standing on the roadside plantation. Morehouse, who loved commotions of any sort, and thought he might write something of this one into his film script, had wandered around, eavesdropping. "They're talking about everything except what they're here for," he said, as though this were far more interesting than the converse might have been. He now had a half bottle of bourbon stashed in a healthy shrub nearby. After a glance around for meandering policemen, they each took a slug. A boy hurried past, carrying a can of Coke and a freshly minted pizza. Brown craned over to look along the curb and saw a kitchen van, which he had taken earlier for a television truck. It was puffing smoke and doing brisk business. Sean Flannery, leading Nickel and Murdoch, pushed past heading for the video room, and they were in a hurry. Murdoch turned long enough to shout, "Verdict!" in Brown's direction, and kept going. Everyone now knew something was afoot and packed around the doors, and Brown guessed that those with pocket radios had heard the message on a news flash. Over the heads Brown could make out a picket line of policemen inside. The doors remained inexplicably closed, and he sprinted instead for an entrance at the far end of the forecourt. When he got there, he saw that the police were directing everyone that way. Some calming measure of crowd control, evidently. Inside, a cop motioned that he should not run in the corridor. The guard at the door of the court had been doubled. He pulled out his press pass. His mouth was dry. 5. Jurors who avert their eyes from the dock when they walk into court will convict because, as Brown knew the given wisdom, they cannot bear to look upon the faces of the damned, so he watched their slow procession all the way, men and women with evasive faces, every one, and the erect foreman, on the verdict of them all, adjudged guilty the first accused, guilty the second, in a quiet and unhesitant voice beside 2 women who covered their mouths with porcelain fingers and wept, and Lindy's bloated and stupefied face drained away all the colors of life when the judge committed her to prison for as long as she shall live, and departed the bench, leaving everyone to break the moment as best they might, Michael by rubbing his shining cheeks with a cuff, the jury by turning to follow a resolute orderly towards the door, while Brown knew he was shouting something after them, the word "bastards" sounding in his suddenly flaming ears, and someone had him by the sleeve, and was sitting him down. 6. In the video room, the 2 reporters who were of such standing that they were assured of immediate clearance to air, on demand, were Flannery and Nickel. Nickel's direct line to Macquarie was in the next room. He ran, the moment sentence was passed on Lindy Chamberlain, a journey of a dozen lanky paces or so, composing copy as he went. Others broke for the booths by the wall. They found Flannery there, his palm pressed over one ear, on air already. He had opened his line to 2UE in Sydney as the judge came on screen, and Flannery then divided his concentration to cover both the proceedings of court and the radio program he could hear through the earpiece. The studio announcer selected a music track and waited on Flannery's cue. When the jury filed into court, Flannery said, "Come to me, now," and heard the announcer say, "To Sean Flannery and Darwin." Assuming the harsh and streetwise tone he liked for crime rounds, Flannery began, "And the jury, lined up, standing quietly now." The transmission lasted 4 1/4 minutes, and he calculated that his listeners were never more than 2 seconds behind the precise course of events. He signed off, slammed the phone down, and walked to the deserted center of the room, cocky, preening his shirt front. Everyone else was still talking, and some hadn't got to air yet. A tabloid journalist who had missed the announcement that Michael Chamberlain's future was not to be considered until tomorrow roamed about asking, "What did he say?" but was shrugged off. Someone shouted from a booth, "What's life in this town?" "A real long time, pal," Flannery said. 7. The stairwell to the basement cells was spiral and shadowy. Kirkham followed Phillips down. Their iron footfalls sounded like the slow strokes of a clock. Kirkham expected Michael would want to know how things could go so wrong, and he couldn't think of an answer. Lindy, judging by the way she looked in the dock, wouldn't see so much as a light passed in front of her eyes. He could hear her sobbing now, somewhere in the hollow shafts below, lost and piteous. The air down here was hotter, step by step, as if they were measurably closer to the netherworld. 8. As Brown ran up the stairs to the video room, everyone was coming down, anxious to catch the departure of the prison van. Brown phoned the duty editor at the Sydney Morning Herald and promised him copy on time. Then he looked the empty and strewn room over. He could hear a cleaner's broom tapping the stairwell. A notice board on the wall announced briefings, excursions, parties, long past. An inclined Darwin Casino postcard, hanging by a surviving thumbtack, showed a baize-green roulette table surrounded by a dozen posed and delighted gamblers. The bets were down. A smiling croupier was about to spin the wheel. Written underneath, weeks ago now with a fading pen, was the caption, "A jury considers its verdict." Brown tore it down and flipped it into a bin. He walked out into the oily night, crossed the forecourt, descended the steps. Trampled wrappers and winded drink cans littered the ground. There was no one about. A television van straddled the curb, a door ajar. Gary Tate's footpath telephone sat on a step. A retreating foot had some time dislodged the handpiece, which lay disabled on the ledge beneath, like an upturned bug. Brown decided against joining the mob he guessed was covering the vehicle exit behind the courthouse. This was his photographer's job, he thought by way of excuse, but he didn't have to search far for the truth. It was his private fear that the custodians now, whoever was arranging the final event, would choose to send her off in a limousine, uncurtained, blatant, exposed to the flashbulbs and to the tumultuous gaze, just as jailers once drove the condemned through village streets in uncovered carts, and for much the same reason. 9. An orderly led Phillips and Kirkham along a carpeted corridor to the judge's chambers and knocked. When he opened the door, they saw Justice Muirhead refreshing a tumbler from a whiskey bottle he then set on the desk. He was in shirt sleeves. "Well," he said, raising his glass by way of a greeting, "I didn't think I exactly summed up in favor of a conviction, did you?" The orderly withdrew, closing the door on the rest of the conversation. 10. There seemed to be parties offering all over town, but Brown wasn't keen to go to any of them. After he phoned his copy through to Sydney, he had a few drinks in the lounge at the Darwin Hotel with one of the sheriff's staffers, who said the first jury vote came out 4 for conviction, 4 against, and 4 undecided. He was then asked not to use the information, but told the man not to be a fool and walked off. He drank with Murdoch in the Regency room, watching a table where the waiter refused to serve 3 journalists who were rolling joints on a dinner plate in full view of a nearby party hosted by a uniformed superintendent of police. Brown knew those journalists were upset with the verdict, and plainly he was observing some calculated gesture of insolence more than anything else. When he walked through to the garden lounge, things were peaceful enough, until 2 radio reporters who were otherwise firm friends got up, gray-faced and shouting, from a poolside table and knocked each other into the water. He walked from there, the slow length of the quietening town, kept walking, sat down on the foreshore a while, hugging his knees, watching the interminable tide grow milky with the ebb change, and the sun came up over his shoulder. 11. Justice Muirhead convened court at 10 o'clock next morning, although it was Saturday, and called on Phillips to speak for Michael Chamberlain. Phillips read directly from notes. The argument he put, for some measure of leniency, concentrated for the most part on the prisoner's previously blemishless character, the needs of his now motherless boys, and his certain notoriety forevermore. Reporters thought Phillips seemed surprisingly unfamiliar with the document from which he was reading. Indeed, he had never set eyes on it before. He had told Kirkham that a sentencing plea was simply beyond the powers of concentration he had just now. So although the voice was Phillips, the words were Kirkham's. The public gallery held only a few spectators now. Most of those seated in the pews were journalists. They heard the judge sentence Michael Chamberlain to 18 months' hard labor, which seemed about what everyone expected, given the gravity of the conviction, and someone whispered to Brown, "Par for the course." Then the judge said, "I have, in this territory, the power to suspend the operation of sentences and, in this case, I consider it not only appropriate, but in the interests of justice to do so." He ordered that the prisoner be placed on a bond of good behavior for 3 years and fixed the amount of the bond at $500. 12. The first time Brown tried to get into the women's compound at Burma jail, he was arrested for loitering. The mistake he'd made was assuming he only had to ring the bell and wait, but when no one came to the gate, he decided to take a look around the grounds, and 2 turnkeys took him away, an arm each, into the men's division for questioning. Brown was of a size that he could have clapped their heads together, but he went quietly, unmanned by his gawky embarrassment rather than funk. He told them he was ghosting a book for Lindy Chamberlain, but they looked as if they'd heard everything now and sat him in the superintendent's office upstairs. The superintendent, a gingery man with fingers which tirelessly roved the edge of the desk, stared at Brown a long time, then told him to get out. When he stood on the hot pavement outside and the clatter of the closing latch had died away, Brown took a breath and looked for a telephone. He found a coin phone in the visitors' room and called a cab. Next time he came here, he'd make sure he was armed with more authority than a press pass. He had decided already to stay around Darwin until he'd got his interview. The Berrima Penitentiary stands on the side of a ridge, a caricature of entombment, stony-faced, a terminal of the spirit. There is in the air, always here, the Moorish smell of rotting bodies and ignoble deaths, which, although known to panic newcomers, has nothing to do with the prison. Much of the paddocky land around is owned by a livestock company, whose slaughter yards are here, and decaying offal is thrown into sodden pits between which a few wormy horses graze. Long-term prisoners say they get used to the stench in a few months. As if to underscore the richness of illusion, this is the end of the road, of Tivendale Road, which loops this part of the hillside enough to service the penitentiary gate and doubles back to the highway. Guards high on the prison walls have a clear view the entire length of the roadway, of the mown grassy field it encloses, of the single-story women's block in the center of it, and of the few women on exercise schedule in the compound. If all the women went to exercise together there would, on any normal day, still only be 8. There is a garden with well-disciplined flowers and a small games court. This tidy complex might resemble, more than anything else, a sports pavilion of steamy showers and locker rooms surrounded by a mesh fence whose only purpose is to restrain an absconding basketball if it were not for the strands of razor wire glinting in the sun like gossamer caught high on the posts, and the way every green thing growing outside is close-cropped so not to impede the firepower of sentries sighting from the penitentiary walls. Not long after Brown's cab took him back to town, most likely a half-hour afterwards, a bright red sedan drove up to the main gates and reversed into a parking slot. Stuart Tipple and Michael Chamberlain climbed out and walked to the visitors' room. A warder there, behind an armor-glass pane like a bank teller's, told them which way to go, and reached for an intercom. They crossed to the women's compound, walked to the gate by way of the concrete path, carefully avoiding the grass, eyes straight ahead and held level. They were exhibiting, Tipple noticed, the excessively predictable behavior of those who knew they were under unwavering surveillance from above. He wondered if it was any different for people who didn't believe in God. He'd heard all manner of stories about the sort of women who worked in these places, and was happy that the blonde warder leading them from the gate to the accommodation block was homely. He guessed there were more than a few prisoners who knew precisely how many paces there were to the path he was treading. The corridor they entered seemed to run the whole length of the building. The wall paint, which would grow dew once the wet season came in, was now cool and glossy. A gecko clung to the ceiling with sticky fingers spread, waiting slyly for mosquitoes. Visiting room was first right. Lindy was already there, waiting. Her arms flew around Michael's shoulders while Tipple and the warder stood back. The warder said, "Will," in not too reproving a tone, and told them to sit down. They sat at a spindly table, and the warder withdrew to the corridor. "They'll take me to the Casuarina Hospital to have the baby," Lindy said, "if I'm not out on bail for the appeal." Tipple nodded. He had promised to begin work on an appeal Monday. Lindy had, herself, all sorts of suggestions for grounds of appeal, but Tipple was guarded. "It's a highly technical area, appeal. A bail," he said. "You just have to take things day by day now." She seemed to have thought about this already. "I'll act as if everything is going to happen today and plan as if I'm going to live forever," she said, which was familiar enough to be a quotation from somewhere, but Tipple couldn't place it. It wasn't the scriptures. She was anxious to talk to Michael about arrangements for the boys when he was away from the house. "Jenny Miller will help out," she said. Jenny Miller was an Avondale College girlfriend who had helped out before. Lindy didn't want to forget anything. She was alert and efficient, far more than her husband, who kept asking her to repeat things. She had instructions about clothes, meals, school. They had dressed her here in a light blue smock which did nothing to hide the size of her belly. Tipple supposed she was not allowed notepaper, since she kept glancing at a pale wrist on which she had jotted single words with a leaky ballpoint. Prison-wise already, Tipple thought. A marvel. It seemed as if Michael was not responding to all this with the enthusiasm of which she thought him capable. His lips were pinched, his eyes clouded. She took his hand. Tipple knew her quick eyes were searching for something cheering. "Michael," she said, as if speaking to someone half her age, "I think you can buy yourself a new camera." It was a purchase on which they all knew his heart was set for months, and this was a sort of gesture Tipple thought quite typical of so astounding a woman, but the event which drove him now to leave the table for the window, for the view of a grim exercise yard and a forbidden world beyond, was the change in Michael's face. He was visibly happier. For the flight home, Tipple rebooked on an earlier aircraft and registered Michael as Pastor Olson, a subterfuge designed to beat a press stakeout at Darwin Airport. It paid off by seating them within a few rows of Ian Barker and a half-dozen ogling journalists. As the crusty and deserted Birdsville track passed underneath, the deadliest roadway in the history of the automobile, as an easily amused captain announced over the PA, Michael reached for his camera to shoot through the porthole. He took it, as the journalist reported almost without exception, from a black camera bag he kept beneath his legs. He put it back afterwards without the lens cap, a slipshod lapse, but it was his old camera now, although the new had not been bought. 13. Tipple liked to walk to work in the mornings, around 8:20, from his villa on the residential hill overlooking Gosford, and it felt good to be doing it again. He strode through the town center and turned into Baker Street. The easterly had in it the fresh tang of the cool Pacific. Gulls rode the breeze from the rooftops. The law office occupied the ground floor of a crisp building built in the 70s. He was the only Adventist lawyer here, and a partner for almost a year, although his name was not yet on the shop front. He walked the length of the typing pool, and the chatty young women seemed pleased to see him back. He collected his mail and carried it into his office. The room was low-ceilinged, around 4 meters long by 5 across, little larger than Lindy's now, he caught himself thinking. He opened the Sydney Morning Herald and saw that Malcolm Brown had somehow got into the jail to interview Lindy and was astonished by her high spirits. Brown ought to know her better than that by now, Tipple thought. He opened mail and sorted it between the out trays, annotated in his neat hand for action. There was an envelope postmarked New Lambton, near Newcastle. It was from Barry Betcher. Although the jury has not yet had to consider its verdict, I'm confident of the outcome. There is only one verdict appropriate. I'm confident that the Chamberlains will not only be found not guilty, but there will be a wealth of commentary. Tipple checked the date of postage, 25 October. Phillips began his final address that day. Andrew Kirkham and John Phillips are excellent in court, and other members of your profession will give them the acclaim their abilities deserve. However, the credit for assembling the material with which they could work goes to you. I applaud you for the tireless effort. He held his head in his hands. He couldn't have believed he would cry like this. He was okay right up until now. A secretary looked in and pulled the door quietly closed. You will always carry with you a feeling of personal satisfaction. It was so joyous, a voice. A Quiet Place on Redemption Street. 1. The birth was celebrated everywhere. Melbourne Herald. It's a girl. Sydney Sun. Girl for Lindy. The Australian. Lindy has big, strong, healthy girl. New York Times. Australian killer gives birth. Darwin, Australia, November 17th. Lindy Chamberlain, who was jailed for life last month for killing her baby daughter, gave birth to a second girl today, but the baby was taken away from her 4 hours later, prison officials said. Australia's Northern Territory government, acting on medical advice, said she could not keep the baby with her in prison. She called the baby Kalia. Let them try to make something out of that, she said. 2. Kirkham was sitting in his law chambers in Melbourne drafting documents for an appeal. He had a tough job finding appellable errors in the judge's charge. The transcript only served to remind him how well they'd thought the defense had done. The afternoon mail brought a letter headed Maidstone Prison, Kent. It was from prisoner Godfried. I'm enclosing a copy taken from papers of last Saturday, 6th November. I do hope these will be of some assistance in the appeal of Mr. and Mrs. Chamberlain. Please, if it is possible, could you give them our condolences? The cutting from the London Daily Mail was entitled, Judge Attacks Dingo Trial Doctor. Kirkham had already seen a version in the Melbourne Age, the report of a neglected baby trial in which Professor Cameron had given evidence of a post-mortem examination, recording the dead baby's weight on a piece of blotting paper rather than in a more durable manner and estimating, wrongly, the weight the baby ought to have been if properly cared for. Kirkham laid the cutting aside with a smile. Evidently, prisoner Godfried hoped it might somehow constitute a separate ground of appeal. The appeal to the federal court sitting in Sydney was scheduled for February 1983. Phillips and Kirkham asked Tipple to consider briefing a specialist in appeals at the Sydney bar, and Tipple chose the Queen's Counsel Michael McHugh and the junior Miller. With spectacular early success, they had Lindy Chamberlain released on $300 bail, and she went home to Currambong, where reporters and television crews, who were barred at the boom gate entrance to College Drive, skirmished with fit and implacable students. The appeal ran from 7 February to 3 March and coincided with lunatic tempests and bushfires all over this end of the continent. In Victoria, an early death toll had reached 50, and in South Australia, no one yet had time to count. In Sydney, foyer windows darkened outside the appeal court on the 21st floor, which seemed to be at storm altitude, and lift wells sighed. A journalist brought a radio into the press room and everyone crowded around listening to Murray Nickel, who was covering, live to air, wildfires in the Adelaide Hills. He was weeping. The blazing house he was then describing was his own, collapsing room by room. When legal argument finished and the appeal adjourned, journalists held a reunion in the upstairs bar of the Surrey Hotel. Even reporters who were no longer covering the case made it. So did Joy Cool, in a canary-yellow frock, chatty but not staying long, and Brian Martin, the Northern Territory Solicitor General, in Sydney on business unconnected with the Chamberlain case. "But forgive me a passing interest," he said, loosening his tie. His pate was ruddy, and he drank with his feet spread wide. He was used to having the floor when reporters were around. Another journalist joined the circle. "Is he one of us or one of them?" Martin said, so the man could hear. The newcomer, perplexed, said he was just a reporter, which caused Martin to laugh. For Territorians, there is no such thing. On the morning of 30 April, the day of the federal court's judgment, Malcolm Brown met Tipple going up in the lift. Tipple thought the judges were split, 2-1, win or lose. Brown knew this was wrong, but he couldn't say so. He knew a girl who worked in the judges' typing pool. Lost, 3-0. 3. The thing that got to Barry Betcher was, when he thought about it, that having started, he couldn't pull back out now. He still needed to know that the anti-serum Joy Cool used was the same, and from the same batch, as the anti-serum he had demonstrated was not specific to fetal hemoglobin in his own laboratories. He and Tipple climbed aboard a flight to Germany and visited the manufacturers. Betcher was interested in the batch numbers of anti-serum exported to this country between April 1975 and September 1982, which covered the period amply. He found that throughout this time, all supplies were from the one batch prepared in 1973. The Germans were still a little skeptical, so he suggested he run his tests again, then and there. To make sure no one was in any doubt that the testing solution was reacting with the blood of an adult, he bared his arm and donated blood of his own. They dried it out. He used the concentrations Cool had used. The anti-serum reacted, and the manufacturers gave him a certificate to attest this was so. Non-specific immune reactions can be observed under certain conditions due to denaturation of hemoglobin A in adult blood and due to alteration of the relative concentration of antigen and antibody. The anti-serum against hemoglobin F, fetal, of this company, therefore, is not suitable on its own for the identification of fetal or infant blood and adult blood. It was wonderful news, but, very likely, too late. 4. Enough letters sympathetic to the Chamberlains were published in correspondence columns of the city dailies that 2 law school academics called for an embargo. A Sydney barrister wrote to the Herald complaining of disrespect for the legal system, and Lindy Chamberlain support groups grew up all over the country. Facilities at the Berrima jail could not handle the increased volume of mail, and neither could its famous prisoner. She began a monthly bulletin with a readership list numbering in the hundreds. "God and I are doing okay," she said. A plea for justice committee in Melbourne began collecting signatures for a petition and was soon joined by the National Freedom Council. An Adventist businessman, whose enterprises included newsletters about health and the investment of monies, sent a squad of investigators to Ayers Rock in search of new evidence and announced his intention to stand against Chief Minister Everingham at the next elections. An analyst commissioned by the Sydney Sun now pronounced Lindy Chamberlain a person without aggression or dishonesty, a conclusion lately reached on the shape of Lindy's signature and a discipline called graphology, which was the analyst's profession. Just after midnight on 18 August, at the Inland Motel at Ayers Rock, a road train driver by the name of Crabbe, who was still sore from being thrown out of the bar, walked to his truck, backed up until he had the bar dead ahead, gunned, and rode her through. It was a Mack Superliner. The bull bar picked up the shop front, and the truck made it through the barroom easily enough, carrying much of the wall like a runaway forklift, but the momentum was not sufficient to take the load out again the other side. The truck stalled halfway, smoking. Crabbe climbed out of the cabin while the debris and the dust were settling and, according to one of those still alive, smiled and walked out the way he had come in. The date, news reports noted, was the 3rd anniversary of Azaria Chamberlain's death, and the black tracker who trailed meandering Crabbe across the sand dunes was old Win Matty. 5. Deep in French's forest, a misdirection that will make Sydney-siders smile because this part of the forest is as built up as a Hollywood hillside, is a belt of private bushland which Michael Thornhill Productions was renting as a movie lot. The attraction for Judy Reimer, the director, was the nature of the scrub, which was arid and sparse, and where it was too healthy, they stunted it with chainsaws. Trucks spilled red sand everywhere, and they trampled it down, counterfeited a solid barbecue, built knee-high railing, and brought in Toyota Land Cruisers repainted with Northern Territory insignia. Along the track, far enough that the lights wouldn't bother the filming, were mobile offices, caravans, kitchens. Morehouse's script called for 2 versions of drama separately, the Chamberlain's account and the Crown's. The shooting schedule specified crisp, dark nights. Under the lamps, the lead actress, Elaine Hudson, ran to the tent and scrambled inside, while the camera and a boom microphone, pressed in through an abbreviated panel, checked the empty bassinet, pummeled the strewn bedding with anxious and incredulous hands, and flew out again, shouting. "Print it," Reimer said, after the 4th. The nights they filmed the prosecution scenario, Morehouse stood about behind the crew, wrapped in a broad anorak and trailing a scarf. When Reimer called for action, Elaine Hudson carried the baby from the tent to a seat in the yellow hatchback. She slaughtered the infant with icy scissors while the camera looked up at her towering face from below and cleaned the car and herself afterwards, all the while in thrall of demonic obligation. It was a tall order, and they tried it again and again. The scene had no persuasion in it. "Cut," Reimer said. The actress threw up her hands. "I'm sorry," she said into the glare. "It's not the writing, it's the idea." She shaded her eyes, looking for Morehouse. "It just won't hang together." Morehouse rubbed a cheek with a palm. The scene was faithful to the prosecution case. "It's the way it is," he said. "Take 9, Reimer said. They had 3 hours before the moon came up. 6. An appeal to the High Court of Australia was lost, 3 judges to 2, on 22 February 1984. The next letter Lindy Chamberlain wrote from Block J, Berrima Prison said, "The total effect of the last 4 years on the lives of myself and my family are permanent and far-reaching. No one who has been touched by our tragedy and the subsequent events can claim to have been unaffected. I don't cry myself to sleep much anymore. I just grit my teeth determinedly. Although I felt broken at times, with God's help, I've risen, armed for the fight. Others haven't been so lucky and will show the scars for life." Others with scars for life seemed a mysterious reference until this item appeared in city newspapers. Chamberlain resigns as minister. Sydney. Pastor Michael Chamberlain has resigned his position as an ordained minister with the Seventh-day Adventist Church. Church spokesman Pastor Russell Kranz confirmed the resignation today. For some time, Michael has been seriously thinking about his future and realizes he cannot continue effectively as an ordained minister, he said. There were rumors about a while now that Michael Chamberlain was suffering a crisis of faith. Lindy wrote, "May God forgive those involved in doing this to me and mine." 7. It seemed to Tipple now that everyone was speaking out. He was keeping a running list. The Chamberlain support groups were drawing good publicity. In Tipple's private assessment, the newspapers were in the pursuit of sales rather than justice, but either way, the publicity resulted in a press statement from Joy Cool, which he thought was indicative of something. Cool announced her resignation from the New South Wales Health Department to join the Northern Territory Police Forensic Science Unit as its director and moved house to Darwin. She had retested her anti-serum, the statement said, and her opinions remained the same. The importance of this diminished unexpectedly when a carefully anonymous juror broke silence long enough to explain that scientific evidence played no great part in the conviction. "It really came down to whether you believed it was a dingo or not," he said, at a secret press interview condoned by the law department, and then he disappeared again. The family Cranwell, who the defense team was unable to trace, came forward and described the way an Ayers Rock dingo dragged their child from a car 8 weeks before Azaria Chamberlain's death. On 23 March, this letter appeared in the National Times. A plea from Ayers Rock. Now that Mr. Max Cranwell has told of his daughter being attacked by a dingo at Ayers Rock in June 1980, it may be that certain experts will give the Chamberlain case more detailed consideration. Legally, the case is finished. All appeal rights have been exhausted. It is a pity Mr. Cranwell did not give evidence at the trial, because I believe his story would have suggested that it was unsafe to convict Mr. and Mrs. Chamberlain. Since the incident of Azaria's disappearance, I have heard dingo experts stating that a dingo would not enter tents or attack humans, whether adult or juvenile. Having lived at Ayers Rock for 16 years, I know that the dingoes of this area are conditioned by and to the people. Consequently, their behavior is not that of a true wild animal and not fully understood by anyone. I have no doubt that a dingo is capable of attacking children, and the possibility of a dingo carrying away a baby is therefore quite feasible. The doubt that is now being cast by scientific people on the forensic evidence given at the trial, together with my experience of dingo behavior, leads me to hope that despite legal channels having been exhausted, humane considerations will result in some form of inquiry into the evidence given at the Chamberlain trial. I do not think any of us should feel comfortable with the present situation. The signatory was the Chief Ranger, Derek Roth. 10 days later, 31 scientists, 25 of them members of the Australian Society for Immunology, signed an open letter protesting against the conclusions drawn from Joy Kuhl's tests and directed the original to Chief Minister Everingham. On 16 August, Dr. Frederick Smith, a Northern Territory Health Department psychologist who examined Lindy Chamberlain at Berrima Prison, gave a television interview at which he made his report public. "Psychologically, I'm unable to account for any criminal behavior on her part. On the contrary, all of the indications available to me suggest that Mrs. Chamberlain is clearly among those persons in society who would be least likely to engage in crime, whether in an habitual or isolated fashion." In a letter to the Governor-General, he went further. "Having interacted closely with hundreds of prison inmates as a psychologist," he wrote, "I believe Mrs. Chamberlain to be the only one whom I have known who is totally innocent." The Plea for Justice Committee and the National Freedom Council had 100,000 signatures on a petition to the Governor-General, and organizers still hoped for another 20,000. An embarrassment of riches, Tipple thought, then recalled Phillips saying something like that at the trial. A heavy envelope arrived on Tipple's desk, postmarked London. It held a copy of the Medico-Legal Society's quarterly journal, sent by a British friend who thought he might be interested in an account of the Society's quarterly gathering. The meeting was held on 12 April, in the evening, at the Royal Society of Medicine. The report didn't note the number of members present, but otherwise seemed to give the proceedings in full. Tipple imagined a modest function room, the remnants of dinner cleared away, decanters of agate port, throaty cigar smoke. The chairman, a judge, rose to introduce the speaker, Professor Cameron. The record noted applause. Cameron then delivered a paper which must have taken a full hour to read, committing throughout so many errors of fact that Tipple, with some measure of dark pleasure, couldn't readily keep count. The recorder, Tipple supposed it was the secretary, gave the rest verbatim. The chairman. The word fascinating is the right one. Professor Cameron has been good enough to say he will answer questions and hear comments from anybody. Mr. Leonard Kaplan. What was it that led to the prosecution naming the wife as the supposed murderer rather than the husband? Professor Cameron. This was a problem which we, as prosecution witnesses, did not need to worry about, but I do know that a number of legal views were expressed, or cast doubt as you do, on the veracity of differentiating the charges. A member. The 2 boys were never questioned? Professor Cameron. The 2 boys were questioned, and from what I am led to believe, when interviewed they gave identical statements, and when re-interviewed and breaking off the interview halfway and starting again, they went and had a playback and carried straight through. They never changed in any way whatsoever, but naturally they could not be interviewed too often. In fact, no blood samples were taken from the children at all, because it was considered totally unnecessary, in view of there being no challenge to the clothing being that of baby Azaria. The Chairman. Are there any accounts of dingoes attacking human beings, particularly babies? Professor Cameron. There are a number of cases in Australia, particularly in the Aboriginal legends, of the dingoes attacking livestock and alleged children, but there is no factual proof whatsoever of dingoes attacking such objects unless they already be dead. They go mainly for insects and small mammals. The Chairman. And do they eat carrion? Professor Cameron. Not often. I have no definite proof. There were a number of dingo experts called, both for the prosecution and for the defense, and there seemed to be considerable diversion of views as to whether they were 4-legged animals or 8-legged octopi, and their views changed from day to day. The Secretary. Professor, I thought you were saying that it looked as if the body had been buried in the baby grow, and then the baby grow had been dug up again. Professor Cameron. No. When one examined the baby grow, there were no bloodstains whatever on the baby grow or on the carry cot. There was very little blood on any of the 6 blankets in which the child was wrapped like a cocoon. There were a couple of drops of blood on a couple of parkas that were found inside the tent, and also on Mrs. Chamberlain's trousers, which were only detected after they had come back from the cleaners. As to the clothing of the jumpsuit, it was my view that this had been buried in sand or in the red sandstone adjacent to Ayers Rock while something was inside it, because there were no crease marks in the clothing, and it was uniformly stained with sand, as if it had been buried in sand, and not as if the clothing had been buried empty. Mr. Evans. What was the defense's explanation for the bloodstains on the mother's trousers and the bloodstains in the car? Professor Cameron. As far as we were led to believe, the Chamberlain's view was that the blood in the car was not that of Azaria. They did offer the explanation initially that, being Seventh-day Adventists, they were very good Samaritans, and if they knocked down an animal and they picked him up and threw him in the back of the car, this would cause the blood contamination. That was one story. The second was that, as was pointed out, it was a child's blood. It was then suggested that the 2 boys frequently fought in the car, and this was coming from them. Then when it was pointed out, or suggested by Mr. Barker, on Mrs. Cool's evidence, that this was a child under 6 months, no explanation was given. There is, and there always will be, considerable disquiet by many forensic biologists as to the presence or absence of fetal hemoglobin in the bloodstain of that age, and is categorically as stated in this case. Mr. Eric Newham, Oxford. I had the privilege to attend a conference in Australia where this subject was discussed. This was, in our view, a wonderful determination by pathologists to show, without question, that the defense put up would not stand up. I think that because of the weird background some of us might think that there might be something in the defense. I am quite certain, in taking not only to the forensic scientists on the spot, but also to lawyers there, that there is no question whatever that the right decision has been made. I think there is a danger, do you not, sir, that because something is peculiar and weird, therefore we do not believe the obvious scientific evidence. But the scientific evidence here, as I understand it, is absolutely clear. The report ran for pages yet, but Tipple was too angry to read any further. He slammed it shut. 8. A well-wisher sent her a poem. A little bird I am shut in from fields and air, and in my cage I sit and sing, to him who placed me there, well pleased a prisoner so to be, because, my God, it pleaseth thee. Within a fortnight, she had news that Regan was caught in the face by shrapnel from a bottle which exploded at a children's party, and he was lying in hospital, blind in one eye. 9. An Adventist church in Melbourne was daubed with red paint. 2 nights later, the same insistent brush drew outsized paw prints on the pavement leading to the church door. In Sydney, a housewife chased Adventist teenagers from the street outside her home. At the top of her voice, she identified them by way of explanation to passers-by, as child killers. At the Arena Church near Gosford, families who arrived early for Sabbath school found a sign scrawled by the doorway. The message read, "Dingo pups for sale. Apply within." So popular now were jokes about dingoes and the inexplicable disappearance of Adventist babies that a publisher released an anthology. The Anti-Discrimination Board of New South Wales reported, "The church once had a rather benign image, which it will now take years to regain unless it involves itself in an active campaign." The Adventist News, a lay journal, predicted in an editorial that the problems the community now faced would take up the greater part of debate at the next meeting of church governance. The executive committee convened in a boardroom in Wahroonga on Sydney's North Shore. The administrative complex here is headquarters for that part of the Christianly world called the Seventh-day Adventist Australasian Conference. These precise titles are important. The church is of 140 years standing, age enough to see change and meet rivalries. There are now congregations which no longer hold so fast to the prophetic guidance of Ellen White, and a reform movement, estranged over objections to military service, has not been part of the mainstream since the First World War. The Wahroonga Centre is on Highway 1. The church on the east side, lofty and solid, has a bell tower which speaks, in architectural terms, of constant vigil for the first shining sign of Advent and of expectations undiminished by disappointment. The office building on the opposite side of the motorway resembles a comfortable, late Edwardian mansion. Sedans in the car park behind are modest and clean, and the most common fender sticker carries the neat outline of a fish. 52 delegates to the executive assembled in the boardroom, all men, all pastors. They represented around 1,000 congregations. They were hushed and solemn. Each one of them had felt the swift unpopularity of their church at first hand. The rate of recruitment to Adventism, which was once a proud and reliable 8% a year, was now halted. Their annual appeal for public donations to the health and mission program was a vivid failure. House-to-house collectors returned with quiet tallies. They had found distrust and evasion. They were met at times with curses and often with slammed doors. Everywhere the story was similar. They were expected to dispel adversity with what they called lives of patient example, but the times were exceptionally ill. Everyone knew of pastors who had answered the telephone late at night to abusive callers. On a popular radio program, a public affairs commentator had associated Adventism, by some feat of reasoning, with the Jonestown massacres. Not long afterwards, a religious studies researcher was asked by a serious reporter to supply the texts which detailed the ceremonies appropriate to the ritual sacrifice of Adventist babies. Those delegates who anticipated, as did the Adventist News, a discussion of the current plight, were surprised by the agenda. It was a heavy list, routine and familiar. It opened for debate the usual labors of their lives in Christ. They spent time speaking and voting on measures to do with public health, education, regional administration, outreach, everything but the acute problem of the day. General business brought an expectant pause, a cough or two, the white reflection of a tentative hand, but nothing came of it. By then it was clear what had happened. The guiding elders had determined, in discreet concert, to leave redemption to the proper intercession of the Lord, should he so choose. Neither the conviction of the Chamberlains nor the bitter predicament of the church would be raised at this session or at any other. They closed the meeting with prayer. 10. Son. Lindy guilty of murder, say most. Most people believe Lindy Chamberlain murdered her baby Azaria, according to the Gallup poll. Of those sampled, 53% believe she is guilty, and 52% say she should not be pardoned. 11. It is the deformity of prison time and prison space which so credibly tampers with the mind. She was finding now that a cell is not confined by the walls. The fault lies with the ungenerous corners. Time makes progress here to the ringing of bells but idles in the muted intervals between. It takes less than a year for the bell to do duty as a biological metronome, persuasive enough to control sleepiness and wakefulness, tolling all the obedient rhythms of the body. The next bell will command darkness, but meantime the high globe burns brightly, and she sits on a chair at a table she uses for writing and holds a pencil as if she were judging its length against the pad. Her fingers are bony. She is so light now that she could scarcely creak a wicker chair. In her own judgment, she has lost 25 kilograms and knows her photograph would alarm her friends. She is dressed in a flat blue smock, and her abruptly cropped hair does nothing anymore to hide the inquisitive shape of her ears. An abandoned shoe lies under the table. It is early August. The afternoon temperature made 31 degrees, and the night air is little cooler now, but these are conditions she has come to think of as soft and pleasant. By day, the window gives her a view over a scrubby plain, dry and ruddy, to a horizon she long ago decided was south. An inlet, some shiny part of the harbor, dribbles in from the west. This is now as familiar to her as a landscape hung on the wall, and at night is replaced by an abstract of cross-hatching where chain wire from the stockade shadows the window pane. The most unsurprising change, the replacement of daytime by night, to choose an example near at hand, is evidence valuable to her of the fleeting nature of things. A notice she has taped to the wall reads, "Tough times don't last." To friends she writes of God's waiting room, as if she were at a siding, momentarily between trains. The tasks she has set herself, during prison classes in the useful crafts, include leatherwork, weaving, and apparel, and there would be nothing remarkable in this were it not for the unison of purpose in the items she has chosen to make. She fashioned and embossed hide belts for the boys to wear to school. She made small suits, soft and snug, for Kalia to wear outdoors in winter, then added a muff and sent them off to Kurenbong. She crocheted a jacket for her mother and mailed it to Naura. In a locker, and ready for dispatch, lay a pair of shoes for Kalia, which matched the pair she planned for herself, and a partly completed tapestry, a caravel in full sail, bound for the long wall in Aiden's room. These are all, one way or another, expressions of motility, as any quick analyst would see, but her own interpretation is far less mystical. She now has a presence in the midst of her family, wherever they are. The surprise, in so disciplined a place as prison, is the truancy of the mind. She finds repetitive tasks easy, but a book cannot hold her for longer than a slow page. She discovers grammatical errors of the simplest kind in her own letters, reread. In conversation, she sometimes refers to Azaria instead of Kalia, and transposes the names of the boys. She often wonders if there is some significance to this she should better understand. Right now, she is struggling with the words of a poem. She has slipped off the other shoe and perches her toes on the rung. In less than a week is the anniversary of Azaria's death, and she has in mind an item for the in memoriam columns of the Sydney Morning Herald. This sort of composition had given her no trouble as a pastor's wife when, for some defeated family, she helped out with an apt and sweet rhyme, but now the words come slowly. She has folded the discarded pages under the pad in the belief that a fresh sheet invites thought. The verse she wants will show the permanence of love compared with temporary death, and will carry the gentle tones of prayer time. She hopes to do better when her mind sharpens, but, so far, she is confident only that it will close this way. Not a day has ended with the fading of the light that I have not remembered you. Azaria, good night. 12. Benches in the hall began to fill, beginning with the second and third rows, since no one ever seemed keen to sit in the very front seats. The rally was due to begin in 10 minutes, at 8 p.m. The speakers stood around backstage. Judy West, although pleased that everyone thought her habitually serene, wasn't sure she felt any better than the trembling Sally Lowe. Greg Lowe has gone off somewhere searching for water with which to wash down his sedatives, but Judy's guess was that he was also looking for a dark corner for a quick cigarette. They had played town halls in most city capitals now, afforded top billing, if that wasn't too theatrical a term, because they, Judy herself, the Lows, and sometimes Wally Goodwin and Murray Haby, were one-time witnesses for the prosecution, dismayed and disaffected. Someone switched on the footlights. They crossed the resonant stage and sat in an enfilade representing the order of speakers tonight. Guy Boyd, the founder of the Plea for Justice Committee, clutching notes, then the Crown witnesses, a space to the lean and peppery Les Harris, this time without a dingo to parade about the stage, and Barry Betcher, stiff-legged and impenetrably silent. The hall was around a third full, allowing for the vacant seats between. A good many couples of middle age and older, muffled against the cold, some of them rank-and-file Adventists, Judy guessed, a dozen or so young people, from Christian youth groups perhaps, a junior reporter alone in the front row on the most dismal assignment of the editor's night sheet, but hoping for enough to lift her to the prominence of a byline, and otherwise maybe 50 others, singly or in quiet company, who had seen the newspaper advertisements. No hecklers this time, so far as Judy could tell. She had recognized in herself a new wiliness for such things now. This was a traveling show, and they were evangelists of a sort, offering the message with what they hoped was persuasive clarity and confidence, while watching, as if at the periphery of vision, for the first signs of disbelief and ridicule. Volunteers were closing the doors. The hall fell silent. Boyd walked to the lectern. To applause, he held his hands aloft, a handsome pilgrim, white-haired and sad. He fiddled with the microphone. Judy had a vision, which she got from a second-hand story, of Boyd standing outside the opening doors of the High Court after the appeal was lost, lone and bewildered, handing to outrushing journalists the press release he had prepared for victory. They had, she rather thought, each joined the troop for different reasons. Les Harris out of fierce anger, Barry Betcher because plain facts had been mislaid, the Lows because, as they often said, the tragedy could have been theirs. Judy's reasons were harder to come by. She simply knew she must. She was not here because she was a Christian. Indeed, of the speakers tonight, probably only Boyd was, in any real way. Judy sustained her own system of human understanding and love with a belief in a more general God, with pragmatism and patience, and with a calming discipline of meditation on demand. But she was not beyond the charming philosophies of the Testaments. The one she now carried around in her mind was from Isaiah chapter 26. Hide thyself as it were for a moment, until the indignation be overpast. For behold, the Lord cometh out of his place to punish the inhabitants of the earth for their iniquity. This seemed to meet the deep and simple needs of the moment. It made the world explicable. Afterward. Were it fiction, no new and risky character would appear so late, but the ways of unruly fact drew in David Brett, leading him here from a quiet English village. Brett was a young man with a belief in the occult and a liking for the rituals which bring good fortune. He had in mind to see as much of the material world as he could, while his own fortune stayed good enough. From Harley, in Kent, he journeyed to the Australian east coast and lived there for around 4 years. His close friends were mystics, in whose judgment David Brett could expect some peak of destiny only with his death, by suicide, which they were encouraging. He was not as convinced of this as they were, and he left them for his mother and home. While Brett was back in Kent, people whose beliefs lay more in the direction of the hard sciences were still investigating how Azaria Chamberlain may have died. In a laboratory in Germany, Doctors Bodner and Storico were fast coming to the conclusion that blood found in the Chamberlain's yellow hatchback should not be identified as fetal, but may well be as adult as the Chamberlains said it was. They were much persuaded by Professor Barry Betcher, who not long before had walked into the laboratory and pumped a sample from his own bared vein for its routine identification, which then classed the professor as a newly born baby. At Kansas State University in the U.S., Randall R. Brzee, an associate professor in textile sciences, was comparing, under many magnifications, damage to the fibers of babies' jumpsuits and singlets sent to him from Sydney. The clothes had been chewed by a dog and by a dingo, the threads neatly sliced by the teeth, in no way different from damage the professor had seen before on textiles bitten by coyotes. They were also identical with the cuts on the Chamberlain garments. Inside the High Court building in Canberra, where the baby's own garments lay in custody, 3 inquisitive laboratory analysts who were picking over the tousled and sorted fibers for any other indications of chewing happened on specks of flesh, glistening as the magnifications were turned higher, suddenly and shockingly meaty. So far as anyone could tell, these were the remnants of Azaria Chamberlain. Around that time, at the Turnbull Research Institute in Melbourne, Hans Brunner, who had now developed a method of classifying species of mammalian hair, turned to the identification of hairs taken 5 years ago from the jumpsuit and the singlet. There were 9 of them, and throughout the trial they were thought to be cat. Brunner found 2 were human. Another he couldn't place at all. The other 6 he was sure about. They were canine. And away at Currambong, Leslie N. Smith was tracking down the source of the blood pattern in the footwell of the Chamberlain car. This was known to everyone by now as the arterial spray, the baby's very last heartbeats, the vivid and indelible place of slaughter. Smith worked with a sanitarium food factory. He was responsible for automated equipment there, and this made him fussy about patterns which seemed to betray some sort of repetitive structure. He took photographs of the car panel close up and enlarged them further. He could see, over the peaks and ridges of these dark stains, a haze of color that reminded him of overspray from paintwork. From the spray to the bottom of the footwell, he drew lines in the air with taut strings, a cat's cradle which pointed slyly at a grommet in the sedan floor. Then he made for the car assembly plant. This was not the blood of a murdered child. It wasn't blood at all. The arterial spray was a sound-deadening emulsion which General Motors called Dufix HN 1081. Not much of this was known to anyone beyond the inquiring scientists and the people to whom they reported their findings, and certainly none of it was known to David Brett in Kent. Brett had discovered in himself certain familiar longings. He was taking telephone calls from his friends in Australia. His mother didn't like it. More worrying, he was making plans to go back. When certificated copies of those scientists' reports landed on the desks of the law department in Darwin, they came with a petition for a judicial inquiry and for Lindy Chamberlain's release. She had so far served 2 years of her term, long enough to outlast the term in office of Chief Minister Everingham, who had moved to political life on the other side of the continent. His replacement was Ian Tuxworth, a politician of blustery mode, but there was no one now with legal qualifications on the high benches of government, and Tuxworth chose, as his Attorney General, Marshal Perrin, who had the clean and regular features of a graduate from law school, though he was nothing of the sort. Perrin passed the new Chamberlain plea back to the law department. The petition was denied. To clear the air, Tuxworth handed around a press release and brought to the debate a perspective all his own. This campaign has as its intended effect the building up of antagonism toward the Northern Territory government, which it seeks to portray as hard, cruel, and lacking in compassion. At stake is law and order, and faith in the due process of a legal system recognized as the fairest in the world. Newspapers which carried this statement also ran reports, attributed to ministerial sources, that Lindy Chamberlain should expect to serve 20 years. Avis Murchison, her tiny and vigorous mother, didn't believe it for a moment. From the Adventist manse in Nowra, she wrote to a friend, "We know that, in God's time and in His way, this terrible injustice will be resolved. May victory come and bring glory to His name." The friend to whom she was writing was not religious, so Avis penned, by way of a defiant letterhead, "Our God is able." When David Brett got to Ayers Rock, summer was at its worst. 6 months living on the East Coast again had taken off the pallor of Kent. He was robust enough now, but here the sky was mercilessly clear day after day, the sun blazed, the desert oaks sighed, and the heat seemed to come equally from the zenith and the sand underfoot. There weren't many tourists around. If Brett had been a follower of the Chamberlain case, he would have seen that the settlement here was much changed. The faded motels had gone. New camping sites and hotels with outdoor bars and veiled swimming pools lay in a discreet hollow. Brett had come here to climb the rock. He was camping alone, so he had no one's capacities to consider beyond his own. He was fit, but so hot was it that a day climb was out of the question. He chose evening and set out just before sundown, carrying a small knapsack of light clothing in case the air up there got chilly. He took the ascent route on the western side, with the post and chain as a guide, as far as a ledge below the peak. No one had told him that a dawn climb was preferable to dusk, because the arkose of which the rock is made holds the heat a long time on the west ridge. He rested a while there. Then he swung the knapsack over a shoulder and started up again. The sun had well gone, but there was still light to see by, enough that a group of departing tourists watched him climb, a small figure, high above the southwest face. He kept climbing east. The air was cool, but not crisp enough yet for need of a sweater. There was something happening now, of which he would have to be careful. It was as if the altitude and the stillness of the night were together pressing from the air a faint but tricky dew. He came to a bluff, which must have located him then somewhere above the great smudge of lichen the Pichichinjara call the campfire of the sleepy lizard. It seems he had chosen a nighttime climb because of the radiant wonders of the heavens, and here they were, within happy reach of the mind. The stars, the planets, the luminous ways, the whirling galaxies, the emblems that begat the zodiac, all the forces of the universe, in glittering and dizzy display. David Brett's body was found below the bluff 8 days after his fall, in the scrubby gully with which news reporters were already familiar. It was here that Wally Goodwin had found Azaria Chamberlain's clothes 5 years back. The local police sergeant, Mike Van Haythausen, roped the ground off for 100 paces each way. He didn't want anybody watching this. The dingo layers around here were many, and now the corpse was not entire. By radio, he called in rangers and maintenance staff and directed a search. It was not that he thought they might find any trace of the smaller parts, but the right arm was gone, and there might be a chance of finding bone that size. They walked abreast, kicking aside shrubs and dusty grasses. The dingoes had evidently pillaged the fallen knapsack, and they located a t-shirt, shorts, a kerchief. Further along, a ranger next in line to Van Haythausen gave a grunt and stooped to inspect the sand by his feet. He tugged at a knot of something buried there, the gritty crust broke away, and he pulled it free. Whatever it was, it had once been white. The sergeant took it and turned it over. A baby's jacket, knitted, with stiff, tiny sleeves. A button at the neck, hung by a thread. "Stay right here and don't move," the sergeant said, and headed for the radio in his truck. He wanted some very clear instructions about what he should do now. Police Commissioner Macaulay was heading for the Chief Minister's office. Macaulay was a stocky man, precise in his ways, who was happiest when things ran according to police manuals and statute books. He'd had the feeling, for some time now, that the Chamberlain case was guided by rules with which he wasn't familiar. When the Chamberlain's petition had come up with solid scientific support, he had expected an inquiry as a matter of legal course. A lawful conviction was one thing, but it seemed to him that scientific opinion had unbalanced the sort of scales of justice he had trained with, and the time had come for someone in judicial authority to rule on it. When he said so, he was told it was a legal matter for Cabinet. Since there were no lawyers in Cabinet, it seemed he was being told it was a matter for politicians. He expected the matinee jacket should turn the manner of debate around, even in the judgment of politicians. It was always part of the prosecution's case that there was no matinee jacket and that Lindy Chamberlain had lied when she said there was. It was thought a convenient phantom to explain why no saliva was found on the underlying clothes, and an effort to link the after-image of a knitted fabric, which Murray Haby found in the sand, with the dingo tracks alongside. More importantly for Macaulay, the jacket now altered certain slight balances of authority. It was recovered during a search under his jurisdiction. He had already decided to have it sent to independent laboratories in Melbourne for examination, rather than to the Darwin Forensic Science Unit. The jacket gave him some standing in the argument, right where he wanted to be. A secretary led him into the chief minister's office. Tuxworth, too big for his chair, Perrin, easing his neat slacks, and the sweaty Crown solicitor, Martin, lounged around the desk, jackets off. They stopped talking when Macaulay entered. This was the wet season, the air conditioner at full blast, the vapors, damp and smelly. They let him stand. Perrin took the easy question. "So it is the jacket?" "Without doubt," Macaulay said. Since no one seemed ready to offer anything more, Macaulay said, "You have to hold an inquiry now. There's no alternative." Martin ran a hand over his sparse hair. Tuxworth sat back in his chair. Perrin shook his head, irritated, as if they'd spent too much time talking this through already. "No," he said. "That's not the way to go." Macaulay turned for the door, red-faced. He had decided to put his recommendations in writing from here on and let them deal with it that way, and he was coming closer to a conclusion of a different nature. He had seen, in a government bulletin, an advertised post with the federal police force. More and more, it seemed an attractive way out of here. Maybe the falling out of allies should play no part at all in the administration of justice, at least no executive role, but that is the way it was, and no one in government seemed to understand the rate at which it was happening. At the offices of the News, Darwin's Daily, a short stroll up Mitchell Street from the chief minister's suite, one of the government's long-standing alliances, was in poor shape. Anyone who could remember the last time the News and the government fell out had a long memory, but a scoop was a scoop, and right now the News had one it wasn't going to let slide. Journalists at the News had discovered that someone had been feeding them misinformation. The acting editor, then, was Jack Ellis. When the Attorney General denied the Chamberlains' petition for an inquiry, the department's reasons satisfied Ellis until they found that they didn't at all satisfy two of the prosecution's own scientists, Andrew Scott and Tony Jones, who were now calling for a new investigation. Not long after, the leader of the political opposition in this town, Bob Collins, took up the issue in the House, but word got around to the presses that Collins was a Seventh-day Adventist. People at the News thought this explained a great deal until they found that Collins was an Adventist for a time brief enough to fit between his 15th and 16th birthdays and had been a church-going Catholic ever since. Ellis doesn't like to be made a fool of, and at times like these, anger makes him unusually single-minded. He assigned staffers to the Chamberlain case full-time. Because he judged that the finding of fetal blood was the crux of conviction, he instructed his reporters to head in that direction. They came up with a copy of Andrew Scott's report and another from Professor Orion Ochterlony, who had written, from Sweden, protesting the way the prosecution had used the procedures which bore his famous name. But it was the Germans who gave them the lead story. The News's staffers telephoned Beringwerke, makers of the testing solution. Dr. Bowdner came on the line. He spoke a convenient amount of English. Certainly, he said, he had advised the law department in Darwin that the testing solution should not have been used as it was in the Chamberlain prosecution. So dismayed was he over the denial of the Chamberlain's petition that he had written again to the Crown solicitor asking for reconsideration. The date on the letter was 2 weeks old. The astonishing fact was this: since that time, the law department had kept Bowdner's judgment to itself. Ellis decided to run everything he had. It was a Friday morning. A 9 o'clock radio bulletin reported that government ministers are confident there will be no new inquiry into the conviction of Lindy Chamberlain. The layout Ellis chose ran the Beringwerke story, page 1, with the Scott and octolony letters in support. It was more space than the news had ever before used on the Chamberlain case. There were small-town niceties to be observed here, so Ellis dispatched a messenger boy to the Attorney General's press secretary with a copy of the lead story and a courteous note. The news generally hits Darwin streets at 3 in the afternoon. Ellis sent the stories off to the setting tables at around mid-morning. A reporter fresh back from the government offices said something was going on there. An emergency meeting of cabinet was scheduled in a few minutes' time, and the police commissioner was in the Attorney General's office. Ellis drank coffee and waited at his desk. The presses would roll in an hour. The way things were done in the territory, he could expect a visit from a ministerial aide any time now. The call came at midday. It was the chief minister himself. He addressed Ellis as Jack, and his voice was loud and amiable. "I know it's on the presses, but I've got a bit of story for you," he said. "We're letting her out." Perrin called a press conference. Every reporter and news photographer in town was there. He handed around copies of a prepared statement which announced an inquiry and the immediate remission of Lindy Chamberlain's sentence. He read it aloud. By the time he finished, no one doubted how deeply he wished the problem over. "Although Mrs. Chamberlain's remission is subject to the usual condition of good behavior," he said, "it is not my intention that she should be taken back into custody regardless of the outcome of the inquiry." Then he turned, leaving the cameras agape, and walked out. Melbourne Age. Chamberlain is set free, rejoicing as new evidence leads to inquiry. The Australian. Lindy free, top-level inquiry, the story that intrigued the world. The Telegraph. Lindy set free. NT promises she will never go back to jail. Adventists at the Avondale College painted "Welcome Home, Lindy" on a cotton banner and carried it, skipping, to hoist above the gates. On the way back, they tied every tree for the length of College Drive with a yellow ribbon. The pastors responsible for Sabbath prayer were in merry conference, fashioning a service of thanksgiving around the verse, "I waited patiently for the Lord, and he inclined unto me and heard my cry." Psalms 40, verse 1. A juror from the trial, Yvonne Kane, told journalists of a recent prescience, a dream in which Azaria had spoken to her from the dead, and was joyful. At his desk on the editorial floor of the Sydney Morning Herald, Malcolm Brown had been taking calls all afternoon from reporters with news like this. Every stringer in Darwin had print fever. A freelance news hound outside the gates of Berrima Prison had watched Lindy Chamberlain, frail, in pink frock and sunglasses, climb into the rear seat of a darkened limousine while a tearful woman in slippers and a housecoat tried to get close enough to give her a clutch of flowers. Reporters in hire cars and taxicabs dawdled the inbound traffic lanes, but were warned off by motorcycle police. Photographers were staked out around a bungalow in town where Lindy Chamberlain was thought to be now, but frangipani and bougainvillea blocked any sidewalk view of the windows. By the time Brown had used enough incidents of this nature to fill a news page headed, "The Final Chapters," it was late. He sent the sheets away with a copy boy. Brown preferred a typewriter to a terminal, and since he was now the paper's chief reporter, he could work any way he chose. He still liked, for example, to stand his typewriter upright on its heel at the end of a day. It implied a natural conclusion, and was at the same time his salute to tradition. He slipped into his jacket and snapped out the light. No one else was around. All the activity in this building was closer to the presses now. He rode the lift down and stepped out onto the pavement. It was a warm evening, soft and indigo. The bright footpaths of Broadway were busy with summer night crowds. A sudden need to be with them made him pass up a cruising cab. He strode seriously along, huge and splay-footed. Brown would have described his gait as jaunty, but the hint of anything so personal rarely makes it as far as his shoe leather. These happy crowds and garish lights seemed to him emblematic enough of a carefree and splendid world, but a candid source for his own humor was not so easy to come by. Brown knew there was a deep sense in which Lindy Chamberlain's freedom had somehow released us all, but he was thinking now more of the other casualties, those along the way, the Lows, Wests, Whitakers, Murray Haby, and Wally Goodwin, all of them united in a chill understanding that they had not so much taken part in a courtroom trial as in some theater of illusion, and all of them imagine a measure of personal blame because they did not see early enough what the prosecutors were making of them, because they did not think quickly enough in the witness box, because they did not give their testimony well enough. Justice was not done, as they reckon it, by their default. They are quite wrong about that. We know, when their voices are gone, when the stories close, our lives don't work that way at all.